Hello and welcome everyone. I hope this message finds you fit and fine. In previous lecture, we were discussing UPSC. Now it's time for SPSC, State Public Service Commission. In our Constitution, Part 14, Article 315 to 323 talks about provisions related to UPSC as well as SPSC. So SPSC is a constitutional body, a state-level recruiting agency, right? Starting from composition, our constitution has not mentioned specifically how many members are there going to be in SPSC. So the decision is taken by governor on the advice of Council of Minister of State, right? Chairman is appointed by governor, right, on the advice of Council of Minister at the level of state, right? And that maximum age can be 62 years and time is 6 years. In case of UPSC, when chairman was getting appointed, time period was maximum 6 years, but maximum age was 65 years. So here's the difference. Now, when it comes to qualification, so Constitution has not specified qualification, okay? But at least half of the members should be from central government or state government, should have at least worked for 10 years. In case chairman's position remains vacant, for example, death happens or removal happens, so in this case, acting chairman is going to be appointed by governor. Now, please remember, in case of SPSC, appointments are being done by governor, right? Governor of that state. But when it comes to removal, removal power is in the hands of president. And this is the difference. Removal. So who is going to do the removal? President is going to do the removal. Okay? So this is an exception. If I make a statement, governor of a state can suspend or has power to suspend member of SPSC or chairman of SPSC. Tell me that statement would be correct or not, true or false? Answer is true, because here I use the word suspension. Suspension is temporary. For example, if removal proceeding means if a matter with respect to removal of SPSC member or chairman is with president and president has referred this misbehavior case to the Supreme Court. So meanwhile, governor has power to suspend that SPSC member or chairman. Suspension is temporary, right? Removal power is in the hands of president. I hope now you will remember it, right? If he is adjured insolvent, like in case of UPSC we discussed, there are 4 cases of removal. Number 1, if the concerned member or chairman is proved to be insolvent, that person's debts are so high that known source of income won't be sufficient to actually pay back, right? So there can be a case of corruption as well in future. So this person cannot be trusted, right? This can be a ground. Second, if that person engages into employment other than this, paid employment, this can be a case. If that person's mind or body is not serving, right? So it means person is not capable to do that job. So it means insolvency, employment, and infirmity of mind or body, right? Apart from that, the last case, that is misbehavior. What is misbehavior is not defined by our constitution. So in this case, president has to refer this matter to the Supreme Court. And whatever advice Supreme Court gives, that advice is binding on president. Some students, when reading Laxmikanth, they get confused here. If the Supreme Court, after the inquiry, upholds the cause of removal and advises so, the president can remove the chairman or a member. So some students think, oh, the word can is there. So it means advice may be binding or not. No, advice is binding. If you read after that, you will find in the second or third line that such advice is binding. Now, independence. First is, you cannot remove SPSC member or chairman apart from these 4 reasons. Means there is security of tenure, right? So one is security of tenure, then comes the financial part, right? So you cannot change the, you can say, conditions of service when that person is there. For example, if CM is saying appoint this person and in this position, and SPSC member chairman said no, we are people of integrity and we cannot appoint as this person has not cleared the exam and we are not going to give undue favor anywhere in interview as anything. So now, so if this protection is not given, don't you think independence can be compromised, right? There can be a possibility that service conditions may be changed of that person, right? So now service conditions cannot be changed. You can actually work with full independence, honesty. Expenses are charged on Consulate Fund of India. Means they are not going to put to vote in state legislature again and again every year. Now, there are two statements and questions are asked from these two statements. So please read them carefully. The chairman of SPSC on ceasing to hold office is eligible for the appointment for the post of chairman or a member of UPSC. Okay. So chairman of SPSC cannot be reappointed on the same position, number one. If you are a chairman of SPSC of Uttar Pradesh, you cannot be, after completing the tenure, you cannot be again appointed for the same position. But you can be appointed as UPSC member or UPSC chairman. A member of the UPSC or the chairman of the other SPSC, but not any other employment. Means you can be means SPSC chairman can become member or chairman of UPSC, can become chairman of any other SPSC. Means you cannot be on same position, but you can actually become chairman of Rajasthan Public Service Commission. Okay, if you were earlier of Uttar Pradesh, but not any other employment under the government of India or state. But you cannot be appointed in any other job under government of India or state. Okay, any job, no. And you can actually pursue your career later as a, say, private academician. That is your will. But you cannot serve in any other job under government of India or state. Clear? The chairman or a member of SPSC is, after having completing his first term, not eligible for reappointment for the same position. I have already told you this. Okay. Now functions. Number one is conduct the examination, right, for the state level exam. It is consulted on the matters related to personal management. What are personal management? For example, method of recruitment. For example, principles of promotion and transfer. Now, there can be a beautiful trap from this particular statement. UPSC might ask, in case of transfer of state government employees, it is mandatory on the government to consult SPSC. Okay. So if someone has read this and not understood it completely, the principle to be followed making appointment of civil service of the post in making promotion and transfer, that person might think, oh, I've read the transfer there. No. It is not saying that you need to consult SPSC for transfer. It is just saying principles to be followed, principle formulation. In that, you can say SPSC can play a role. Okay, but it's an advising body. Okay, playing on principles, not regular transfers. Any claim for reimbursement of legal expense, for example, a state level government employee is facing some, say, charges and there is court case going on, and this court case going on is in official capacity because some decision was taken by that person. So in this case, the person can say these legal expenses, please give me. Okay. Apart from this, if that person actually suffers some injury during the service, wants some pension, other benefits, so this kind of mechanism can also be suggested by SPSC. Supreme Court has held that if government fails to consult SPSC in these matters which we discussed, personal management matters, the aggrieved public servant has no remedy in the court. So a direct statement wise question can be asked. So this can be a statement. Okay. So SPSC need to be consulted, but if SPSC is not consulted, then you cannot go to court why SPSC was not consulted. Now, limitations. Same in case of UPSC, for example, in case of reservation for backward classes, it is not mandatory that you need to consult SPSC. In case of some claims which are leveled by SCs and STs, then also this SPSC can be excluded. Governor can also exclude SPSC in certain cases, service matters. But in such case, what you need to do, you need to present such proposals before state legislature, and state legislature can amend them or repeal them. These provisions are same as in case of UPSC. This power was with president there. Okay. Now role. So it is concerned with recruitment, right? Watchdog of merit system at state, like watchdog of merit system at India level, right? In case of UPSC. Not concerned with classification of service, pay, service conditions, cadre management. These things are not under SPSC. This is the limitation, because these things are taken care of by different department of personnel, right, which is responsible for cadre management and training, etc. Recommendations made by SPSC are advising in nature, means not mandatory. There is also a limitation. SPSC is consulted by governor for framing the rules, for example, Provincial Judicial Civil Service, PCSJ, Provincial Civil Service Judicial. So in this case, governor may consult SPSC that you have to conduct the exam, but we need to take High Court in the loop, because High Court is having the power, right? SPSC is just a exam conducting agency and High Court is going to suggest that. So we are talking in case of Provincial Civil Service Judicial, right? PCSJ. Now let's discuss the case of JPSC. So JPSC is not a constitutional body, it's a statutory body. Please understand, remember this, because there can be a question statement there. Can be created by an act of parliament, that's why we are saying it's a statutory. Request of the state legislatures concerned. If two state legislatures say to the parliament that we are not having capacity to conduct our own recruitment and that is why we want support of centre, in this case an act can be made for actually making JPSC. Now, in case of SPSC, appointment was being done by governor, removal was being done by president. But in case of JPSC, although it is going to serve those two states or more than that, but in case of appointment as well as removal is done by president. But in case of age 6 years, 62 years, that is same as in case of SPSC. I hope you'll remember that, right? JPSC presents its annual performance report. Now, in case of SPSC, that is going to present its annual performance report before governor, and governor is going to present before state legislature. But if there is one JPSC for two states, so where this particular JPSC is going to present its report? It is going to present to the both governors, and then governors are going to present into respective state legislatures. Report to each of the concerned state governors. Each governor places the report before the state legislature. Now, so sometimes one statement is made from historical context. It was in Government of India Act 1935 that it was clearly mentioned that there will be a federal Public Service Commission, which took the shape of UPSC later. There will be provincial service commissions, means state public service commissions, and there was also mention of joint public service commissions for 2 or more states. Okay, this is a fact. Now these are the articles 315 to 323 which talks about UPSC and JPSC, SPSC. Now attempt this question. On which among the following matters in the State Public Service Commission not consulted? Not, okay. Method of recruitment of civil service in the state is consulted. On the principle followed in making appointment for civil service state, principle, yes. On the principles to be followed in making of promotion, yes, principles, fine. Making transfer of civil servant, no, and that is why it is not consulted. D would be the answer. A member of State Public Service Commission may be removed by governor, no, governor, no, governor, no, because you know that SPSC members are removed only by president, right? In case of misbehavior, inquiry need to be conducted by Supreme Court, right? Joint Public Service Commission may be established for 2 or more states. If respective states agree in this regard, Parliament appoint JPSC Commission by law. Both are correct, A and B, right? Hello and welcome everyone. I hope this message finds you fit and fine. Today in our Laxmikanth series contest, we need to talk about UPSC, mentioned in part 14 of Indian Constitution, starting from Article 315 to 323. Now, here's a tip for you. Whenever you have to revise any topic of Indian polity, open the first page and look back. Look back in your memory what you actually covered broadly in this chapter. For example, UPSC. So what is the status? It's a constitutional body mentioned in Indian Constitution, right? What about the composition? So composition is a heading, right? Within composition, what you covered? Okay, so is there a specific number mentioned in Indian Constitution about the composition? What is the appointment process? Who appoints these members? Then how they are removed? What about the functions of UPSC? What are the limitations of UPSC? What provisions we can say give independence, required independence to UPSC, right? So in this way, you will remember the broad structure of the chapter. And when you have to recollect this information for solving a question, it will be easier for you. Okay. Apart from this, always remember some areas where UPSC play some traps, some twists. Okay. So this way you will have better integration with the content. Now, let's start. So UPSC is a central recruiting agency. Means prime purpose is to conduct examination, release merit list and tell government that these people are fit for this particular position. Now, it is on the government whether to appoint you or not. What does it mean? It means recommendation of UPSC is not mandatory on government. Although UPSC is an independent constitutional body. Please remember, independent constitutional body. Now talking about composition, numbers. Constitution has not specified any specific number. When it comes to appointment, they are appointed by President. Okay. And maximum tenure can be 6 years and by age it can be 65 years. Here it is mentioned. Generally the composition is between 9 to 11 members. Now what about qualification? Constitution has not specified qualification as well. Although half the members of this UPSC board should be employees of central state government, at least they should have served for 10 years. In case chairman position remains vacant, in this case, President can appoint any member of UPSC as acting chairman. Now removal. Please remember, there are 4 grounds of removal. Only 4 grounds which are mentioned in Indian Constitution. Number 1, insolvency, bankruptcy. It means if the concerned member or chairman is having such a huge loan that by his or her known sources of income, that person cannot repay back. So what does it mean? That this person is actually near bankruptcy. So do you think that person can be trusted for such a crucial job? No, right? There can be a chance of corruption, right? So that is why this can be a ground of removal. Apart from this, paid employment. If you are a chairman of UPSC, you cannot simultaneously come to any coaching and give lecture and have some payment. Okay. Although after that, you can come and give guidance. This happens, right? But during tenure, if you are doing such thing, then you can be removed. Okay. So 2. Now third one, infirmity of mind and body. If due to some mind problem, brain problem or say body problem, you are not able to fulfill your responsibilities. So this can be a ground for removal. And 4th one is misbehavior. Now for misbehavior, it is not defined what misbehavior means. So in this case, President has to consult Supreme Court. It is binding. You have to consult Supreme Court. And the advice given by Supreme Court to the President, whether this person has actually committed this misbehavior. Now this advice is binding on President. Please remember, there can be a question from here. UPSC has asked such statements earlier. Okay. So in short, you can remember by this mnemonic IEMM. I means insolvency, E means employment related removal, M means mind and M means misbehavior. Okay. Now independence of UPSC. Number 1, the members and chairman are given security of tenure. It means they can be removed only on the basis, these 4 bases which we have discussed. President cannot remove any member or chairman on whims and fancies or any advice given by Council of Minister, like in case of removal of governor. So there's a difference. Governor position is not having security of tenure. Governor of state I'm talking about. Okay, but they are having security of tenure. Apart from their salaries and allowances, they are charged on consolidated fund of India. Right? It means there is security there as well. Otherwise, by fluctuating these salaries and allowances, you can actually untwist the person who is member of the board, right? So such a thing should not happen. Now attempt this question. Consider the following statements. Members of the commission are not eligible for appointment at all after retirement or removal. Chairman is also not eligible for appointment in any job after retirement or removal in the country. Which of the following statements are true? Come on, attempt. We have not discussed it, but attempt. Because there's a rule in psychology, if you commit mistake and you get the right answer here and now, then there are greater chances that you're not going to forget it. And that's our purpose, right? Now, attempt. First of all, let's identify the gaps. member of the commission are not eligible for appointment at all after retirement or removal. This is wrong. You know why? Because members can be appointed as chairman of UPSC, right, as well as chairman of SPSC, State Public Service Commission. Means elevation can happen, right? Now, chairman is not eligible for appointment in any job after retirement. Some of you might be thinking, this seems correct. Oh, you think so? What about this, any job? Any job. Don't you think it is quite a broad term? Is it not possible that chairman of UPSC after retirement, that this person starts pursuing some academic career, say becoming professor in a university where he was or she was earlier serving? So any job is wrong. The word any job is wrong. You cannot limit his actually freedom to earn livelihood, right? So that is why answer is D, means neither. Okay, none of these are correct. I've given you the explanation already. Now, functions and role. So prime purpose, recruitment. So all India service, central service and public services like IAS, IPS, for that you have one exam, right? Civil service exam. Then IES, IRS, IFS and many others. Means these are the positions. Apart from this, UPSC can also actually help states in joint appointment. Okay. And to the civil service exam, people are also get recruited in provincial service, civil services. For example, DENIPS, Delhi Andaman Nicobar, you can say cadre service. SE DENIPS, similarly, Delhi Andaman Nicobar Island Police Service. Okay. So it is commissions to make. Apart from this, UPSC also make rules and regulations for appointment, removal, promotion, and so on. So please remember, this is also a role of UPSC. It's not like UPSC is just going to recommend that this person is fit for this job, now my job is done. No. If you've done some adventures in your job, means huge corruption charges are leveled against you and inquiry proves, yes, this person has done such thing. So in this case, UPSC will actually have some role. Means your file is going to be moved from the state in which you are serving, or even in central government if you are serving, your file is going to be moved to UPSC as well. Okay, so UPSC has role in removal as well. Because suspension and removal are different. Na? Suspension can be done by state government as well, wherever you are serving. Okay, as an IS officer, IPS officer. Suspension is temporary. We are talking about removal, termination from service. There, UPSC has a role. Now, the commission looks after disciplinary matters. The commission gives annual report to Honorable President, what you have done in the whole year. The role and functioning of UPSC are like that of watchdog of merit system. Watchdog of merit system, why it is said that? So that in these key positions, people who truly deserve through this system of examination, they should reach these positions. Because if we go back, in the time when Public Service Commission was not introduced in India, I'm talking about the time of Britishers, I'm talking about Charter Act 1853. Before that, what was happening? Recommendation was given, idea was actually floated in Charter Act 1833 as well, but it could not materialize. So before that, in these key civil service positions, those people were appointed who were in good terms of the court of directors who were sitting in Britain. Means the shareholders of the company, they were having say, okay, I'm going to appoint this person as district collector. Okay, such things were happening, but now this could not happen because now we have Public Service Commission. Now, when it comes to limitations, there are some areas where UPSC's consultation is not mandatory. For example, providing reservation for the appointment of some backward classes. If certain SCs and STs are setting claim regarding some appointment, in this case also UPSC's consultation is not mandatory. Selection of chairman of other commissions and tribunals. There are a number of commissions which actually government make, right? For example, this NCW, National Commission for Women, NHRC. So these are commissions which are there. But time to time government also constitutes some ad hoc commissions for inquiring in particular purpose. So there it is not mandatory that you need to consult UPSC. Similarly in case of tribunals as well as in Group C, Group D services. With regard to selection of temporary officiating positions, for example, if you are being hired in a particular position for 1 year, then it is not necessary that you have to go through UPSC. Okay. Constitution states that President, in respect of All India Service, Central Service, may make certain rules, right? It is possible. And it is not mandatory that President has to consult UPSC. But in this case, if you make such rules, you have to present such proposals before Parliament as well within this 14 days. Okay, and President and Parliament has power to amend such proposals, such rules, or repeal them, remove them. Now, these are the articles related to UPSC. Factual thing. Now, attempt this question. The President can remove the chairman of UPSC from office under which of the following circumstances? We have discussed 4 bases on which removal can happen. Adjudged insolvent, I, we discussed it. If he engages during the term of office in any paid employment, E, we discussed it, right? So, IE means we are talking about both 1 and 2. Apart from that, MM, mind, right? And what? Misbehavior. So, D means both are correct. You know this already. Now, which one of the following is not function of UPSC? Not. Conduct examination for appointment of service, right? Consultation, disciplinary matter, method of recruitment, manner of reservation. It is not function, right, of UPSC. Which of the following the first Indian chairman of the UPSC, means Public Service Commission? So, these kind of factuals are also asked by UPSC sometimes. H.K. Kripalani. So, you should remember, you need a Kripa of UPSC, right? And the first Indian chairman of UPSC was Mr. Kripalani. Okay, H.K. Kripalani. Hello and welcome everyone. I hope this message finds you fit and fine. Today we need to discuss union territories. This word is mentioned in Part 1, Article 1 of Indian Constitution. Article 1 says that territories of India include territories of state, UT, and such other territories which may be acquired by India at any point of time. But you should have some questions in mind. What is the difference between UTs and state? Why we needed UTs? So let's start. So states have federal relation with center. It means there's distribution of power between center and state. The state can say these areas are my areas means subjects on which I am going to make law. I have the power, right? But can UTs make such claims? Answer is no. Union territories. These are the territories of union. And that is why there's another name, centrally administered territories. So how they were created? Initially during Britishers' time, there was one system, scheduled districts, which were later converted into CCPs, means Chief Commissioners' Provinces. And later, when states were being categorized, means areas were being categorized, when Constitution was being framed, at the time, some of these areas were categorized under Part C and Part D. Later, after enactment of Indian Constitution, by 7th Constitutional Amendment Act and State Reorganization Act, union territories came into place. 1956, they were constituted as UTs by 7th and this State Reorganization Act 1956. Generally, some of these UTs have been elevated to the level of state. For example, Himachal Pradesh, yes, right now it's a state, but earlier it was a UT. Manipur, Tripura, Mizoram, Arunachal Pradesh, Goa, they all were UT at one point of time. Territories which were acquired from Portuguese like Goa, Daman and Diu, Dadar Nagar Haveli, for example from French Puducherry, so they were given status of UT. Now, you should have this question, why they were given this status of UT? Number 1 point, political and administrative considerations. For example, Delhi, for example, Chandigarh. In Delhi, you have seat of union government. For political considerations, they wanted this area to be administered with having, some areas in some subjects, center should have more say. Because this system has been observed in many nations. Capital have spatial arrangement. Similarly, Chandigarh, both Haryana and Punjab were laying claim over Chandigarh. Political considerations, a new, or you can say a UT as an administrative setup was launched there. Then cultural distinctness, for example, Daman and Diu and Puducherry, Dadar Nagar Haveli. So, distinct culture, they needed to be preserved in a different manner. If they are merged with one state, then the distinct culture may be under impact. So, a different status. strategic importance. Location is such that union wants direct control there. Andaman Nicobar Island, Lakshadweep Island. Similarly, special treatment and care for the backward and tribal people. Just for example, Mizoram, Manipur, Tripura, Arunachal Pradesh, which later became states. So you can easily remember this when question is asked in mains on the debate, while some UTs were claiming that statehood need to be given, for example, Delhi. So what are the logics? So for these logics, you can remember PCSS, okay, 4. Now, Jammu and Kashmir, you remember 2019 action by central government, right? Now, Jammu and Kashmir was bifurcated and 2 UTs were carved out. Jammu and Kashmir UT and Ladakh UT. Ladakh UT is not having any legislative assembly, but J&K UT is given provision of having legislative assembly. So reasons for Jammu and Kashmir bifurcation, why it happened. First, Ladakh's case. Number 1 point, sparsely populated, low density, difficult terrain, long pending demand of Ladakh people, no legislative assembly for now. Then why J&K as a separate UT? Internal security, cross-border terrorism, central government wants direct say to tackle these problems with legislative assembly. Now, administration of union territories. First of all, please remember, in case of UTs, there is no uniformity in administration. You cannot say, oh, say you are a UT and you are also UT. It means you should be following same scheme of administration. No. You can say this thing in case of states, but not in case of UTs. No uniformity in their administrative system. Every union territory administered by the president, acting through administrator or lieutenant governor appointed by president. Okay, for example, in Delhi, you have lieutenant governor. Union territory of Pondicherry, National Capital Territory of Delhi, and Jammu and Kashmir are provided by legislative assembly. So you have 3 UTs which are having legislative assemblies: Delhi, Puducherry, and now J&K. The parliament can make law on any subject pertaining to UTs, whether it is union, state, or concurrent. UTs, you may be having legislative assembly, but you cannot say that all the subjects which are mentioned in state list, I am having the power. No, center has power, right? So with respect to, you can say, UTs, apart from these 3 UTs, in all the list, center can make actually laws. With regard to Delhi, Puducherry, and J&K, we have certain judgments regarding this, where Supreme Court has said, okay, in this area, Delhi government is going to have say, although file needs to be moved through lieutenant governor, who is a representative of center. Now, the parliament can establish high court for a union territory, and parliament can also make an arrangement that, okay, you are a UT, but we are not giving any special high court to you because population is less. Your matters can be taken care by the adjacent high court of any state. Jurisdiction of adjacent high court, for example, Delhi is the only UT which is having its own high court. Okay? Now, special provisions with respect to Delhi. First of all, 69th Constitution Amendment Act 1991 provided special status for UT to Delhi. Earlier, Delhi was not a UT. Delhi, National Capital Territory of Delhi, it was a status given later. Okay? Please remember, there's a difference between this word NCT and NCR. Can you tell me the difference between NCT and NCR in the comments below? It created Legislative Assembly and Council of Ministers for Delhi. So how many members are there in Legislative Assembly of Delhi? Answer is 70. Earlier, Delhi was Metropolitan Council and was also having Executive Council. Means more, you can say, hold of center government. Strength is 70. Election is conducted by Election Commission of India. Council of Ministers fixed strength is 10%. Okay, means 7 ministers can be there in Delhi. Okay, Chief Minister is appointed by President. Then Chief Minister gives a list. Sir, appoint these MLAs as members of my council, ministers. So then President is going to appoint. President means ministers as well as CM holds office on the pleasure of President. It means you need to ensure majority in Legislative Assembly. Then you are going to be there. Council of Ministers collectively responsible to Assembly. It means the moment you lose majority in Legislative Assembly, your government is going to lapse, right, dissolve. In case of failure of constitutional machinery, then President can impose President rule there, can be done with a report of Governor in case of state. Here, in case of Lieutenant Governor, more power in the hands of Centre. The provision actually resonates what? Provisions mentioned in Article 356, resonates, okay. Advisory Committee of Union Territory. The Government of India, allocation of business rules, Ministry of Home Affairs. So, Ministry of Home Affairs is the one who is having major power with regard to administration of UTs. Okay, for example, this Lakshadweep, Andaman. So, who at the centre is responsible for managing the affairs of these UTs? Answer is Ministry of Home Affairs. Okay. Nodal ministry for all matters of union, you can say territories, relating to legislation, finance, budget, services, appointment of Lieutenant Governor, administration. So, Home Ministry is the nodal ministry, main ministry. Now, have a look over the UTs, and you must be aware of this fact. In January 2020, Dadar and Nagar Haveli and Daman and Diu were merged. Okay, this is the update, and due to administrative reasons. Now, what is the difference between state and UTs? Let's sum up them. Okay, their relationship with centre is federal, but their relationship with centre is unitary. Means centre is having the ultimate say. They share distribution of power, they don't share distribution of power. They have autonomy, they don't have autonomy. There is uniformity in administration, there is no such uniformity in administration across UTs. Executive head is known as governor, executive head is known as lieutenant governor or administrator. Like in Chandigarh case, you have administrator. A governor is constitutional head, here administrator is the constitutional head or lieutenant governor. Parliament cannot make law on matters of state list until unless extraordinary circumstances are there. But in this case, on any matter, Parliament can make law. Now attempt this question. Which one among the following union territories of India has the smallest geographical area? Factual question. Answer is Lakshadweep, right? Which of the following union territories is given partial statehood in India? Answer is Puducherry, having legislative assembly. The jurisdiction of which of the following high courts extend to union territory of Lakshadweep? Answer is Kerala. Which of the following is not possible by a law of parliament under Article 3 of Indian Constitution? So what does Article 3 says? Come on. You can alter the boundaries, right? You can bifurcate, means trifurcate. So it means formation of new state can happen, right? For example, Uttarakhand being carved out of Uttar Pradesh, right? Alteration of area can happen, alteration of boundaries can happen, admission of new state cannot happen. Why? So you have to answer no. So this is the answer. Why? Because we discussed Article 2 talks about admission of new states, right? Constitution of India describes India as what? Constitution of India describes word union of states. Answer is union of states. Okay. Hello and welcome everyone. I hope this message finds you fit and fine and your preparation is well in line. Today in Laxmikanth series contest, we need to talk about urban local government. Let's start with a question today. Which of the following central government ministry deal with subjects of urban local government? Options are Ministry of Home Affairs, Ministry of Defence, Ministry of Urban Development. Means home, defence and urban development. And options can be 1, 2, 3, 2, 3, whichever you want, your wish. Can be none of these also. We have not discussed it. Still I'm asking because there's a reason for that. When you make mistake and you're given the answer right away, then there are less chances that you are going to forget it. It's a rule in psychology. Answer is all three ministries are correct. So let's start. So urban local government was given a constitutional status through 74th Constitutional Amendment Act. But it doesn't mean that this idea actually emerged after this Constitution Amendment Act. It was taking shape during the Britishers' time, right? And this can be one question. We have just actually attempted it. And we need to discuss this in detail. Means how these three ministries and which area they take care of. We are going to discuss it. Now, historical perspective. First municipal corporation was set up in Madras and then later Bombay and Calcutta. Obviously, these were British presidencies, and Britishers wanted these urban setups to be, developed as role models of development. Later, Lord Mayo's resolution came, which talked about financial decentralization and development of self-government institutions. But later, Lord Ripon, who is regarded as father of local self-governance in India, so he made a resolution, and this was more detailed in terms of structure, finances, functions, and that is why Lord Ripon's resolution was considered as Magna Carta of local self-government in India. Okay? Other Royal Commission was also appointed for the same purpose. In 1919 Act, GOI Act, we discussed about diarchy, if you remember. So diarchy, which divided these provincial subjects into two types, right? Reserved subjects and transferred subjects. Transferred were the one on which Indian representatives were having say, right? So after this Government of India Act 1919, this urban local government was shifted to transferred subject and under the charge of responsible Indian minister. Please remember it, because there can be a question statement from here. Okay? Under the provincial autonomy scheme in this Government of India Act 1935, which we discussed in historical background of Indian Constitution, when these three subjects were divided, right? This will be a union subject and provincial subject. So now this urban local government was shifted to provincial subject, and we have the 7th schedule, right? And in 7th schedule as well, this major say with regard to this urban local government lies with state. Means roots are in Government of India Act 1935, right? Now we have certain committees related to these bodies. There can be a question, which of the following committee is not related to urban local governance, right? So for that, just have a look over the name and the title of these committees. It's not like you have to cram them right away, okay? When you go through them and when you practice some questions on them, then it will be easy for you to answer. P.K. Wattal, John Mathai, Nuruddin Ahmed, A.P. Jain, Rafiq Zakaria, Girjapati Mukherjee, and K.N. Sahay and C.M. Korea. Now, constitutionalization. So, attempt was made by Mr. Rajiv Gandhi as well as V.P. Singh, but it could not formalized. Later, P.V. Narasimha Rao's government was successful in having the 74th Constitutional Amendment Act, right? Now, 74th Constitutional Amendment Act added Part 9A in our Constitution, 243P to 243ZZ. So these are the articles which are dealing with urban local government. From 243 to 243O, we talk about panchayats, right? Added 12th schedule with 18 functions. Can you just tell me which schedule was added through 73rd Constitutional Amendment Act? 11th schedule, right? And how many functional subjects were there? We discussed in previous lecture, right? 29, right? UPSC also plays on some kind of facts in some question. That is why just remember them. Aim to revitalize and strengthen the urban government, right? Means urban government is already there, but by giving constitutional status, we are going to strengthen them, revive them. Now, what are the salient features? First of all, remember, there are three major types. I am not using the word 3-tier, which we discussed in panchayats. When I say 3-tier, what does it mean? Village panchayats are connected to block panchayat, right? Block panchayat are connected to Jila panchayat, right? Jila parishad. But in case of 3 type, it simply means what kind of urban development body you are going to have. It depends on certain qualifications which this particular area is having. For example, if some area is actually in transition from rural to urban, then there you are going to have Nagar Panchayat. If there is an urban area which is small, then you are going to have Municipal Council, or we also say this Nagar Palika. Then a large urban area, we have Municipal Corporation, okay. So it is not like within a large urban area, on top you have Municipal Corporation, then you have Municipal Council. No, this is not the function. The type of municipality you are going to have in a particular urban setup, it depends on kind of urban setup you are having. Transition Nagar Panchayat, a small municipal council, big municipal corporation. I hope now it is clear. Now, composition. I hope you remember in the Panchayat chapter, I told you some provisions are compulsory, whereas others are voluntary. When I say voluntary, it means state legislature have flexibility how to actually implement it by making law regarding that, right? So, members are directly elected. We are talking about composition, each representing ward within the municipal area. A state legislature can provide manner of election of chairperson. Okay, so what you got? When it comes to ward members, means small territories within an urban setup, they are directly elected. Okay, although in this municipal council, we have elected as well as some nominated members about whom we are going to discuss it, right? So, state legislature is going to decide about the manner of chairperson election, okay? Means whether it is going to be indirect, means means members of this council from all, from different wards, they are going to decide from among them that who is going to be a chairperson of this urban area, or it is going to be indirect or direct. Direct means there can be a separate election for the position of chairperson of this urban local body. People can vote 2 times. 1 for the member of the ward, 2 for the chairperson of this urban body, right? But state legislature has power, please remember it. A state legislature may provide representation of local MLAs, MPs. I hope you remember this is same as we discussed in case of panchayats, right? Now reservation of seats, this is also same. Reservation of seats for SCs, STs according to population, right? 1/3 seat reserved for women. These are compulsory. But when it comes to having power with the legislature is having power related to how many seats you want to reserve for chairman position for all 3 categories, means SC, ST and women. Along with this, a state legislature has power to decide whether you should give reservation to OBCs in member as well as chairmanship, right? So, I think you remember it is same like we discussed in panchayats as well, right? With regard to backward classes, please remember, it is as a trick. The power lies with state legislature. There should be no confusion in this, okay? Now, duration. This is 5-year term, same as panchayat, right? In case of dissolution, election must be conducted in 6 months, same, before expiry of the duration of 5 years. Now, I hope you remember, I told you that if out of these 5 years, the panchayat got dissolved in 3 years, okay? 2 years are remaining. Now, there are fresh elections. Now, the newly constituted panchayat is going to remain there for how much time? 5 years or 2 years? There can be a statement in your exam. Answer is 2 years, because in local government, whether panchayat or municipality, this remainder function work means new municipality after dissolution will only continue for remainder of the 5-year term, okay? But this remainder term logic is not going to work if the dissolution happened in less than 6 months time till 5 years. For example, dissolution happened after say 4 years, 8 months. So there were just 4 months remaining to complete the tenure, right? So now when fresh election is going to happen, the newly constituted panchayat is going to continue for 5 years, right? Now, disqualification, same in case of panchayat. For example, law for election to the legislature means MLAs. So if some law is stating that such disqualification is going to work on member of legislature, then such disqualification criteria can also be used towards members of urban local bodies. Along with this, any law which is made by state legislature stating no, this disqualification can also happen. Minimum age 21 years, same in case of panchayat. State election commission, same, single body for panchayat as well as municipality election, okay? State election commission. So, state election commission is a constitutional body, right or wrong? Right. 73rd, 74th Constitutional Amendment Act have given State Election Commission a constitutional body status. Okay. Powers and functions. So, state legislature may provide additional powers to these municipalities. Main plan is you have to ensure implementation of government schemes in that particular area which are pertaining to your functions. Okay. For example, Union government has started, Urban Development Ministry has started a scheme, and there was a scheme by previous government, JNNURM. Present government changed that scheme to Amrut scheme, AMRUT. So these schemes are related to urban development. So who is going to be that implementing body at urban level? Urban local government body, right? Along with this planning, the economic development and social justice in this area, implementation of matters which are mentioned in 12th schedule. 18 functional items are mentioned there, right? Now finances. So same in case of Panchayat. For finances, one, revenues from the power of collection of taxes, tolls, fees which is given to you. Number two, grants which you get from central as well as state government, right? Third, loans. Yes, urban local government bodies can also take loans from state government as well as other financial institutions. But when urban local government bodies take loan from other financial institutions, they need permission of state government. Please remember that. Okay. A state legislature may provide municipalities with power to collect taxes, appropriation, same in case of Panchayat, right? Constitute a dedicated fund from where funds are going to be transferred to these municipalities. Now, State Finance Commission, I hope you remember, right? State Finance Commission is a constitutional body, right? After the 73rd and 74th Amendment Act. So, State Finance Commission reviews and recommend, right, how much funds should be distributed from state consolidate fund to these urban local government bodies, right? So, distribution to improve how you can improve the finances of these bodies and provide grants to these bodies for a specific purpose, that this much amount we are giving, this should be spent on drinking water only or say schooling only. Okay. Now, audit and account. State legislature is going to recommend how you need to compile your accounts and how they are going to be audited. Okay, maintenance and auditing. Exempted areas. So like in Panchayat we discussed, the 73rd Constitutional Amendment Act does not apply in latent split in scheduled areas and tribal areas. And after that we discussed PESA, Panchayat extension in scheduled areas, right? Similarly, urban local government body, after the 74th Amendment Act, so these provisions are not applied in latent split in scheduled areas or tribal areas. Okay, some exceptions are given for ensuring their culture, being sensitive to their customary laws. It shall not affect the functions and powers of Darjeeling Gorkha Hill Council of the West Bengal, because it's also an autonomous area. Now, District Planning Committee. I expect a question from District Planning Committee. There can be a good one. Okay. So, as the name suggests, Planning Committee for the district. Developmental plans we are talking about. So, who decides the composition? So, state legislature decides the composition. Manner of election of members as well as chairperson. Okay. So, if I ask that who remains on the position of chairperson of District Planning Committee, okay, what Constitution says? So, Constitution doesn't say anything on this. Okay. This power is given to state legislature. They are going to decide how members as well as chairperson of DPC are going to be elected. And that is why when you Google, you will find in some states, minister in charge of that particular district is the DPC chairperson. In some areas, local MLA is DPC chairperson, one of the local MLA. In some areas, chairman of Jila Parishad is the chairman of DPC. So it varies. Please remember this, UPSC can actually lay a trap for you in this particular statement. Okay. Functions are also going to be decided by state legislature. and this is with respect to members I've already discussed. So composition, manner of election and function. 3 points you need to remember. The power lies with state legislature. Clear? Now, on this detailed question can be actually asked. 4/5 of the total members of DPC, they must be elected from these local representatives, elected by elected members of district, panchayat and municipalities. Okay? District panchayat, not block panchayat or village panchayat, and municipalities. Okay? In the district, and this out of 4/5, how many are going to be elected by these district panchayat and how many by municipalities? So what is going to be the ratio? So representation of these members in the committee should be proportion to the ratio between the rural and urban population. If rural population is more, so out of these 4/5, obviously, the proportion of these district panchayat actually electing people would be more. For example, let me give an example. Consider there are 10 seats, okay, 10 seats reserved, okay. So now if 10 seats are reserved and we know that around 70% people resides in rural area, so it means 7 members in this DPC are going to be elected by these this district panchayat, means elected members of district panchayat, right? And 30% are this, so 3 members are going to be elected by this municipality, right? The chairperson of such committee shall forward the development plan to the state government. Now there is Metropolitan Planning Committee, and UPSC may try to confuse you between the two, DPC and Metropolitan Planning Committee. What is the difference? When I say metropolitan area, it's a big area. It includes more than one district. Okay, for example, Delhi, Mumbai, Kolkata, Chennai. In Delhi, we have 11 districts, right? So for that, for this metropolitan area, there can be a metropolitan committee, right? Obviously, Delhi is an exception in case of Metropolitan Planning Committee, but you should know what Metropolitan Committee do, right? What's the composition? Although when it comes to composition, manner of election, representation, function, power lies with state legislature. And I hope now you will recognize why I said Delhi is an exception. Because in Delhi's case, municipality, in case of municipality, MCDs, power lies with central government, right? So functions, so you need to remember 3 things: composition, manner, right? Composition, manner of election of members and chairperson, functions. All these power lies with state legislature. Now, 2/3 of the members of Metropolitan Planning Committee should be elected by the members of the municipalities and chairperson of the panchayats. So now recognize the difference. In case of DPC, we said 4/5 of the members elected by whom? Elected members of Jila Panchayat, right? And the members of municipalities, right? But here, 2/3 are actually appointed, elected by these chairpersons of Jila Panchayat. Why we are saying that? Because in DPC, you have only one Jila Panchayat. But in case of metropolitan area, as I told you, there are multiple Jilas, multiple districts. So multiple Jila Panchayat, multiple Jila Panchayat chairpersons. So that is why chairpersons are going to vote, Jila Panchayat chairpersons are going to vote only, not members in case of metropolitan area, right? And this is same, means chairperson of Panchayat and this elected members of municipality. But change is just here, okay? This is the change, okay? Representation of these members in the committee should be in proportion to the ratio between population of municipalities and the panchayats, same. Now, 12th schedule. UPSC has asked one question on which of the following is not mentioned in 12th schedule. Which of the one question was which of the following is a subject under 12th schedule. So as I told you that there are these 18 subjects, right? What you need to do? Just go through them one by one and just recognize what can be the offbeat which UPSC will try to confuse you. Urban planning, including town planning, regulation of land use, means agricultural land or commercial land or residential land. Planning, the socio and economic plans, rail, bridges, water supply, public health, sanitation, solid waste management, fire services, urban forestry, safeguarding interest of weaker sections of society, including handicapped people, means differently able people, mentally challenged people, some improvement and upgradation, urban poverty elevation, provision of urban amenities like parks, seatings, gardens, promotion of culture and education, aesthetic aspects, burial and burial grounds, cattle ponds, prevention of cruelty to animals. Prevention of cruelty to animals is mentioned in 12th schedule, please remember. Vital statistics including registration of births and death. Means when you take birth, so you are issued birth certificate by whom? Urban local body, right? Similarly with death. Public amenities including street lighting, parking, regulation of slaughterhouses and tanneries. So slaughterhouses remain in news, you know that, right? So it is subject in 12th schedule with urban local body, right? I think it is clear to you now. Now, type of urban bodies. So these are the types, okay? Let's talk about them one by one. Municipal corporation, the biggest body among the municipalities. So some examples like Delhi, Mumbai, Kolkata, Hyderabad, Bangalore and others established by the acts concerned state legislature. So there can be a question that municipal corporations are established only by acts of parliament. That statement would be wrong, right? But if it is saying that municipal corporations can be set up in India only by act of state legislature, tell me that statement would be true or false. That statement will also be false. You know why? Consider the case of Delhi. In Delhi, you know, recently there was a news that now the MCDs are going to be merged in Delhi, right? So who is going to do that? Central government through an act by parliament, right? Act from parliament. So that is why in all states, a state legislature. In case of UT, if there's this municipal corporation need to be set up, then act of parliament. Okay. Now this should be clear. You should not commit mistake now. Municipal corporation has three basically bodies. One is council. Then we have some standing committees. Then you have municipal commissioner. There are three things. Okay. Council. Council means we are talking about members. Okay. Council is the deliberative and legislative wing. Discussion is going to happen there, right? Final decisions are going to be taken here. Consists of directly elected as well as nominated members. Please remember it. Composition governed by 74th Amendment Act. Council is headed by mayor, assisted by deputy mayor, 1 year. Standing committee. Out of these members in the council, some are given, charge of specific standing committees. For example, standing committee of health, a standing committee of education, a standing committee of cleanliness, sanitation, right? Now, council has taken some decision that this need to happen. Now, standing committee is responsible to ensure that what is happening, right? A standing committee is also responsible to propose suggestions with respect to their area. Area means subjects. For example, standing committee on health. So, standing committee on health is going to present some views before council. Sir, this should happen. Council is going to discuss, deliberate, and final decision is going to be taken, right? Now, who is going to implement this decision? Municipal commissioner, generally a IAS officer, right? Or a senior PCS officer, responsible for implementation of decisions taken by the council and its committees, appointed by the state government is generally an IAS officer. So these are the three: council, standing committee, and municipal commissioner. I hope you will remember that. Now, municipality, established administration town and small cities by state legislature, UTs by parliament, as I told you. Various names like municipal council, municipal committee, municipal board, municipality, city municipality, these are other names of these municipalities. Now, three authorities, similarly, first is council, deliberative and legislative body, directly elected councillors. In case of this, council is headed by president, chairperson, vice president, deputy chairperson. Also, please remember, there can be a possibility that state legislature has made a law that there can be nominated member in the council as well. Unlike the mayor, the post of president is pivotal, means has more executive power. We have standing committee, same, right? Then we have chief municipal officer. There's another name to that, EO, executive officer as well. Appointed by the state and is in charge of day-to-day general administration of the municipality. Means decisions taken by council need to be implemented by this chief municipal officer. Then you have notified area committee. Now this is totally different from municipal corporation and municipality. So that is why, please remember, created for administration of two type of areas. Number one, a fast developing town due to industrialization, for example, on the outskirts of a district or a city. So state government recognized now we need to develop it as a separate, area, right? We need to develop infrastructure there. Then actually industries are going to come in. And present municipal corporation or a municipality is not having that kind of dedication, or you can say is not having capability to deliver that in a record time. For that, you are actually having a notified area committee. A town considered to be important by the state government and does not qualify as a municipality. So there can be two cases. So in this case, a notification by the state government is going to released. Then State Municipal Act, as per State Municipal Act, it is going to be notified. Can also have powers under other acts, power almost equivalent to municipalities, entirely nominated body. This is different. Entirely nominated body, including the chairman by the state government. Okay, so you can remember notified area committee, notified, and for notified committee is going to have only nominated members. So notified, nominated. I think now you are not going to forget it, right? Thus, it is neither elected nor statutory. Now, town area committee. This is also different. Set up administration of a small town, municipal authority within limited civic functions, drainage, road, street, lighting, created by a separate act of state legislature, composition, function and other matters are governed by act. It is wholly elected or wholly nominated or partially elected, partially nominated, right? So, how you can remember? Town area committee, town, small area, okay, small area, small town, right? So it has not qualified for Nagar Panchayat, right? But it needs civic amenities, right? That is why it is made limited civic amenities. Now cantonment board, Kent. Now we are talking about defense, right? You must have visited some Kent areas. You must be impressed by the kind of management and cleanness which we find in cantonment board, right? So municipal administration of civil population in cantonment area, that is why cantonment board is created. Yes, within cantonment board, civilian population also lives, right? If you have not noticed, then you should notice next time, okay? Set up under Cantonment Act 2006 enacted by the centre, works under administrative control of the Defence Ministry of the Union. Defence Ministry, right? Urban government body, right? IDES, I just told you, Indian Defence Estate Service. It consists of partially elected and partially nominated members, hold office for the time of 5 years. Nominated members actually remain in this position till they are in service in this area. Okay, means we are talking about defence officials. Commanding officer of that area, of that basically cantonment, is recognized as president of this cantonment board, right? So it's an ex officio position. Whoever is going to be CEO, right, is going to be considered as president of this cantonment board. Similar functions to municipalities, executive officer is appointed by President of India. Means we are talking about CEO, right? Members of Indian Defence Estate Service. Now townships. Have you actually ever recognized, if you pass through some big cities, on the outskirts there are some big plants, right? PSUs, for example, Bhel, NTPC, right? So there are plants like, there are townships like Uchahar. So Uchahar is on the outskirts of Raebareli, UP. So it's a township, which was actually created by NTPC, right? National Thermal Power Corporation. For example, Bhel. So this is a township in Haridwar, on the outskirts of Haridwar, which was actually established by Bhel, Bharat Heavy Electricals Limited, a central government PSU. So when they found that this is the area, because for establishing a PSU of the scale of NTPC, BHEL, you need a large chunk of land, right? Sometimes this large chunk of land is actually far from urban setups, right? And you need to give some good amenities, then only people are going to come to reside there, right? So that is why these PSUs take responsibility to develop township there, to provide amenities to the families who are going to serve, the people who are going to work there, their families need to live there, schooling, roads, drinking water, playground, street lights, etc. enterprise appoints town administrator who is assisted by engineer and the non-technical staff. Township is not elected, is not having elected members. Okay, no elected members. Means it is like extension of bureaucracy of that enterprise to manage this township. Simple as that. Okay, extension of bureaucratic structure of the enterprise. Now we have port trust. Okay, first of all, port trust, who is having say there? State government or central government? What's your answer? Port trust established by in port areas like Mumbai, Kolkata, etc. They serve two purposes: protect and manage port, provide civic amenities. Port trust is created by an act of parliament. Please remember it. You cannot say, okay, port is in Maharashtra, now port trust is going to be created by act of state legislature of Maharashtra. No. Okay. Consists of both elected and nominated members. Chairman is government official. Chairman is always government official, generally a senior IAS officer. Civic functions are more or less similar to municipalities. Then you have special purpose agency. So it is different from municipalities. Okay. It's special. It means for a specific purpose, a body has been created. For example, Town Improvement Trust, Urban Development Authority, Water Supply, Housing Board, Pollution Control Board, Electricity Supply, City Transport Board. So set up by states as a function-based and not area-based body. So it's function-based body. There can be one statement over this. Okay. Now, you must have, if you come to Delhi sometime, and you will find that to resolve this problem of the slums in Delhi, there's a separate board, a special agency for that. The name is DUSIB, Delhi Urban Shelter Improvement Board, right? So it is not having area-based approach. Its function is to rehabilitate people from slums, right? To convert these slums into, regularized areas. Now, established by State Legislature Act, functions. Now, this statement you need to remember, function independently from the municipalities and corporation. Okay, it's not like municipal corporation is going to consider you have to report us, no. Now, municipal personals. So we have discussed type of municipalities, but who ensures that these municipalities function? Obviously, personal, people. So there are three categories. One is that you are having a dedicated personal staff, means specifically municipal corporation has hired them, right? Under the system, each local body appoints, administer and control own personnel. They are not transferable to other bodies. So this is separate personal system. Then you have unified personal system. It means transferable across local government bodies. Okay, the state government appoints them, administer, control municipal personnel, and they are transferable between the local bodies of the state. Okay, that is why it is called unified personal system for municipal. But then you have integrated. So how it is different? First of all, transfer can happen to various, you can say, departments as well. It's not mandatory that these people are going to be transferred only in local government. It's not like these people are not going to be transferred to any other local government. They are transferable not only between local bodies in the state, but others as well. Municipal personnel are the members of the state service. Okay. The various national level institutions. Now, this has been a favorite area of UPSC, that one question on institution, sometimes matching them with committee or location. Okay. So UPSC may say 3 institutions and location. Ask this question in 2014. This kind of question. Now, All India Institute of Local Self-Government, Mumbai, Center for Urban and Environmental Studies, New Delhi. So why we are discussing them? You know the importance of urban local government bodies, right? The basic amenities you want, you're living in cities, need to be delivered by these urban local bodies, right? So the people who are working there, the staff needs to be trained, sensitized, right? Upskilling need to be done. So that is why these institutions are there. They also conduct researches on best practices which are happening across the world, right? Recommendation of Nuruddin Ahmed Committee on Training and Municipal Employees. So on this recommendation, this institution was created. Regional Centers for Urban and Environmental Studies. And in what regions they are established? Kolkata, Lucknow, Hyderabad, Mumbai. National Institute of Urban Affairs, Human Settlement Management Institute, established in 1985. Now, how revenues are actually taken care of by these municipalities? I told you, right? Revenue through taxes, non-taxes, grants, loans. The revenues from local taxes, property tax, entertainment tax and taxes on advertisement, you can say the biggest chunk of tax revenue come from property tax. Okay. The municipal bodies impose various cesses also, library cess, education cess, beggary cess, means we are going to have this money from you if you are using some utility of urban local body, and this money is going to spend only on specific purpose, on this purpose. Octroi tax, it used to be recognized as chungi kar in Hindi, but in most of the states it has been removed, but in some state it is actually working. What does it mean? If you are having some truck, car, and you are actually mobilizing some goods into other area of this urban local body and for the purpose of say doing business, so some small tax can be collected from you. This is one example. For use and sale therein has been abolished, and property tax is the most important tax revenue. Source include rent or municipal properties, means we are talking about non-tax. Okay, rent from the properties of municipalities, fees, fines, royalty, profit, dividend, user charges, water charges, sanitation charges, sewerage charges. So these are the sources. These include various grants given by to municipal bodies by centre as well as state government, already told to you. Devolution if state government on the recommendation of State Finance Commission devolve some of the power to collect taxes and appropriate taxes, tax revenue, then it can be also a source. Urban local bodies can raise loans from state government as well as other financial institutions. I told you that if urban local government body wants to take loan from say other say financial institution, then they need to take permission from state government first. Okay, this can be a question. In comment box you should tell me what is municipal bond. So it pertains to actually GS paper 3 economy topic, but since it is considered as an important tool to enhance the financial capabilities as well as thereby developmental capabilities of municipalities, so we should know what are municipal bonds. Now, attempt this question. Consider the following functions. You need to identify which of the following functions are mentioned in 12th schedule. Urban planning including town planning, regulation of land use, planning for economic social development, roads, bridges. I just told you all four, right? Hello and welcome everyone. I hope this message finds you fit and fine. In previous class, we were talking about Panchayati Raj institutions. We talked about different committees and how they contributed in the way Panchayati Raj institutions we have in India now. We also talked about 73rd Constitutional Amendment Act. Now this is part 2, and let's start with finances, as no administrative setup can work without finances, right? So we have 4 points here. Number 1, a state legislature may authorize panchayats to levy, collect and appropriate taxes, duties, tolls and fees. Now, I'm not using the word union legislature, means parliament is not having this power, state legislature is having this power, right? So levy means you can impose, means panchayats can impose, collect means you can collect, appropriate means you can spend money from that collection, that revenue on your own, right? You will have flexibility in spending, right? Second is assigned to panchayat, taxes, duties, tolls, fees levied, collected by state government. Now many students would think, sir, what is the difference between 1 and 2? Because there also you're talking about taxes, duties, tolls, and here also you're talking about taxes, duties, tolls. You just change these words, authorize and assign. The difference is these parts are new kind of setup, means new levy, new collection and new appropriation. But here we are talking about those taxes, those tolls, those fees which are actually collected by state government. Now they can be assigned to panchayat. I hope now you got the difference. This is the old one, this is the new one. Okay. Provide for making grant in aid for specific development projects. For example, we are giving 10 lakh rupees, say 20 lakh rupees. You can spend that and state government is not going to take back, right? And from where? These grants are going to be given by state legislature, from consolidated fund of state. Please remember, approval of these grants are not by state government, but by state legislature, because we are talking about consolidated fund of state. So permission of state legislature is mandatory if you want to spend money from consolidated fund of state, right? They can also institute a separate fund From there, money can be credited to different panchayats. So for financial matters, a state government gets recommendation from State Finance Commission, which is a constitutional body as per 73rd Constitutional Amendment Act. And this is constituted by Honorable Governor of that state. After every 5 years, constitute a Finance Commission to review the financial position of Panchayat. Don't you think it is having the same mechanism like we have with respect to Finance Commission of India, Article 280, right? It shall make the following recommendations. Number 1, the distribution between the state and Panchayat. So you can remember these 3 words: distribution, determination and grants. 3 areas on which State Finance Commission is going to play. So distribution means how money is going to be distributed between state government and these local bodies. Here we are talking about panchayats. Determination of taxes, duties, tolls, fees that may be assigned to panchayats. Such recommendation can be given, and let me tell you, this recommendation is not mandatory, right? Not binding over state legislature. Grant in aid to be provided to panchayats from consolidated fund of state. So these 3 areas, State Finance Commission is going to give recommendation. I hope you will remember that, right? UPSC is going to make statements from here. Now, I would say a question can be asked from here. State legislature may provide for the composition, qualification and manner of the selection of the members of State Finance Commission. What does it mean? It means on these 3 areas, Constitution has not said anything. No specifics are mentioned in our Constitution. So who is given power? State legislature is given power. So please remember, composition, qualification, manner of selection of members of State Finance Commission. Clear? You should remember it. Central Finance Commission can also give recommendation to the state. This is how you can enhance your financial resources and empower your local administration more. Now 11th schedule. So it mentions 29 functional items which are placed under the purview of panchayats. So these are the 11th schedule, 29 subjects. And by reading them, you should not think that panchayats have sole authority to actually work on these subjects. Because on most of the subjects, the state governments are the one who are working, who are having power. They have not devolved complete power with regard to these areas to the panchayats. Because this is a voluntary, you can say, clause. A state legislature is going to decide. Because panchayat should have ability, you can say administrative capability to do that, to deliver on such, you can say, venues. Compulsory and voluntary provisions, UPSC has asked questions from here. That is why, please understand, compulsory provisions first. Organization of Gram Sabha, that is must. And what is Gram Sabha? All of you know that by now. We talked about this in previous lecture, right? All the voters present in that particular gram means adult members who are part of electoral roll, right? Establishment of panchayat at 3 levels, right? Direct election on 3 levels, panchayat, village means intermediary and district level. But please remember, direct election for the member position, okay? Indirect election on 2 positions are compulsory, means immediate, you can say intermediate, it means we are talking about group of villages, and district level. When it comes to chairman of village panchayat, we discussed in previous class, matter is with state legislature, right? 21 years to be the minimum age, reservation of seats both for the members of SCs and STs at all 3 levels, reservation of 1/3 seats for women, we also discussed in previous class, fixing tenure 5 years, establishing state election commission. So these are mandatory provisions, okay? Sometimes students get confused. They say, oh, sir, in our village, the chairperson of village panchayat, gram panchayat means pradhan. Actually, that's a direct election. So why you have not mentioned this in compulsory? Because we are talking about compulsory, means what must happen, and rest, yes, direct election can happen. So there's a difference between must happen and can happen, right? Now, voluntary provisions giving representation to the members of parliament and state legislature in these Panchayat Raj bodies. So it is a prerogative of state legislature. Providing reservation for backward classes. Please remember, for backward classes, Constitution has given this power to state legislature. Granting powers and authority to the panchayats to enable them to work as an autonomous body. That's a voluntary provision. So it depends on state legislature, how much power they want to devolve, right? To perform some or all 29 functions. This is what I was referring to when we were talking about 11th schedule, right? Granting financial powers to the panchayats to levy, collect these duties. Now, panchayat extension to scheduled areas. What does it mean? It means that the way 73rd constitutional amendment was made, it was not like it was viable for all grams or village habitations of India. For example, scheduled areas, tribal areas, they have their own traditions, practices. They may not be able to connect with this, setup of Panchayati Raj 3-tier system. For some people, this may be alien, right? But we need social and economic development activities should happen there. And that is why this PESA Act was made. And it's an important one. UPSC has asked questions over this. The provisions of Part 9, that is Panchayati Raj, not applicable to 5th schedule areas. There can be a statement-wise question. Parliament can extend this part to such with other modifications and exceptions. Now, here you can say Parliament is having say with respect to scheduled areas. Means panchayats will come, but with certain modifications. Under these provisions, Parliament enacted this PESA. Now, these are the objectives of PESA, one by one. Provision for Part 9 to the scheduled areas, self-rule to the tribal population. They should not feel that this is an alien system. Village governance with participatory democracy, evolve participatory governance with traditional practices. So just remember the keywords. Otherwise, this will seem bol bachan to you. Achhi baatein. Just remember the keywords. Self-rule, participatory governance, traditional practices, preserve and safeguard traditions and customs, empower panchayats with power conducive to tribal requirement, to prevent panchayats at higher level. It means we are talking about intermediate and district level, to assume powers with respect to the lower level, right? So this is the prevent one. Now, features of the Act. First of all, state legislation on the panchayat in the scheduled area shall be in consonance with customary law. Means the customs of that tribal community should be respected. Social and religious practices, traditional management of community resources. Means you cannot force panchayat laws on them. They should be in consonance with their traditional practices. A village shall ordinarily consist of habitation or group of habitation. Because in some areas, in tribal areas, what used to happen, what is happening even now, there are 6-7 houses in one patch. Then you go say 1 kilometer ahead, or say 800 meters ahead, then you will say 10 houses, then 25 houses after 1.5 kilometer. So in this case, we have to group these habitations, right? And it should be, the services of this act should be extended to all. Every village shall have Gram Sabha consisting of persons, Every Gram Sabha shall be competent to safeguard and preserve tradition and customs of the people and their cultural identity. Now, every Gram Sabha shall approve plan. Now, this is important. As per PESA, this is the power. Approve plans, programs, projects for socio-economic development. Gram Sabha is going to approve that. Okay. Responsible for identification of beneficiaries also of different poverty alleviation and other programs of government. Who is going to be the beneficiary? Every panchayat at the village level shall be required to obtain Gram Sabha utilization certificate. If you have made a road, then you should actually have approval of Gram Sabha. People of the village will say, yes, a whole road has been built. So that is utilization certificate. Then only other grant is going to provide it to you. Otherwise, it will not be possible. Don't you think it will engage more people with this administration, participatory governance, right? The state government may nominate such, now this is important, may nominate such scheduled tribes which have no representation in panchayats at intermediate level and district level. Please remember, this nomination power is given with respect to intermediate level and district level, not village level. Nomination, but such nomination shall not exceed 1/10 of the total members to be elected to that panchayat. Means we are talking about intermediate and district level. Reservation of these tribes cannot be more than 1/10. in this area. We're talking about PESA. Reservation of seats in scheduled areas in every panchayat shall be in proportion to population. Okay, because here we were talking about the nomination part. Okay, and when I'm talking about here reservation, I'm talking about reservation for elected seats. Okay, now however, the reservation of scheduled tribes shall not be less than 1/2 of the total number of seats, because we are talking about tribal area, right? All the seats of chairperson of panchayats at all the levels shall be reserved for the scheduled tribes. This can also be a question statement. Clear? Gram Sabha or panchayats at the appropriate level shall be consulted before making acquisition of land. And this is important. Please remember, in case of acquisition as well as rehabilitation, say of Gram Sabha and panchayat becomes important after this PESA. However, the actual planning and implementation of the project, it happens at this level of state. Recommendation of Gram Sabha becomes important when it comes to license, mining lease, minerals of that particular area. There can be a question from here. Prior recommendation of Gram Sabha when it comes to exploitation of minor minerals for auction from this area. So don't you think it is empowering the local community? A state legislature shall ensure, means such power need to be given by state legislature. Number one, when it comes to regulation, restriction of sale or consumption of any intoxicant. Ownership of minor forest produce, power to prevent alienation of land from scheduled areas, means land cannot be taken away easily. Power to manage village market. So state legislature will give power to these panchayats. Now finances of panchayat. So now this part is, you can say, this is about why Panchayat Raj institutions are deficient of resources after so many years of independence. Second, Administrative Reforms Commission of India. So it summarized this, what is happening. So as of now, you should know what are the resources of funds for these Panchayat Raj institutions. Number one, grants, which are recommended by Finance Commission of India. That is Article 280. Second is devolution of grants from state on the recommendation of State Finance Commission by state government, Article 243I. Apart from this, loans and grants by state government. Apart from this, there are certain government programs, right? Program specific allocation under centrally sponsored program, additional central assistance, and internal resource generation, for example, tax and non-tax. Now the point is, this internal resource generation, it is quite weak. This tax and non-tax revenues are weak. And that is why our Panchayat Raj institutions are deficient and they're not having that much flexibility or decision-making power for any developmental work. Kerala, Karnataka, Tamil Nadu, they have done significantly well when it comes to empowering Panchayat Raj institutions, but still there are a lot of scope for improvement. One can draw following broad conclusions. First, jaise aapko bataya, like I told you, weak internal resource generation. Panchayats are heavily dependent on grants from union and state. Wherever there is dependence, it means it is going to impact the efficiency, effectiveness. A major portion of grants, both from union as well as state governments, they are scheme specific. For example, if some villager has come before this panchayat and they are saying, sir, we need this is what we are facing, trouble we are facing, and there is no scheme to actually sort out this trouble. So you can say that panchayats have their hands tight, because they are dependent on these grants, these specific schemes. There is very less area to actually help beyond that. In view of their own tight fiscal position, that is why state governments are having their own tight fiscal position. That is why they are not devolving more funds to this panchayat. As state governments are saying that most of the functions which are mentioned in Schedule 11, 29 functions, for example, education, healthcare, water supply, sanitation, all of them, they are being taken care by state government. So that is why state government is having more money also. They don't want to actually devolve more because they are not having that much surplus. Now, reasons for ineffective performance. So these are the reasons which we can sum up now. Lack of adequate devolution, means not much power is given. Excessive control by bureaucracy, tight nature of funds, or you can say overwhelming dependency on government funding, poor infrastructure, creation of parallel bodies. So these are the reasons why they are actually not performing well. Now just attempt this question. It is quite easy one. Which statement is not correct regarding Gram Sabha? It is a body consisting of persons registered in electoral rolls of a village. You have to identify not correct. It is a village assembly consisting of all registered voters. Power determined by central government. This is wrong because power determined by the state government, right? Hello and welcome everyone. I hope this message finds you fit and fine. Today in our Laxmikanth series contests, we need to talk about Panchayati Raj institutions. We have divided this topic into two videos. First, we are going to talk about evolution of Panchayati Raj as a concept in Indian polity. So this concept got shaped through recommendation of different committees, and UPSC has asked question on these committees' recommendations. And I would advise that you have just a A4 size paper and have 6 boxes over this, or you can have 4 based on your handwriting. Then as we complete this particular topic, these committees part, then just mention the keywords related to that particular committee. For example, Balwant Rai Mehta committee, we are going to talk about the whole statement, but mention just one keyword. Then Ashok Mehta committee, one keyword. So you will have some 4 or 5 keywords in these committees' recommendation, and then you will see that many of these recommendations are similar with different committees. So then you can highlight, okay, so it will become easier for you to retain these recommendations and solve those questions, right? Let's start. So Panchayati Raj institutions are given constitutional status, means they are mentioned in constitution. So this happened after 73rd Constitutional Amendment Act. If I say that concept of panchayat actually got shaped after the 73rd, or you can say was formed after 73rd Constitutional Amendment Act in India, do you think that statement would be correct? No. Concept of panchayats was not formed after this particular amendment. Even just it gave constitutional status to that, okay? Because panchayats in India are present historically, right? They were present in ancient time as well, in medieval time as well, right? So the word panch represent 5, right? This is a social institution which later got a status of informal political institution, then later formal political institution. It simply means that people themselves chose 5 Panch Parameshwar, that these are the most respected people in our village, and when it comes to any issue of the village, we'll go to them, we'll have a panchayat, means before each member of our village, majority of the members of the village, and whatever decision is taken in that panchayat, we are going to adhere to that, right? So it was serving a great purpose of conflict resolution as well as some minor developmental works at the level of village without even government support, right? So then government identified its importance, and that is when we actually took steps to actually formalize it. Okay, so now in these recommendations, we need to identify, okay, this recommendation was given, and do we have this recommendation in place as of now? So you will find one recommendation we adopted from, say, Balwant Rai Mehta committee, then Ashok Mehta, G.V. Rao. So we compiled these, best from these recommendations, and then we actually made this constitutional amendment. Okay. So Balwant Rai Mehta committee was formed to review 2 important schemes of that time, which were made for actually ensuring basic services in our villages. Those schemes were CDP, means Community Development Program, and National Extension Service. So Balwant Rai Mehta identified there are a lot of gaps in the implementation of these schemes, and the gaps are because administrative structure is weak at the level of village. Means government's ability to reach out to actually these people is very there's a lot of deficiencies there, and that is why he recommended there should be a 3-tier structure dedicated for changing the rural environment, right, bringing true development there. And he said there should be gram panchayats, means at the level of village, then over the group of villages there should be panchayat samiti, and when it comes to all the villages concentrated in a district, there should be a zilla parishad. Okay, zilla means district and parishad means council, but he used the term zilla parishad. Now 3 tiers organically they should be linked through indirect election. What does it mean? He said at the level of village panchayat, election should be direct, but when it comes to panchayat samiti and zilla parishad, its members should be actually elected from the members who are elected by villages, means at the level of village panchayat. So this was his recommendation, right? I hope you got this. Okay, means at the level of village panchayat, adult members having their name in voting list, they are going to vote, right? But now you have group of villages, gram panchayats, right? And over this you have one, you can say panchayat samiti. Now whoever are elected representatives in gram panchayats, now they are going to choose who are going to be the part of this panchayat samiti. Then you have so many panchayat samitis. Now these panchayat samiti members are going to decide who is going to be part of this Jila Parishad. I hope you got the idea. Now, panchayat samiti should be the executive body, means execution responsibility should be at the level of middle tier, right? Jila Parishad should be advisory, coordinatory and supervisory role. So you found that means execution power was given to this, right? District collector should be the chairman of Jila Parishad. But this is not the case as of now, right? Genuine transfer of powers and responsibility and resources. So can you tell me which article of Indian Constitution, DPSP, actually this particular statement is representing the spirit of that particular article? That is Article 40 of our Constitution, right? Organization of Panchayats, Gandhian principle. We discussed it when we were discussing DPSPs, right? Now, recommendations accepted in 1958, and after that we found Rajasthan actually started this, you can say Panchayati Raj, Nagaland district, right? But please remember, these recommendations were adopted and states were having their, their choice whether they want to implement it or not. There was no talk that they should be given constitutional status as of now. Then we had Ashok Mehta Committee. December 1977-1978, Janata government, Morarji Desai, they actually appointed this committee and it gave 132 recommendations. But we need to go through important recommendations and differences. Balwant Rai Mehta Committee recommended 3-tier structure, 3 levels, right? But Ashok Mehta recommended 2-tier structure. There should be just 2 tiers. Zilla Parishad at district level and below it Mandal Panchayat, means over group of villages. Consist of group of villages with a total population of 15,000 to 20,000. Now some of you might be thinking, sir, why he actually made this recommendation of 2-tier? 3 tiers were good, more representation. But Ashok Mehta Committee observed that there are certain villages which have disproportionate, amount of population when it comes to comparison with other villages. Means some villages where we have very few actually families living. There are other villages who are, bigger in size. So how we can actually ensure, you can say, a uniformity when it comes to representation at Gram Panchayat level, right? So he said, let's actually consolidate some villages and then make different mandals and have Mandal Panchayat there. Jila Parishad should be the executive authority, executive body. Now, what Balwant Rai was saying? Balwant Rai was saying that executive power should be at the middle level, Panchayat Samiti. But he said, no, Jila Parishad, okay, at district level. And there should be regular social audit also. For example, some function has been, some developmental work has been done. But whether that development work has actually done there, this audit should be done from the people themselves. If people say, yes, this work has been done, then only payment should be released. That's a good concept. The Panchayati Raj institution should compulsory power of taxation. And he also stressed on this, that there should be self-sufficiency at the level of Panchayat. The Panchayati Raj body should have money. And how can they have when they are given power to give, impose tax, right? And there should be a Nyaya Panchayat also. Nyaya Panchayat should be kept a separate body. Means there should be a developmental Panchayat, which are this Mandal Panchayat and this Jila Panchayat. And Nyaya Panchayat would be a judicial body. Because why Ashok Mehta was saying that? Because many villages are so far from the district center that it takes around 2 hours journey, or at that time maybe more than that, to actually reach to the district center. So every villager don't have this, capacity or time to actually go there. So their cases should be resolved at the level of village only, right? That's why there should be a Nyaya Panchayat where there should be a qualified judge. Chief Electoral Officer of the state should consult the Chief Election Commissioner, and there should be regular elections. Minister of Panchayati Raj should be there in the State Council of Ministers. There should be a separate ministry there. The constitutional recognition should happen. Now, I told you, at the level of Balwant Rai Mehta, there was no talk that let's give it a status of constitutional body. But at the time of Ashok Mehta, this talk started that yes, constitutional status needs to be given. Okay, so there can be a question statement there. That is why please remember it. Clear? Developmental function should be transferred to Jila Parishad, and development staff need to be given to this Jila Parishad level, because he told us in the previous recommendation that executive power should be at the level of Jila Parishad. For execution, you need staff, right? Seats for SCs and STs should be reserved, and this is another important recommendation, new one, right? Based on their population, there should be reservation for SCs and STs. And due to the what happened actually, due to the collapse of Janata government, means Morarji Desai government, no action could be taken on the recommendation of Ashok Mehta committee at central level. But since recommendations were out, 3 states, Karnataka, West Bengal and Andhra Pradesh, they accepted certain recommendations and modeled their Panchayati Raj on these lines. Now came GVK Rao committee. So it was made to review the existing administrative arrangement for rural development, which were actually in place in different states. And you should also know there were a lot of differences actually. There was no uniformity. So now poverty elevation programs government was planning. So first we need to know how things are working on ground. Then only we can identify, okay, whether this program will actually penetrate to the grassroots or not. So that is why this GVK Rao committee became important, appointed by Planning Commission. What were the recommendations? Now, district level body, that is Jila Parishad, should be the pivotal importance. Now, do you find comparison? Do you find similarity here? Ashok Mehta committee was also saying, yes, district level should be the executive body. And here they are also saying district level should be the executive, means pivotal importance should be there. Some planning functions at state level should be transferred to district planning. And for this, GVK Rao became important, because we have district planning committee concept. Now, Panchayati Raj institutions at the district and lower level should be assigned and important with respect to planning. So it means 3 functions. GVK Rao said planning, implementation, monitoring. These are the 3 crucial functions, right, for changing the scenario of development in an area. All 3 functions should be given to Panchayati Raj. Don't you think it's a major recommendation? Planning, implementation, monitoring. Elections to the Panchayati Raj should be held regularly, and Ashok Mehta was also stressing on that, right? Now, recommendation of GVK Rao committee report differed from those of Dantwala committee and Hanumanta. These were other committees. Hanumanta Rao committee advocated separate district planning bodies under either district collector and a minister. Means separate means different from Panchayati Raj. Okay, but GVK Rao was saying no, Panchayati Raj. He was saying for Panchayati Raj at the level of district. There should be district planning committee. Now, collector should be the coordinator at district level for all developmental and planning work. This is what Hanumanta Rao was saying. And Dantawala saying block level planning. Okay, obviously different. GVK Rao was saying this Zilla level, district level planning. Okay. So sometimes question is asked, which of the following committee is related to Panchayati Raj evolution. So for that you should know Balwant Rai Mehta, Ashok Mehta, right, GVK Rao, Dantwala or this Hanumanta. Now name the committee appointed in 1986 by Rajiv Gandhi on revitalization of Panchayat Raj institutions for democracy and development. And you have to answer. Ashok Mehta committee, LM Singhvi committee, GVK Rao committee, Balwant Rai Mehta committee. As of now, we have discussed these 3 committees, right? Tell me what's the answer. Obviously, none of these means the committees which you have discussed is not the answer, right? Answer is LM Singhvi committee, which we have not discussed because Rajiv Gandhi era has just begun. LM Singhvi committee, 1986. So, Rajiv Gandhi government appointed this committee to prepare, and this is the term, revitalization of Panchayat Raj institutions for democracy and development under the chairmanship of Mr. LM Singhvi. So, recommendations were constitutional status. Don't you think it is same, resonating, right, what Ashok Mehta was saying? Villages should be reorganized. Now, I told you, Balwant Rai Mehta was saying there should be three-tier structure. Ashok Mehta said two-tier structure. Why? I told you, because disproportionate population across villages, right? So that is why this committee recommended, let's do one thing now. Let's reorganize villages, right? Village panchayat should have more financial power. Nyaya panchayat concept, we already actually got recommendation, should be established at cluster of village. Judicial tribunal should be there so that any dispute with respect to election can be adjudicated at this level. Then came this Thangan committee, 1988. Now, a subcommittee for consultative committees parliament. Now, some of the recommendations you will find that yes, they are being implemented as of now. That is why we are discussing it. So this was consultative committee of parliament and political administrative structure for the purpose of district planning. This is what they need, this committee need to analyze. So what recommendation? Panchayati Raj should be constitutionally recognized. Again, they are also saying, bana dijiye isko constitutional body. Panchayati Raj body should be having fixed tenure of 5 years. There should be a 3-tier Panchayati Raj system, yani ke village, block and district. Maximum period for supersession is 6 months. It means, although elections should be conducted before completion of the tenure of one panchayat, that is 5 years. But if due to some reason the elections have not happened, then it can be extended till 6 months, not more than that. Jila Parishad should be a pivot. Importance of Jila Parishad. Don't you think so many committees have actually agreed on the same thing, right? Ashok Mehta, then G.V.K. Rao, then Thangan is also saying same. Planning and Coordinating Committee, Chairmanship of Minister Planning. President of Jila Panchayat should be its members. Now, District Collector should be the Chief Executive Officer, not the Chairman, Chief Executive Officer, right? Reservation for the seats in all 3 tiers for SC dynasties based on population. One more thing, Thangan said women. There should be reservation for women also. A State Finance Commission should be there, and we have State Finance Commission, right, as a constitutional body after 73rd Constitutional Amendment Act, right? Then came this Gadgil Committee. Committee on Policy and Programs was constituted in 1988 when Gadgil. Some of the recommendations are important. Was asked that you need to review how we can make them more effective. Constitutional recognition should be given. Again, they are also saying the same thing. Panchayat Raj institution should be fixed, have term for 5 years. Again, what Thangan was also saying. 3-tier system, members of panchayat to have, they should be elected directly at all 3 levels. And why I'm saying it is important, because this is in practice, right? Panchayat body should be empowered to levy taxes so that they can become self-sufficient. Reservation for SC/ST women, what Thangan was saying. And this Panchayati Raj body should have responsibility for preparation and implementation of socio-economic development. So this is what the prime you can say responsibility of Panchayati Raj institutions is, right? Establishment of State Finance Commission, what Thangan was also saying, same. Now, constitutionalization. Now, what Rajiv Gandhi government did. So they introduced 64th Constitutional Amendment Bill. Okay, so many committees are saying that they should give the Panchayat Raj as constitutional status. But what happened? It got passed in Lok Sabha. But Rajiv Gandhi government was facing, you can say, apprehensions in Raj Sabha. Because many states were saying this will actually take away power of various states, right? States. They want, the control and the power related to development of villages in their hand. If there's a 3rd tier which is developing, it's like center, state, and then Panchayati Raj. They were thinking if there's so many power are going to be given to Panchayati Raj, then why would people will come to, state legislators, right? Their powers are going to be compromised. So finally, this could not actually pass from Raj Sabha, and that is why it could not actually float. Then VP Singh government came to strengthen Panchayati Raj institutions. They also actually introduced Constitutional Amendment Bill, but their government fall, and that is why this bill lapsed. Then came Narasimha Rao government, and this Narasimha Rao government, they played smart. They made certain tweakings in Constitutional Amendment Bill so that states were given some avenues where they can actually make laws as per their, you can say, viewpoint, right? So there were some mandatory provisions and there were some more voluntary provisions. So states actually found it quite, useful. Yeah, there are some voluntary provisions as well. So finally, when these removal happened of controversial part, then finally it emerged as 73rd Constitutional Amendment Act 1992. So who was the leader at the time? Mr. P.V. Narasimha Rao. Which one of the following articles direct the state government to organize panchayat? Article 40, right? 73rd Constitutional Amendment Act finally happened, 1992. Now some of the features. It added Part 9 and 11 schedule. Some facts, right? Article 40, DPSP was saying about it. Article 243 to Article 243O talks about these Panchayati Raj institutions here. Now some salient features. Act provides Gram Sabha. What is Gram Sabha? Gram Sabha means group of people of that village, of that gram, who are adult and they have their name in this voting list, right? You can say electoral rolls. So these are Gram Sabha. Please remember, Gram Sabha is not a you can say a framework where some people are there. Means there's a difference between Gram Panchayat and Gram Sabha. Gram Panchayat is an elected body. Gram Sabha actually represents the people, right? It is a body consisting of persons registered in the electoral rolls. Thus, it's a village assembly consisting of all the registered voters. This is what I have explained this to you. It may exercise powers and perform such functions the village as a state legislature may make. I told you, some provisions are voluntary. So, state legislature can actually give them more power also, have control over other panchayat institutions. So now we have 3-tier structure: Zilla Parishad district level, Panchayat Samitis block level, and Gram Panchayat village level. Don't you think we started from this? Balwant Rai Mehta recommended 3-tier, right? Zilla Parishad at the district, Panchayat Samiti block level means group of villages, and then you have village level. Now election of members and chairpersons. Now remember this detail. Chairperson of Panchayat at intermediate level and district level, they shall be elected indirectly. Indirectly means at the middle level and at the district level, indirectly. However, the chairperson of Panchayat at village level, how that person is going to be elected, directly or indirectly, this is power of state legislature to determine. This is power of state legislature. Please remember, there can be a question from this fact, this provision. Now, when it comes to reservation, there will be reservation for SCs and STs in all 3 levels, but based on population, right? It may be possible some areas are not having ST population. Then can you have mandatory ST reservation seat there? No, because they don't have population there. The state legislature shall provide for the reservation of office of chairperson, the panchayat at the village, and any other level for SCs and STs. So here we discuss Act provides reservation of seats for SCs and STs in every panchayat, okay, in proportion to their population, total population, okay. And here we are talking about office of chairperson, okay. So members and chairperson, there's a difference, right? Act provides for reservation of not less than 1/3 seats for women. But please remember, it also includes the number of seats reserved for women belonging to SC and STs, right? So these will be included in the 1/3 seats which are reserved for women. This is not a separate reservation that 1/3 seat reserved for women and separate 1/3 for SC, STs. In that, there will be separate reservation for women. No, it's included. That also authorizes legislature to make any provision reservation seats panchayat officer for backward classes. It simply means we have talked about SC and STs, we talked about women. When it comes to backward classes, how much reservation need to be given at what level? This is power of state legislature. If panchayat is dissolved, elections are to be held within 6 months from the date of dissolution. Now duration, it can be dissolved before the completion of its term also. The term is 5 years, right? Consider a panchayat got dissolved in 3 years. Then you will have new elections, right? And the new panchayat is going to continue only for 2 years, 3 plus 2. It means the new panchayat is not going to have full 5-year term. Clear? And there's another case here. Consider 5 years is the term, right? And there are 5 months remaining or 4 months remaining before this panchayat completes its tenure. Okay. So now do you think, Now the newly constituted Panchayat is going to serve for just for 3 months or 2 months remaining? No, because that would be wastage of public resources. Again, you have to conduct elections, right? That is why if time remaining is less than 6 months, then this separate, this continuation of the term clause is not going to be applicable. I hope this is clear now. Fresh election before expiry of duration of 5 years, before the expiry of a period of 6 months from the date of dissolution. Within 6 months it should happen. As I told you, if it happened less than 6 months are remaining, then this clause is not going to apply, right? Not necessary to hold election. A Panchayat reconstituted after premature dissolution does not enjoy the full period of 5 years. I told you is going to continue for the remainder period. This is the word remainder. You already got it, right? Disqualification. Now there can be a question over it. All right. A statement would be that the disqualification at the level of Panchayat or Panchayati Raj members can also happen as per the law which is applicable for disqualification of state legislature members. Do you think that statement would be true? That's true. Read. Under any law for the time being in force for the purpose of election of the legislature of the state concerned. Right? On this basis, disqualification can happen here also. Or any other law which is made by state legislature in regard to Panchayati Raj. That, on these basis, disqualification can happen in Panchayati Raj. This power is with state legislature. No person shall be disqualified on the ground she is less than 25 years. Why we are referring? Because 25 years is the minimum age if you want to become an MLA. But if you want to become member of Panchayati Raj, you only need 21 years as the minimum age. Right? I hope many of you can become member of Panchayati Raj bodies. Now, to review annual statement of accounts, annual progress report of the Panchayat is the main function of. Now see, some people would think, collector should be the person, right? But the answer is Gram Sabha. Gram Sabha is given this power as well as responsibility. Now, fundamental object of Panchayat system is to ensure which of the following. This was asked by UPSC. Answer is democratic, decentralized. Hello and welcome everyone. I hope this message finds you fit and fine. In Laxmikanth series today, we are going to discuss special provisions for some states. First question which should come in your mind is why some states are having special provisions for them in our constitution. It means there must be some different challenges on ground in these states. Once you connect with those challenges, it would be cakewalk for you to understand why those provisions were made and what these provisions are saying. UPSC has asked questions from here. Question on Nagaland, question on Sikkim, directly from provision. Once you read the provision, question will be done. Okay, so let's start. So if you find any difficulty at any point of time and you feel I can be of help, then you can shoot me a message on my personal Instagram handle. Now, Article 371 to 371J, we are having 12 states here. One question can be, which of the following state is not part of this? Part 21 having special provisions. So just go through the names. Now, some of you might be thinking, sir, do we need to cram the names? It would be easy for you if you just look at the map, look at the location of these states. You will find similarities and it will be fixated in your mind. Maharashtra, Gujarat, Nagaland, Assam, Manipur, Sikkim, Mizoram, Arunachal Pradesh, Telangana and Andhra Pradesh, then Goa and Karnataka. So it means if you do the clubbing, just look at the map, then it would be easy, right? Now, in original constitution, we were not having these provisions. Constitution did not make any special provision for these states. They have been incorporated by various subsequent amendments. So there can be a question on that. Please remember it. Now provisions for Maharashtra and Gujarat. Now we are going to go state-wise. So what it's saying? Article 371, President is authorized to give power to whom? Governor. Okay. Maharashtra and Gujarat would have special responsibility. So these governors are going to have special responsibility. What is special responsibility? Just look at the development board. Development board, for the reasons when we are talking about Maharashtra, so there are three kinds of development boards which they are talking about. Vidarbha, Maharashtra and rest of Maharashtra. Okay, so Vidarbha, Marathwada and rest of Maharashtra. Okay, there are 3 boards. Saurashtra, Kutch and rest of Gujarat. SK and then rest of Gujarat. So there are 3 boards. Making provisions regarding reports on the working of these boards to be placed every year before State Legislative Assembly. Okay, every year their report need to be presented before State Legislative Assembly. Why we are having these boards in first place? Equitable allocation of funds, and the focus is on developmental expenditure, means they should be equitable there, and along with this technical education need to be provided, vocational training need to be provided, employment opportunities need to be developed in these areas. So why we have these provisions? Because if you look at the areas, Vidarbha, Marathwada, we have seen that there is, you can say, disparity when it comes to level of development. That is why these areas needed some spatial focus. Okay. Now provisions for Nagaland. Just attempt this question now. I have not explained this to you. Just read this question so that you can relate the importance of that provision. Acts of Parliament related to the following matters, means we are talking about matters, would not apply to Nagaland until and unless the State Legislative Assembly so decides. Means Parliament has made the law, but it is not going to apply in Nagaland till that State Legislative Assembly approves that. So what are those matters? So matters like religious and social practice of Nagas, Naga customary law and procedures, administration of civil and criminal justice involving decisions according to Naga customary law, ownership and transfer of land and its resources. So which of the following matter? Answer is all. 1, 2, 3, 4. Okay. Now this thing is directly mentioned in Article 371A. Just take a look. Religious and social practice, Naga customary law and procedure, administration of civil and criminal justice involving decisions according to Naga customary law. It means you cannot say that if you are a Naga person in this area, then we are going to deal with you as per IPC only, Indian Penal Code only. Right? If you do that, consider you are an officer in that area and you are thinking like that, then someone will actually sensitize you. Sir, please read Article 371A. How you have cleared UPSC if you have not done this? So you will say, sir, I have forgot it. Ownership and transfer of the land and its resources. Governor of Nagaland shall have special responsibility with respect to law and order. In the discharge of this responsibility, the governor, after consulting with Council of Ministers, exercises his individual jurisdiction and decisions in this regard. Now, there can be a question statement here. Can President actually take away the special power of governor with respect to law and order given in Nagaland? What do you think? It would be true or false? Some people would think, no. You are saying governors, and governor's role is important as per Article 371A. No, President can take it, because President is the one who actually gives these powers to governors in these special provisions. The special responsibility of the governor shall cease when President so directs. That is why I am saying there can be a question statement here. Now, the governor has to ensure that the money provided by the central government for any specific purpose, for example, 500 crore are provided by central government as a grant for, say, drinking water facilities. Okay. Now this fund has been received. Now, can state government utilize this fund in other activities? No. And who is going to ensure that? Governor is going to ensure that. Now you would be thinking, sir, how governor can stop the state government? Because I told you when we discussed governor chapter that when it comes to grants, appropriation of the funds from consolidated fund of state, that needs to be passed from state legislative assembly, and after getting passed from here, it needs assent of governor, right? And that is why governor has a say there. Related to that purpose only, not in other demand moved in the state legislative assembly. I hope it is clear to you now. Now, a regional council consisting of 35 members. Now, please remember the name of district we are going to talk about now. Okay. should be established for the Seonsang district in the state. There is a specific, the special council consisting 35 members. The governor should make rules for the composition of the council, manner of choosing its members. UPSC will make a statement that these members, 35 members of this council are nominated by governor only. It's not necessary because manner is decided by governor. Their qualification, terms, salaries, allowances, etc. The procedure and conduct of business of the council, it is also going to be decided by governor. Appointment of officers, staff of the council and their service conditions, this is also going to be decided by governor. So, governor of Nagaland is having considerable power due to these special provisions for a period of 10 years. So, please remember there are two actually options here. One is this provision is going to extend, means establishment of this council for Seonsang district will extend for 10 years, or governor will have power to extend it. For such period, the governor may specify, right? The administration of Seonsang district shall be carried on by the governor. The governor shall in his discretion arrange for equitable distribution of money provided by the central between Seonsang district and the rest of the Nagaland. Okay? Any act of Nagaland legislature shall not apply to Seonsang district unless governor directs. There can be a question here. Means in this case, governor's say is more than the say of state legislature, right? With respect to this district. Clear? Now, make regulations for peace, progress. I think it is clear to you now. I think this is clear. There shall be a minister for Seonsang district. This provision is important. In Council of Minister of Nagaland, there will be a special minister for this. It can be possible there is a minister and he is having additional charge for Seonsang district affairs. Okay? Or that person need to be selected, I would say. That person is already a member of legislature or need to be a member of legislature within 6 months when that person is appointed as minister, but that person should belong to Seonsang district only. Now, with respect to Assam and Manipur, President is empowered to provide for the creation of Committee of Assam Legislative Assembly. Now, with respect to Assam and Manipur, there are a lot of similarities. Okay, that is why, but just remember, the President is going to empowered to actually create a specific committee consisting of members elected from tribal areas of the state and such other members he may specify. He means elected members of state legislative assembly, state legislature. They are going to be part of the special committee. And who are those elected? Elected from tribal areas, right? So it means this provision was made so that rights of these tribals can be ensured, right? Now, Article 371C, President is authorized to provide the creation of Committee of Manipur Legislative Assembly. So there we are talking about Committee of Assam Legislative Assembly, here Committee of Manipur Legislative Assembly. Obviously, members are going to be from the assembly itself, right? Consisting of the members elected from hill areas of that state. The President can also direct that the governor shall have special responsibility to secure proper functioning of that committee. So these are the two provisions. Now, governor should submit annual report to the President regarding the administration of hill areas, and there can be a question from here. Okay, so we are talking about Assam, Manipur. The central government can give direction to the state government to administration of the hill areas. Now, talking about Andhra Pradesh and Telangana, DE means 371D and 371E. They are related to Andhra Pradesh and Telangana. 371D was extended to Telangana itself because you know that bifurcation of state happened. The President is empowered to provide equitable opportunities and facilities for the people belonging to different parts of that state. Please remember, now we are going to talk about education and government jobs. What special rights these two states have. Education and jobs. President may require the state government to organize civil posts for local cadres of different parts of the state so that the local people can have representation in the jobs there. Okay, we are talking about government jobs. may specify part of the state which may be regarded as the local area, and which area is going to be regarded as local area, that can also be specified. He may also specify extent and manner of preference, means how much reservation you are going to give and in what way you are going to give in the matter. And please remember, in all of these points, I am again and again using the word he, and he or she is the position of president. Okay. So I think it is clear to you: education and jobs, reservation, local population. These 4 keywords you need to remember, that's it. President may provide establishment of an administrative tribunal. Now here you need to remember, there is a dedicated administrative tribunal, and this administrative tribunal is beyond the supervision of High Court. Okay. Only only you can say the matter here can only be dealt later by Supreme Court. Okay. Outside the purview of State High Court, no court other than Supreme Court is to exercise any jurisdiction with respect to matters subject to this tribunal. And why this tribunal was made? Because we are talking about new provisions, reservation, local population in the civil positions. So there are chances there will be grievances, dispute with respect to government positions which are going to be dealt in this manner. Such disputes are going to be taken by this specific tribunal. President may abolish the tribunal when he is satisfied that now circumstances such are not existing. Now attempt this question. Under the provisions of Article 371E, we have just talked about 371D, okay? But question is from E. Which of the following is empowered to provide establishment of Central University in State of Andhra Pradesh? Central University in State of Andhra Pradesh. Look at the options. President of India, Parliament of India, Legislative Assembly of Andhra Pradesh, Governor of Andhra Pradesh. Answer is Parliament. Why? Directly it is mentioned here. Empowers Parliament to provide for the establishment of a Central University in Andhra Pradesh. Direct statement kind of questions were asked. Now provisions related to Sikkim. All of you know that Sikkim was later, means when we got independence, when Constitution was enacted, Sikkim was not part of India. Right, they were having monarchy there, right? But later it was included. Which of the following can extend with restrictions modification to Sikkim any law which is in force in the state of Union of India? So which can extend such laws? So we have answered President of India. Why we are saying that? It is as per the special provision. As per 36th Constitutional Amendment Act, full-fledged state status was given to Sikkim in Indian Union. It included Article 371F. So DE were Andhra Pradesh, Telangana, right? After E we are having F with respect to Sikkim. Now Sikkim Legislative Assembly is to consist of not less than 30 members. Now also remember these lines, we are going to talk about them also because UPSC has asked questions on that. Now there is a uniqueness in the Legislative Assembly of Sikkim, because in other states you know that when it comes to MLA, Member of Legislative Assembly, we follow the concept of territorial constituency, right? So you represent this territory and all the members, all the valid voters here, all the members living here, you are their representative, right? And valid voters, they are going to vote. But this is not the case in special cases which are given to Sikkim. For example, with respect to the monasteries which are present in Sikkim, they can have their own representative as MLA in a Sikkim legislature. So in that case, that MLA is not representing a specific area, that MLA is representing a section, right? And how is it possible? It is possible due to this Article 371F. UPSC can ask question from here because it is an exceptional kind of case. That is why please remember it. One seat is allocated to Sikkim in Lok Sabha. Sikkim forms one parliamentary constituency. Now, for the purpose of protecting the rights and interests of the different sections of the Sikkim population, the Parliament is empowered to provide for the what they are providing number of seats in Sikkim Legislative Assembly which may be filled by candidate belonging to such sections. Delimitation of assembly constituencies which candidates belonging to such section alone may stand for election to the assembly. After reading this, some students actually just understand, oh, they are talking about reservation it seems, right? And this reservation seems like it is beyond the definition of SCs and STs. That is what you get, right? But I have told you, this monastery, section, representation, difference from territorial constituency concept, right? The governor shall have special responsibility for peace, equitable arrangement of ensuring social economic. Now, the discharge of this responsibility, governor shall act as in discretion, subject to the direction issued by president. Discretion part is there, that is why please remember. The president can extend with restriction modification to Sikkim any law which is in force in the state of the Indian Union. President has power with respect to Sikkim. Now coming to Mizoram, the acts of parliament related to Mizoram. So what special, you can say avenues they have. Such question was asked by UPSC in case of Nagaland. Now it can be asked in case of Mizoram. So if you have we have gone through Nagaland, right? So just see the similarities, right? And it will be easy for you to relate. Religious and social practice of Mizos, Mizo customary law and procedure, administration of civil and criminal justice involving Mizo customary law, ownership and transfer of land. Don't you think all these special provisions were given to Nagaland also, right? And this state legislative assembly consists of not less than 40 members. Now talking about Arunachal Pradesh and Goa, just attempt this question. Governor of Arunachal Pradesh shall have special responsibility of law and order. Arunachal Pradesh legislative assembly is to consist of at least 40 members. So actually this is wrong. We have 30 there, that is why only one is correct. So the governor shall have special responsibility for law and order, right? In the discharge of responsibility, the governor, after consulting with Council of Minister, individual judgment, decision, this special responsibility governor shall seize when president so direct. So we also discussed this, right? This special responsibility can be taken away by the president. The Arunachal Pradesh, I told you, not less than 30 members, but in this question it was saying not less than 40 members. Goa provides that Goa Legislative Assembly shall not consist of not less than 30 members. Can you tell me how many members are there in Goa Legislative Assembly? That was in news few times back due to this hung assembly which actually went there. 40. Now, but here it was saying not less than. So not less than is 30. Okay. Provision for Karnataka. So in Karnataka, you have this Karnataka here. But actually this Hyderabad, initially this Hyderabad was a Hyderabad state before it became part of Indian Union. So some part here in Karnataka, we say this is Hyderabad Karnataka region. And to remove the disparities in economic progress, these provisions were added. Established a special development board for Hyderabad Karnataka region, making a provision that report on working of the board every year before the state legislative assembly. Please remember, when you are using the word Hyderabad, we are not talking about Hyderabad as a capital of Telangana. Okay, we are talking about that Hyderabad region, which we say there is a region of Karnataka. Okay, because Hyderabad state was there. It was quite bigger, than the city which we are having now. The equitable allocation of funds, development, reservation seats in education institutions, vocational training, reservation in state government posts. So it means we are talking about education and jobs. We are talking about reservation and we are talking about local. So these 4 keywords you need to remember. That's it. 371J, which provides for special provision for this Karnataka Hyderabad. 98th Constitutional Amendment 2012 was added. Actually, before that, I'm talking about 2010. So Karnataka Legislative Council and as well as Assembly actually passed resolutions in this regard that we need some special provisions here. Establishment of an institutional mechanism for equitable allocation of funds, development needs, enhance human resource, promote employment, education, reservation. 4 keywords that I'm telling you that you need to remember. That's it. 2010, as I told you, there is the demand. Resolution sought to accelerate development of most backward regions, promote inclusive growth, intra-regional and inter-district disparities that they need to be removed, and that is why this was created. So these are the provisions. Part 6 of the Indian Constitution, India is not applicable to. Part 6, what is Part 6? States. Part 5 is Union. So is not applicable to which of the following state? Answer is applicable in all states in India. Hello and welcome everyone. I hope this message finds you fit and fine. We are in video number 50 of our Laxmikanth series Kanthas, and today we need to talk about state legislature 2. Means we have discussed other half in the previous video. I want you to recollect what we discussed in case of union legislature. Let's start with presiding officers. In case of Lok Sabha, I hope you remember, speaker and deputy speaker. Same is the position in case of state legislative assembly. If a state legislature is having two houses, means bicameral legislature, then the same format. Like in case of Raj Sabha, we have chairman and deputy chairman. Similarly, we have in case of state legislative council, chairman and deputy chairman. If these two presiding officers of the both houses are absent, who is going to preside the house? We have a panel in both houses, right? In case of union legislature, in case of Lok Sabha, we have panel of chairperson. In case of Raj Sabha, we have panel of vice chairperson. Same is the format in case of state legislature, right? Now, speaker of the assembly. A speaker is appointed from among the members, I would say elected from among the members of the state legislative assembly. He vacates his office in which of the following cases? Number 1, ceases to be member of assembly. If you became speaker, but now you have resigned or you got disqualified as member, it means now you will not be considered as speaker anymore. Resigns, and whom is going to resign? Resignation will be given to deputy speaker. You can easily remember it. A speaker is going to give resignation to deputy speaker is going to give resignation to speaker. Okay, and same is the format in case of legislative council. Chairman is going to give resignation to deputy chairman and deputy chairman is going to give resignation to chairman. Easy, right? If he is removed by resolution, and which majority is needed? Effective majority. All the then members of the assembly, means vacant seats are not going to be included. Same is the case of Lok Sabha, Raj Sabha. 14 days prior notice need to be given if you want to remove this speaker via this resolution, right? Now, powers and duties, same format. What is the power? Maintain order and decorum in the assembly. Final interpreter of constitution within the house. Rules of procedures and conduct. Legislative precedents within the assembly. So, all of these functions are taken care of by a speaker. He adjourns the assembly or suspends the meeting in the absence of quorum. It means the minimum number of members which are required to conduct the proceeding, that is 1/10. For example, if there are 100 members in the house, that is the total strength, then you need at least 10 members to conduct the proceeding. If even these number of MLAs or in case of legislative council MLCs are not present, then presiding officer will say, I am not going to conduct the meeting. Okay. He does not vote in the first instance because you are the presiding officer. You need to act neutral. But in case of tie, you can vote. That vote is going to be called as casting vote. Okay. He can allow a secret sitting. It means members other than the members of the house are not going to be allowed. Right. It can happen. Right. Media is not going to be allowed. So secret sitting can be allowed by presiding officer. This power is with presiding officer. He decides whether a money bill or not. Means Council of Minister of State is going to present a bill before Speaker of Legislative Assembly. Sir, please declare this as money bill. And he will see, okay, I am declaring it. So only presiding officer, or you can say Speaker of Legislative Assembly, is having power to declare a bill as money bill. And his decision is final. He decides the question of disqualification in case of anti-defection. You are a member, where it is found that you have defected to other party. Means under 10th schedule, you need to be disqualified. Who is going to take the final call? Presiding officer of the house. In case of legislative assembly, a speaker is going to take the decision. Right? Now tell me, what if you are a MLA, but you have flouted some rule which is mentioned in Representation of People Act, or you have flouted some rule which is mentioned in our constitution. For example, you took citizenship of other country. Now who is going to remove you? In that case, Governor of the state is going to remove you on the recommendation of Election Commission. I simply told you there are 3 pillars of removal, disqualification. In one pillar only, that is anti-defection law, presiding officer of the house holds the power. In other 2, governor, and at the level of union, president, on the recommendation of Election Commission. And my friends, if question is asked by UPSC whether in these 2 cases recommendation of Election Commission is mandatory or not, it is mandatory. Whether such recommendation and such decision by president or governor in case of state can be considered under judicial review. Tell me, answer is true or false? Answer is true. For example, case of 21 Aam Aadmi Party MLAs in Delhi. So they were declared disqualified by President himself because it's a UT, not a complete state. And Delhi High Court put a stay there, right? It can be under judicial review. So it means you have to keep your eyes and ears open. What is happening? And just grab the provision part of polity, which is in news, right? He appoints the chairman of the committees of the assembly and supervises the functioning. 3 committees, please remember, himself the chairman. Business advisory committee, same in case of Lok Sabha speaker. Rules committee and general purpose committee. It means just remember what we discussed in Lok Sabha and it can be replicated here also. He can allow secret sitting, as we discussed. Deputy speaker of the assembly. Deputy speaker, another position. This is also elected one. It's not like speaker of legislative assembly has actually given this position to someone. It's not a nominated position. Please remember that. Usually remains in office during the life of the assembly, vacates in these 3 conditions, same. Means ceases to be a member, resigns to speaker, or removed by resolution. All the then members. It means same majority. 14 days notice. So CRR 14. Please remember, when it comes to presiding officers, whether Lok Sabha, whether in this state legislature, whether speaker, deputy speaker, chairman, or deputy chairman, this 4 conditions you need to remember. That's it. Deputy speaker performs duties of the speaker's office if speaker is not in the house. Also acts as speaker when later is absent. Speaker nominates from among the members a panel of chairperson. That's a separate panel, right? For the purpose, if both are not present, then someone from the panel is going to preside, right? One among them. And same power as the speaker is going to be held by the person who is presiding the house. Now, chairman of the council means chairman vacates his office in any of the 3 cases. Means we are talking about legislative council, okay? Vidhan Parishad. Ceases, resigns, removed by the resolution by a majority of all the then members of the council. Such a resolution can be moved 14 days. Presiding officer powers and functions as the same as case of legislative assembly. It means you have to conduct the proceedings of the house as per the rules and process. You are going to decide which agendas are going to be taken first, which later, which person is going to given preference for actually speaking out. However, the speaker has one special power, that is money bill. Only speaker can decide whether a bill is money bill, not chairman. They are charged on consulate fund, means expenditure on these houses is charged on consulate fund of India. It means you are not going to put this to vote or to put this to discussion and vote how much you need to give this year. Deputy chairman, same. Ceases, resigns, removed, 14 days notice. Performs duties of the chairman's office if chairman is absent, means vacant. Acts as chairman when absent. Tell me if there is any difference between these words vacant and absent. Yeah, there is. When I say vacant, it means no one is representing that particular seat. But when I say absent, absent means that person is not there, but someone is there on that position. It may be possible that person is ill, that person is not present due to some jobs elsewhere, right? This is the difference between absent and vacant, right? In vacant case, you have to appoint, elect, or nominate some other person there. But in case of absent, no, that person, someone is representing that position, right? Chairman nominates from amongst the members a panel of vice chairman. Any one of them can preside. Now, sessions of state legislature. First of all, you have to call the session. Calling the session is called summoning. Who summons the house? Governor, on the advice of Council of Ministers. And what is going to be the maximum gap? Maximum gap can be 6 months between 2 sessions of state legislature. In case of adjournment, adjournment का मतलब है that within the proceeding, means consider house has started and within this time house is ending here, this is ending, this is starting. Within that you can adjourn the house for 2 days, 3 days. Who can decide that? This can be decided by presiding officer, not by the governor. Please remember that. Adjournment signed by, it means now we are at this stage and now presiding officer saying that we have completed the agenda of this session. Now, sir, we are doing adjournment signed by. It means I'm saying that yes, these MLAs can go back. We are not holding session, and I'm not declaring the time when the session is going to be held again. And now this is an indication to the governor, and governor can actually say, okay, I'm proroguing the session. means session itself is going to end now. Now dissolution. Legislative Council is a permanent house, right? You cannot dissolve Legislative Council. Same is the case of Raj Sabha, right? Only Legislative Assembly can be dissolved, okay? Unlike the prorogation, a dissolution ends the very life of existing, means Legislative Assembly. That can be asked as a question. Why? Because when I say prorogation, it means governor is saying, "ठीक है, job is done, I am declaring proroguing this session, session is ending, now I am going to call another session." But when I say dissolve, it means the Legislative Assembly itself is getting dissolved. Now we need fresh elections. Okay, this is the difference between dissolving and prorogation. Position with respect to lapsing the bill. You remember the trick which we discussed in lapsing of the bills video in case of Lok Sabha? Same trick you need to remember. The trick was, consider legislature which is say bicameral. Okay, a bill is introduced in Legislative Assembly, and now that Legislative Assembly got dissolved. So bill will also dissolve, or you can say lapse. You are going to use the word lapse with the bill. Why? Consider that Legislative Assembly is getting dissolved, so Legislative Assembly has some shrap or sin over it. Okay. So now consider second case. Legislative Assembly passed the bill, and now it is in Legislative Council, and now Legislative Assembly dissolved. What is going to happen? Bill is going to lapse. Why? Because this bill has already introduced in Legislative Assembly, and that Legislative Assembly is having some shrap or sin. Okay, and protection can also only be given when this bill touches Honorable Governor. That's a trick. Okay. So consider a third case. The bill is introduced in Legislative Assembly, also passed from Legislative Council, and now this bill is before Governor. And at this moment, Legislative Assembly dissolves. Now tell me, the bill will lapse or not? Bill is not going to lapse. Now this bill has touched Honorable Governor. That is third case. Fourth case. Consider a bill was introduced in Legislative Council. It has not been touched or introduced in Legislative Assembly, and Legislative Assembly dissolves. What is going to happen with the bill? Bill will remain. It is not going to lapse. Next case. Bill introduced in Legislative Assembly, passed from Legislative Council, presented before Governor, but Governor returns the bill for reconsideration in Legislative Assembly, and now Legislative Assembly dissolves. What is going to happen with the bill? Bill is not going to lapse. Why? Because it has once touched Honorable Governor. The security the boost has been given. Okay, so this is the easy way to actually remember this trick. Okay, and you are not going to mark any question wrong. Prorogation, I told you, who is going to do that? Governor is going to do that on the advice of Council of Ministers. If UPSC make a statement that Governor can adjourn the House, proceedings of the House, tell me the statement would be true or false. Some of you might be thinking, he is Governor, he may actually do this also. No, that's not possible, because adjournment and adjournment sandai can be done by presiding officer only, not Governor. Governor start the proceeding and the Governor start the session and end the session. Within that, function will be taken care of by presiding officer. Within the next few days, means after adjournment sandai, within the next few days, prorogation is declared by Governor. However, Governor can also prorogue the House which in session. Means even when adjournment sandai is not issued by presiding officer, then also Governor can prorogue the session, but prorogue, end the session. Unlike adjournment, prorogation terminates the session of the House. Terminates session. Now we are going to have fresh session. When I say quorum, I told you minimum number of members which are required for continuing the House proceedings, that is 1/10. If there is no quorum, it means what is going to happen? Presiding officer can actually adjourn the session or suspend that particular session, that you have to come again with a due strength. When it comes to voting in the House, all the matters at any sitting of the either House, they are done by simple majority, means majority of members who are present and voting. Is specifically in some instances we have other, you can say other majorities which we call say spatial majority, effective majority. Only a few matters which specifically mentioned in Constitution: removal of the Speaker of the Assembly, Chairman removal, and shown a special majority, you can say effective majority in this case, not ordinary majority is used. The presiding officer, Speaker of the House or Chairman in case does not vote in first instance, you all know that whoever is going to preside the House, that's a rule. That person cannot vote in first instance. First voting should happen, matter should be decided. If there is a case of tie, then only presiding officer can vote. We call it casting vote, right? Rights of ministers and advocate general. Both have this common function. Whichever house member you are, in case of minister and advocate general, it means you can say topmost legal officer of state government, they can actually present in any of the house. They can take part. They can speak also if they are asked to speak, but they cannot vote. Means minister can vote only in that house in which minister is member, and advocate general obviously cannot vote. So minister and advocate general of the state have right to speak and take part in the proceedings of the house. Minister can participate in the proceedings of the house which he is not a member. Consider a minister who is not a member of either house. It means that minister can continue in such position for 6 months. Before that, that minister has to be part of any house. Not a member of either house can participate in the proceedings of both the houses. Same case, right? So please remember, either house and speak, but vote only where you are member. Clear? Legislative procedure of state legislature means how laws are made in state legislature. Consider ordinary bill. So ordinary bill can originate in either house, whether legislative assembly or legislative council. Such a bill can be introduced either by a minister or other member. Please remember, this particular provision is applicable only in case of ordinary bill, not in case of money bill. Because in case of money bill, it can only be introduced by a minister. Why? Because money bill talks about matters related to expenditure from Consulate Fund of India, or in case of state, Consulate Fund of State, right? Increasing taxes, decreasing taxes, such kind of functions are there. Although in case of taxes, a lot of powers by state has been shifted to GST Council now. But the point is, related to expenditure revenue, who is going to take such reasons? Government, right? And that is why minister actually introduced this money bill. Okay, that is why it is called public bill. Okay, government bill you can say. After the bill is passed by originating house, it is transmitted to second house. A bill is deemed to have been passed by the state legislature only when both the houses have agreed to or with or without amendments. Same case. In case of unicameral legislature, you just need to introduce this bill in legislative assembly. When it is passed, it is presented before governor and governor signs, it becomes an act, right? So it means bill presented in state legislative assembly, then this, when it is passed from here, state legislative council, when it is passed from here before governor, governor signs and it becomes an act. If state legislative council is not there, then this bill is going to be presented in state legislative assembly and directly it is going to be presented before governor. Okay. Now bill in second house. Consider a bill is cleared by legislative assembly and presented before legislative council. Now there is an important aspect, question can be asked. Sometimes UPSC actually try to compare within a statement this particular part of state legislative council with Raj Sabha, and it is going to be quite simple for you. We are going to discuss each and every provision. When a bill is passed by the legislative assembly and transmitted to the legislative council, the letter has 4 alternatives. 1, may pass the bill as it is, okay, without any amendment. May pass the bill with amendment, saying that we want these changes. In this case, this bill needs to be presented again, returned to legislative assembly. Okay. May reject the bill altogether, that we are not agreeing with that, or may not do anything. So these are the 4 alternatives with legislative council. But what impact it is going to have on the bill? If the legislative assembly rejects the amendments suggested by the council, for example, this second point was used by legislative council, that we want these changes. Now legislative assembly is saying, oh, you are saying these changes. Okay, we are accepting it. It means if we are accepting, now it is going to present it before governor and governor signs and it becomes an act. But it may be possible that legislative assembly says we are not accepting, we are rejecting the amendment suggested by you. Council does not take any action for 3 months. Now they are presented this bill again to the council that we are rejecting, and now council is, say, in first instance, council actually took this bill on hold for 3 months. Okay, in first instance, council can actually hold the bill only for 3 months. Okay, and then this bill is presented back to the Legislative Assembly. Okay, so now you should remember, in first instance, Legislative Council can hold the bill only for 3 months, and in the second instance, with amendments or without amendments, when Legislative Assembly is giving back the bill to the Legislative Council, this time Legislative Council can actually hold the bill just for 1 month. It means maximum delay period can be 4 months, not more than that. I hope you are able to understand. Legislative Council has less status when it comes to legislative power in comparison to Rajya Sabha. In case of ordinary bills, we discussed, if there is a case of deadlock, it means legislative, for example, Rajya Sabha is not agreeing with the amendments proposed by Lok Sabha, or Lok Sabha means there's no consensus between two houses. In that case, joint sitting can happen. But in case of state legislature, no case of joint sitting is mentioned. Please remember it, there was question asked on this. So in case of state legislature, Legislative Assembly has more say. The Assembly may pass the bill again and transmit the same to the Council. If the Council rejects the bill again or pass the bill with amendment not acceptable to the Assembly, does not pass the bill within 1 month, as I told you, then the bill is deemed to have been passed by both the houses in the form which it was passed by the Assembly for the second time. So it simply says, whatever Legislative Council can do is to stall the bill for 4 months at max. That's it. Legislative Assembly has more say in ordinary bill as well as money bill. Let's attempt this question so that it can settle in your mind a better. The Constitution does not provide for the mechanism of joint sitting of both the houses in state to resolve the disagreement between the two houses over a bill. You have to say the statement is correct or not. Okay, the statement is correct. I have just told you this. Council can detain or delay the bill for a period of 4 months. 3 months first instance, 1 month second instance. I have just told you it is correct. The Council has been given lesser significance, position, authority than Rajya Sabha at the center. This is what we discussed. Correct? It means answer is all of the above. Right? I hope it is clear now. Now assent to the Governor. Consider the bill is passed, okay, from Legislative Assembly and Legislative Council. Now before Governor can give assent to the bill, then it can become an act. Governor may withhold the bill, then it will not become an act. May return the bill for reconsideration, but this return can happen once, and when it is sent back to the Governor that we are not agreeing with that or we have accepted some of your suggestions, then Governor must accept it. Same is the case with President. May reserve the bill for reconsideration of, you can say, President. So it means assent, withhold, return and reserve. This part we discussed when we were comparing the powers between President and Governor also, right? If Governor gives assent to the bill becomes an act. Withhold, the bill ends. Return the bill with or without amendment, presented to the Governor again, the Governor must give his assent. Means for once this can be returned. Thus the Governor enjoys suspensive veto. The position is same as center level also. Same provision is with President. Now in case of money bill can be introduced only in Legislative Assembly. Same is the case at Union Legislature. It can be only introduced in Lok Sabha. I hope you remember. Bill is transmitted to the Legislative Council for its consideration. It is passed from Legislative Assembly, sent to the Legislative Council. Now Legislative Council cannot reject or amend money bill, can only make recommendations and must return the bill to the Legislative Assembly within 14 days if they have some suggestions. The Legislative Council does not return to the Legislative Assembly within 14 days. If such thing happen, then the bill is deemed to have been passed. It means in case of money bill, the maximum period for which Legislative Council can hold this bill is 14 days only. In case of ordinary bill, it was 3 months plus 1 means 4 months. Finally, when a money bill is presented to the Governor, he may either give his assent, withhold his assent or reserve. The bill is for presidential assent cannot return the bill for reconsideration of the state legislature. I told you in this comparison also that money bill cannot be returned because it's a wastage of time, right? And money bill means it is possible that government is raising money bill because there is some essential, means some urgent matter is there. It may be possible. Expenditure of government is dependent on it, right? Normally, the governor gives assent to a money bill as it is introduced in state legislature because it is introduced with prior permission of governor. Same is case of state as in case of center, right? In center, money bill can be introduced in Lok Sabha only on the prior recommendation of president. Now attempt this question. Money bill can be introduced by any member or minister in legislative assembly. Do you think it is true? No, it is false. How can any member introduce? Right? It's a government bill. Ministers introduce. The Legislative Council has restricted powers with regard to money bill, right? Money bill is as it is introduced in the state legislature with his prior permission of the governor, right? President can return the bill to the state legislature for reconsideration, but governor can't. Means it is saying that president can return what? Money bill. No, it is not possible. As I told you, when a money bill is reserved for the consideration of the president may either give his assent to the bill or withhold his assent to the bill, but cannot return. As I told you, it's a wastage of time. That should not happen in case of money bill. Now, position of legislative council. So there are two cases here. The areas where legislative council is having equal say as legislative assembly, and then second case is unequal. Okay. One question can be made from here. Okay. Introduction and passage of the ordinary bill. So in case of ordinary bill, it can be introduced in either house, means legislative assembly or legislative council. However, in case of disagreement between two houses, the will of the assembly prevails over the council. Will of the assembly prevails. As I told you, there is no case of joint sitting there. Approval of ordinances issued by governor, means once governor issues ordinance under Article 213, when house is reconstituted, then it must be passed from both the houses. Selection of ministers including chief minister, means if someone has to be appointed as minister, then that person can be a member of either house. Like in case of Yogi Adityanath, he was member of legislative council. Consideration of reports of the constitutional bodies like State Finance Commission, State Public Service Commission, Comptroller Auditor General of India, yes, CAG's report with respect to state, right? So it can be considered by the both houses. Enlargement of jurisdiction of State Public Service Commission, in this case also, this they have both houses have same say. Now my suggestion to you is, please remember these 2 points, because earlier 3 points were quite obvious. These are the points which generally students actually forget. Okay. Unequal. In case of money bill, it can only be introduced in legislative assembly, not legislative council. Final power to decide whether a particular bill is money bill or not, it is with the Speaker of Legislative Assembly only. The final power of passing an ordinary bill lies with the assembly. Means legislative council can hold this money bill only for 14 days. Council can only discuss the budget but cannot vote on the demand for grants. Cannot vote, only discuss. Please remember. Council cannot remove the council of minister. Why? No confidence motion can only be passed in legislative assembly. Same in case of Lok Sabha, right? And when an ordinary bill which is originated in council was sent to the assembly, it is rejected by the assembly, the bill ends and becomes dead. Remember it. But in case of Raj Sabha, this doesn't happen. Why? Because there is a case of joint sitting there, right? If there is a deadlock. But if legislative council proposes a bill and legislative assembly rejects it, then it is dead. It ends. Please remember it. The council does not participate in the election of the president, because in case of election of president, only elected MLAs vote. I hope you remember. Now, privileges of state legislature. Compare with what we discussed in parliament. It has right to publish its report, debate, proceedings, and also the right to prohibit others from publishing the same. Prohibit others from publishing the same. Although after Supreme Court judgment, any truth can be actually presented, or you can say published by the media houses. Okay, truth, but it should be truth. It should not be you can say their opinion which demeans the house. Otherwise, that is going to be considered you can say against privilege of the house. It can exclude strangers from attending the proceedings. It can make rules to regulate own procedures. It can punish members as well as outsiders for breach of privilege. Same. It has right to receive immediate information of the arrest, detention, conviction, imprisonment or release of member. That is collective privilege. Can institute inquiries, order to attendance, witness and send of relevant papers in the court if matter is under consideration there. Court are prohibited to inquire the proceedings of the House or its committees. This protection has been given to the House. No person, either a member or outsider, can be arrested. No legal process, civil, criminal, can be served within the premises of the House, okay, without the permission of presiding officer. Individual privilege, same. The MLA or MLCs, they cannot be arrested 14 days before, 14 days after and during the session. The privilege can only be available in case of civil, not in criminal cases or preventive detention cases. Their question can be asked. So this protection is available only in civil cases. For example, case related to tax, family or land dispute, etc. If you have murdered someone and you are thinking, no, for at least 40 days before, 40 days and in between session you are not going to be arrested, then you are mistaken, my friend, if you are MLA. They have freedom of speech in the state legislature. No member is liable to proceedings in any court, whatever they say within the House. They are exempted from any jury service. So jury service has itself ended. Now it is not used, right? There can be a means question from here. We say that freedom of speech to the in the state legislature. Do you think there is truly a freedom of speech? Because if an MLA of a party speaks her mind and his opinion is against the opinion of majority of its party members, then this can be a basis of disqualifying this particular member. So now this member is becoming a sheep of the herd. This member is not having independent voice. So some people say this is actually against freedom of speech and expression. So how anti-defection law is curbing freedom of speech and expression of these members? How these members are reduced to party members, not true representative of their people. So this can be a question here. Now Council of Ministers does not include whom? Parliamentary secretaries, because all three categories are part of COM. I discussed with you in video number 1. Video number 1 of state legislature. Using which of the following can terminate a sitting of the state legislature for an indefinite period? Adjournment sine die. Please remember, we are using word sitting, not session. That is why adjournment sine die. This is a factual question. Madhya Pradesh 7th Amendment Act, part 1 video of state legislature, and within the start I discuss these facts. Article in the Constitution provides for dissolution of a state assembly by the President. Article 56, President rule. Suppose the Legislative Assembly dissolves. Now you have to answer this. And suppose a bill has already been passed by Legislative Assembly and also Legislative Council, but is returned for reconsideration by the Governor. Means the bill has already touched the Honorable Governor. President at time dissolution. Then what will happen to the bill? Tell me, the bill will lapse or not? The bill will not lapse because that bill has already touched the stage of Governor. Hello and welcome everyone. I hope this message finds you fit and fine. Today we need to talk about high courts in India. Even if you have covered Supreme Court, don't take High Court part lightly because there are some differences and UPSC has asked questions from this topic consistently. Let's start with the basics. So High Court were introduced in India by Britishers, for example in Calcutta, Bombay and then Madras. In our constitution, High Courts are mentioned in part 6 of Indian Constitution, okay, starting from article 214 to 231. Original constitution was saying there will be one High Court for one state, but after 7th Constitutional Amendment Act, now there can be one High Court for more than 2 states or UTs. It means one state, one UT. Now, can you tell me, can you give some examples of common High Courts in comments? So we have integrated judiciary, right? We have Supreme Court, then we have High Court. So today our focus is on High Court. Let's talk about some differences. There can be questions from here. When it comes to Supreme Court, decisions are binding on all courts. All courts means whether High Court or subordinate court, means district court. Can transfer High Court judges? It means we are talking about collegium, in which CJI's role, means Chief Justice of India's role, and Senior Supreme Court Judge's role becomes important. Can call a case from lower court to itself, can transfer cases from one High Court to another. So these are the powers of Supreme Court. High Court. considers appeal from lower court, appellate jurisdiction, we are going to talk about it today, has the power to issue fundamental right, means writs in fundamental right, Article 226, deals with cases within its state jurisdiction, means you cannot take up case from other state. What does it mean? If some crime has happened in another state and district court of that state has given some judgment, can you take that particular case as an appeal? No, that particular state's high court is going to take up that. Supervises and controls lower court. We are going to talk about supervisory jurisdiction of high court here. District court deals with local cases of the district, consider appeal regarding lower court decisions, decides serious crime cases. Subordinate court deal with cases of civil and criminal nature. Now, appointment. So judges of high court are appointed by president. Please remember that. They are not appointed by governor. Sometimes UPSC play along these lines. Chief Justice is appointed by President after consultation with CJI and the Governor of the state, although we are going to talk about third judge's case here, then you are going to remember the collegium part. For appointment of other judges, Chief Justice of Chief Justice of that High Court need to be consulted. Okay, that's a standard rule you should remember. Okay, for example, if you are a team manager and someone need to be appointed in your team, so this is a standard practice now. You are going to be consulted because any judge of a high court has to work in close coordination with the CJ of that high court, Chief Justice of the High Court. Chief Justice of High Court is going to decide which kind of cases, what case is going to be taken up by this particular judge, okay, this particular bench. In case of common high court of two or more states, the governors of all state concerned are consulted by the president. In second judge's case, Supreme Court ruled that no appointment of judge of the High Court can be made unless it is in conformity with the opinion of Chief Justice of India. Then it was later elaborated, third judge's case, collegium. Supreme Court opined that in case of appointment of High Court judges, the Chief Justice of India should consult a collegium of two senior most judges of Supreme Court. This is what third judge's case was saying in 1998. It means one CJI and two senior most judges. The sole opinion of CJI is not going to be considered, right? Consultation means you have to consult two senior most judges in case of appointment of High Court judges. Okay, there can be a question from here. 99th Constitutional Amendment came and there was a body NJAC which government tried to make, National Judicial Appointment Commission. We discussed this in Supreme Court chapter also. But what happened? In fourth judge's case 2015, Supreme Court has declared both the 99th Constitutional Amendment Act, which was creating NJAC, as well as NJAC Act as unconstitutional and void. Why? Because Supreme Court said it is going to compromise independence of Supreme Court, independence of judiciary, and independence of judiciary is basic structure, right? Earlier the collegium system became operative again. So this was an attempt, 99th Constitutional Amendment Act was an attempt to replace collegium system. And why? The reason was that collegium was or is opaque body, opaque mechanism. Lack of transparency is there. Qualification. You need to be citizen of India, obviously. He should have a judicial office in the territory of India for 10 years. Or he should have been advocate of a high court or high courts in succession for 10 years. These are OR's part, okay. Either you can have this combination or you can have this combination. Oath is given by governor. Please remember, appointment is being done by president, but oath is being given by governor. Tenure, there is no fixed tenure, okay. But what is age? Age, maximum age is 62 years. Now there can be a question from here. What if we have some discussion on the age of that concerned judge of High Court, or a person who is going to be appointed as judge of High Court? In this case, any question regarding his age to be decided by president after consultation with Chief Justice of India, and the decision of the president is final. It means UPSC can play with you by saying in case of confusion or dispute with respect to age of a concerned candidate for the position of judge of High Court, Supreme Court's decision will be final or Supreme Court will take this up, but reality is president, okay. And it is saying president is going to consult CJI. Okay, it's not like a formal case is going to be leveled regarding this. He can resign his office by writing to the president. Now, oath was given by governor, okay, but resignation is being given to president because president is the one who appointed. What UPSC is going to play with you? They are going to use CJ of High Court, and many students would think, oh, since High Court judge and senior of High Court judge is Chief Justice of High Court, it means he or she should give resignation to Chief Justice. But that's not true. That is going to be a trap. He can be removed from office by the president on the recommendation of parliament. There's a process to that we are going to discuss. He vacates his office, judge of Supreme Court, or means the way Supreme Court judges are removed is the same way for removal of High Court judges. Removal of judges. So process of removal is elaborated in Judges Inquiry Act 1968. For that, a removal motion signed by 100 members in case of Lok Sabha and 50 members in case of Raj Sabha. We discussed the same in case of removal of Supreme Court judges. Same is the process. Then they are going to present this before Speaker in case of Lok Sabha, Chairman in case of Raj Sabha. Now, Speaker or Chairman may admit it or may decline it. If they admit, then there are going to be an inquiry committee and 3-member inquiry committee. And who is going to be part of this inquiry committee? There can be a question. Chief Justice of India or Judge of Supreme Court. Chief Justice of India or Judge of Supreme Court. What UPSC is going to play with you, they can use the word Chief Justice or Senior Most Judge of Supreme Court. But Senior Most Judge is not there. Or Judge of Supreme Court. And some of you might say, sir, why you are playing on these intricacies? Yes, because there is a logic behind it. Why the word senior was not used here? Because same kind of setup is used when we talk about removal of Supreme Court judge. Okay, and consider a Supreme Court judge is quite close to the senior most judge or CJI. Now in this case, don't you think this will be a conflict of interest if everyone knows that they are related, right, or they have some common link? So on this basis, that particular person, CJI would say, okay, I am not going to be part of inquiry committee since I have common connection. Senior most judge would say, okay, I am having common connection. So that is why the scope was Judge of Supreme Court, so that other judge can actually take up this responsibility. Okay. A Chief Justice of High Court or distinguished jurist. So you need to remember one person from Supreme Court, either CJI or Judge of Supreme Court. Second is Chief Justice of that High Court, Chief Justice of High Court. And distinguished jurist, Chief Justice of High Court, okay, not necessarily that High Court. That is also need to be remembered. Please remember. If committee finds the judge guilty of misbehavior, now tell me, if committee found, yes, this person has committed this particular misbehavior. Now tell me, the decision of this committee is going to be final on this house, that now it is mandatory that person is going to be removed from Judge of High Court position, or it is not mandatory? Answer is not mandatory, because if it is mandatory, then why would you have a voting by special majority? Then there is no point of having voting if it is mandatory just after the recommendation of this 3-member committee, right? You should think on these depth. After the motion is passed by each house by special majority, then it is presented before Honorable President, and when President signs, it stands removed. The President passes an order for removing the judge. Clear? Now transfer of judges. So President can transfer a judge from one High Court to another. Okay, President is appointing, President is transferring High Court judges. Please remember. In 3rd Judges case 1998, Supreme Court opened that in case of transfer of High Court judges, Chief Justice of India should consult, in addition to collegium of 4 senior most judges of the Supreme Court, Chief Justice of the 2 High Courts. What does it mean? It means Chief Justice of India along with 4 senior most judges is going to consult 2 High Court judges, High Court Chief Justices, who, one from where you are transferring this High Court judge, and other Chief Justice should be in whose High Court you are transferring this judge. Okay, so it means 4 plus 1 5 and 2 7. Clear? Acting Chief Justice. So President can appoint a judge as acting Chief Justice. So what is the meaning of acting? It means present Chief Justice is not in position to work. Office of Chief Justice of the High Court is vacant. Chief Justice of the High Court is temporarily absent. Chief Justice of High Court is unable to perform his duties. So President can appoint qualified person as additional judges of a High Court or a temporary period not exceeding 2 years. So not exceeding 2 years is also a clause there. Now, independence of High Court means, do we have some provisions which shows that yes, independence is maintained? Yes. For example, mode of appointment, collegium system is there, right? Security of tenure, 62 years, right? And you can be removed only by a process of parliament. Please remember, removal of High Court judge cannot be done by state legislature or state government. Okay, CM, MLAs, they don't have any role. Clear? Fixed service conditions, expenses charged on consulate fund, charged. It means they are not going to take up for vote again and again in the budget. Conduct of judges cannot be discussed in the house until and unless there is a removal motion in place. Power to punish for its contempt. Its jurisdiction cannot be curtailed. You cannot curtail the power. Freedom to appoint staff. For example, State Public Service Commission work in close coordination with State High Court when it comes to staff hiring. Separation from executive, ban on practice after retirement, means judges cannot practice as a lawyer in court after retirement. Now coming to the other important part, jurisdictions. Now recollect what we discussed in original jurisdiction. What does it mean? It means that in these areas a person can directly go to this level of court, right? So original jurisdiction, power of High Court to hear disputes in first instance, not way of appeal, means cases which can directly go at the level of High Court, then these cases or these areas will come under original jurisdiction of High Court. Okay, it extends to what kind of matters? For example, will, marriage, divorce, company law, contempt court, dispute relating to election of members of parliament, state legislature. Please remember, members of parliament, right? Dispute related to this also comes under original jurisdiction of High Court. There can be a question. Revenue matter, fundamental rights, for example, Article 226. You can directly go to High Court. Cases to be transferred from subordinate court involving interpretation of constitution, means interpretation of constitution. You know, there are just two level of judiciary, higher judiciary, you can say, High Court and Supreme Court, who can interpret constitution, right? So these are original jurisdiction. Now writ jurisdiction, we discussed these writs when we discussed Article 32, the meaning of these writs, and I told you there that as per Article 226, High Court can issue these writs for protection of fundamental right as well as legal rights. But when it comes to Supreme Court, under Article 32, Supreme Court can issue these writs just for fundamental rights. Okay, so this is what we have discussed here. So writ jurisdiction of the High Court is wider, okay, because it also includes protection of legal rights. Okay, I hope it is clear to you now. Now in Chandra Kumar case, Supreme Court said writ jurisdiction of Supreme Court as well as High Court are part of basic structure of Indian Constitution. So please remember the case as well, Chandra Kumar, writ jurisdiction. Okay, for that you should remember, make some mnemonic, logic, means your own logic, a story, because these are the high probability questions. Now appellate jurisdiction, it simply means by way of appeal you can reach to High Court. For example, primary court of appeal is High Court, means High Court works as primarily as court of appeal, because from subordinate court, district court, matters take up at High Court for appeal. It hears appeals against the judgments of subordinate court in its territorial jurisdiction, means if there is a UP High Court, it is not going to take up appeal from district court of Madhya Pradesh, right? It has appellate jurisdiction in both civil and criminal matter. Hence the appellate jurisdiction of High Court is wider than the original jurisdiction. Now civil matters means we are talking about matters related to land disputes, matters related to tax revenue, family disputes. So first appeal from the orders and judgments of district courts, they can come as appeal before High Court if the amount exceeds a stipulated limit. Second appeal from the orders and judgments of the district court when there is a question of law, means you need interpretation from High Court on this particular law. So it means both the cases, whether it is amount, whether it is about interpretation of that particular law, these cases can come at the level of High Court as a way of appeal. Calcutta, Bombay, Madras High Courts have provisions of intra-court appeal. Please remember it. First of all, what is intra-court appeal? It means Your case was taken up at the level of Calcutta High Court. Okay, judgment has been given, but you're not satisfied. So you should not necessarily think about Supreme Court. You can actually go for appeal within Calcutta High Court. This is called intra-court appeal, means within court you can appeal. Okay. Appeal from decisions of the administrative and other tribunals lie to the divisional bench of State High Court. It means from tribunals as well. Appellate jurisdiction of High Court extends there. In 1997, Supreme Court said that tribunals are subjected to writ jurisdiction of High Court. Means High Court can issue writs against tribunals. Consequently, it is not possible for the aggrieved person to approach Supreme Court directly against a decision of the tribunal. Now my question to you here is, can you tell me, what about appeal against a award or judgment of water dispute tribunal, interstate water dispute tribunal? So you have to answer this in comments. I'm simply asking, this particular statement is saying, when it comes to decision of a tribunal, you cannot directly go to Supreme Court. First you have to go to High Court. I'm asking, can this case or this particular notion be applied for the case of interstate water dispute tribunal? Okay, so think about it. Water dispute tribunal, search about it, let me know in comments, because these are the areas where UPSC is going to play. Now, criminal matters. Appeals from judgments of Sessions Court, Additional Session Court lie in the High Court if sentences of imprisonment are more than 7 years. You simply need to remember two things when it comes to appeal in case of High Court. Number one is 7 years and more. If sentence is 7 years or more, then it can be taken up at the level of High Court as appeal, right? Second is, in case of death sentence by a district court, district session court, no matter that person has appealed before High Court or not, High Court is going to take up this matter because it is about death sentence. Okay, death sentence cannot be executed without High Court taking up this matter. So in death sentence, please remember, in some cases specified in various provisions, Criminal Procedure Code, the appeal from the judgments of the Assistant Sessions Judge, Metropolitan Magistrate and other magistrate judicial to the High Court. Means in certain cases they can directly go up as appeal to High Court. Now comes the supervisory jurisdiction. What does it mean? Supervising. What is the meaning of supervising? It means you are taking care of the rules and whether they are being followed on regular basis in these lower courts, right? So it means High Court has the supervisory jurisdiction over district court, subordinate court, not Supreme Court. Supreme Court is not having supervisory jurisdiction. Some students are going to get confused. Like it is said that judgment of Supreme Court is applicable on all courts. Judgment is one thing, but when it comes to supervision, it has two components, administrative as well as judicial. Means staff related function, and these functions, general rule, prescribed forms, book entries, accounts, how many court fees you are taking, in what way you are taking. These matters are also under the control of High Court of that particular state. The power of superintendence of High Court, it extends to all courts, tribunals, whether they are subject to the appellate jurisdiction of High Court or not. This question can be asked. Means supervisory jurisdiction is applicable on all tribunals in territorial jurisdiction of that High Court. Okay. It covers not only administrative superintendence as well as judicial. Means the kind of decisions you are taking, the speed with which you are actually taking up the cases. So judicial part is also going to be considered here. Revisional jurisdiction means judgment can be revised, right? It can also take suo motu action, means on its own. However, the power does not vest in the High Court with any unlimited authority over the subordinate courts and tribunal. It is limited to access of jurisdiction. Means in what cases High Court can intervene in the functioning of subordinate court. If there is access of jurisdiction, it means you are not given that much power, but you are exercising power beyond your ambit. Then High Court can supervise. Gross violation of natural justice, error of law, disregard to the law of superior courts, means High Court has said something and High Court is a court of record, but you are not giving adherence to the what High Court has said on this particular matter. Perverse findings, manifest of injustice. So in these cases, High Court can intervene in functioning of subordinate court. Now control over subordinate court, it is consulted by governor in the matters of appointment posting. For example, I told you, in case of transfer, appointment, a State Public Service Commission is going to conduct the exam interviews, but in close coordination with State High Court. And who is going to appoint? Their governor is going to appoint. I'm talking about subordinate courts. Okay? It deals with the matters of posting, promotion, grant, leave, transfer, discipline of the members of the judicial service of the state, other than district judges. It can withdraw a case pending in a subordinate court if it involves substantial question of law require interpretation. So because district court cannot interpret constitution, if it seems that interpretation is constitution is needed, then high court can take up that case from district court. It can either dispose of the case or determine the question of law. Dispose means case is quashed, or it can take up the case. Law is binding on all subordinate courts because it is part of supervisory jurisdiction. When I say court of record, what does it mean? It means perpetual memory and testimony. In your judgments, you are going to quote this. These records are admitted to the evidential value and cannot be questioned when produced before any subordinate court. They are recognized as legal precedent, legal references. Means on this basis, you are going to rule the judgment. It has power to punish the contempt of court either with simple imprisonment, fine, or both. Expression of contempt of court is not mentioned in our constitution. Please remember that. There can be a question from here. We have a law, Contempt of Court Act 1971, which elaborate on the definition of contempt and what can happen. Under the contempt of court may be civil or criminal. Civil means willful disobedience to any judgment, order, writ, or other processes of the court, willful breach of any undertaking given to the court. That would be considered as civil contempt. Now, power of judicial review. We discussed in Supreme Court as well, right? Judicial review, Article 12, right? Article 13. Article 13 we talked about, and Article 32. So, judicial review is the power of High Court to examine constitutionality of the legal or executive actions. The phrase judicial review is nowhere mentioned in Indian Constitution, but Article 13 and Article 226 in case of High Court, it gives power to High Court to review whether legislative or executive action. Now, in what cases the judicial review can happen? One is fundamental right. If some law or some executive action is taking away your fundamental right, judicial review can actually work. Second is outside the purview. It means any authority has taken some action which is outside its power. How can this happen? Judicial review can apply. Or these provisions or these laws which are being made or some executive action, this is against some constitutional provision. In this case also, direct judicial review can be applied. So these three are the areas which you should remember when judicial review is going to be applied. Direct question can be asked. So during Indira Gandhiji's time, 42nd Amendment Act, it actually limited the power of judicial review of High Court, saying that judicial review is going to be applicable just to state laws, right? But after this 43rd Amendment Act, it restored the original position. What does it mean? There can be a question. Meaning is that judicial review power of High Court is applicable also on central law. Please remember it. Now, which of the following is the oldest High Court in India? Calcutta High Court? That's a factual question. Now, Article 213 provides that there shall be a High Court for each state. Tell me, do you think that statement is true? Now, some of you might be thinking, sir, we don't remember the articles. What now? My friends, sometimes some articles are regularly in news and UPSC wants to check whether you are aware about them or not. It's not like UPSC wants you to cram the whole constitution article wise. Article 213 is related to ordinance making power of governor, right? And Article 123 is about ordinance making power of president, right? So how can this statement be true then? It's false. Now, judges of High Court are appointed by President, you just got to know. Under Article 226, it has the power to issue certain writs. We discussed it. As per provisions of the Constitution of India, Common High Court can be established for 2 or more states. It is right. By which Constitutional Amendment Act? We discussed 7th. Right? So, answer would be 234. C. Right? Hello and welcome everyone. I hope this message finds you fit and fine. Many students struggle in scoring well in exam because they miss on 2 crucial aspects. One is not having right understanding of syllabus. Knowing what keywords are there is not enough. You need to know what is the utility of that keyword. What are the spectrum of questions which can be asked from that keyword? and what is the utility at different stages, prelims, mains, interview. And for that, you need to follow the second step, that is going through previous year question papers diligently. Whatever you are gaining from this series, Laxmikanth series contest, you need to reflect through previous year question papers. Are you gaining confidence or not? Are you able to solve those questions or not? Otherwise, what is going to happen? You may become good in certain areas and miss on certain other aspects from where UPSC can ask questions. For example, subordinate courts. So UPSC has consistently asked questions on Nalsa, Lok Adalat, Gram Nyayalas. But students take these topics lightly. Their major focus is on Supreme Court and High Court when it comes to the judiciary. And maybe on certain key, you can say, events or judgments, that's it. But you have to clear the exam. This is a competition, right? Your strategy should be fine-tuned. So let's start subordinate courts and give attention to the details, because devil is in the detail. And I'm also going to mark Q, means question, from where question may be asked. Subordinate court are mentioned in part 6 of Indian Constitution, Article 233 to 237. So why we are using the word subordinate courts? In the previous sessions, I've told you that we have integrated judiciary, Supreme Court, High Court, then subordinate court. At district level and below that also we have certain courts. So we call them subordinate courts, right? Now, appointment of district judges, appointment. And please understand, UPSC can play with you by saying in one statement, appointment of judges at district level and appointment of district judge. So there's a difference between the two, right? Because judges at district level can be other judges as well. For example, additional district judge, metropolitan magistrate, right? So you need to give attention to the district judge, okay? So appointment, posting, promotion of district judge in a state done by governor of the state in consultation with High Court. Now tell me, have I mentioned SPSC here? No. So who is appointing? Governor is appointing in consultation with High Court. So primary role is with High Court actually, right? Have we mentioned a state government here? No, we have not mentioned state government here, right? So primary power is in hand of High Court, right? A person to be appointed as district judge should have the following qualifications. Qualifications are not already be in the service, whether central government and state government. You cannot be part of government and you simultaneously will say, sir, please appoint me as district judge. Okay. He should have been an advocate or a pleader for 7 years. He should be recommended by the High Court for appointment. Recommended by the High Court for appointment. Obviously, should be citizen of India. Now, appointment of other judges, and there's a difference here, right? Judges in subordinate judiciary means at the level of district court or below that, okay? Appointment of person other than district judges to judicial service of a state are made by governor. Appointment is made by governor, but process is different, right? After consultation with SPSC, means State Public Service Commission, and the High Court. So in case of judges at the level of district, the question can be asked on difference. So difference is SPSC. I hope now you're not going to make the mistake. Now control over subordinate court. So High Court has the control, right? And district judge at the level of district is having prime responsibility, right? The control over district court and other subordinate court, including the posting, promotion, leave, person belonging to judicial service of the state. So all these functions lie with High Court. I hope you remember in the previous session, when we were discussing High Court, I told you about supervisory jurisdiction. And in the Supreme Court chapter, I asked one question, whether Supreme Court has supervisory jurisdiction over subordinate court or not. So answer was no. You cannot say, sir, it is the apex court. Why we are not saying that supervisory jurisdiction of Supreme Court extends to district court? There are so many districts. Do you want to burden Supreme Court more? Right? That is why the supervisory jurisdiction of subordinate court lie with only High Court. Now structure and jurisdiction. So this is the structure. Please look at this side, means civil court and criminal court. Here we have revenue court, where when you are going to become civil servant, you will have role here. Now civil court, district judge or district session judge, sub judge, family court, municipal court, small causes court. Criminal court, we say sessions court. District sessions judge, metropolitan magistrate or first class magistrate, second class magistrate, third class magistrate. And in revenue court, we have board of revenue, commissioner or collector, tehsildar, naib tehsildar. Sub-collector means sub-divisional magistrate also have say in case of revenue court. There's a revenue court of sub-divisional magistrate also, SDM, right? But we are focusing here. Okay. Now, district judge is also called a session judge. Although district judge is having responsibility with respect to civil as well as session matters. Okay. When I say sessions, it means criminal nature. When I say civil, it means we are talking about civil nature. Civil Procedure Code is going to be applied. In case of sessions, IPC, right? Indian Penal Code is going to be applied, or you can say referred. He is the highest judicial authority in the district. Now, he possesses original and appellate jurisdiction. There can be a question from here. So, original jurisdiction, what does it mean? It means cases of civil nature or criminal nature can come before district judge, okay, in first instance. So, this is called original jurisdiction. But appellate means can come via appeal, and appeal can come only from lower court. Now, some of you might be thinking, sir, this is district judge, and he is also having, or she is also having, this position is also having appellate jurisdiction. Yes, just take a look. So, we have below the status, we have other courts as well, na? So, judgment can be appealed here. Okay, so both is there, means original as well as appellate. Okay, original as well as appellate, and criminal matter as well as civil matter. Okay, there can be a question. He exercises the judicial and administrative power. Now, judicial power, you know, when he is acting like a judge, and administrative power include the management of staff in the judiciary at the level of district or below that. Okay, that is administrative function. You know, the way files are going to be processed, the way cases are going to be taken up, the way court fees is going to be accumulated, right? That is administrative function. He also has supervisory power over all subordinate district court. This is we have discussed. Appeals against the orders and judgments of district judge lies at the level of high court, because above district judge there is only one stop, that is high court, right? I hope these things are clear to you now. The session judge has the power to impose any sentence, including life imprisonment. Capital imprisonment means death sentence. Okay, but in case of death sentence, I told you in the high court part, death sentence cannot be executed till that death sentence is reviewed by high court of that state, whether that person who has received death sentence, you can say appeal or not. Okay, a capital punishment passed by him subject to confirmation by high court. Okay, whether there is an appeal or not, right? I hope you will remember that. Twice we have discussed it. Now, let's talk about NALSA, National Legal Service Authority. First question which I should ask from you is, what is the utility of NALSA? Why there is NALSA? What NALSA do? What is the status of NALSA? Since we are saying it's an authority, is it a constitutional authority? Is it mentioned in constitution? Or it is a statutory authority, means mentioned in a law made by parliament? What is its status? Or it is a executive authority, means not mentioned in constitution, and neither we have a law made by parliament in this regard. This was made just by executive resolution of the cabinet. What do you think? What is the status? Come on, answer. I can actually directly teach you, but why I ask in this way? Because there is a rule in psychology. When you are going to commit mistake and you get the right answer, there is high probability you are not going to forget that, and that's our purpose. Now, Article 39A, do you remember? Free legal aid, DPSPs, we discussed it, right? So, it was a constitutional promise, right? It was a direction to the state that whenever you make policies, when you are having resources, you should actually make efforts to give free legal aid. Because if you have created, so many courts, but having justice is a costly affair, then how can a poor person actually attain justice? Then if poor person is not able to attain justice because that person is not having money, then don't you think it is injustice in itself? System is not allowing that person to take services of court, right? So that is why we created NALSA, okay? Of the Constitution of India, free legal aid in poor weaker sections. Article 14, equality before law. So it should not be like now that if someone is rich, that person has committed murder, Now, the father of that person who got murdered is not able to actually file a case because that person is not having money. So don't you think this would be equality, this would be against the principle of equality before law as well as equal protection of law? So that is why we needed NALSA. Along with this, Article 22 subclause 1, if you remember, for example, if you are being arrested, then you should be told reason why you are being arrested by the police. So if you are being arrested arbitrarily, so you can only come out if that police is having kripa over you, or other ways that you have an advocate taking stand for you before magistrate. So you need an advocate, and if you don't have money, how you are going to come out? That is why we needed some authority, and that's why NALSA was created through an act of parliament. If it is created by an act of parliament, what is the answer? Answer is statutory body. Okay. Legal Service Act enacted 9 November 1995. NALSA has been constituted under this act, means statutory body, to monitor and evaluate. Now, please remember the functions, objectives. Okay, UPSC has asked question on NALSA on this aspect. What NALSA do actually? Monitor and evaluate implementation of legal aid program. Can you actually tell me some legal aid program which was recently in news? Means a program by government for providing legal aid to the poor people. Can you name some program, scheme of government, initiative? Fast. Think. No? Search about telelaw. What is telelaw? What government is providing in this? How this telelaw facility is going to be provided? What is the role of CSCs here, common service centers? Should be aware of this. Okay. In every state, a state legal service authority, in every high court legal service committee have been constituted. Okay. District legal service authorities, taluk legal service committees have been constituted in district and most of the taluks. Taluks, you know, blocks, to give effect to the policies and directions of the NALSA. Now, why these are being created? Now, you should not think that these are bodies totally independent of NALSA. Some students have these kind of misconceptions. But read this line. Means these bodies were created so that the purpose of NALSA can be fulfilled. Right? To give effect to the policies and directions of NALSA. Directions. What is directions? UPSC will play on these points. Okay. Now, provide free legal aid service to the people. Now, one statement which UPSC can play with you is that Lok Adalats were also created as per this Legal Service Authority Act. Now, what you are going to think? Question is from Lok Adalat, but UPSC is linking Legal Service Authority Act and Lok Adalat. Come on, what's your guess? Some of you might think, sir, Lok Adalat seems different. It is Adalat. And this NALSA is actually providing free legal aid, means advocates, court fee, documentation work. But Lok Adalat is a proper Adalat. So how can these two be connected? But the reality, my friend, is that they are connected from the same law. And that is why this is a trap question, where many students are going to be trapped, but you should not. Okay. So we are going to elaborate it further. NALSA lays down policies, principles, guidelines, frames, economical for the state legal service authorities to implement legal service programs throughout the country. Primarily state legal service authorities, district legal service authorities, taluk legal service committees, etc. have been asked to discharge the following functions, and functions are these three functions. First, free and competent legal service. Free and competent legal service. Who is going to provide legal service? Advocates, right? Free of cost advocates. Second, to organize Lok Adalats or for amicable settlement of disputes, means without fighting the case in the formal court, you can resolve that case peacefully in Lok Adalat. So Lok Adalat is also connected with the same law, right? Now, to organize legal awareness campaign. So you got three primary, you can say, ways in which this NALSA system work. Now, free legal service include, what is included? One is court fee, second is lawyer, and third is documentation. Documentation during the proceeding of the case, Along with this, if you need to file an appeal, so in both the cases, because documentation, affidavit, all of them need, money to be paid. So this will be taken care of by NALSA or these legal service authorities. So I hope you will remember these keywords, right? Court fee, lawyer and documentation, and it would be quite easy for you now, right? Now, Lok Adalats. So Lok Adalats is a forum. So first of all, what is the meaning of the word Lok Adalat? Lok means public. Adalat means court, means it's a public court. And actually it is different from the conventional court because the working of Lok Adalat is flexible, right? It is flexible and it is made so that your matter can be resolved in a speedy way, right? And it is bit of informal as well, which is pending in, because you know that a lot of cases are pending in all the courts, and that is why Lok Adalat actually can actually working as a cushion to resolve these pending cases not yet brought before. Now there is a scope of question from here. Okay, read this, and I'm going to also show a question which was asked from here. Lok Adalat is a forum where the cases or disputes which are pending in a court or which are pre-litigation stage, not yet brought before the court, are compromised or settled in an amicable manner. So two aspects are written here. One is pending, or those which are in pre-litigation stage, means case has not started yet. The case has been just filed. Okay. In both the cases, matter can be taken up in Lok Adalat, right? Please remember it, because in UPSC, one statement is going to be made that only pre-litigation cases can be taken up in Lok Adalat. That would be wrong. Okay. Now the word Lok Adalat means people court based on Gandhian principle. Remember, is one of the components of alternative dispute redressal mechanism or system. Means rather than going in long litigations and expensive litigations, resolve the disputes out of the court. As Indian courts are overburdened with backlog of cases and regular courts are to be decided that involving lengthy, expensive and tedious. So that is why it's a resolution process. Now statutory status. First of all, Lok Adalat is the executive body or statutory body. I told you, statutory body, right? Institution of Lok Adalat was given statutory status under Legal Service Authority Act 1987. That is why I was saying NALSA and Lok Adalat are linked to the same law, right? I hope it is clear. Now, Act of provision related to organization and functioning of Lok Adalat. The State Legal Service Authority or District Legal Service Authority, Supreme Court Legal Service Committee. So at the level of Supreme Court, High Court, we have these committees. For the same purpose, they have advocates to actually support, give free legal aid. High Court Legal Service Committee, Taluk Legal Service Committee may organize Lok Adalat. So who can organize Lok Adalat? This can be a question. At what stage it means Lok Adalat is going to be, you can say, organized. So this is my understanding that many students, when they read about Lok Adalat, they have this notion in mind, oh, we are talking about Lok Adalat. So they must be actually organized at the level of, say, subdivision, village, right? That's some mental picture many students have in this mind, right? So that is why if UPSC play on this point, many students would say, oh, it means Taluk Legal Service Authority or District Legal Service Authority. They should be the one who are going to organize these Lok Adalats. Why would actually these High Court based committees or Supreme Court based committees organize? So this is where there will be a trap. Okay. So if you are gaining from these series and you are actually this way of actually make you understand these things, if you are gaining from this method, do let me know in comments, or you can share with your friends as well. Now, every Lok Adalat organized for an area shall consist of such number of serving or retired judicial officers. Generally, a Lok Adalat consists of a judicial officer as chairman. Judicial officer as a chairman. There can be a question from here from composition point of view. A lawyer, advocate and a social worker as member. Alright. So composition also include lawyer or social worker. Social worker is also there. Okay. Now, any case pending before the court can be referred to the Lok Adalat for settlement if the parties thereof agree that yes, we want to go to Lok Adalat, or any one party actually apply that we want to go to Lok Adalat, or court itself actually found that this case is actually fit for Lok Adalat, means is appropriate to transfer Lok Adalat. So in any of these cases, matter can be referred to Lok Adalat. Okay, and if someone has actually paid a court fee, and now court has said your matter is quite simple, why don't you go to Lok Adalat? So when your matter has gone to Lok Adalat and that has been resolved there amicably, then your court fee is also going to be refunded. Lok Adalat shall have the same power as vested in civil court while trying to in these matters. So what does it mean? It means enforcing the attendance of any witness, means witness is the keyword should know, discovery and production of any document, reception of evidence on affidavit, requisition of any public record or document, such matters may be presented. So it means for actually, while taking decision, what a judge require? It requires some proof, arguments, witness, documents. So all of them can be actually used in Lok Adalat as well. Okay, Lok Adalat has these powers. All proceedings before a Lok Adalat shall be deemed to be judicial proceedings with the meaning of Indian Penal Code also. So it means criminal nature cases are also going to be taken up, right? And every Lok Adalat shall be deemed to be a civil court for the purpose of Code of Criminal Procedures. Benefits of Lok Adalat: court fee can be actually refunded, speedy trial hai, flexible hai. There is no strict application of procedures like CPC, CRPC, means concept of natural justice can be used. The parties to the dispute directly interact and judge through their counsel, which is not possible in court of law. Means you have a counsel and you can directly interact with the judge. The award by Lok Adalat is binding on the parties and the status of decree of a civil court, and it's non-appealable. Once UPSC asks question from here, non-appealable, what does it mean? And why non-appealable? Don't you think it can be injustice also? Means a matter has been decided in Lok Adalat and you want to appeal in further, you cannot appeal. Why? Because in Lok Adalat, it is not like judge is pronouncing a judgment. So in Lok Adalat, method uses alternative dispute redressal. It means both parties will actually agree. They will shake hands. Okay, we are settling on this. And the Lok Adalat will sign the order that both parties have agreed on these conditions. It means resolved. So if both parties have agreed in Lok Adalat, why you want to waste the time of court further? Now if you ask, sir, if there is no scope of appeal, yes, there is a scope. And the scope is, if one of the parties says that I'm illiterate or I was not of sound mind when such sign or such signatures were taken from me. On this basis, appeal can be done. Legal Service Authorities Act 1987 also talks about having permanent Lok Adalat. What does it mean? There may be certain cases related to public utilities. For that, there can be a permanent Lok Adalat. District judge or additional judge or held judicial higher rank, means above this additional district judge, can actually be part of that composition. Chairman would be district judge or ADJ or anyone above this rank. Now, what is public utility we are talking about? If there is dispute related to transport service, air, road, water, postal, telegraph, telephone service, supply of power, light, water, so these are public utilities, right? Permanent Lok Adalat shall exercise jurisdiction in respect to more public services. Now, you must be aware of this fact. If not, then listen to this. Majority of litigations which are pending in court, one party is government, and that is why to reduce the litigation, what many governments are doing, they are actually absolving their stake in the litigations. This is happening. So this is the alternative mechanism to settle this in Lok Adalat. Now, pecuniary jurisdiction. It means if a case is related to some money. For example, you are in contract and you were bound to pay someone, but you have not paid. So that would be pecuniary jurisdiction if such matter is being discussed. Permanent Lok Adalat shall be up to 10 lakh rupees. Matter can be discussed in this. However, the central government may increase this. How means of how much money cases can be taken up in this permanent Lok Adalat. Now, before dispute is brought before any court, any party of the dispute make an application to the permanent Lok Adalat for settlement of dispute. After the application is made to the permanent Lok Adalat, no party that application shall invoke jurisdiction of any court in the same dispute. So it means once it is filed in permanent Lok Adalat, then you cannot simultaneously file a case on the same dispute in any other court. Don't waste the time of any other court if you have filed a case in permanent Lok Adalat. Then we have family court. Why they are called family court? Because there are so many cases related to family disputes. For example, divorce, separation, marriage issues, alimony. So Family Court Act 1984 was enacted to provide establishment of family court. Now, status of family court, is it an executive, constitution, statutory? Statutory, because there is a law, parliamentary law for that. Marriage and family affairs. Now reasons. So 59th report of Law Commission suggested that stressed that dealing with the disputes concerning the family, the court adopt an approach radically different from the adopting ordinary civil proceedings. Because if there is a matter related to tax, fraud, those are different nature, and family disputes are of different nature. So why you are using same judicial methods, right? Many family disputes can be resolved through mediation purpose, right? Give some chance for second thought without engaging into legalities. That is why this family court as an institution was established for speedy trial and having less burden. The Code of Civil Procedure was amended 1976 to provide for a special procedure to be adopted in suits and proceedings related to matters concerning family. Because within family also there can be a tax there can be a dispute related to land, right? Money, right? This is a major dispute. So these disputes come under civil procedure. So this civil procedure was amended so that alternative judicial process can be used for these matters, family matters. Now main objective and reason for settling family courts, to create specialized court. One thing is that exclusively deal with family matters instead of mechanism for conciliation. As I told you, sometimes methods can be disputes can be resolved through mediation, giving second thought. Inexpensive remedy it is, flexibility and informal atmosphere. This is needed for the resolution of dispute. Features are family court by state government in consultation with High Court judges. Now, state government word is used. Okay, state government constituting family court in consultation with High Court. It makes obligatory on state governments to set up a family court in every city or town with a population exceeding 1 million, more than 10 lakh population. It provides only one right of appeal and shall lie on the level of High Court. Means there can be one appeal and that is at the level of High Court. This can also be a scope of question. Now it exclusively provides jurisdiction of the family courts matters related to property of spouses, legitimacy of any person, guardianship, maintenance of wife, children, parents, nullity of marriage, judicial separation, conjugal rights. So these are the family matters. Now we have Gram Nyayalayas. Gram Nyayalayas, as the name suggests, Nyayalayas at the level of Gram, right? Now, in some areas, we have districts having more than 700 villages, yes, in one district, right? And it is very expensive for a person from a village to come to the district or even subdivision for a case hearing, right? And that is why many suffer exploitation, because they can't devote that much time and resources. So that is why we invented this concept of Gram Nyayalayas. It is like justice at your door, right? Now, Gram Nyayalayas Act 2008 has been enacted to provide for the establishment of Gram Nyayalayas. It means it's a statutory body, grassroots level for the providing access to justice of citizens of their doorstep. As I told you, justice at doorstep. Ensure opportunities for securing justice, not denied citizen, socio-economic and other disabilities. If someone is not having money or any other factor, that person should not be limited from the justice. Now, they are appointed by state government in consultation with High Court. Two courts I have told you having same format when it comes to their constitution, means organizing them. That is family court as well as Gram Nyayalayas, right? They have same process. Gram Nyayalayas shall be established in every panchayat at intermediate level. It means block level. Gram Nyayalayas shall be mobile court. It means it is not like going to be a brick mortar. Okay, it may be possible Gram Nyayalaya is being organized in a government school, then a dispensary, then some other government school. Okay. And please remember, both criminal and civil matters can be taken up at this level. So, halke mein nahi lene ka, right? You should not take it lightly. Both civil and criminal. Question can be asked from here. Gram Nyayalaya shall try to settle the dispute as far as possible, bringing about conciliation between the parties. Conciliation is also a way. Gram Nyayalaya shall not be bound by Evidence Act, Indian Evidence Act, and natural justice principle can be used. Appeal in criminal cases shall lie to the court of session. Court of session means at the district level we are talking about, and shall be heard and disposed of within a period of 6 months. This is what it says, and this can be a question. Some students would think, sir, is there a law regarding this? If there's an appeal from Gram Nyala at the district level, that matter should be disposed of in 6 months. Law says that, but does it happen really? That's a different story. Now, attempt these questions. With reference to Lok Adalats, which of the following statements are correct? Read each statement. Lok Adalats have the jurisdiction to settle the matters at pre-litigative stage and not those matters pending before any court. What do you think? Statement is true or false? It is false, because I have told you both ways, in both cases, pending as well as pre-litigation. Lok Adalats can deal with matters which are civil and not criminal. This is also wrong. I told you, criminal also. Every Lok Adalat consists of either serving retired judicial officer only and not any other person. That is also wrong. I told you about social worker, advocate. So none of the statement is true. I think now it is clear to you. These kind of questions have been asked by UPSC. Composition also we discussed. District judge in a state are appointed by governor. We discussed it, right? And on the advice or consultation of High Court. Now, with reference to Gram Nyala Act, which of the following are correct? As per Act, Gram Nyala can hear only civil cases and not criminal cases. Tell me, is it correct or not? It is incorrect. We have just discussed both. Act allows local social activists as mediator, conciliator. That is correct. So it means only 2 is correct. Composition we discussed, or you can see here, right? The power of district collector as a district magistrate are maintaining law and order, control over police, to check passports of foreigners. Now the word is control land revenue, collect land revenue, or you can say adjudicate matters of land revenue. That could have been correct, but control land revenue, that is incorrect. So that is why ABC. Clear? Now, answer the following question by correct. You need to identify correct. According to appellate system, a person dissatisfied with the verdict given by the court of district judge could appeal on which of the following level? High Court. We discussed it, right? Specifically the statement was there. Hello and welcome everyone. I hope this message finds you fit and fine. We are in video number 49 of our Laxmikanth series contest, and today we are going to talk about state legislature, part 6. Article 168 to Article 212. It is also going to be a cakewalk for you if you have a comparative understanding. Means as we go through state legislature, just reflect what we discussed in case of union legislature, parliament. At the level of center, we have 2 houses, bicameral legislature. We have Rajya Sabha and Lok Sabha. Similarly, at the level of state, we also have in some states 2 houses, Vidhan Parishad, which we call Legislative Council, Vidhan Sabha, which we call Legislative Assembly. Please remember, not in every state we have bicameral legislature. Okay? Which one of the following state does not have a bicameral legislature? West Bengal. Now, when this question is going to be asked by UPSC is not expecting you to cram everything. It is just that it was in news. Mamata Banerjee, CM of West Bengal, she was demanding from the center that yes, West Bengal deserve a second house. So what point you got now? One is West Bengal is not having legislative council. Another is power is with parliament, right? Now, so these are the states where we have Vidhan Parishad as well, means second house. Bihar, Maharashtra, Andhra Pradesh, Karnataka, Telangana, Uttar Pradesh. Now some facts related to organization of state legislature. Legislative Council was abolished by J&K, Reorganization Act 2019. Tamil Nadu Legislative Council Act is there but has not come into force. If UPSC is making one statement, there is no uniformity in the organization of state legislature, what would you say? You will say true or false? You will say true. Okay? Don't think that's a trap. Okay, that's correct notion, right? Because we don't have a bicameral legislature in every state, right? The 7th Amendment Act 1956 provided for Legislative Council in Madhya Pradesh. It provided, but what happened? However, a notification of this effect made by the President, so far no such notification has been made, and that is why Madhya Pradesh continues to have one house. Legislative Council Vidhan Parishad is the upper house. As you know, in case of Rajya Sabha, we have upper house Rajya Sabha, and Rajya Sabha is also regarded as second house. Similarly, Vidhan Parishad means Legislative Council is an upper house, but second house, second chamber. Why? Because in some respects, the bills are first introduced only in Legislative Assembly. For example, Money Bill. Legislative Assembly, Vidhan Sabha is the lower house, first chamber or popular house. Why popular house? Because members of Legislative Assembly are directly elected by people, right? But when it comes to members in Legislative Council, they are indirectly elected or nominated. We have 22 states. This is the structure. You are clear about this. Now composition. Attempt this question. What can be the maximum number of members in Legislative Assembly of a state? Answer is 500. So it means maximum strength can be 500, minimum strength can be 60, although there can be exception like Goa, right? Territorial constituencies means on what basis it is decided that yes, this MLA is going to represent this area, other MLA is going to represent that area. So the purpose is that each and every constituency of a state should represent a proportionate amount of population, right? For example, consider I'm an MLA and I'm having a constituency where 2 crore people are there, and there is a other MLA who is actually representing same state, representing a constituency where there's 50 lakh people. Don't you think it is actually, you can say, injustice with the people who are part of my constituency? Because for 2 crore people, one representative, and there for 50 lakh people, one representative, right? So to reduce this kind of disparity, this is the process which is used. Demarcation of constituency is done on the manner ratio between the population in each constituency, and the number of seats in the state remains same. Okay. Now readjustment after each census. Now, I also made a separate video on delimitation commission on the main study IQ channel. In the Shashank series, you'll find that. Okay. There was a specific video, but let's discuss this here also. After each census, a readjustment to be made in total number of seats in the assembly of the state, each state, division of each state into territorial constituencies. But this is what provision says, but it doesn't actually happen, right? Means you know that after 10 years we have census, but after 10 years it is not necessary that number of seats and the territorial constituencies are being changed. Right? So why they're not being changed? Because Parliament has enacted Delimitation Commission Act 1952. So this Delimitation Commission is responsible to decide the boundary, okay, of the constituency. So these acts were made for this purpose, but 42nd Constitutional Amendment Act 1976 had frozen the total number of seats assembly of each state and the division of the state. So the point is, there was disparity in population, means in state-wise as well. For example, in 1970s, when government started this population control program, family planning program, to some states, for example, southern states, they have done good job, right? For example, Karnataka, Tamil Nadu, Kerala, Andhra, they have done good job. So that is why the population growth rate in these states after this 1970s was considerably managed in comparison to the northern states like Uttar Pradesh and Bihar. Now think, if you, after 10 years, you are actually bringing a census and you are also deciding on the basis of population that this particular state is going to have how many seats in Lok Sabha as well. So don't you think this would be injustice with the southern states? Because northern states have not done their homework well and their population has increased leaps and bounds, and since they have more population, then by the logic of Delimitation Commission, now these highly populated states are going to have more seats in Lok Sabha and Rajya Sabha than these southern states. So don't you think this is wrong? These states have done good job, and that is why their representation is being reduced, right? To reduce such disparity, that is why these seats were actually later, this readjustment was banned for some time. As of now, this readjustment is going to happen after 2026. Now some of you would think, sir, why 2026? Because idea was that in between this time, this growth rate disparity between states can be normalized, minimized. But there are some opinions against that as well. But we should know that as per 84th Amendment Act, it has been, you can say frozen till 2026. Now, later 87th Amendment Act 2003 provided for the delimitation of constituencies on the basis of 2001 census and not 1991 census. However, now what is going to happen? Just read this line. This can be done without altering the total number of seats in the assembly of each state. We are not going to alter the total number of seats. Now, some of you would be thinking, sir, we got the point that the number of seats from each state in Lok Sabha need not to be reduced. Otherwise, this would be like less representation to that state in parliament, right? But why there's such hue and cry on reducing or increasing the number of seats in state? So this can happen. So the point is, if a particular state, say northern state, got more population and their number of seats are increased, so don't you think their weight in election of president will also increase? Because in election of president, who votes? Elected MLAs vote, right? So to reduce this disparity, this logic was said that you are not going to alter the total number of seats in the assembly of each state. Okay? Reservation of seats for SCs and STs. Now, if I ask, a statement is minimum 15% seats. As per constitution, minimum 15% seats need to be reserved for SCs and STs in each state, in each state legislature. Do you think that statement would be correct? I say 7.5% for STs and 15% for SCs. Now tell me, is it correct? Answer is no. Why? Because reservation is there, but as per population. It may be possible now that there's some state where there's no population of tribals. What is going to happen then? What is the use of having 7% seats reserved for STs there? Right? That is what the logic was on the basis of population. Clear? So you should not mark wrong answer in exam now. Our reservation was initially for 10 years. All of are aware of this. Later it was extended and then it was kept on extending. Now, composition of council. Unlike the members of Legislative Assembly, the members of Legislative Council are indirectly elected. I told you, indirectly elected plus nominated. Okay. Now, what is the maximum strength of a Legislative Council? So, Constitution is not said ki, or any law is not saying ki this is going to be the maximum strength. It simply says maximum strength cannot be more than 1/3 of the total seats of Legislative Assembly. Means at 1/3 of the total strength of the assembly, and minimum strength is 40. What does it mean? Consider maximum total strength of a legislative assembly is 90. Okay. Now tell me the total strength of legislative council of that state can be what? 1/3 of 90 is 30. Right? So it means the total strength of legislative council of that state can be 30. Okay. It means that size of the council depends on the size of the assembly. This can be a direct statement which can be asked. Because I told you, the size of legislative council depends on the size of legislative assembly. 1/3 logic maximum. Now, manner of election. In legislative council we are talking about. Because in legislative assembly there is direct election from the people. Legislative council, 1/3 of the members are elected by members of local bodies. Panchayats, municipalities, municipal corporation. 1/12 are elected by graduates. Now, some of you might be thinking, sir, we are graduate and we have never voted in this legislative council election. Because for that, you need to be added in electoral roll of that state for this legislative council elections. Then 1/12 are elected by teachers of 3 years standing in the state, not lower in standard of secondary level. Please go to this kind of detail as well. Then 1/3 are elected by members of the Legislative Assembly and the remaining are nominated. So how you can remember it easily? 1/3 is more than 1/12, right? So more weight in this indirect election of Legislative Council member is given to political representatives. These are political representatives, members of local bodies, and these MLAs, members of Legislative Assemblies, these are also political. So 1/3 seats, 1/3 seats are decided, or you can say elected by political. Okay. Now comes the role of teacher and student, means graduate. So teacher and student have 1/12, right? And remaining 1/6 they are nominated by governor, right? It is quite easy. Now, on what basis governor can actually nominate? Obviously on the advice of council of minister of the state, but their bases are literature, science, art, cooperative movement, social service. It means 5 areas are there. Okay. So it means 5/6 of the total members of the legislative council are indirectly elected, means 1/3, 1/3, 1/10, 1/12. It means 5/6, and 1/6 are nominated by governor. Okay. Now duration of 2 houses. Normal term is 5 years. I'm saying normal term. It may be possible before that, right? House can be dissolved. However, a governor is authorized to dissolve the house before that on the advice of council of minister, right? The term of assembly can be extended during the period of national emergency by law of parliament 1 year at a time for any length of time. This we discussed in emergency chapter as well, right? The extension cannot continue beyond a period of 6 months after emergency ceased to operate. In case of national emergency we are talking about. Okay. Now duration of the council. Now equate this with Rajya Sabha. Legislative council is a permanent body. 1/3 of its members retire on the expiration of every second year. Same in case of Rajya Sabha we discussed, right? So the vacant seats are filled by fresh elections, nomination by governor at the beginning of every 3rd year. This happens. So it means total duration would be 6 years for that particular member of legislative council. If I say the tenure of legislative council of state legislature is 6 years, do you think that statement would be true? No, because there is no tenure to the permanent house. Tenure word means this particular position or this particular house will cease to actually exist after this time. There is a need of separate election, right? But this is not the case of legislative council. It is same in case of Rajya Sabha, right? The retiring members are also eligible for re-election, re-nomination any number of times. There is no bar on that. Now attempt this question. You know, in Delhi, Delhi is a UT, but it is a special case. In Delhi, you have Legislative Assembly, you have CM Arvind Kejriwal, right? In which year this was actually turned into a Legislative Assembly of 70 members? So answer is 1992. Now members of state legislature, membership, qualification should be a citizen of India, subscribe oath by the Election Commission. For becoming a member of legislative council, minimum age is 30. Same in case of Rajya Sabha. As in case of Lok Sabha, minimum age is 25. Same in case of Legislative Assembly, 25. The Parliament has laid down qualifications of Representation of People Act. Representation of People Act provisions are same as in case of Parliament. A person to be elected Legislative Council must be an elector. Now, other provisions are same. For example, disqualification provisions. Okay, but these provisions are specific. Question may be asked. Okay. And UPSC might try to confuse you by saying for fighting an election of a Lok Sabha MP, that person should be a registered elector in that particular constituency. Now tell me the statement would be true or false in comments. Now come back to this. If you want to become member of Legislative Council, then you should be an elector for any assembly of constituency of that state. If you want to become member of Legislative Council, you need to be an elector in that state. And to be qualified for governor's nomination, he must be a resident of concerned state. Right? Concerned. A person to be elected to the Legislative Assembly must be an elector for an assembly constituency in the concerned state. Simply you can remember, for becoming a member of Legislative Council, elected for Legislative Assembly, you need to be an elector in a concerned state. For this particular part, nomination part, idea is resident. There's a difference between elector and resident. It may be possible I'm an elector added in voting list of different state, but for past few years I'm living in this state, different state. So I can be nominated. It may be possible that my name is yet to be added, but since I'm a resident here, I can be added. Alright? He must be a member of scheduled caste, scheduled tribe if he wants to be contest a reserved seat. However, a member of scheduled caste, scheduled tribe can also contest a seat of other, general category. This is obvious. Disqualification, office of profit, unsound mind, or when charges of unsound mind, then that person should be declared so by the court. Undischarged insolvent, It means that person is on the verge of bankrupt, has gone bankrupt. It means now this person cannot be trusted with the public money, responsibility. Not a citizen of India, voluntarily acquires foreign citizenship, then your membership is going to go. Is disqualified under any law made by Parliament. Any law, for example, Representation of People Act law. He must not have been found guilty of certain election offences, same as in case of Lok Sabha, Raj Sabha. He must not have been convicted of any offence resulting in imprisonment for 2 or more years. I hope you remember the case of Lalu Prasad Yadav. I mentioned that when I was discussing Parliament. Detention of person, preventive detention law is not a disqualification. This can be a question scope. If you're detained under preventive detention, you're not going to be disqualified as an MLA. He must not be a director or managing agent holding office of profit in a company where government share is more than 25% or at least 25%. He must not have been dismissed from the government service for corruption and disloyalty. If someone is dismissed means removal on these charges, then that person cannot become MLA. Disqualification on ground of defection, same, anti-defection law. Means 10th schedule says legislative council, in case of legislative council, who is going to take decision of disqualification, anti-defection? Chairman. In case of legislative assembly, speaker. Supreme Court ruled that decision of chairman, deputy speaker in this regard are subject to judicial review. Means whether they have followed the proper rule or not. Now, vacation of seats. If double membership is there, you cannot be member of state legislature as well as parliament. Disqualification we discussed, right? So disqualification grounds are 3. Same in case of parliament, means Constitution, Representation of People Act and anti-defection law. Absence, if you are absent from more than 60 days without any intimation, action can be taken. Resignation, if you have resigned. Now, attempt this question. Parliament by law may appoint governor of a state as the administrator of an adjoining union territory. Tell me, that statement is true or false? The statement is false, although some of you might be referring to this part. This statement seems correct. But what about this? Parliament by law. You don't need a separate law by parliament to actually give additional charge to a state governor as an administrator, right? Second, if a governor of a state is appointed as an administrator for adjoining union territory, he shall exercise independently of the council ministers. Consider you are governor of, say, Maharashtra, and you are given additional charge as administrator of Lakshadweep. There's a charge of administrator there. That's a UT. So, do you think for your functions as administrator of that Lakshadweep, you need to take advice from Maharashtra Council Minister? No, right? So that is why second statement is correct. Answer is B. As regards legislative powers, the governor of a state is not part of state legislature. The governor of a state has no emergency power to meet the situation arising from external aggression. Now, I hope you remember when we started this parliament part, and I gave you example. In case of parliament, it is Lok Sabha, Raj Sabha and President. In case of state legislature, it is State Legislative Assembly. If there is Legislative Council also, State Legislative Council, as well as governor. And first statement saying, as regard legislative power, governor of a state is not part of state legislature. How can it not be a part of state legislature? No bill can be turned as act without sign of governor, at least presented before governor. One way is presented to president. But the point is, governor is an essential part of state legislature. And this part is correct because no emergency power is with governor. So second statement is correct. De jure head of the government is governor. State government is governor because de facto real head is CM. In which one of the following state, it is not constitutionally obligatory to the governor to appoint minister in charge of tribal affairs. That's a factual part we discussed in the start. In an election to a state legislative assembly, a candidate is declared defeated, lost his deposit. It means zamana zabt hona, means in which case it will happen. Candidate got failed to secure 1/6, even 1/6 of the valid vote polls, then it means even the deposit which you have given, that is going to be forfeited. Speaker of the legislative assembly is elected by the members of the assembly. Same in case of Lok Sabha. Which one of the following is part of electoral college of the election of president but does not, this question was asked by UPSC in Prelims, does not form part of the forum of impeachment. So in case of election, member of legislative assembly elected, they are part right? But when it comes to impeachment, do you think MLAs participate? No, right? In impeachment, it is just parliamentarians. So it means answer is D, State Legislative Assembly. Hello and welcome everyone. I hope this message finds you fit and fine. We are in video number 48 of our Laxmikanth series, and today we need to talk about State Council of Minister. But before I start, let me remind you one thing. I told you when you start states part, that is part 6 of Indian Constitution, with each topic, have a comparative understanding, have a reflection, what we discussed in part 5. For example, when we covered governor, we were comparing with president in part 5. Why? One is, many processes, provisions are same. So it would be cakewalk for you to understand this, to retain this. Second is, sometimes UPSC play on differences part. For example, difference between some parts of president and governor, right? So since we have discussed Union Council of Minister, processes and provisions are same. So here you are going to revise as well, okay? So as the Constitution of India provides a parliamentary system at the level of union as well as state. Yes, at the level of state as well. Although we don't use the word parliament for state legislature, but the system is parliamentary. Why? Because we have a council of minister at the level of state. We have this government being formulated on the basis of majority a party or coalition gets in state legislative assembly, right? We have this council of minister collectively responsible to legislative assembly. It means features of parliamentary system are reflected in state government or state legislature as well, right? So in the state's union pattern, that is what I've explained to you, the council of minister in the state is constituted and function the same way as I told you as the council of minister at the level of center, same way. What does it mean? First is constitution, means how they're formed on the basis of absolute majority a party or coalition gets in state legislative assembly, not council, right? Please remember, assembly, MLAs, not MLCs, right? Then I also told you, when it comes to chief minister, in chief minister chapter we discussed, chief minister can be an MLA or MLC. And I told you it is same in case of PM. Like Manmohan Singh ji was member of Rajya Sabha. Similarly, assembly and council consider upper house at the level of state legislature, right? But when it comes to forming government, you need majority in assembly. For example, you need majority in Lok Sabha at the level of union, right? Absolute majority. Now what constitutional provisions say? I hope you remember Article 163. We discussed it before as well. Because these topics, governor, CM and council of minister, they are interlinked, right? There shall be a council of minister with chief minister as the head to aid and advise governor. I hope you remember, I also told you about Article 163 subclause 1 and subclause 2, right? And what is the difference? Can you recall? If any question arises, and this is subclause 2, arises whether a matter falls within the governor's discretion or not, decision of the governor shall be final. This is subclause 2 of Article 163. And I told you, this kind of power is not available to Honorable President. Okay, so that is why please remember, because UPSC play on these things. These are the traps. The advice tendered by minister to the governor not be inquired into any court. Advice given to governor, you cannot inquire that. This is a kind of privilege which is given to minister. Okay. Now some of you might be thinking, so this is wrong. What if these ministers give wrong advice to governor? Advice which is unconstitutional. What is going to happen then? For once, governor can say, council of minister, please reconsider your advice. And if they fix on their advice, no, I'm not going to reconsider, then governor has to accept. But you need not to worry. Because if there's a legislative action or say executive action which is unconstitutional, then we have our higher judiciary to interpret the constitution, right? And if such thing happen, then they are going to declare that particular law as null and void. But they need not to go into this advice. They can just struck down the output. Okay, I hope you got the logic now. Article 164, other provisions related to ministers. This also we discussed. The states of Chhattisgarh, Jharkhand, Madhya Pradesh, Odisha, there shall be a minister in charge for tribal. I told you how ministers are appointed. Actually, when one person got more than 50% MLAs supporting him or her name as CM, then governor says, okay, now you are going to be CM of that state. Now that person gives a list to who? Governor. Sir, please appoint these people as ministers. Now governor is going to appoint those people as ministers, right? Now who is going to get what ministry is also a decision of CM, because it's CM's Council of Minister, right? What kind of ministries CM needs, that is also a sole decision of CM, right? But in case of these states, there's a mandatory clause that you need a dedicated minister in charge for tribal affairs. And what's the logic? Logic is presence of considerable number of tribal population here, right? Welfare who in addition in charge of the welfare of scheduled castes and backward classes. Now, a state of Bihar was excluded from this list. Okay, so UPSC sometimes play on facts now, so this can be a fact on which UPSC can play. Now the total number of ministers, 15% of the strength of the Legislative Assembly. Please remember, 15% strength of what? Legislative Assembly. What does it mean? Consider there are 100 seats in Legislative Assembly, State Legislative Assembly, means 100 MLAs, right? Now a party get 60 seats. Now that party is going to form the government. Now CM has, this issue, right? We have more than 60 MLAs, and I have to make some of them as ministers. Like this was in discussion recently in Punjab, right? So many MLAs were saying, no, I'm going to be minister, I'm going to be minister, otherwise I'm going to get angry, or I may actually join another party. So now we need a rule for that. Earlier, actually, this provision was not mentioned in Constitution. And that is why, under the pressure of these MLAs, sometimes these CMs actually used to appoint so many people as ministers, and then problem is you have to give each of them as a particular bungalow and a car, the staff, etc., things, right? Allowances, privileges, etc. Now, apart from that, if you have formed so many ministries, don't you think it will be a troublesome job to get a policy action done? Because it may be possible for a particular work, you need approval of 3-4 departments. If 3-4 departments are attached to one minister, then that one minister can actually enact that policy in a faster manner. But if there are multiple ministers heading these small departments, then it would be difficult for actually enacting that policy, right? So burden exchequer as well as administrative inconvenience, and that is why 15% was made the standard. It means out of 100, that is the total strength, you can only make 15 ministers along with CM. Okay. The number of ministers including CM in states shall not be less than 12. So maximum is 15% and minimum is 12 for states. Okay. 91st Amendment Act was that. Now a member either of how, as I told you, you can be a MLA or MLC to become a minister, right? And even if you are not a member of Legislative Assembly or Legislative Council and you want to become a minister, and CM thinks, yeah, you are going to be a good asset in his Council of Minister or her Council of Minister, then such action can be taken. But same rule applies that within 6 months you have to become part of, or you can say member of, one of these houses, if there are 2 houses in that state legislature. Okay. Another is, consider you are disqualified on the grounds of defection. As I told you, 10th schedule of Indian Constitution, anti-defection law, right? So if you are disqualified on the ground of defection, now you are going to be removed or disqualified from the appointment of minister as well. Okay, you cannot say, oh sir, for the appointment there's a rule that I can be there for 6 months without being a member, so allow me to be a minister although I'm getting disqualified from. No, the moment you get disqualified from the house, you are going to be removed from the post of minister. Okay. 91st Amendment Act. Now the Council of Ministers shall be collectively responsible to Legislative Assembly. What does it mean? If no confidence motion is passed here, then the whole Council of Ministry has to resign. Governor shall administer oath. So who gives oath? Governor gives oath to these ministers. Minister who is not a member of the state legislature, as I told you, 6 months they can be there. Once conduct of business of the government. So I hope you remember in the governor chapter I told you, the executive actions of the state government are taken in the name of governor, right? Like president is the executive head at the level of union. Similarly, we have governor as the executive head at the level of state. But nominal power, real power is in the hands of CM. Executive action of the state shall be taken in the name of governor. Now, validity of an order. Consider you're a minister and you have signed a file for a particular, say, policy action. So is it mandatory that it need to be countersigned every time by the governor? No, that's not necessary. Okay. So what does it mean? You can actually have a noting on the file in the name of Honorable Governor of Uttar Pradesh or Madhya Pradesh, whichever state we are talking about. These policy actions have been decided to be taken, and I being a minister in charge of this particular ministry, I am giving this authority that this policy need to be implemented and signed. So it will be considered, yes, governor has agreed. But in which category giving file to the governor is mandatory, in which category you need not to give file to the governor. So regarding this, rules and procedures can be decided. Governor shall make rules of the more convenient transaction of the allocation business. Convenient transaction, why? Because every file should not circulate towards governor. It will actually create unnecessary delay in policy actions, right? So such rule can be made by governor, but obviously on the advice of Council of Minister. 167 duties of Chief Minister. We discussed it. To communicate about administrative actions, to furnish details of legislative policies which they are planning, their government are planning, right? As I told you, CM is like a bridge between State Council of Minister as well as governor, right? Rights of ministers as respect to the house. Consider there are 2 houses in that state. Legislative Council, Legislative Assembly, and you are member of Legislative Assembly, you are MLA. So you have this right to be present in LC or LA both. Why? Because it may be possible some member of LC, Legislative Council, want to ask some question from you. Then you have to present there, give the answer if such is the demand of the house, right? But you cannot vote in the other house. Vote can be given only in that house in which you are member. Right? Same clause as with Union Council of Ministers, we discussed this. Nature of advice by the ministers. As I told you, advice tendered by the Council of Ministers, they are mandatory for the governor, right? Reconsideration can be done for once, right? Otherwise, they are mandatory. Although there are some discretionary areas as well. So, Supreme Court ruled that Council of Ministers must always exist to advise. Such is the importance of Council of Ministers. Even after dissolution of State Legislative Assembly. Consider State Legislative Assembly has been dissolved, right? So it means now this particular Council of Ministers doesn't stand any chance to actually function formally. But this Council of Ministers can work as a caretaker government. So this is going to be caretaker government. The word is may. Please remember UPSC can play here. UPSC can use the statement and say the existing ministry, means they can attach this particular statement with that, and they say it is mandatory that at any time, every time, there will be a State Council of Ministers. They can play with you along these lines. But please remember the word is may, means it is possible, it can be done. Appointment of ministers. So Chief Minister is appointed by Governor, then Chief Minister gives list to the Governor, and then Governor appoints other ministers. Responsibility of the ministers, as I told you, they swim and sink together. If no confidence motion is passed, it means this government stands no chance to continue as government, then ministers have to resign. Same as case of Parliament, yeah, Lok Sabha. Council of Ministers can advise the Governor to dissolve Legislative Assembly before time as well, right? There can be re-elections. Does not represent the views of the electorate faithfully and call for fresh elections. So fresh election they can call for. It is duty of every minister to stand by the cabinet. What does it mean? Consider, you have some independent views and you have read Article 19, subclause 1, subclause A, and you are saying, I am having my freedom of speech and expression. Now you are a minister, but the cabinet means the key ministers cabinet minister, the key ministers, they decided, no, we have this stand on this policy, but you are having different stand. Now, can you actually continue as a minister in this case? It is duty of every minister to stand by the cabinet and support them both within and outside the state legislature. And if you are saying, no, I'm going to use my freedom of speech and expression, I'm not agreeing with what CM is saying, I'm not agreeing with what other cabinet ministers are saying, and I'm going to raise voice against my own government. If you do so, you may be asked to resign, buddy. Means if any minister disagrees with a cabinet decision and is not prepared to defend, he must resign. Okay? I mean, some of you would say, sir, it is actually, freedom of speech and expression are being compromised. You may say that. But please remember, when you are a minister in CM's Council of Ministers. CM is the leader. You have to uphold his or her vision, his objective. If you're not fulfilling that, you will be asked to resign. Individual responsibility. Contain the principle of individual responsibility. Governor can remove a minister at a time, but on what basis? If CM advises so, right? Or if that person is disqualified, right? Then obviously that person is going to go. Or it may be possible that now this particular Council of Ministers is not having majority in the Legislative Assembly. Enjoy the confidence on the advice of Chief Minister. On that advice of Chief Minister, Governor can actually remove. Okay? In case of difference of opinion and dissatisfaction with the performance of a minister, in this case also CM may ask you to resign, right? Please remember, UPSC can play on these part. UPSC may try to confuse you between governor's power to remove minister, its cases, and governor's power to remove a member of state legislature and its cases. Please note it down and identify the differences. Okay? And let me know in comments that so that I can be sure, yeah, you are actually giving attention to these intricacies, these details. Right? General understanding many students are going to have. But you have to become, that kind of master that any question which is thrown upon you, you're not going to mark it wrong. Such should be the clarity, because everything is logical. No legal responsibility. As at this level of center, no provision in the Constitution for the legal responsibility of the minister in the state. It is not required that an order governor for a public may be countersigned by the governor. Court are barred from inquiring into the nature of advice. As I told you, that court are not going to barge into the advice, why you have given this advice, right? Whatever advice they have given, if you're not agreeing with the decision, just declare this null and void if it is unconstitutional. As simple as that. But you cannot take legal action on the minister that why you have given this advice, right? This protection has been given. Composition of Council of Ministers. Constitution has not specified any size, right? Does not specify any size of the State Council of Ministers. Please remember, it can be a question. That it is determined by CM. Like at the center in the states to council. Why I'm saying doesn't specify any size? Some of you might be thinking, sir, you just said about 91st amendment, you said about 15% maximum. So don't you think that 15% strength of the total legislative assembly, we need at least these many ministers? No. I've said maximum ministers can be 15% of the total strength of legislative assembly. I've not said you need 15%. That's a decision of CM. CM may say, no, I'm going to have just 10 ministers. I'm going to have, so minimum is 12. So I'm going to have 13 ministers. I'm going to have 15 ministers. That is total discretion of CM. Okay? But specific strength, what is going to be specific strength? That is not clearly mentioned in our constitution. There are three categories of ministers, same at the level of union. You have cabinet ministers, you have minister of state, then you have deputy ministers, right? So these are the details. Cabinet ministers, these are the main ministers, means like the part of inner circle of CM, right? Having important portfolios, most important portfolios, home, education, finance, agriculture, and so forth. They are members of the cabinet, attend its meetings, and play an important role in deciding policies. Actually, from among these Council of Ministers, real power is in the hands of cabinet ministers. Their responsibilities extend for the entire gamut of state government. Prime responsibilities with them. Minister of State, they can be given independent charge or they can be just Minister of State. Okay. When I say independent charge, it means they will be having sole responsibility of the respective ministry, respective departments, right? Then we have deputy ministers. Deputy ministers are attached to other ministers. They're not given independent charge. Attached to the cabinet ministers. Now cabinet. What is cabinet? As I told you, in case of union, this is a smaller body. It's like the nucleus of the Council of Ministers, main body. Highest decision-making body, chief policy formulation, supreme executive authority, chief coordinator of state government, advisory body to the government. Real power actually lies with cabinet, you can say, a group of cabinet ministers. And cabinet committees have standing committee as well as ad hoc committee. A standing committee are permanent, means at any point of time you need policy decisions on these areas. For example, cabinet committee we discussed in case of union, right? Ad hoc committee, they are formed time to time. When they are given their advice, then they can be. The Council of Ministers in the state shall be collectively responsible to the governor. Do you think that statement is true? Collectively responsible to governor or collectively responsible to state legislative assembly? Tell me, because you have to identify the correct one. The state minister shall hold the office during the pleasure of the governor of state. Who appoints these ministers? Governor appoints. Who removes? Governor removes. Same is the case of President and Union Council of Ministers, right? That is correct. The number of ministers, including the chief minister in a state, shall not be less than 12. I've just told you. So it means first statement is wrong, because here it should have been state legislative assembly. So that is why 2 and 3 are correct, means B is the answer, right? Consider following statement. You have to identify the correct. Legislative council of the state in India can be larger in size than the half of the legislative assembly of the particular state. So our next topic is state legislature. Okay. In that we are going to discuss the statement, but as of now you should know that strength of legislative council cannot be more than 1/3 of the total strength of legislative assembly. That's a rule. Governor of state nominates the chairman of state legislative council of that particular state. When it comes to state legislative council, the chairman is the elected position, means from among the members of state legislative council, one member is appointed or elected as chairman. So in this case, both statements are incorrect. It means answer should be neither 1 and 2. The size of state legislative council cannot be more than 1/3 of the members of the state legislative assembly. That's a rule under Article 171. We are going to discuss it in next chapter as well. Chairman of legislative council elected by the members. Okay, then this is not appointed by the governor. Okay, nominated by governor, right? It is an elected position. In which of the following matters the power and status of council are broadly equal to that of assembly? So we are talking about state legislative council equal to state legislative assembly. So in which area they have equal say? Approval of ordinance issued by the governor, they have equal say. With respect to ratification of the Constituent Assembly, no legislative assembly has say. Selection of ministers including chief minister. Tell me, don't you think person can be a minister or chief minister even if that person is member of state legislative council, like Yogi Adityanath was member of state legislative council? So this is correct. With respect to passing of no confidence, no, obviously no confidence motion is actually a tool or procedure or device of legislative assembly, not of legislative council. That is incorrect. So 1 and 3 means B is the answer. Correct. Hello and welcome everyone. I hope this message finds you fit and fine. We are in part 6 of Indian Constitution. In the previous class, we discussed governor, and today we need to talk about chief minister. As we have already covered the office of prime minister, so chief minister would be cakewalk for you. So let's start with chief minister. CM is the de facto head of state government. What does it mean? It means real power in the state government remain in the hands of CM, and governor is de jure or nominal head, symbolic you can say. As per Article 164, CM shall be appointed by governor. But do governor has discretion in this regard? No, there's a process, there's a standard which governor has to follow. And the standard is the conventions of parliamentary system of government. And what is the convention of parliamentary system of government? It means governor has to appoint leader of majority party of state legislative assembly. Okay, it means you are going to vote in MLA elections. So whichever person is going to get support of more than 50% MLAs of a state legislative assembly is going to be appointed as CM by honorable governor. What if I say that CM is going to be appointed by governor whoever is having majority support in state legislative council? Do you think that statement would be correct? No, that statement would be wrong, because majority support is needed in state legislative assembly. Same like in case of union, we talked about in parliament, majority support in Lok Sabha is needed for the position of prime minister, not of Raj Sabha, right? Now, no party has clear majority. Consider there's a case of hung assembly. So this condition is known as hung assembly. Okay. Now, who governor is going to appoint as CM now? You can take example what happened in what governor did in case of Goa. So Goa is having 40 assembly seats, out of which you need 21 MLA support to appoint someone as CM. So there, Congress got 17 seats, BJP got 13 seats in the previous elections I'm talking about. Now no single party or coalition was getting 21 mark. So now in this case, governor is going to use his or her discretion. Please remember, discretion means it would be the decision of governor only. Who he or she is going to give the chance for taking oath of CM. Now, you would be thinking, sir, if someone is not getting more than 50% MLA support, then how can this person be taking oath of CM? Yes, it is possible if governor gives you chance, but there's a condition here. Condition is that within the time frame which is given by governor to that concerned person, means CM, that person has to prove majority support in floor test in the state legislative assembly. It means you have to prove within this time that yes, I have more than 50% MLA support. It means you need to get support of other parties as well, right? I hope it is clear to you now. The governor usually appoints the leader of the largest party or coalition. In this case, governor can give chance. Plus, please remember, UPSC can play with you by saying this is mentioned in constitution. Okay, in case of hung assembly, what governor is going to do is not mentioned in Indian constitution. That is why it is part of governor's discretion. Okay, I hope you remember when I was discussing center-state relations, then I mentioned about Sarkaria Commission and Punchi Commission report, and there I also discussed that this governor's discretion is also a point of conflict between center and state, right? A person who is not a member of state legislature, can that person be appointed as CM as well? Yes. For example, you have not participated in any election, right? But you can be appointed as CM as well. This is possible. And how is it possible? If more than 50% MLAs of state legislative assembly supports your name, give your name to the governor, then you can be appointed as CM. But you need to be part of any of the house. If there are two houses in state legislature, say legislative assembly, legislative council, so you need to be part of state legislature within 6 months period. Otherwise, your CM position will be taken away. Okay, so it means not a member of state legislature, still you can be CM. UPSC asked this question. This was a statement which was used. But within 6 months, you need to be part of any of the house. If there's one house, then you need to be part of this house. Okay. Now, can a member of state legislative council be appointed as CM? Or it is mandatory that a member of state legislative assembly only can be a CM? Now, even if we have not discussed, now think the convention which we discussed in case of Prime Minister. So I told you that Manmohan Singh ji was Raj Sabha member, still he was Prime Minister, right? Same is the case of CM. For example, UP CM, Mr. Yogi Adityanath, so he was part of legislative council and he took the oath of CM, right? So it means LC or LA. You can be member of any of them, right? Within 6 months period. According to Constitution, Chief Minister may be a member of any of the two houses. This is what I have just explained you with example. Now, oath. Governor is responsible for giving oath to the CM. When it comes to term, if a statement is used and the statement is saying Chief Minister of a state is having 5-year term, Tell me that statement would be correct or not. Some of you would say, sir, yes, the statement seems correct. Because we have seen many chief ministers have completed 5 years term, and after 5 years there's an election. But my friend, that statement would be incorrect. You know why? Because CM position has no fixed term. There's no fixed term with the position of CM. CM is there just till the time that person is having majority support of state legislative assembly. That's it. Okay, so no fixed tenure. Can governor remove CM at any point of time? Because it is said that CM is there for the pleasure of governor, because governor has appointed CM. No, governor cannot remove CM until and unless this CM actually loses majority support in state legislative assembly. Okay, this does not mean that governor can dismiss him at any time. This is what I have explained to you. He cannot be dismissed by governor as long as majority support of state legislative assembly is with the CM. Okay, if he loses confidence of the house, then CM must resign or governor will actually dismiss him. Okay, so majority support in state legislative assembly is mandatory. Now when it comes to power and functions of CM, number one, CM is like a bridge between governor and council of minister. Means governor is expected to ask CM if you want any report on any department. You should not directly approach the department officials. This kind of controversy we have seen in case of West Bengal, in case of Tamil Nadu governor, right? So governor appoints only those council of minister members. Those lists are being given to governor by CM. It simply means governor has appointed CM, whoever got majority support in state legislative assembly. Now CM will give a list to honorable governor. Sir, these 20 names I have fixed and please give them, appoint them as ministers. So governor is appointing these ministers in state legislative state government, but the list is given by CM. So that is why we say that this council of minister is at the level of state is CM's council of minister. Same convention applies like we discussed in case of prime minister. The point prime minister resigns, council of minister also resigns. We discussed this is like a ship. They actually swim and sink together. Same convention applies in case of state government as well. He allocates and reshuffles the portfolio among ministers. Consider that you are a minister in UP government and you are given a charge of PWD department. But we have found that you have not done satisfactory work, and CM thinks you have not done satisfactory work because you have to satisfy the vision of that CM, right? CM is the leader. Now, if you have not done that work, it may be possible that CM will say, now I'm taking your PWD ministry and now I'm giving you another ministry. Okay, say environment ministry, technical education ministry, women and child welfare ministry. Okay, and if you don't perform well there, then CM can remove you from there as well. But how CM is going to remove? CM is going to ask you to resign peacefully. If you are not resigning, then CM will give your name to the governor. Sir, please dismiss him or her. Then you will be dismissed. Okay. He can ask minister to resign or advise. I told you. And if you don't resign, then governor is going to dismiss him on the advice of CM. And if the advice of CM regarding dismissal of a minister is mandatory on governor, yes or no? Answer is yes, because council of minister of state is actually council of minister of CM. That is why governor has to accept this recommendation of CM. Presides over the meetings of council of minister. As I told you, leader guides, direct, control and coordinate the activities of ministers. What does it mean? It means CM is going to communicate to you that these are the goals which we want to achieve, and that is why you are given this ministry. Now, in relation to the governor, as I told you, governor and between governor and council of ministers, CM is like the bridge. Okay. Now, it is the duty of chief minister to actually communicate about the administrative decisions which you are taking to the governor. Now, some of you would be thinking, sir, why CM has to communicate these decisions regarding the administration to the governor? Because governor is not having any real power. But my friends, in the previous video I discussed that governor is actually the head of the state executive, right? Executive actions are taken in the name of governor. That is why it becomes a necessity. Okay, so furnish such information as governor asks regarding state legislature or state administration. So it is duty of CM. Okay, I'm using the word CM again and again because UPSC will frame a statement, and then in that statement UPSC will use governor will actually ask a concerned minister of a state government to furnish these details, and then minister is bound to furnish such detail to the governor. That statement is true or false? Actually, convention says otherwise. Convention says CM is the link. Okay. If governor is so required to submit for consideration, consider a case that you are a minister and you have some idea, and that idea has been discussed a lot, but your idea has not been taken up for discussion among your council of minister. So in this case, governor can communicate this to CM. Sir, I have heard, Mr. CM, I have heard that this was an interesting idea of one of your minister. Why you have not taken up this in your council of minister meeting? You should take up. He advises the governor, and CM advises the governor with regard to important appointments. For example, in the previous video, I asked one question: who appoints SPSC chairperson? The question was who removes, because there's a twist there. So within the solution, I told you SPSC chairperson members are appointed by governor, but on whose advice? CM's advice. Okay, and CM's advice is mandatory. Same with state election commissioner. Same with Advocate General. Advocate General, the senior most legal officer of the state government. Like we have Attorney General in union at central level. Now in relation to state legislature, he advises the governor with regard to summoning and proroguing. Now, in the legislative power of governor, I told you that house of a state legislature can be summoned and prorogued only by governor. Summon means to call the house, and prorogue means to ending the proceedings of the house, right? Start and end. Who is going to do that? Governor. But on whose advice? CM's advice, along with council of minister. Okay, and this advice is mandatory. He can recommend the dissolution. Consider, now CM is thinking that I want election, right? And even if there are 6 months left before the completion of 5-year term of state legislative assembly, but I want elections. So now the CM can recommend to the governor, so please dissolve this legislative assembly and we want election. So in this case, governor can actually do that. He announces the government policies on the floor. Who announces? The CM announces the government policies. Other powers, chairman of the state planning board. Now please remember, UPSC is asking these kind of factual questions, right? Regarding CM, 1 or 2 questions may be conceptual and 1 question would be factual. Like CM is vice chairman of zonal council by rotation for 1-year period, maybe member of interstate council, right? So this question was already asked, right? And other statement can be interstate council is headed by CM on the rotation basis. Now tell me the statement would be true or false. It would be false, but the UPSC will try to confuse you between zonal council and interstate council. But if you know that these are the traps, now you are not going to fall into traps, right? Chief spokesperson of the government, because prime responsibility of government lies on the shoulder of CM, and that is why CM is regarded as crisis manager of the state government. Relationship with the governor. Now, what we have discussed until now, the provision related to CM, now we are going article wise. Okay, Article 163, it says that there shall be a council of minister headed by chief minister to aid and advise governor. Now our constitution has not elaborated on this fact. What does this aid and advice means? Is it mandatory or is it just advice as we know in dictionary? But the convention has developed that in parliamentary system, in democracy, real power should be with elected government. And that is why this aid and advice should be considered mandatory. But there's a twist there, which we don't find in the case of president. In Articles 163, subclause 1, it says it like this. But in subclause 2, it says that the discretion, the word discretion means where governor is going to act on his own, on her own, not with the advice of CM. Who is going to decide in what cases you need to act as per discretion? So actually our subclause 2 says that this is going to be decided by governor only. And this is the fact on which we say that governor's discretionary power seems to be more than president. And this specific statement can be asked in your exam. Please remember, as per Article 163 subclause 2, governor is the one who can decide the areas where governor is going to take discretionary action, not on the advice of council of minister, but such provision is not present in case of President of India. I hope it will be clear to you now. Article 164, CM shall be appointed by the governor, you know it, and then CM will give a list to the governor, sir, please appoint these people as ministers, then governor will appoint them. Minister shall hold office during the pleasure of governor. Why we are saying pleasure of the governor? Because governor is the one who is appointing them, and minister don't have any fixed tenure. The moment CM says, sir, I've asked this minister to resign, but he's not resigning, just dismiss him. So he will be dismissed. Ordinarily, if CM says you have to resign, then you resign, because you know how your political career is going to end then. The Council of Ministers shall be collectively responsible to the Legislative Assembly. Now, please remember, in case of COM at the level of union, I told you the meaning of collective responsibility. It means you are minister, you have government only till the point you have majority support in Legislative Assembly, right? The moment you lose that, then you will actually resign from the position. Okay. Article 167, as I told you, communicate. CM is responsible to communicate about the administrative decisions, furnish the details as asked by governor with respect to legislative or executive part. Governor requires submit for consideration of the. So this is what I have discussed this. I told you now, if concerned minister is having some important decisions to take, but that particular proposal has not been taken up at the level of Council of Minister, in this case, governor may told to convey to the CM that please take up this matter. So this matter can be taken up. Now let's attempt some questions. Assertion: Chief Minister of the state can disqualify a sitting MLA after obtaining the advice of State Election Commission. This is assertion. Do you think that statement is correct? This statement is incorrect. If someone, even after going through this Kanthas series of Laxmikanth, is saying this statement seems correct, then that is a sinful act. Okay? That statement is incorrect. Chief Minister is the de facto head of the state. This is correct. Now, look at the options. A is incorrect, R is correct. It means 3. 3 is the answer. Right? Now, second question. Which of the following is not correct about the Chief Minister? Not correct about the Chief Minister. Council of Ministers shall be collectively responsible to the Legislative Assembly of the state. Article 154 states that governor will appoint the Chief Minister. Now, if you say this, see this. So this part of the statement is correct. Okay. Although UPSC can ask this question like Chief Minister and COM. Okay. Now, but even if you don't remember 154, but since you are going to go to this part so many times, you will remember that in 164 I told you Chief Minister shall be appointed by governor. It was 164. And what question is saying? It is saying 154. So it means not correct is second option. Right? Now, what is the minimum age for the appointment of Chief Minister of a state? Although our constitution has not specifically mentioned that this is the minimum age criteria for CM, but since it says that within 6 months, even if you are not a part of state legislature, within 6 months you have to be part of you have to be member of any state legislature, means legislative council or legislative assembly. And what is the minimum criteria? What is the minimum age which you require to be part of legislative assembly? Means MLA. That is 25 years. So that is why answer is 25 years. Okay. Which of the following is not matched correctly? Now, so in these kind of questions, sometimes students think, oh, I don't remember all the articles. It means this question is going to go in vain. No, that's not correct. You should attempt. In Article 163, I just explained you that governor, there will be a Council of Ministers headed by CM, aid and advice governor, right? And I told you 163 subclause 1, 163 subclause 2 talking about discretion, right? But look what 163 they are saying, swearing in of CM. It means this is not correct. So it means it may be possible you have gone through one or two articles so many times that one or two article may be matched incorrectly. So that is why you should attempt such questions. Okay. Hello and welcome everyone. I hope this message finds you fit and fine. We are in video number 46 of our Laxmikanth series Kanthas, and today we need to talk about governor. Part 6 we are starting today. We have completed part 5, that is union. It would be quite easy for you if you try to compare the dimensions which you have covered in precedent chapter. Since governor remain in news saying that governor position has been misused by center to hamper the principle of federalism in Indian polity, UPSC has asked questions on governor in prelims as well as mains. So let's start governor. When we discussed the word parliament, so I told you that in parliament we include Lok Sabha, Raj Sabha and president, right? I hope you remember this. You remember this? Now, what about governor? So I told you why in the idea of parliament president is included, because parliament is there to make law, and there cannot be any law till the point president signs on that bill, right? It needs to be passed by Lok Sabha, Raj Sabha and then presented before president, right? Similarly, at the level of state, when we use the word state legislature, we have legislative assembly. In some states we also have second house, that is legislative council. Along with them, we need to count the office of governor, then we can say that yes, this is state legislature, because bill is presented in assembly or council if there are two houses and then presented before governor. When governor signs, then it becomes an act in that particular state. So part 6, article 153 to 167, we talk about this state executive. Governor is the chief executive. It means all the executive actions of the state are taken in the name of governor. What does it mean? Many people have read this, but what does it mean? It simply means, consider a minister is issuing some policy, some directions. So on that file, the noting says that in the name of governor, such actions are being taken by state government, vetted by that particular department, and department head is, who is department head? At the level of minister, because policy actions are taken at the level of minister, right? Then implementation part is taken by the civil servants, right? So that is why governor is the chief executive head of the state, okay? Usually one state used to have one governor, but after 7th Constitutional Amendment Act, this provision was changed, and now one governor can be counted as governor of more than one state, okay? A state executive consists of governor, chief minister. I hope you remember when we use the word union executive, I told you UPSC asked one question in prelims, that which of the following is not part of union executive, right? And one option was saying CAG, right? And that CAG was wrong, and some students were like, sir, how can CAG be wrong, because CAG is executive, right? But that is not correct in the definition of union executive that is mentioned in part 5. Similarly, when we are using the word state executive, so you should not say, sir, if I am posted as a civil servant in state government, it means I am part of this permanent executive, so why I am not being counted as state executive? You will be counted as state executive, but not state executive in the definition mentioned in part 6 of Indian Constitution, okay? So this definition says governor, chief minister, council of minister and advocate general. And in the part 5, what we discussed, president, PM, council of minister and attorney general, right? Nominal executive head. What does it mean? It means real power remains in the hand of chief minister and the council of minister. Governor remains the nominal head. Along with this, governor acts as agent of central government. Now you may be thinking, sir, why central government needs an agent to be in the state? Yeah, this point was actually raised in Constituent Assembly also. Then decision was taken that we know that in India there's huge diversity, right? And it may be possible some states may have secessionist movement, because the size of states and the population we have in Indian state, we have less than this territory and less than this population, we have nations in Europe. So it may be possible some state get inspired, no, let's actually convert the state into a separate nation, and some of them will have chance to become prime minister, right? So we cannot allow these kind of secessionist movements in India, right? It could hamper integrity of India. And that is why it was needed that state government should work as per constitution, right? There is one rule book of the whole nation, fundamental rule book, that is constitution, and that is why who is going to ensure that in state, governor is going to ensure that in state. Now some of you might be thinking, sir, how can governor ensure that state government is going to work as per constitution when you have said that governor is just a nominal head, real head is CM and council of minister, real power is in the hands of CM. The reason is, the moment governor discovers that this state machinery is not working as per Indian constitution and there is no way out at the level of governor, then governor can actually recommend president rule in that particular state. And then president rule means now state government will not have say. Now that state is going to be directly ruled in the name of president, and now president is going to ensure that this state is going to run as per Indian constitution, right? So I hope you got the logic why we needed an agent of central government in state as governor. Now appointment. So governor is appointed by president. So do we have some election for governor? No, we don't have any election. Consider you are Indian citizen and you are above 35 years of age. We are considering that you are above 35 years of age, and your name is presented to Honorable President by Prime Minister. Prime Minister said, sir, this name Shashank Tyagi, we want him to be made governor of Uttar Pradesh. Then President will say, okay, since this name has been recommended by Prime Minister and Council of Minister, okay, I am appointing that person Shashank Tyagi as governor of Uttar Pradesh. Okay, so this can be done by president. I am using the word pleasure of president here. What does it mean? It means my position as governor is not having some secure tenure. Although it is said that there is a 5-year, means once I am appointed and no one has removed me, no one means president has not removed me, then I can be on this position for 5 years. But this position is not secure. Any point of time, without any reason, president can remove me. It means I am there for the pleasure of president. Now you may be thinking, sir, president seems to have a lot of power. No, that's not correct. Actually, president is doing that, means appointing as well as removing on the recommendation of Prime Minister and Council of Minister. Okay. Now, what about oath? So, Chief Justice or Senior Most Judge of the High Court are responsible for giving oath. For that, you can just easily remember this. Yes, I think it is visible to you. Yeah. Appointment and resignation means resignation oblique removal. Means consider that governor wants to give resignation. So governor is going to give resignation to whom? To president. Okay. But when it comes to oath will be given by Chief Justice of that High Court, or if Chief Justice is not there, he may be busy, he may be ill. So at that point of time, the senior most judge of that High Court is going to give oath to the governor. So please remember this. These kind of facts are also asked by UPSC. I think this is clear to you now. Now coming to the conditions of the governor's office. First of all, he should not be a member of House of Parliament or state legislature. It means you cannot remain member of parliament or member of state legislature and simultaneously you want to become governor. Okay. Now I'm making a statement here and you have to tell me that statement is right or wrong, because there's a scope of question there. The whole thing is written before you. Okay, you can read it out and then answer me. Okay. So statement is, any sitting MLA or sitting MP's name cannot be recommended for the position of governor by Prime Minister, Council of Minister, full stop. It means it can be recommended only after resignation has been accepted of the concerned person from the House. Now tell me that statement is true or false. So those who are not able to concentrate on it, just pause the video, think on it, or just go back and listen to what I have said. I am saying that consider you are an MP or state legislative, means member of state legislature. Your name cannot be recommended for the position of governor till the point you leave that seat. Some of you would say, sir, that is true. That is written here. He should not be a member of either House of Parliament. Acha. Do you think both things are same? No. Name can be recommended for the appointment of governor, even if that person is a member of Parliament or state legislature. But the moment that person is going to be appointed as governor, he will cease or she will cease to be on the position of MP or MLA. And that is what is mentioned here. Just read it. If any such person is appointed as governor, is deemed to have vacated the office, so then it will be considered that that person has vacated that house on the date on which enters upon office as governor. So it means it will be considered the date that person enter into office of governor. From that date it will be considered now this person is not member of Parliament or state legislature. So if you got it now, mention got it. Clear? Now, second, he cannot be arrested or imprisoned. I remember a case when Ms. Sheila Dikshit was governor of Kerala, and there was a CNG scam which was in news, and CBI was investigating. So now investigation was on, and CBI court was saying, and there were news that it may be possible that a direction for arrest may be raised, means conclusion, means proofs are of such level. But Constitution was saying something else. Constitution was saying you cannot imprison, you cannot arrest a sitting governor. Then what could be done? Considering the seriousness of that particular case, the concerned president, on the advice of Prime Minister, Council of Ministers, can remove that person from the position of governor, and then you can arrest that person. But till the time he or she is on this position, you cannot imprison that person. Okay. Along with this, any action which has been taken in official capacity for the official purpose, you cannot actually raise proceedings against that person, because that actions are having immunity. Why? Because most of the actions of governor are on the aid and advice of Council of Ministers, right? And if any action is unconstitutional, invalid, then court is there, na? High Court is there, Supreme Court is there. They can review that particular judgment, they can review that particular direction, they can review that particular order, and they can declare that ultra vires or null and void, right? But in case of civil proceedings, means after giving 2 months notice, civil proceedings can be instituted against him during his term of office for personal acts. So only for personal acts, civil proceedings can start. Civil proceedings means any matter with respect to tax, family matter. So those proceedings can start. Okay, but 2 months notice need to be given to the governor, so that governor can prepare and finalize all the pending works, responsibilities with respect to that state. That is why these provisions were added in our constitution. You should understand the logic. Now, when the same person is appointed as the governor of 2 or more states, what is going to happen? Who is going to pay the salary? Consider a governor is appointed for a single person is governor for Maharashtra and Andhra. Now, who is going to pay the salary? Now, you would say, sir, anyone can know. Both states would say, why we should pay the full salary, full allowance, when that person is also working as governor of other state. So now you should split the expenditure, right? Like you do in your parties with friends. Emoluments, allowances payable to him shared by the states in such proportion as determined by president. Now, the allowances, the salary is going to be splitted. Okay, it's going to be shared. That is correct. But please remember, UPSC can play on this. Who is going to determine what portion is going to be given by what state? This determination is not going to be done by one state or other, because they cannot agree on one thing. Right? One state can say, sir, I'm small state, why should I pay half salary? Other state is bigger state, so many cases, so many files, that state should give more. So that is why regarding this, that condition will be determined by president. Okay, there then can be a scope of question here. Please remember it. We are doing operation of every provision of this chapter. Now qualification. As I told you, 35 years of age and you are an Indian citizen, it means you are fit to become governor, right? But you need kripa of Prime Minister and Council of Minister for that. No education qualification is there, no maximum age is there. Even if you are 110 years of age, God bless you. If your name is recommended for the position of governor, you can be appointed on this position. Now over the time, some conventions have been actually developed. Conventions means these things are not mentioned in constitution, but these things have been followed considering these are good. For example, if you take a look, governor of UP, governor of Rajasthan. So governor of Rajasthan is actually a resident of UP. So most of his life, active political life, he was residing in Lucknow, UP. So he was appointed as governor of Rajasthan. Governor of UP, she was actually a politician, seasoned politician in Gujarat. So the logic is that if a person from outside is actually appointed under the state, it is less likely that person will be considered as a political person, because governor position should be neutral. So he should be an outsider who does not reside in the state where he will be appointed or she will be appointed. Another convention which was raised was that when you appoint governor, and since governor has to work in close tandem with the CM, then chief minister of that particular state should also be consulted. But this convention remains convention, matlab this is not mostly followed, and that is why many CMs have raised this matter. But this convention is mostly followed. Okay. Now oath, I have already told you, oath, CJ or J. Now terms of office of governor does not lay down any grounds upon which governor can be removed. As I told you, if you are a governor of any state, say Maharashtra, and the next day you receive a fax from the president office that Mr. Rohit, from this date, now you are removed from the office of governor, you just pack your bags. So you cannot do any if and but. Why I am being removed? I'll go to the court. Then court will say, beta, you should read governor chapter from Laxmikanth, right? Because governor cannot question this, because governor position is there on the pleasure of president, right? And there are some cases with regard to this. National Front government headed by VP Singh in 1989, what VP Singh did, so he read this particular provision. He said, now I am giving a direction that Prime Minister is actually giving a direction. So Prime Minister cannot actually remove governors. Governors can be removed by President. Prime Minister can recommend President, right? So VP Singh asked all the governors to resign. That you yourself resign, otherwise I'll recommend to the President and President is going to remove you. So you should resign as you were appointed by Congress government. But after that, what happened? Eventually some of the governors were replaced and some were actually continuing that position. After that, when next government came in 1991, PV Narasimha Rao government, it means Congress government, then they changed 14 governors appointed by VP Singh government, Chandrasekhar government. So the point is that the central government removes governor from the previous government, right? And there has been question on this, that there should be some ground of removal also. Then only governor will actually act in neutral manner. Some of you would say, sir, what is the harm? Just remove them. What is the harm? Harm is that if governor knows that I have to be in good books of the Prime Minister and Council of Minister of the Union, then what they can do, they can actually misuse this provision of Article 356 of Indian Constitution, means President rule. Means if the party in power wants a different party's government in state to be quashed, so they would like to actually install a governor who is going to actually dislodge that government. So that is why Article 356 President rule has been misused many times, and governors were misusing them for their own security, because they wanted to remain in this position of governor, right? President may transfer a governor, appoint to one state to another, right? Further, a governor whose term has been expired may be reappointed. Now my question is, consider you are a governor and you have completed 5 years there. Now can you be reappointed in the same state, or you need to be, if you are being reappointed, you need to be reappointed in different state. Since our constitution is not saying anything about it, that is why you can be reappointed in any state, in the same state as well. Okay, please remember it. You have to read between the line. Okay. In case of the death of sitting governor, who is going to be working as a temporary governor? Chief Justice of that High Court is going to be appointed as temporary governor for that time by the Honorable President. Please remember it. Okay. Chief Justice of that High Court. Now coming to the power and functions of the governor. Let's simplify executive power. You can easily remember these power by understanding this logic. Executive means implementing law. For example, there is a law regarding appointment and governor is just following this law, executing this law. It means this is executive power of governor. For example, appointing chief minister, council of minister, appointing advocate general means topmost legal officer of state government. So these appointments are done by governor and these come under executive power of governor. Along with this, governor can also appoint a state election commission. Now there's a trick here. UPSC might say that appointment of state election commissioner and appointment of chief minister comes under executive power of governor, and these positions are there on pleasure of governor. Now tell me that statement is true or false. Come on. Should I repeat, or you can pause and go back? I'm saying appointment of chief minister and state election commissioner are executive powers of governor, comma, these positions or these people serve there on the pleasure of president. So half statement is written before you and other half I have made up, that they serve on the pleasure of president, pleasure of governor, I'm saying. Now tell me that statement is true or false. Pleasure of president is obviously wrong. And if I'm saying pleasure of governor, now tell me that statement is true or false. Some students would say, sir, it is correct. Because chief minister is not having any secure tenure. Someone can be on this position of chief minister only till the point that person is having majority support in state legislative assembly. When more than 50% of the state MLAs are supporting that person as leader, then only governor appoints that person as CM of that state. Right? Now the point is, the moment that person loses that confidence in the state legislature, governor is going to remove that person. This may be after 6 months. So removal can be done by governor. It means this position is connected to pleasure, although condition is there. Till the point majority support is there with the CM, with the CM, then governor cannot remove that CM, right? Now, what about state election commissioner? So twist is, when it comes to these positions, CM, council of minister, advocate general, they are there on the pleasure of governor. But when it comes to state election commissioner, so this position is not there as per pleasure of governor. Okay, so this is exception, and UPSC play on exception, right? So executive power, all executive actions of the government of state are formally taken in his name. As I told you, in the file, actions are taken in the name of governor. Now, what process is going to be followed while you actually approve these files? It can be decided by a governor on the advice of CM, council of minister, obviously. Appointment of CM ministers hold office during the pleasure of governor, as I told you in that question. So this is executive power. And what is this actually? Now council of ministers are appointed by governor, but which person is going to give in which ministry? How many ministries are going to be there? A sole power of CM, chief minister. Chief minister recommends to the governor and governor do that. Then in these states it was considered mandatory that tribal welfare minister need to be there. Chhattisgarh, Jharkhand, Madhya Pradesh, Odisha. State of Bihar was excluded from this list. Okay. Now second, emergency provisions. Article 356. President can actually, governor can recommend president rule in that state. So that is also what? Executive power, because law is already there. Governor is just executing that process. And if in this condition, means if these recommendations are accepted by president and president rule is imposed, now governor would be like, now extensive power is with me. Who is CM now? Right? So it means extensive executive power will come in the hands of governor if president rule is imposed. Then take information from CM regarding the legislative actions which they are planning, the bills they are planning regarding administration. Governor can ask CM. CM works as a bridge between Council of Minister and governor. You may have heard about some issue which was going on in Tamil Nadu when governor actually took meeting directly with some district officials. So it was said that governor should not meet directly with district officials, governor should not question even the ministers directly, governor should seek information from CM. So this I have already explained to you. Advocate General appointed by governor, imposition of president rule, appoint state election commissioner. How state election commissioner is removed? The state election commissioner can be removed like the same manner on the grounds of judge of a high court. Such is the importance of state election commissioner. And why it is given? We are talking about democracy, and in democracy free and fair election is the primary feature. And how you can ensure free and fair election? The key official for in state should be the neutral one, should be free from any bias. So that person should be given this security. He can seek any information relating to administration. As I told you, seek information. This. So I think broadly if you remember this, then it would be cakewalk for you. I hope it is clear to you now. Now attempt this question. Who can remove chairman of state public commission? Although we are going to discuss these later, but you should connect them simultaneously. Topics are interlinked. Yes, President, Governor, Chief Minister, Chief Justice of High Court. Some of you might be thinking, sir, remove chairman of State Public Service Commission. Okay, so State Public Service Commission, we are talking about state. So that person should be removed by governor, right? But that is wrong. Answer is president. Governor appoints chairman and members of State Public Service Commission. It is executive power, however, removed only by president. And question was asking, remove. So please remember, okay, appointment by governor, removal by president. Legislative power. So legislative power means power of governor with respect to house. Whatever happens in house, in this regard, governor is given certain responsibilities. For example, to call the session. Session will start only when governor summons the session on the recommendation of CM, Council of Minister. So summoning the session is legislative power of governor. Then governor is there to prorogue the session, same like president is there to summon and prorogue the session of parliament. Prorogue means end the session. Like I told you in president chapter, president is there to address the house in the first session every year, right, as well as after general election, first session, right. Similarly, at the level of governor, address the house in the first session, means after every year, as well as after new elections, right, fresh elections. Send message to the house asking them that these legislative proposals are important, do please consider them, as well as disqualification. Yes, that is also legislative power. So in what case governor has power to disqualify? Whose disqualification we are talking about? We are talking about disqualification of state legislative assembly members, members of state legislature. As I told you in parliament chapter, there are three broad categories on the basis of which a member of state legislature or member of even parliament can be removed. One category is mentioned in Constitution, other Representation of People Act, and third 10th schedule, that is anti-defection law, right. When it comes to anti-defection law, the decision to remove disqualifying that person lies with presiding officer of that house. For example, if you are talking about disqualification in state legislature on the basis of anti-defection law, then decision will be taken by Speaker of State Legislative Assembly. But when it comes to Constitution, Representation of People Act, where primary investigation is done by Election Commission, the Election Commission is going to recommend to the governor, sir, please remove this MLC. Then that is also a legislative power of governor. So please remember, appointment power in executive power, disqualification in this legislative power, disqualification of MLA. Okay. Now, presiding officer means who is going to be the presiding officer in case a speaker and deputy speaker of the state legislature are not there. So who is going to decide? Governor is going to decide. Similarly, there also president can act, although there is a panel also there. Ordinance making power is also legislative power of governor. Ordinance, what are ordinance? I told you, Article 123 in case of president, Article 213 in case of governor. In case either house of parliament is not functioning, it means there's no condition where this can be made, this important law can be made, since house is not functioning and there's immediate action which is needed. So this bill can be turned into a temporary law in form of ordinance by governor, right? So that is also legislative power. Nominate 1/6 member in state legislative council. Similarly, in case of president, 12 nominated members in Rajya Sabha. I hope you remember, right? Similarly here, 1/6. Now I think this will be cakewalk for you. Means this is what we have discussed, right? One thing you should remember, this is the same case. Promulgate the ordinance, but once house reassembles, you have to get it passed within 6 weeks from its reassembly. Same. Nomination, there's another condition called cooperative movement. It means 1/6 members are nominated from which category? Literature, science, art, social service, along with this cooperative movement. Okay. When a bill is sent to the governor, after it is passed by state legislature, he can consider a bill is presented before governor after it is passed by state legislature. What can governor do? Governor can give assent. Assent means now this bill will turn into an act. Governor can withhold. It means now done. This bill is not turning into an act. Governor can return. Means send the bill back to the house for reconsideration. But once house says, no, we are not amending anything, we are agreeing that this bill is correct, now governor has to sign this. Okay. Same as the case of president. Now there is additional fourth function with governor which is not with president, that is reserve the bill for president. So these are the 4 categories or 4 choices which governor has when a bill is presented before governor. I hope you will remember it. Now financial power, this we are going to use also because now we are going to compare president and governor also. These things are going to get embedded in your mind, don't worry. Now financial power. In case of president, I told you, budget is presented in Lok Sabha with prior recommendation of president. Similarly, in case of state government budget, it is presented in state legislative assembly on the prior recommendation of governor. So that is financial power. Like I told you, no grant, no demand can be made except on his recommendation in case of president as well as in case of governor. Money bill is presented in Lok Sabha with a prior recommendation of president. Similarly, money bill is presented in state legislative assembly on the prior recommendation of governor. He can make advances out of contingency fund. Similarly, we have contingency fund at the level of president also, contingency fund at the level of state also. Constitutes finance commission, but this finance commission is state finance commission. It is there to decide how much resources need to be distributed between state government and municipalities and these panchayats. Okay. Now I am asking a question and you have to tell me that statement is true or false. Finance commission, when I am saying just finance commission, it means I am talking about union level finance commission, which is actually constituted by honorable president. Finance commission can also recommend ways by which panchayats or municipalities should supplement their resources. Means finance commission at the center can give recommendations to state for enhancing the resources for municipalities or panchayats. Tell me the statement is true or false. Answer is true. Although we have State Finance Commission for that purpose, but Union Finance Commission, Union Level Finance Commission can also recommend the same. Clear? UPSC has asked these kind of questions. Now, judicial power. I hope you remember in President chapter we discussed pardon, reprieve, respite, remission, right? Same judicial power are with governor, but there are some differences and their questions are asked. For example, take example that in case of death penalty, so president has power, this judicial power, to actually pardon death penalty. When I say pardon, pardon means absolving that person from any conviction. It is like ja simran ji le apni zindagi, no case, nothing, go home. That is pardon. When I say commute, there we discussed that now we are reducing the amount of punishment, right? So president can pardon death sentence, but governor cannot pardon death sentence. Okay, means governor cannot say a person with death sentence just ji le simran apni zindagi, right? Cannot completely absolve that person from conviction, but can use respite and reprieve, these kind of things. Okay, another thing, with respect to court martial, president has power, this judicial power can be used, but in case of court martial, means military court's decision, governor's actions are not going to be used. Okay, so these two differences you should remember. Apart from this, he makes so you can easily remember this. First of all, appointment and transfer in subordinate judiciary, it means district court, municipal court, right, session and the civil courts. So appointment of judges at this level is done by governor, obviously on the recommendation of State Public Service Commission and State High Court, right? Transfer is actually chiefly done by State High Court, but State High Court give recommendation, right? Governor do that. So prime power is with State High Court, but governor do that, right? So make appointment, posting, promotion of district judges in consultation with State High Court. Please remember, posting, appointment and promotion. Okay. Appoint person to the judicial service of the state, appoint. So just remember, appointment, posting, promotion. You can remember it like this. Remember this mnemonic: appointment, posting and promotion. Okay, postings means changing one position to other position, right? I think this is clear to you now. Now let's compare president and governor. So with regard to ordinary bill, if a bill is ordinary bill is presented before president, what choices president has? President can give assent, withhold and return. If it is returned once and it comes back again, then president is bound to sign. With respect to governor, governor has fourth option as well: assent, withhold, return as well as reserve. Reserve the bill for president. Now president has reserved the bill. Now governor has reserved the bill for president. Now what president can do? Means now this bill is reserved for president. Here is we have governor. Okay. Now what choices president is having? President can give assent. If he says assent, it means now this state bill can be turned into a law, right? Can return. Return means you have to return. Now when you return, there is a condition. Condition is that concerned state legislature has to consider this bill within 6 months time and send this bill back to honorable president. Okay. Withhold. So it means assent, withhold and return. So all three conditions which are with president in normal conditions are with president in case of reserved bill of state also. But here just one thing you need to remember: 6 months time is there with state legislature. In normal conditions, with the bill, when the bill is of parliament, means Lok Sabha, Raj Sabha, no such 6 month condition is there. But on reserved bill, 6 months condition is there because this bill belongs to state. Clear? Please remember, when this reserve function is used by governor, now governor has no role with respect to this bill. This bill will directly go to that particular, means this bill is going to be presented in that state legislature, and when state legislature is going to send back, this bill is going to be presented before president. Now no role of governor in case of reserve function is used. Clear? With regard to money bill, What choices president has? President can give assent or withhold. Means president cannot return this bill because money bill is actually presented in Lok Sabha on the prior recommendation of president. Normally president gives assent to the bill. In case of governor, governor has three powers: assent, withhold and reserve. Please remember, one thing is common: return function is not used by president as well as governor in case of money bill. Return function is not used. UPSC is going to make statement on this. You need not to fall into trap. Okay. Now, consider reserve function is used. President has sent. Now, president is taking up this bill, state bill, as governor has sent this bill. Now, what options president has? President can give assent to the bill. President can withhold bill. Return function, as I told you, is not going to be applicable in case of money bill. So the president cannot return money bill for the reconsideration of state legislature. Clear? So please, it is quite easy now. And similarly, as I told you, once reserve function is used, governor has reserved the state legislature bill for the president. Now governor has no role. Now it is between president and that state legislature. I hope it is clear now. It is quite simple. It means while you are reading, it seems like so many words, but you need to just pick up the logic. Comparing ordinance making power of president and governor. Please remember, first of all, in which case ordinance can be used. If one house or both house, means either house is not in session, then president as well as governor can exercise this power of ordinance on the recommendation of prime minister headed by council of minister, means council of minister headed by prime minister in case of president, and here CM, right, heading COM. He can promulgate ordinance only when he is satisfied that immediate action need to be taken. He is satisfied immediate action need to be taken, although works on the recommendation of council of ministers. So it is also same. So both is same. Now his ordinance making power is coextensive with legislative power of the parliament. It means ordinance making power of president is applicable on laws on which parliament has power to make law. Okay. Some of you might be thinking, sir, it is too obvious. Acha, it is too obvious. Let me ask one question from you. Ordinance making power of president is applicable only on union list. Now tell me that statement is true or false. I am repeating my statement. Ordinance making power of president can be extended only till union list or concurrent list. Okay. Tell me the statement is true or false. Some of you might be saying, sir, it is true, since you are saying can make law only on subjects where parliament can make law, right? Achha. I am reframing this statement again, and then I am going to tell you the right answer. Now the statement is, ordinance making power of president cannot be extended to state list. Means president cannot make ordinance on a subject which is mentioned in state list. Now tell me the statement is true or false. Some of you would say, sir, it is false, because it is clearly saying his ordinance making power is coextensive with the legislative power of the parliament. This means that he can issue ordinance only on those subjects on which parliament can make law, right? My friends, both the statements which I have made are wrong. Answer is false. Now some of you might be thinking, sir, then this is what is written here is wrong. Is Laxmikanth wrong here? No, Laxmikanth is right. You are wrong. You are misunderstanding. You are not listening to me. You are relating to things with your own preconceived notions. Let me prove you how. Here statement is saying president's ordinance making power can be extended only on those subjects. Word only is used. Only on those subjects where parliament can make law. Right? And the statement which I have made, in which I am saying only union list and concurrent list. First statement, that is wrong. The reason is, in special circumstances, Parliament can make law on matter mentioned in state list as well. And that is why both statements were wrong. Because Parliament can make law in union list case, in concurrent list case. But the statement was saying only, no, not only, because Parliament in special case, in a case of emergency, can make laws on matter of state list as well. So that is why in that case, ordinance making of power of president in that special case extend to state list as well. If you got it now, mention VA in comments, because I have saved you from a trap which UPSC is going to make in exam, and many students are going to fall in this trap, but you are not going to fall. Clear? His ordinance making power coextensive only extends to matter on which state legislature can make law. Should I play along this point as well? Chali, I am making another statement. A statement is, governor's ordinance making power cannot extend to union list. The statement is true or false? Tell me. Answer is true, because there is no case, no emergency case in constitution where state government or state governor can actually make law on a matter mentioned in union list. ये तो औकात से बाहर की बात हो जाएगी. That would be more, that would be way beyond the ambit of state legislature, right? I hope this is clear to now. An ordinance issued by him has same force as an act of parliament. Similarly, an ordinance issued by governor has same power as law made by state legislature. Ordinance issued by him subject to the same limitation as an act of parliament. This means ordinance issued by him can be made invalid. Means judicial review will be applicable here also, and judicial review will be applicable here also. Okay. Can withdraw ordinance at any time. Similarly, governor can also withdraw any time. Ordinance making power is not discretionary, has to act on the aid and advice of council minister. Similarly, not discretionary, has to act on the aid and advice of council of minister at state. Ordinance issued by him should be laid before both the houses when it reassembles. Same cases here. Within 6 weeks, same cases here. Within 6 means no instruction for the making of ordinance. In this case, instructions are that in case any bill which is presented before state governor by the council of minister of state, which has certain provisions in which this matter need to be referred to the president, then that matter need to be referred to the president. It means no ordinance should have provisions which are in conflict with central government. Now, pardoning power, as I told you, is applicable on central law, applicable on state law in case of governor. Only authority who can pardon that sentence is president, and governor cannot actually pardon that sentence, but governor can suspend, remit, commute death sentence. Means temporary. Suspension means temporarily, means now death penalty is actually delayed. That can be done by a governor. Governor cannot say ja Simran jail apni zindagi or completely absolved. No. Can grant pardon, reprieve in case of court martial, but in this case no court martial. Means court martial case cannot be taken by governor, right? So I think it is clear to you now. The difference is clear. So these are just articles, you need not to cram them. These are some factual questions because we have played around the traps of this chapter. You are confident about it now. But UPSC sometimes are asking one or two statements on facts as well. Which of the following first Lieutenant Governor of Ladakh? Ladakh is in news. R.K. Mathur. First women governor of state in free India, Sarojini Naidu. Yes, this is a good question. Which one of the following statement is not true with respect to governor? Not true. They are part of state legislature. This is true. They can forgive the death penalty. This is not true. You got the answer. B is correct. Which of the following power is not vested in the governor of Rajasthan? So since Rajasthan governor was in news, so you should not think UPSC can play around this point, and some of you might think, oh, governor of Rajasthan must be having some different power. That is why governor of Rajasthan word is used, and that is not correct. Just read the statement. To summon the assembly, it is saying not vested. Summon the assembly, yeah, this power is with governor. Adjourn the legislative assembly. Adjourn power is not there because adjournment power is with Speaker of State Legislative Assembly, right? Presiding officer. So it means this is the answer. Dissolution and prorogation are power of governor, right? So this is the answer. Second, I think that is correct. Hello and welcome everyone. I hope this message finds you fit and fine. We are in video number 45 of our Laxmikanth series contest, and today we need to talk about PIL, public interest litigation. In previous class I mentioned that PIL is a manifestation of judicial activism. I hope you remember, right? Now what is PIL actually? Let's divide this word into two parts. One is litigation. Consider you are having dispute with someone and your private interests are being compromised, and that is why you file a litigation in court. The core of your litigation is your own private interest. You cannot call it public interest litigation. But there's a second case. You're filing a litigation for poor. You're filing a litigation for rights of some ethnic religious minorities. You're filing a case in court for the interest of consumers. Now, focus is not just you. Focus is a section. Focus is interest, general interest of public. Right? So that is why we can call now the second case, the second litigation as public interest litigation, right? And why public interest litigation is important? My friends, you know that every person living in our society is not aware about his, her rights, right? Even if some people, some sections are aware, they're not having enough resources. They don't know the way so that they can actually ensure their rights are protected. So that is why we need some good Samaritans, people who know the way, right? So they can file petition on their behalf. That is why PIL is important. This concept actually developed in USA, and purpose was to give legal representation to underrepresented, unrepresented sections like poor, consumers, like I gave example, environmentalists, etc. Legal representation. What does it mean? You know that our nation works on law, means constitution is the fundamental law, right? And constitution has given certain rights. Constitution has also given certain obligations to the state, means government authorities. And if they are not doing their job well, don't you think there should be something in this regard? And how can we ensure such action? So judicial activism becomes important in this particular scenario. And that is why in previous class I told you, when legislative or executive branch fails to fulfill their responsibility, then judicial activism becomes a necessity. In case of India, Mr. V.R. Krishna Iyer and Mr. P.N. Bhagwati, Justice P.N. Bhagwati, they were regarded as the people who forged this idea of PIL in Indian context. Apart from word PIL, we have other names as well. Social action litigation, social interest litigation, class action litigation. Okay, so these are actually other names of PIL. Now what is the meaning of PIL? You have understood the meaning? To summarize it, PIL constitutes a legal action initiated in court, right? You have filed the litigation. It means legal action initiated in court, and the purpose is for safeguarding general interest, right? Not just your private interest. Now this PIL as a concept was defined in which case? It was SP Gupta versus Union of India case. Please remember, UPSC can ask a direct factual kind of question as well as UPSC can make a statement. Okay, one statement would be on the case in which it was defined, and other statement would be on condition, or you can say guideline with respect to PIL. Okay, so real purpose of PIL is to ensure rule of law. This nation should be run with law, right? No one is above law. Second, access to justice to these poor people, or you can say socially or economically poor people. Then meaningful realization of fundamental rights. So it means you need to remember 3 points: rule of law, access to justice, fundamental rights. For these, PIL becomes important, right? Now, public interest litigation in India is to be linked with what? Come on. It's like a basic question. Judicial activism, I've just told you, right? PIL is a tool or manifestation of judicial activism. Feature of PIL, number one, it is like a strategic arm for legal aid movement. Legal aid movement, as I told you, some people are not having enough legal representation. lack of knowledge, lack of awareness. Even if they are aware, they don't have enough resources, they don't understand the way. So that is why PIL becomes a legal aid movement, giving legal support to these people. It is different from other litigations. As I told you, there can be private litigation as well. Example number 1. Example number 2 was public interest litigation. PIL brought before court with the intention to promote and vindication of public interest. Purpose is public interest. Constitutional legal rights need to be protected. This remains a focus of PIL, right? PIL is essentially cooperative effect. So what is cooperative? When PIL is being filed, you should not consider that this is other litigation. In other litigation, there may be two warring parties who are engaging in conflict. But the idea of PIL is that court is doing its duty, the person who has filed PIL is doing his or her duty, and state is going to perform his or her duty. Means government is going to perform their own duty. So it means when all three work in tandem, then only you can actually do the work which is needed. So that is why PIL is essentially a cooperative effort. Now, purpose is to ensuring public duty. Means if government has not done something, then government should do that. Protecting social, collective, diffuse rights, interest, right? Now, there's another point here. There's a difference between public and private, right? So, public interest litigation is not going to pronounce judgment in lieu of some individual right, right? Purpose is to talk about what are the rights of public and what has not been done and what should be done now. Such directions are given. Now, which one of the following case Supreme Court gave direction to end child labor? So, it was Bandhua Mukti Morcha versus Union of India. Again, I am saying this is factual, but UPSC can ask question by multiple statement. One statement is going to be there. Now, scope of PIL. In what cases PIL can be filed? So, Supreme Court has given some guidelines with regard to this, and these guidelines have modified in time also. One is bonded labor. It means your PIL can be on the basis of bonded labor. Second, if labor laws are not being implemented in letter and spirit by some employer, then in that case, there can be a case of PIL. Second, jail. It means if basic human rights are being abridged in jail, it may be for speedy trial for fundamental right. So, the petitions from jail can be considered of one case of PIL. Again, petition against police, not filing FIR, harassment by police, judicial, you can say death in custody, right? So, these are the cases of, you can say, PIL on the basis of police, against police. Petition against atrocities of women, against women. You must have heard about this, that there was no law before Vishaka guidelines were pronounced by Supreme Court with regard to sexual harassment of women at workplace. So, it means issue was there. In India, we have skewed sex ratio in our jobs. Women are less in number in formal sector. And one reason is sexual harassment at workplace, right? No effective law in that regard. So, in this case, Supreme Court actually pronounced the judgment. And later, Sexual Harassment of Women at Workplace Act 2013 came into play, right? So, these petitions become important. Then it may be a petition on the basis of for rights of SCs, STs or economically weaker section, economically backward classes. Petition for environment or family or pension, etc. Now, in which court PIL can be filed? It can be filed in High Court as well as Supreme Court. So, answer is both. Principles of PIL. For Supreme Court, High Court, they can exercise their power under Article 32, Article 226 in this regard. Means any interested person can file this PIL for disadvantaged section. If court found that there has been serious gaps when it comes to protection of fundamental rights or state not performing constitutional duties, in this regard also, court can even accept your PIL via letter or telegram. If court found that large section of people, there has been some injustice. For example, in case of rights, there were allegations that district administration acted in biased manner. In this case, court can invoke these provisions under Article 14, Article 21. Equality before law, right to life and personal liberty. If court found that yes, violation of constitutional right of a group of people happened, in this case, it may not allow the state or government from raising the question as to maintainability of the petition. Means state cannot say that we are raising our voice against mentability of this petition. It is not worthy to be discussed. Court will say, we will decide whether it is worthy or not you. Because this petition is going to have implication against your functioning. It is going to bring gaps in your functioning. Dispute between two warring groups purely in realm of private law would not be allowed to be agitated as PIL. But please understand, UPSC can play here. A statement can be made, dispute between two warring groups and a litigation in this regard cannot be considered as PIL. Tell me, the second statement which I have just said, is true or false? It is false. Because it may be possible a litigation between two warring groups may have some orientation, may have some angle of public interest. If this is the case, then it can be considered as PIL. But if only it is focused on private motive, then it won't be considered as PIL. Court in special situation may appoint commission also to investigate. Court would ordinarily not step out of the known areas of judicial review. High Court though may pass an order for doing complete justice to the parties. Now let me explain what is complete justice here, and in case of Supreme Court Article 142, UPSC in prelims has actually made one question specifically on this. It may be possible that state, means legislature or executive, they have not made a law in a particular area, and some people are getting impacted due to this. Now court, when pronouncing judgment, may issue a decree which may have power of law, which is going to have power of law. So in this case, for giving complete justice, court can act in this manner. For example, Vishaka guidelines case, I mentioned, right, sexual harassment of women at workplace. So this law came way later in 2013, but Vishaka guidelines came earlier. So this is point number 7. Now guidelines for admitting PIL. PIL is not a pill or panacea. I mean, it is not the ultimate solution for all the wrongs which we are observing in our system, right? It was essentially meant to protect basic human rights of the weak and disadvantaged. It is just a way so that we can actually work, but it is not like now every other branch should actually lay their arms, okay, PIL is there. No. Public spirited person file a petition before the court for poverty, helplessness, economic, social disabilities, and there have been recent times increasingly instances of abuse of PIL. So now our topic of discussion is abuse of PIL. When people use PIL just to you can say add hurdle to the working of some other person, it may be government functionary. So Supreme Court laid the following guidelines for checking the misuse of the PIL. So it may be against private person also, it may be against industries, it may be against government. So it is said that some people are actually doing this as a profession. First they file PIL, when they create some legal hurdles against other person, then they will take money from that person, and that's how they settle the matter. So it means precious time of judiciary is being misused by these faulty PILs, right? And judiciary is well aware of this, and that is why they have issued guidelines. Encourage genuine and bona fide PIL. Bona fide PIL means on affidavit you accept, here this is the truth. If it is found that you have, there has been mismatch in what you said and what is the reality, and you knew that, so then action can be leveled against you. The court should prima facie verify the credentials of the petitioner also. Instead of every individual judge devising his own procedure for dealing with PIL, it would be appropriate if court itself actually standardize this process. Means court should accept PILs in an orderly manner, and high priority should be given on larger public interest, urgency and gravity issues. Court, before entertaining PIL, must aim at redressal of genuine public harm and public injury. No personal gain, private motive should be there. Court should also ensure that petition filed by busybodies or extraneous or ulterior motives should not be actually given chance as well as discouraged. So when I say discourage, it means fine can be a way of discouraging such PILs. Which one of the following will not be entertained as PIL? Come on. Petitions of early hearing, case pending in High Court, obviously it is not going to be. So it means not. So it means this is the answer. You cannot file a PIL that my case is pending and please actually give me an early date. Although Right, neglected children, forest and wildlife, these all can be considered as cases of PIL. Hello and welcome everyone. I hope this message finds you fit and fine. We are in video number 44 of our Laxmikanth series, Kanthas. I hope your preparation is well on track. Today, we are going to discuss judicial activism. The word simply means that judiciary is going to work as an activist. It means for larger good of society, judiciary must sideline the set precedents. Here, the word precedent represents the boundaries which are set by doctrine of separation of power. As you know, legislature is there to make law, executive to implement law, and judiciary to adjudicate, to resolve conflict. Now, if legislature loses confidence of the people, means not making laws which people need. Executive loses confidence due to poor administration. Now, can there be a stable system if people are not having confidence in these two important pillars? No. Now, what choice judiciary has? To remain in boundary or to step up? What you suggest? I think you would say, sir, judiciary should step up in this situation, if situation is such at least. Right? So, in this case, when judiciary step up, then we call it judicial activism. Judiciary may pronounce some judgments which are actually considered as encroachment into the work of legislature or executive. Okay. Now this term was first coined in USA. There was one article, The Supreme Court 1947 Fortune magazine. Although this term actually got applied in India in 1970s, and there is a specific reason to that. Because first 2 decades after India's independence, Congress was having huge legitimacy in the eyes of people. And that phase of India's judiciary is considered as pacifist phase. Judiciary was agreeing with what executive was saying. But then things changed. Let's start with one question. Who among the following is associated with judicial activism in India? Answer is all 3 judges. Now, meaning of judicial activism, you should remember, judicial activism is there for protection and expansion of individual rights. Protection and expansion. And for that, judiciary depart from the set precedents, as I told you, established patterns. And sometimes it is considered that it is like intrusion into the legislative or executive matters, right? So these 3 key points you should remember. Now just attempt this question. Which of the following is an outcome of judicial activism? Please remember, question is not saying which of the following is related to judicial activism. It is saying outcome. If it says related, then answer would be different. Outcome. Judicial review, public interest litigation. Answer is public interest litigation. Because the public interest litigation is actually manifestation of judicial activism. Clear? Judicial review we discussed in the previous video. Now, the concept of judicial activism, and as I told you that if it is saying related, then answer would be different. Because judicial review is also used for judicial activism. But it is saying outcome of judicial activism. Outcome is not judicial review, right? The concept of judicial activism is closely related to concept of PIL, as I told you. PIL is like a tool, one tool of judicial activism. Apart from the reasons which I have just mentioned, like failure of legislature or executive, there are others as well. For example, judicial enthusiasm. It means judges like to participate in the social reforms. It encourages the public interest litigation, and it happens due to the relaxation of principle of locus standi. It means even if you're not party to that particular case, but for larger public interest, you can take up this matter before judiciary. You can take example that when it comes to some social evils in our society, so legislature is there to make law regarding this, that these evils are prohibited and this is going to be punishment. But if there's a situation that legislature is not doing anything in this regard, and someone actually filed a PIL in court, so now judiciary can actually use the judicial enthusiasm and be part of social reform. Judiciary can prohibit by its decree that this social evil is prohibited, right, and punishable. Then legislative vacuum, it is connected to this. It means if legislature has not made the law and there is a requirement, then judiciary can step up. The Constitution of India has also given enough scope for judiciary to actually work in this manner, means to legislate on these important matters. When I say legislate, it means it's not like judiciary is actually making an official law bill. No. For example, the judgment of Supreme Court, because Supreme Court is court of record, has power that it is going to be applied as a precedent, right, by other courts as well. Now, activators of judicial activism. According to Mr. Upendra Bakshi, we can categorize them in these following headings. 1. Civil right activist. It means there may be some activists who are demanding some civil and political rights. So this is one section where judiciary work as judicial activism, uses activism. Then people right activist, here we talk about socio-economic reforms. For example, there's a PIL for, say, farmers. Farmers not getting their due. Payments not given to farmers for their sugar cane, which they have already given to some sugar mills. So judiciary can actually intervene here, although this function is of executive. But for the larger good of society, these poor farmers, judiciary can intervene there. And it will be considered as an economic right. Consumer right groups. For example, judiciary is saying that these particular brands has to give this detail. These details should be published before you present this product to any consumer, right? It means labeling, etc. Any law regarding this, it will come under consumer right groups. Citizens for environmental action. In past few years, if you have seen, especially with regard to the pollution in Delhi NCR, our Supreme Court has acted, in a wide variety of manner, right? Supreme Court has established a dedicated commission who actually also coordinate with Delhi, Haryana, Punjab, specifically on this matter of pollution near Diwali, right? So environmental action. Rights of child groups. As you know, that child are the least represented group of a democracy because they don't have the age, they don't have the say, right, vote. So in this regard, judiciary has intervened. So if activists bring this point to judiciary and judiciary work in this regard, this is one section. Then women rights groups, for example, Vishaka guideline, for example, judiciary interpreting sexual harassment laws. Assorted lawyers. It may be possible that some dedicated influential lawyers, they also influence the point of view of judiciary on a particular important matter. Now, judicial activism versus judicial restraint, there are two words, activism and restraint, and these are opposite words. Restraint word itself represents that judiciary is setting a limit on its own action. This judicial restraint word has been used by our former CJI also, for example, Mr. R.M. Lodha. In his farewell party, he was saying that judiciary should use judicial restraint moreover and judicial activism rarely. Now, what is this? In judicial activism, judiciary loosely interpret constitution. Loosely, it means judiciary actually increases increases its power by interpreting constitution. But when it comes to judicial restraint, it is a strict interpretation. It means judges should follow the precedent. So when judges follow the precedent, it is judicial restraint. When they set aside precedent for the larger good, that is judicial activism. Now, assumptions of judicial restraint. So now we are going to talk about assumptions which are used in USA. Okay. So in case of USA, and this is very much applicable everywhere, that they say that judiciary should actually use judicial restraint, not judicial activism, because judiciary is not an elected body, right? In democracy, faith of the people is in parliament, legislature, and thereby executive, right? So undemocratic, non-elective, non-responsive to the people. That is why they should not encroach upon, into the powers of legislative and executive. Origin is also, discussed that it is questionable, not specifically granted by the Constitution. The way it is acting means activism is not granted by the Constitution. It is due to the loose interpretation of judiciary that judiciary has given itself this power. Doctrine of separation of power is being compromised due to this. Concept of federalism. Take example of USA. When it comes to federal and state, they have different laws. It may be possible that federal law is totally different on that particular topic and state law is different. And you know that concept of federalism is quite strong in case of USA in comparison to India. So dividing the powers between the nation and the states require the court deference, means court should also uphold this. Means court should not actually intervene into the state government and its officials. Non-ideological but pragmatic assumption that since court is dependent on the Congress we are talking about US, House of Representatives, because court is dependent on Congress for its resources, right? So in this manner, that court should actually limit its power because they are also dependent on House of Representatives, on public acceptance for its effectiveness, not to overstep its boundaries, right? So this particular point is based on this fact that law is based on reason, and reason represents reason of people, faith of people. When people accept you, then only you can be effective. So judiciary should not surpass that boundary. Then being a court of law, custodian Anglo-American legal tradition, law being a process of reason and judgment. So it represents that legal precedents are also having social context, and judiciary should also take into consideration this. It is not like if some courts in the world are using the judicial activism in this manner, so you also do this interpretation in context of your country. Now, it was of USA, assumptions which USA has with regard to this. Now, what our Supreme Court has observed. Now just see, Supreme Court has said that judicial restraint should be used. Judicial restraint and ask courts to take over the functions of legislature, or should not take over the function of legislation and executive. Should not encroach into this. So it is with concern to the bench that they should uphold this particular principle. Because if they encroach into legislature and executive, then it actually gives an image that the system is not balanced. And if judiciary is getting strong and legislature or executive are getting weak, this is not good for country. Some people may say what we want is good. If judiciary is doing that, then what is the harm? There's a harm. Because if a law is there which is made by legislature and you're not happy with that, you can change that particular party in the next election, right? You can give them a message, but same cannot happen with regard to court, right? And if you don't follow the decision of court, then it actually is a question on legitimacy of court. That is why balance is necessary. Trying to perform executive and legislative functions is clearly unconstitutional. Constitution has not said that you perform legislative and executive function. And on this point, you can also remember, consider the example of coal scam. In coal scam case, Supreme Court actually, in coal scam as well as in this telecom scam, this 2G spectrum scam, court by its judgment said we are actually cancelling these licenses. So cancellation of license could have been an executive action by the respective ministry, but court did that. Now, a point on this is that court is not well versed with the market dynamics. Court is not well versed with the ground reality because court is not having department working on ground, but executive has. So executive has more experience, practical experience. That is why if court perform such actions, it may be having some ramifications in that actual market or on the ground. That is why it is unconstitutional to work in this manner. Judicial activism must not become judicial adventurism. It should not be like an adventurism. Restraint should be there, and minimization of judge preferences. I mean, there should be some standards which need to be upholded by every judge. It should not be an adventurism. Judges must know their limits and must not try to run the government, because running government is not your job. They must have modesty and humility. They should not work as an emperor. Now, judicial restraint is actually complementary to the balance of power concept. There should be balance of power. Judicial restraint not only recognizes the equality of other two branches, means legislative and executive. These are the positive points of judicial restraint. It also fosters that equality by minimizing inter-branch interference in the judiciary. Because if you interfere in legislative executive, then it may be possible in future they will intervene. So it is also a threat. It may also turn into a threat to this independence of judiciary concept. So judicial restraint tend to actually protect independence of the judiciary. So if they set their limits, then other will also set their limit. This is how practically system is acted. Now let's attempt this question. In recent time, judicial activism comes in news frequently. Judicial activism can be said in action in which of the following cases? Legislature, executive wings of the government fail to discharge their duties under Constitution, Supreme Court intervenes. It is correct. This is the basic definition. High Court intervenes through appeal against the judgment of lower court. No. Here, judiciary is taking appeal from the lower court. This is not correct. A court monitors the development in a case during the period and issues necessary direction. It is also correct. So it means answer is 1 and 3. It means C is correct. Hello and welcome everyone. I hope this message finds you fit and fine. We are in video number 43 of our Laxmikanth series contest, and today we need to talk about judicial review. As the word suggests, judicial review means power of judiciary to review actions of legislature and executive. As you know, our political system is having three pillars. Legislature is there to make law, executive is there to implement law, and judiciary is there to adjudicate the conflicts, right, to resolve the conflict by pronouncing judgment. So this concept of judicial review is giving power, some additional power to judiciary to keep a check over legislature and executive, that they should perform their duties as per Indian Constitution. Although this is the concept, but UPSC is going to play on the depth, on some intricacies, some details. So we are going to cover those details as well. So this concept was originated in USA, specifically in this case, Marbury versus Madison case. Mr. John Marshall was Chief Justice of American Supreme Court, who actually contributed in evolution of this concept. So by now, you are clear about the basic idea of this judicial review. Our Supreme Court says that judicial review is part of basic structure of Indian Constitution. What does it mean? It means that our Parliament cannot take away this power from judiciary by even amending our Constitution. So a protection layer is actually given to this concept. Such is the importance of this concept. Okay, and in what case actually, in which case this particular concept was given the status of basic structure? Indira Gandhi versus Rajnarayan case. Okay, so judicial review gives power to judiciary, right? Now, even though we have in India principle of separation of power, principle of separation of power evolved from ideas of Mr. Montesquieu, who said that too much power concentrated in one pillar will turn this pillar as tyrant. That is why these three crucial functions should be separated in three pillars. So he was talking about separation of power among these three pillars, right? But don't you think this concept of judicial review gives power to judiciary to intervene in the functioning of other pillars, right? And that is why some sections, some legal luminaries have said sometimes the judicial review actually becomes judicial overlapping. Okay, we are going to talk about it further. So as of now, you should know that even though we have in India the principle of separation of power of the three arms of the state, namely executive, legislative, judiciary, clear to you, judiciary is vested with the power to review over actions of other two arms. This is what I have explained to you. Now, consider a law has been made and this law is taking away some of your fundamental rights. This law is against some of the basic principles of Indian Constitution. Now, the point is how judiciary is going to act. If all the laws which are made through our Parliament are submitted before Supreme Court so that they can be reviewed and then they will be implemented, is this the practice? No. Now, how judiciary came to know that this particular concept is against fundamental right or is against some of the features of Indian Constitution? How does it work actually? So for that we should know suo motu cases. Suo motu means on its own. It may be possible that government has released this particular act, and this act has been covered in media and as well as this gazette notification, which is like the official newspaper of government. And some of our judges in Supreme Court or High Court, they have read some of the provisions which are published in gazette, and they came to know, oh, these provisions are against this particular part of Indian Constitution. These provisions are going to take away these fundamental rights of people. So in this case, Supreme Court can act suo motu as well. Suo motu means on its own. Even if none of you go to Supreme Court against this particular law, Supreme Court will act for your protection. That is called suo motu cognizance. Okay. And second is PIL, public interest litigation. It may be possible that some of you consider yourself good Samaritan. You consider that, oh, we are preparing for UPSC and we understand what are the implications of a particular law are going to be. So you have read and you found that this is against Constitution. So you can actually file a PIL in Supreme Court or any high court, wherever you are, right? In this case, now court can actually take up this case, okay? And it may be possible the particular law is abridging fundamental rights of a tribal community, okay? And you are not from tribal community. So court is not going to say, if you are not from tribal community, your fundamental rights are not being abridged, why you have come here? Court cannot say that. Why? Because this condition has been relaxed, that discontinuation of the principle of loco standi means it is not necessary that you should be the person who is being implicated or you are the true sufferer, okay? Anyone can file this public interest litigation. The word itself says public interest. You file this litigation for public interest, okay? So then judiciary can actually do the review work. Now, Justice Syed Shah Muhammad Qadri has classified the judicial review into three categories. What are? Number one, judicial review to actually keep a check over constitutional amendment. For example, a constitutional amendment is against fundamental right, is against any provision of constitution, then it can be, that judicial review can be used, okay? Second, judicial review can be used against some legislative action of parliament or state legislature. Means they have not amended constitution. It is plainly a law which is made by parliament or any state legislature, but if it is against the spirit of constitution, then also judicial review can be used. And third is executive action. It means if some administrative action, for example, you are a district magistrate and your action is against the spirit of constitution, your circular is against the spirit of constitution, then it can also be taken up under judicial review and your action can be reviewed, and if it is found against constitutional spirit, then it, or constitutional provision, then it can be declared null and void. Okay, so you need to remember three ways, okay? Constitutional amendment, legislative and executive. Clear? Now, Supreme Court has used this power in number of cases. For example, Golaknath case, bank nationalization case, Privy evaluation case, Kesanand Bharti case, the minimum mill case. Do you remember about NJC discussion which we were having in the Supreme Court lecture? I told you that Supreme Court declared NJAC as null and void, which was supposed to replace this collegium system. So how Supreme Court did that? Supreme Court did that by using this power of judicial review, right? Supreme Court said it is against the independence of judiciary, and independence of judiciary is basic structure of Indian Constitution. Now, importance. What is the importance of judicial review? So you can remember these points. Number one, it actually upholds the supremacy of Constitution. This country should be run as per Constitution. And who is going to ensure that? Judiciary can ensure that, but judiciary needs some tool, some power, some weapon. And that weapon is judicial review. Then to actually keep a check if executive is turning into a tyrant, right? To actually balance the federalism. What does it mean? It means, you know that our constitution has certain features which give some more power to center, right? For integrity, for ensuring integrity of India, right? But state might say, sir, this is against federalism. Center is abusing its power and taking away our power. So in this case, who can actually come into picture for balancing this by balancing this federalism? So this can be done by judiciary. Okay. UPSC even asked this question last year in prelims regarding federalism, and one of the statement was related to this, right? So you should remember, means independence of judiciary is also important for ensuring federalism in India. This should be a statement in your mind. Now, it is essential to keep a check on legislature, as we discussed, for securing independence of judiciary, right? For example, this case NJC, and for actually protecting your rights. For example, Article 32, Article 226. Our High Court and Supreme Court can actually issue writs for protection of your rights, right? And they can also review any law which is taking away your fundamental rights. So these are the, you can say, importance of judicial review. Clear? Now, constitution provisions for judicial review. Now we are going to go article wise, and some of these articles we have already discussed, but still I want to go with you article wise. Article 13. Remember fundamental right discussion. So Article 13 says that any law that is inconsistent with or derogation of fundamental rights, means any law which has been made which take away any of your fundamental rights, means provisions mentioned in part 3, then it will be declared null and void. So our constitution framers have not mentioned the word judicial review, but they have clearly given this scape, this you can say space to judiciary to act in this regard. Okay. Article 32, regarding fundamental rights, Supreme Court issue writs. Article 131, original jurisdiction, we discussed it, right? Just told you, na, center state, right? In the previous session, we discussed interstate. So interstate, center state, any kind of dispute can be taken up at the level of Supreme Court as per original jurisdiction. 132, appellate jurisdiction, means a matter which you have not satisfied with, which has been already been pronounced, say at level of High Court, you can take up this matter at level of Supreme Court. 133, provide appellate jurisdiction to Supreme Court. 134, appellate jurisdiction in case of criminal. So it means civil and criminal. So 132, 133, 134, they're talking about appellate jurisdiction. Okay. You may be thinking, sir, how they're related to judicial review? These we have discussed in our Supreme Court chapter as well. So my friends, we are discussing judiciary, right? And the way judiciary can act. For example, a case has been lost in Supreme Court through appellate jurisdiction. Okay. Within that case, a matter has been raised in which judiciary need to review a particular law. So judiciary can review that particular law, but how that case actually came to judiciary? Through appeal. First, that case was, for example, a case was related to a law made by state. So first that case was discussed at level of High Court, then it came to Supreme Court, right? So these are the ways by which judiciary can actually do the review. Article 134A, certificate of appeal. I hope you remember, in High Court, if judgment has been pronounced and you are not satisfied, you can go to Supreme Court. For that, High Court is going to issue you a certificate. If you are not given the certificate, High Court is saying, no, you don't waste the time of Supreme Court. Then also you can go to Supreme Court, but for that, what you need to file a special leave petition, SLP, right? We discussed it. 135, empower the Supreme Court to exercise jurisdiction power in pre-constitutional law. I gave you example of Mullaperiyar Dam. I hope you remember, Travancore state, Madras state, right? So they were having this treaty. Now Kerala and Tamil Nadu government are actually coordinating this Mullaperiyar Dam on the basis of a treaty which was signed before constitution, right? And in that case, if there was, say, any issue, then federal court was there. Government of India Act 1935. So our constitution is saying that later the function of federal court will be taken up by Supreme Court. 136, authorize Supreme Court to grant special leave petition. Now please remember, consider you were charged in a criminal case, okay, and you were given life imprisonment. Now you want to file a case in Supreme Court, appeal, but High Court is saying no, you should not go, okay. But now you can go to Supreme Court using SLP, special leave petition. But now Supreme Court Secretariat is going to actually keep a check over the affidavits you have submitted, and it is their prerogative whether to accept your case or not. But please remember, SLP is not available to military tribunals and court martial. For example, you were serving in Indian Army, you were a major, and you were charged on some indiscipline which you have created. Now, the judgment which has been pronounced by court martial, if you're not satisfied, so you can go to AFT, Armed Forces Tribunal. You can actually move further. But if High Court, you can go to High Court later. But if High Court has pronounced the judgment and High Court said, no, I'm not going to issue certificate to you to go to Supreme Court, then you cannot go to Supreme Court. because FLP way, special leave petition way, is not available in case of court martial. Please remember that, since it is an exception case, that is why I'm saying there can be a question on this point. Okay, I hope it is clear to you now. Article 143 authorizes president to seek opinion. I hope you remember advice jurisdiction. And in advice jurisdiction, I gave you 2 points, right? There were 2 ways, right, on which a president actually seek advice of Supreme Court. And I also told you in which case it is binding on Supreme Court to give the advice, right? Article 226, we are talking about High Court to issue writs, and I told you about that High Court's power to issue writs is elaborate than Supreme Court, right? Because High Court can issue writs for protection of fundamental right as well as legal right. Article 227 vests High Court the power of superintendence. I told you about that High Court is having supervisory jurisdiction, means supervisory power over these district courts. I told you about this logic in the start of Supreme Court chapter. So we are revising here. 245 deals with territorial extent of the laws, means if a law has been made by state legislature, till what extent this law will be applicable. 246 deals with matter of laws made by parliament, by legislature state, for example, union list, concurrent list, and state list. Article 251 to 254 provide conflict between, in case of conflict between central or state law, in case of concurrent list, whose law is going to prevail? Central law is going to prevail. We discussed it. Article 372 deals with continuation, for example, pre-constitutional treaty, Mulla-Periyar Ring Treaty. So it is continuing, right? Pre-constitutional law is continuing. There are many pre-constitutional laws. For example, our whole IPC, CRPC. So for example, Indian Penal Code. So it's a pre-constitutional law. But don't you think it is continuing? It is the basis of giving punishment, right? So this is continuing as per Article 372. Now, scope of judicial review. There are 3 grounds. Number 1, FR. Means in which way this judicial review can be used. So if FR, fundamental rights, are taken away, in that case judicial review. It is if it is outside the competence of the authority which has made the law. For example, consider a law has been made and that is not taking away any of your fundamental rights, and that is also not against constitution. Can judicial review be used here? Can there be a scope there? Yes. Because the authority which should be responsible has not actually made the law. For example, you know that a state can make law on matters mentioned in state list and concurrent list. If state legislature has made a law on a matter which is mentioned in union list, now tell me, don't you think it can be struck down by using judicial review? Yes. Why? Because it is also against constitution, right? So this is the second scope. I hope it is clear to you by this example. Repugnant to the constitutional provision, if any law is against any constitutional provision, then it can be considered as a scope of judicial review. Okay, I hope it is clear to you now. Now, judicial review and 9th schedule. So there's an interesting twist in our constitution which happened during the time of our first Prime Minister, Mr. Jawaharlal Nehru. So what he did, so he wanted to make these land reforms. For example, prohibition of zamindari, land ceiling laws, etc. But at that point of time, right to property was fundamental right. So there was this fear, if law has been made, that's a good law, right, for ensuring socio-economic justice. But the point is, many people who are going to lose their land, they're going to file case in Supreme Court and High Court saying our fundamental right is abridged. And Supreme Court, High Court may say that since it is against fundamental rights, we are declaring your law, the law which is made by Parliament, as null and void. To protect the sanctity of this law, they wanted some tools, so they wanted some change in our constitution. So they made this Article 31B. So what 31B is saying? That any law which is added in 9th schedule. So in our original constitution, there were 8 schedules. So 9th schedule was added. Schedule means a list which is added at the end of constitution. So in the end of the constitution, there is a list which was added. And this Article 31B is saying any law which is added by a government in this 9th schedule of Indian Constitution, then it will be considered to be, you can say, beyond judicial review. So if means Article 13, judicial review power won't be applicable on any law which is mentioned in Schedule 9. Right? So I hope you understood what it was, why it was made. Right? So originally 1951, 9th schedule contained 13 acts, and now it is more than 280. Of these acts and regulations, the state, so purpose is land reforms, abolition of zamindari system. You know, zamindari system, there's a farmer, there's a middleman. Zamindar was responsible to collect the taxes and pay to Britishers. So it is under this taxation policy of Britishers. Now, in a significant judgment, IR Coelho case, Supreme Court said this is not going to continue. Means, if you are saying any law which is added in 9th schedule is beyond judicial review, then this particular precedent can be misused. Fundamental rights of people can be taken away. As of now, you have given the logic that we are doing this for good of poor, farmers. Understood. But a legal precedent can be misused by any government in future. So judicial review cannot be restricted by this mere adding of 9th schedule. And that is why this IR Coelho's case said that judicial review will be applicable even in the case of 9th schedule. Okay. The court held that judicial review is a basic structure, basic feature for Indian Constitution. It cannot be taken away. And it also said the laws which were added after 24th April 1973, they can be challenged, even if they are mentioned in 9th schedule. The laws which were added before, means before this date, 24th April 1973, they will remain there. There is no need of challenge in that case. So Kesan and Bharti case was the reason of this date, because Kesan and Bharti case said basic structure doctrine is going to be applicable. Now these are some examples of amendments. So you know to cram these or date, just attempt the questions here. Which one of the following statements regarding the exercise of judicial review is not correct? You have to tell not correct. A case must be brought before the Supreme Court regarding the validity of a law. Do you think it is true or false? It is true, right? But you have to identify not correct. Unanimous opinion of all the judges is necessary for declaring a law null and void. This is false. Because I told in the Supreme Court chapter that decision by Supreme Court bench is taken on the basis of majority. If there's a 5-judge bench, if 3 are saying we are in favor of this, then that is going to happen. Legislative enactments, executive orders may be struck down by Supreme Court. It is correct, although we got the answer. The power is implicit in the provision of Article 3. Implicit. Please remember, if UPSC make another statement and says explicit, then that statement would be wrong, because the word judicial review is not mentioned in Article 13. Now the next question, which one of the following is correct? The power of judicial review means the power of Supreme Court to set aside any, now please read the statements in detail, because some statements would be close to correct, right? But we have to identify the correct one. The set aside any executive decision if it is against statutory law. Tell me, do you think judicial review is there to keep a check on subsequent laws, whether they are in consonance with the law which is made by legislature? No. In judicial review, our focus is on constitutionality, not any law, right? Set aside any provision of law if it is contrary to fundamental rights. It is correct. But it is saying set aside any provision of law. Now tell me, judicial review is used just to set aside a provision in law, or it can actually struck down the whole law. It can struck down the whole law. Now on this point, I hope you remember, also talked about the doctrine of severability, doctrine of eclipse, when we were talking about fundamental rights. And I told you that sometimes UPSC makes statements in which 2 statements seem to be correct. But we have to identify which is more correct, right? Which is actually exactly correcting to the statement which is mentioned in question. Examine constitutional validity of any administrative action as well as legislative provision. Strike it down if not found in accordance with the constitutional provision. Now read this question statement. The power of judicial review means the power of Supreme Court. Remember, many students are going to commit this mistake. The second statement also seems to be true, because this can happen. If there is a law and this law is having, say, 10 provisions, and 2 provisions are against fundamental rights. So we talked about this doctrine of stability, doctrine of eclipse when we were talking about fundamental rights. So it means can set aside any provision of law, right? But in this question statement, the word is review means. The power of judicial review means. So do you think it means just that, or it means third statement? It means third statement. This is the actual meaning. And since this is the actual meaning, that is why the statement is correct. This is the answer. Okay. So by this, what I want to convey, in prelims exam, sometimes 2 statements may be correct. But we need to identify which is correct answer. So answer to judicial review means is this. Okay. Review its own decisions or decisions of any court tribunal. This is incorrect. Okay. This is not judicial review, right? To review its own decision. I hope it is clear. Now, judicial review in the Indian Constitution is based on procedure established by law. Why? Because it is saying in the Indian Constitution. So our Indian Constitution mentions procedure established by law, although at least later stage our judiciary adopted this doctrine of due process of law from US Constitution. So we adopted that, right? But mention when we talk about procedure established by law. The jurisdiction of Supreme Court of India may be enlarged by Parliament by law. I mentioned this when I was talking about Supreme Court. Hello and welcome everyone. I hope this message finds you fit and fine. We are in video number 42 in this Laxmikanth series, and today we are starting Supreme Court, one of the most important topic for prelims as well as mains. Let's start with the background of Supreme Court. Supreme Court is highest judicial court. We have a hierarchy in our judicial system: subordinate court at district level, then high court state level, then Supreme Court at union level. It is final court of appeal. If I say that president is the final court of appeal in India, and you read a news that this person has filed an appeal before president against a judgment which was given by Supreme Court, would you say that statement is true, that president is highest court of appeal? No, because president is not having court there. Okay. It's not like there will be an advocate who is going to have some, discussion on behalf of you before president. Just file is going to be submitted before president. So president is not highest court of appeal. It is Supreme Court. Okay. It is highest constitutional court. What is the meaning of constitutional court? A court which is having power to interpret Indian Constitution. And why we are saying highest? Do we have other courts having this power to interpret our Constitution? Yes, we do. High courts. So High Court and Supreme Court, they both have power to interpret our Constitution, but highest is Supreme Court. If High Court has interpreted something and Supreme Court has interpreted another thing, after that, then whom we are going to support or going to obey? Supreme Court's interpretation, obviously, right? So India has single and unified judicial system, and there are 3-tier structure, as I told you: subordinate, High Court and Supreme Court. Now let's start with the history, background of this word Supreme Court. So there was Regulating Act 1773. We discussed about this in historical background of Indian Constitution chapter, right? Within this law, for the first time, Supreme Court was established. Means that the provision was there, and then Supreme Court was established in Calcutta. But please remember that Supreme Court was different from the Supreme Court we are having now. Okay? Because this was court of record with full power and function, but that function was not actually applicable to whole India, right? It was established to determine any suits actions for Bengal, Bihar and Odisha. Later, other Supreme Courts were also started. Yes, Supreme Court in Madras, Supreme Court in Bombay. So as of now, you know that there is one Supreme Court in Delhi, right? But there were other Supreme Courts which were established. 1800, Madras and 1823 Bombay. You need not to cram the facts, but you should know about the journey of this idea of Supreme Court in India. Then there was India High Courts Act. You should remember this particular fact because UPSC can frame a statement. A statement can be like this: Indian High Courts Act 1861 abolished Supreme Court at Calcutta, Madras and Bombay. Because I told you, separate Supreme Courts were established. 1773 as per that law in Calcutta, then 1800 Madras, then 1823 Bombay, right? So that was regulating Act 1773, but it was actually established a year later, okay? Now the point is, as per this act, these Supreme Courts were actually revoked, okay? They were removed. And there was a time when these high courts were actually having this distinction of being the highest court, okay? But in Government of India Act 1935, from this particular law, we established federal court. Okay, now this federal court, you can actually now familiarize with the concept of Supreme Court, which we are having now. It means now this federal court is going to be above these high courts. Okay, so please remember this particular fact. There can be a statement on this in your exam. Now, since one or two questions are asked like facts of, so we are having this question. When was the Supreme Court of India first inaugurated? It was in January 1950. Okay, so it's not like you need to cram all the dates. Okay, now constitutional provisions. Where is Supreme Court situated in our constitution? It is in part 5 chapter 6, the union judiciary. Okay, part 5 is union, and within that chapter 6 is union judiciary. Article 124 to article 147, we talk about Supreme Court. There we talk about its organization, jurisdiction, power, etc. Now, Indian Constitution under Article 124 subclause 1 says that there shall be a Supreme Court of India constituting of a Chief Justice of India, and until Parliament by law make some changes, there will be 7 other judges. Okay, not more than 7 other judges. But since it is saying Parliament by law can actually increase the strength of judges, that is why our Parliament has increased the number of judges. The jurisdiction of Supreme Court of India can be broadly categorized into original jurisdiction, appellate jurisdiction and writ jurisdiction. They are quite simple. We are going to understand them logically. Organization of Supreme Court. So as I told you, we have a hierarchy, right? We have subordinate court, district level. So if there is a metropolitan area, there also we are going to have 2 branches, civil and criminal. In district, we have 2 branches, civil and criminal. Criminal matters are dealt here. We also call it Sessions Court. Then we have High Court, and then we have Supreme Court. Now, I'm making a statement. You have to tell me the statement is true or false. I've not explained you this, okay? I'm just asking you so that you can become, a bit more curious. Supreme Court has supervisory, or you can say supervisory powers over district courts or subordinate courts. That statement is true or false? Come on. I've not explained you this. I just want you to attempt, because there's a rule in psychology. When you are going to attempt wrong and I'm going to say this is correct answer, then this is going to be retained in your mind. So attempt. What do you think? Supervisory role, supervisory power. Supreme Court over district court. Some of you might think, sir, Supreme Court is the topmost court, and you just told us unified judiciary. So it means Supreme Court must be supervising district courts. That statement seems true, right? But reality is that statement is false, because district or session courts, these subordinate courts, they come under supervisory jurisdiction of High Court. Means High Court supervise their transfer, postings, right? So this is called supervisory work. Okay, it is not under Supreme Court. And why? Because everything is having logic in Indian polity. Why? Don't you think it is like adding burden to the Supreme Court's work if you give the supervisory work to Supreme Court, so many districts in India? Do you think it is logical? No. Now let's talk about strength. So as per Supreme Court number of judges bill, that it turned into act as well. Now the maximum strength can be 34. Okay. The Parliament is authorized to regulate them. Regulate what? Strength I'm talking about. Now let's talk about appointment of judges in Supreme Court. So judges are appointed by President, please remember. Okay, but the real twist is how? Because there's a debate there also. First we need to understand how it happens, then we are going to understand what is the debate there. Okay, so CJI is appointed by President after consultation with such other judges, judges of Supreme Court and High Court as he deems fit. Who deems fit? President deems fit. Okay, and is it really President using discretion? No. Council of Ministers headed by Prime Minister. So it means when it comes to CJI, President is going to appoint what this provision is saying, but President is going to take into consideration the consultation from Supreme Court judges, High Court judges. Okay, but how it actually happens, we are going to talk about it. I'm just talking about what provision is saying. The other judges are appointed by the President after consultation with CJI. Okay, and such other judges of Supreme Court, High Court as he deems fit. So it means in case of CJI, we are talking about consultation. In case of other judges, we are talking about consultation with CJI. Now, please remember that in general, there is a convention by which CJI is appointed. Convention is seniority. The senior most judge in Supreme Court is appointed as CJI by Honorable President. Although there is no law in this regard. That is why this convention has been broken in past as well. We are going to talk about it. But you need to be aware of these nitty-gritties. What is written in Constitution, what is not written in Constitution, what is convention, what is not. Okay. So appointment of Chief Justice from 1950 to 1973, the practice has been appoint the senior most judge of Supreme Court as the Chief Justice. So this was the practice till 1973. Then came the change. In 1973, Mr. A.N. Ray was appointed as CJI, superseding these three senior judges. Who did that? So Indira Gandhi ji was having government. As I told you, President has to act on aid and advice of Council of Ministers, and this happened. Okay. Again in 1977, M.U. Beg was appointed the Chief Justice of India by superseding then senior most judge. Now this discretion of government, don't you think it is like influencing the judiciary? Don't you think it is against the principle of independence of judiciary? Some judges may try to actually give some judgment in favor of government in order to get this plum plastering. So this should not happen, right? So how this evolved? The discretion of government was curtailed by Supreme Court in second judge's case. So now Supreme Court actually pronounced judgment so that this concept of independence of judiciary can be actually protected, in which Supreme Court ruled that senior most judge of Supreme Court alone, please remember, alone, can be appointed to the office of CJI. So now it's not just a convention. Now senior most judge of Supreme Court is going to be appointed as CJI because Supreme Court made this judgment in second judge's case 1993. I think it is clear. Now, who among the following was the first woman judge of India? This is a factual question. Ms. Fatima Bibi, you should know about it. Which of the following statement is not true about India's Supreme Court? Not true, you have to tell. Okay. Article 124 to 147, Part 5 of Indian Constitution informs the composition and power of Supreme Court. Supreme Court was inaugurated on January 28, 1950. The first female CJI was from Karnataka. The statement is false. The reason is, till now, we did not had any female judge as CJI. Okay, but soon we are going to have in 2027. Okay, you have to mention the name in comment. Okay, this was in news. Judges of Supreme Court are appointed by President of India. So these three statements are correct. This is wrong, and you have to tell not true. Okay. Controversy or consultation. So first we talked about provision. Now controversy and how the system evolved. Now we are using the word collegium system. So this word collegium, what does it mean? It means who is going to be appointed as judge. Obviously, is going to be decided by President. But someone has to give the name before President. Who is going to give that name? So now judiciary is going to give that name, obviously, because provision says consultation. So now this consultation is more organized now in the form of this collegiate system. Supreme Court has given different interpretation of the word consultation. Now, as I told you, President should consult senior most judges of Supreme Court, High Court as he deems necessary, deems fit, right? So now this consultation, is it mandatory or it just advisory? So our constitution has not elaborated on that. So now what Supreme Court said? In first judge's case 1982, Supreme Court said actually this consultation is not mandatory. It means the court held that consultation does not mean concurrence and it only implies exchange of views. What does it mean? It means government, means Council of Ministers got more power than Supreme Court. Why I am saying that? Because Council of Ministers can advise President that we need not to listen to the consultation or advice given by this collegium or these group of judges. Okay, because consultation does not mean mandatory or concurrence, right? But later, in the second judge's case, 1993, the same judge's case which talked about this appointment of CJI based on seniority. Now, what it said about this consultation interpretation? The court reversed the earlier ruling and said, change the meaning of the word consultation to concurrence. Concurrence means no, President cannot appoint someone on his own. Means consultation, you have to concur with the consultation. So what does it mean? It means now Supreme Court, I am using the word Supreme Court so that you can relate to the word judge, okay, collegium, okay. Although in this collegium there can be High Court judges as well, okay. So now means power, or you can say ball came in the court of judges, right? In the third judge's case 1998, the court opined that consultation process to be adopted by Chief Justice of India requires consultation of plurality. Now, what does it mean? As I told you, in the second judge's case, one thing was clear, that the recommendation or consultation of this judges, it is mandatory. You have to concur with that. You cannot actually randomly pick and choose anyone as judge who is not actually given this recommendation by these group of judges, okay, whom we are calling collegium. But now the point was, in this collegium there is CJI and the other judges. So what if CJI is recommending one thing and other judges were actually not agreeing with that? Whom we are going to consider consultation as concurrence? CJI's authority or CJI's recommendation will be superior than others. So on this third judge's case said that no, CJI requires consultation with plurality. And what is the meaning of plurality? It means CJI should consult other judges as well. And if other judges, for example, more than two judges are saying no, we are not agreeing with the name, then CJI cannot recommend that person's name to the President that please appoint that person as Supreme Court or High Court judge. The sole opinion of CJI does not constitute consultation process. This is third judge's case. He should consult a collegium of 4 senior. Now, after this third judge's case, the word collegium, its structure became more clearer. He should consult collegium of 4 senior most judges of Supreme Court, and even if 2 judges give adverse opinion, as I told you, if 2 judges are saying no, we should not actually recommend this person Supreme Court judge, then CJI should not send recommendation. And even if CJI send recommendation, then government, or you can say Council of Ministers advising President, they can actually say no, we are not going to concur with this, because consultation equal to concurrence is only when CJI consult with the other judges as well, right? And in this consultation, more than 2 should not actually disagree. So that is why recommendation made by Chief Justice of India without complying with the norm, this is the norm, required consultation process are not binding on government. That won't be binding. Clear? Now lawmakers and contestation. Now there has been this debate that collegium system is opaque. Many times, see some senior most judges of Supreme Court and High Court, their son and daughter, they also are recommended by collegium, whereas there are many other first generation judges as well, but they don't get due chance. These are kind of allegations. So it means this opaqueness should be removed. On this, NJAC was actually introduced by Parliament. So they amended the constitution and they brought this NJAC, National Judicial Appointment Commission. And in this NJAC, I think it is visible to you, In this composition, they also added Union Law Minister. So it was CJI, 2 senior most Supreme Court judges, Union Law Minister, and 2 eminent persons. So now, judiciary said, no, you are adding 2 eminent persons, you are adding Union Law Minister. It is like executive is having say in deciding who is going to be judge in Supreme Court. So judiciary said this is against the principle of independence of judiciary, and that is why this NJAC was declared null and void. So this idea of bringing transparency in this appointment of Supreme Court judges, this was declared null and void. So now we don't have any NJAC system in India. But since it was a part of debate, that's why I've brought up here. This PDF will be shared in my Telegram group, Shashank Tyagi for you. You can pick up from there. If you have any doubt whatsoever, you can shoot me a message on shashank.powerbeing. That is my Insta handle. A person to be appointed as judge of Supreme Court, what qualifications that person should have? That person should be citizen of India, number 1. Apart from this, this is a mandatory. Now, from these 3, so there should be at least one condition which should be met. That person should be judge of High Court or High Court for 5 years. Okay, you should be judge of High Court for 5 years. If you're not judge of High Court for 5 years, you should have actually followed the second condition. He should have been an advocate of High Court or High Court in succession for 10 years. Okay, advocate in High Court for 10 years. Even if you are not fulfilling this condition, then you have third option. He should be a distinguished jurist in the opinion of President. President should declare, oh, this person is a legal luminary. That person is a legal researcher and that person has contributed in our law making process or interpretation of law in India. So on this basis, you can also be considered for this position of judge, right, in Supreme Court. Now the Constitution has not prescribed minimum age. Please remember, Constitution has not prescribed any minimum age for the judge of Supreme Court. Okay. But these conditions are such, they themselves actually make sure that only a person who has achieved this much feat is going to be there. So it is going to take some time. Now oath and affirmation. So it is given by President. Tenure of judges. So there's no time limit. There's no 5-year, 6-year tenure to the Supreme Court judges. What happens? They can be in this position for the maximum time of 65 years. If you are appointed at 62, it means you have 3 years remaining. If you are appointed at 60, then you have 5 years remaining. He can resign office by writing to the President. So President gives the oath and you can write resignation to the President. He can be removed from your office by President on the recommendation of Parliament. So there is a process there. How removal happens? UPSC has asked question in prelims. So this is the stage. Number 1. So if you want to start this removal process of Supreme Court, High Court judge, you should actually have at least support of 100 members in case of Lok Sabha, 50 members in case of Rajya Sabha. Consider you have a letter on which 100 members have supported. Now you need to present this letter before Lok Sabha Speaker. If you are in Rajya Sabha, you need to take a sign of 50 members saying, no sir, we have some proof against this particular judge. We want this removal of judge. So this matter need to be referred to chairman of Rajya Sabha. After that, if Speaker, Chairman accepted, please remember the word is if, means there's a possibility. You have the sign of 100 members and you have presented before Speaker Lok Sabha, sir, we want removal of this Supreme Court judge. It may be possible that Speaker says, no, I'm not agreeing, I'm not accepting your recommendation to actually start this removal process. So that is why if word is used. Please remember, UPSC play these kind of tricks. Then if they accept, a Speaker or Chairman, whichever house you are taking up in, then 3-member committee will be constituted who is going to investigate the charges. Committee investigate the charges and they are going to see whether that person is guilty of incapacity or misbehavior. And if they found, now the process of impeachment is going to start. Although some book says that impeachment word should be used for the removal process of President only, there are other books which also use this impeachment word for the removal of Supreme Court, High Court judges. So point is, after this committee has investigated, found the charges valid, then this process is going to start. Then motion must be passed by special majority in the first house. Then this particular motion will be presented to the other house, and other house also it need to be passed by special majority. Okay, and when it is passed by both houses, then motion is presented before President. As President signs on this, then it is considered that this judge is removed. As of now, in our history of independent India, no judge has been removed by this process. Okay, no impeachment happened. Now, we have a question relating to this particular subtopic. Just attempt. Consider the following statements. You have to answer which statements are correct. The Judges Inquiry Act 1968 regulates the procedure relating to impeachment of judge. The President can issue the removal order only after an address by Parliament has been presented to him in the same session for the removal. Same session. It means, consider this process started in, say, winter session. Okay. And it was passed from Lok Sabha, but somehow when it was presented to Raj Sabha, it could not be taken up, and then session actually ended. Now, can Raj Sabha take up the same motion in the next session and get it passed and then get it presented to President, and President sign, and that person will be considered removed, the judge will be considered removed? Or you need to get it passed in the same session. If it is a monsoon session, get it passed from the both houses in the same session. If it is not passed from the same session, then you have to start it again. Okay. So this is the meaning of the second statement. Now, the address must be supported by absolute majority of each house. As I told you, it is a spatial majority. It's not absolute majority. The statement is wrong. So far, 2 judges have been failed to impeach, and 1 impeached in Supreme Court of India. This statement is wrong. I've just told you no one has been impeached till now. So it means 1 and 2 statements are correct. It means A is the answer. Clear? So this is the explanation. This will be available in your PDF. Acting Chief Justice. What is the meaning of this? Consider, Chief Justice of India has vacated office. It may be resignation, death, or removal. Then you need acting Chief Justice. Who is going to appoint acting Chief Justice? Who is going to appoint? President. Please remember, President. Chief Justice of India is temporarily absent. For example, Chief Justice of India is on, say, on medical treatment, that he's in coma or something. So in this case also we need acting Chief Justice, right? President is going to appoint. Chief Justice of India is unable to perform duties. It may be possible. So in this case also, President has to appoint acting Chief Justice. Then we have ad hoc. Ad hoc means temporary. Consider, we need a bench. Bench means in Supreme Court, decision on a particular judgment is not taken by one judge. There's a bench of 3, 5, etc. So there's a shortage of judges at that point of time, and one bench is having just 2 judges, and we need 1 more. So temporary arrangement can be done. When this lack of quorum, we call it quorum, means minimum strength which is required. For example, 3. Then, and because there is shortage of permanent judges. So in this case, Chief Justice of India can appoint a judge of a high court as ad hoc judge in Supreme Court for a temporary period. Ad hoc means temporary. But for this, you need to actually consult with the Chief Justice of that high court, because you are giving additional work to a judge of high court, right? So you need to take permission, consult with that Chief Justice of that high court. Consult word needs to be used, and you need to take permission. You need to keep into, you can say, loop President of India. So after consultation with the Chief Justice and concern with the President. So Chief Justice of that high court and President should be kept in loop. Then only CJI can appoint a high court judge as ad hoc judge in Supreme Court. I think this trajectory is clear to you. Judge so appointed should be qualified for the appointment of Supreme Court judge. For example, that if a high court judge, if a person got a position of high court judge six months back, can that person be appointed as ad hoc judge? No. At least you should be qualified for becoming Supreme Court judge. For example, in the appointment criteria, what I told you, in case of high court judge, you need to be high court judge for at least 5 years, right? So a question can be actually played at this point. Judge so appointed attend the sittings of the Supreme Court in priority to the other duties of his office. While so attending, enjoys all the jurisdiction, power, privileges during discharging his duty as Supreme Court judge. Now retired judges, can they be actually taken into job again for temporary period? Yes, there's a scope. CJI can request a retiring judge of Supreme Court or retired judge that we have a shortage of judges and we need your work, your contribution. So at this point, that person can also be given some position. He can do so only with the previous consent of the President and also with the person to be appointed. So President should be kept in loop. Now procedure of court. So what does it mean? means how actually court work, what kind of judgments or what kind of powers it is having. For example, Supreme Court wants some new rules. So can Supreme Court make its own rules? Yes, Supreme Court can make own rules or own procedures, but in this case, approval needs to be taken from President. Okay. Constitutional cases or references to the President under Article 143, we are going to talk about it. The purpose is that there are certain procedures. For example, all the cases are usually decided by bench consisting of not less than 3 judges. Okay. When there is a case of advisory jurisdiction, President has referred a matter, that need to be taken up by 5 judges. As I told you, 3, 5, right? So odd numbers are the numbers of judges on a bench on Supreme Court. Why not even? Why not 4, 6? Because there will be a tie, right? If there's odd, so majority, actually the support of the majority is going to decide the judgment of Supreme Court from that bench, and that is why odd numbers are taken in the Supreme Court benches, not the even ones. Now, Constitution has made following provisions to safeguard and assure independence of judiciary. So what are the points? For example, mode of appointment. In mode of appointment, judiciary has a say, concurrence, consultation, security of tenure. You cannot remove Supreme Court judges arbitrarily. There is a process, we just talked about it. Fixed service conditions, Parliament cannot change them when that person is already a judge. Expenses charged on Consulate Fund of India. It means you cannot vote again and again every year how much you need to give to the Supreme Court judges as salary or pension. You cannot do that. Conduct of judges cannot be discussed. Okay, charge on Consulate Fund of India, I told you about in Parliament chapter as well. It means this much amount need to be given, and this will be given. Okay, you need not to vote it during the budget, right? Conduct of judges cannot be discussed in Parliament until unless there's a removal motion which is in place. Okay, so that you can uphold the dignity of this court. Ban on practice after retirement. You cannot practice as an advocate after retirement, so that there's a transparency there. Power to punish for its contempt. If someone does not obey, or you can say attempt to, you can say demonize, or you can say, spread such news which hampers the dignity of the court, then such contempt can be leveled. I hope you remember there was a case of Mr. Prashant Bhushan, advocate in Supreme Court. There was a contempt court which was going on. Freedom to appoint its staff, its jurisdiction cannot be curtailed, and separation from executive. So these are the, you can say, provisions which make sure that Supreme Court can work in independent manner. Now, these are the important sections within Supreme Court. Original jurisdiction, advisory jurisdiction. Supreme Court is a court of record. It means decisions binding on other courts, as a court of record, as well as highest court of appeal, as well as writ jurisdiction. So these are the jurisdictions of Supreme Court. We are going to talk about them in a step-by-step manner. Okay. First of all, original jurisdiction. It simply means the matter can be taken up at the level of Supreme Court directly. For example, if there is a matter between center and state, center versus state, if they are having dispute, they can take up directly towards Supreme Court. If there is a dispute center plus state versus some other state, original jurisdiction. Third case, state versus state, original jurisdiction. Means these disputes can be taken up directly to the Supreme Court. That is why they are called original jurisdiction. But there is another word, exclusive original jurisdiction. What does it mean? It means matters which can be taken up only at the level of Supreme Court, only. So let's attempt this question, then we are going to expand it further. Consider the following statements. Matters referred to Finance Commission, interstate water disputes, dispute arising on any of treaty agreement, certain expenses, dispute arising of any pre-constitutional treaty agreement. Which of these does not come under original jurisdiction of Supreme Court? What does it mean? It means matters which cannot be taken up directly at the level of Supreme Court. I hope you remember our discussion in center-state relations. I talked about, for example, interstate water disputes. What our constitution says, there will be a tribunal, right? And the decision taken by tribunal will be final, right? This need not to be taken up at the level of Supreme Court. You cannot take up this matter directly to the Supreme Court because there's a tribunal. So our constitution says that, right? So now I hope you are relating. It means this matter is not going to come under original jurisdiction. So there's a list. Original jurisdiction of Supreme Court does not extend to the following cases. I hope this is visible to you. Let me zoom in a bit. For example, if there's a dispute related to some interpretation on pre-constitution treaty. What is pre-constitution treaty? A treaty which was signed during Britishers' time. Yes, they are applicable even now. So if there's a dispute, okay, for example, there's a dispute on a pre-constitutional treaty between Kerala and Tamil Nadu regarding Mullaperiyar Dam. So that is pre-constitutional treaty example. Agreement, covenant, sanad and other instruments. So they are not coming under original jurisdiction. It is not they are going to be directly taken up at the level of Supreme Court. Any dispute arising out of any treaty, etc., specified specifically if that treaty is providing that this matter will be taken up by this jurisdiction, said jurisdiction. It may be tribunal, right? Interstate water disputes can be taken up tribunal, right? Matters referred to Finance Commission. Adjustment of certain expenses pension between center and states. Ordinary dispute between of commercial nature between center state. Recovery of damages of a state against center. When I say they are not coming under original jurisdiction, it means they cannot be taken up directly at the level of Supreme Court. When I say exclusive original jurisdiction, it means this matter need to be taken up directly at the level of Supreme Court. Okay. Now, let me give you one other example so that this becomes much more clearer to you. Take example of writ. Writ issued by Supreme Court related to protection of fundamental right. Okay. Tell me, if a statement is being asked by UPSC that writs for protection of fundamental right, they come under exclusive original jurisdiction of Supreme Court. That statement would be true or false? That statement would be false. You know why? Exclusive nahi. That is original, means can be taken up directly at the level of Supreme Court, but not exclusive. Why? Because this writ can be taken up by using Article 226 at the level of High Court as well. By using Article 32, it can be taken up at the level of Supreme Court. So it means it will be considered under writ jurisdiction as well as original jurisdiction of Supreme Court. Can be taken up directly at the level of Supreme Court, but not exclusive original jurisdiction. Okay, because why not exclusive? Because it can be taken up at the level of High Court as well. I think it is clear now. So writ jurisdiction. Supreme Court is empowered to issue writs including habeas corpus, quo warranto, certiorari. We discussed about them. In this regard, Supreme Court has original jurisdiction, as I told you, explained already. Can go directly to the Supreme Court. However, writ jurisdiction of the Supreme Court is not exclusive, already explained. High Court are also empowered to the issue such writs. That is what I have explained this to you, right? If I say writ jurisdiction of High Court is much more elaborate than writ jurisdiction of Supreme Court, that statement would be true or false? Come on. Statement would be true. You know why? Because High Court's writ jurisdiction, High Court can issue writ for fundamental rights as well as legal rights. But in case of Supreme Court, as per Article 32, Supreme Court is empowered to issue writ for protection of your fundamental rights only. Okay? Now attempt this question. Which of the following statement is not true? You have to identify not true. Supreme Courts can issue writs that relate with only fundamental rights of citizens. High Courts can issue writs on issues that relate with fundamental rights as well as other reasons. The jurisdiction with regard to writs is wider for the High Court as compared to Supreme Court of India. Writ jurisdiction of Supreme Court can be extended by Parliament but never decreased. All statements are correct. Parliament cannot decrease, but Parliament can increase writ jurisdiction, right, of Supreme Court. Clear? Appellate jurisdiction. The word comes from the word appeal. If you're not satisfied with the judgment of High Court, you can go to the Supreme Court, right? So appellate in which cases? In constitutional matters, means it is related to interpretation of Constitution by High Court. For example, in case of this IPC section 377, I'm talking about homosexuality. So that matter was appealed from Delhi High Court to Supreme Court because that was an appeal in constitutional nature, because some people said it is against Article 21, right? Means right to life and personal liberty. Matter related to civil matter, appeal related to criminal matter, appeal related to special leave. What is special leave? Can anyone tell me? In comments. So special leave means, for example, High Court. So if High Court has pronounced a judgment and you're not satisfied with the decision of High Court, you can actually appeal to Supreme Court, right? But there's a process there. If you want to appeal to Supreme Court, you want to use this appellate jurisdiction of Supreme Court, you need a certificate from High Court. If High Court thinks that your case is not worthy to be sent to Supreme Court, and High Court is not issuing you the certificate on the basis of which you can appeal in Supreme Court, then what you consider means doors are shut in Supreme Court for you? No. So in this case, you can use the special leave, as the word says special leave. In this case, you will present an affidavit before Supreme Court saying, sir, I have not got permission from High Court, I have not got the certificate, but I want my case to be actually heard at your level. So in this case, the Supreme Court Secretariat is going to decide whether to accept your special leave petition or not, whether to accept your case or not. Means discretion is with Supreme Court whether to accept or not. But if certificate is issued, then Supreme Court has to accept. Supreme Court has to at least listen once. Okay. So I think it is clear now. Advisory jurisdiction. As the name suggests, advisory. So as per Article 143, President can seek advice from Supreme Court on two matters. One, if there is a matter of urgent public importance arising which is likely to arise, or any dispute arising of pre-constitutional treaty, agreement, covenant, engagement, etc. In this case, there is also a twist. Twist is, in case of advisory jurisdiction, Supreme Court is bound to give advice to the Honorable President in the second case, but not bound to give advice to Honorable President in the first case. You would say, oh, such thing can happen. Yeah, this happens. And there's a logic behind it. Consider the case of Babri Masjid. So before the final judgment by Supreme Court, this was a matter, urgent, important matter, right? There was a huge debate going on. In this case, if President use Article 143 and seek advice from Supreme Court, what's your opinion? What should happen in this case? Then Supreme Court can say, sir, though it's a matter of public importance, but we are not going to give you advice because matter is already under sub judice. And if we give you our advice and it becomes public, it means the judgment is already done. Why wasting arguments there, right? We cannot put the matter out till we actually listen to all the arguments. That is why we are unable to give you such advice. But in second case, you are bound to give advice. Now my question to you, as per advisory jurisdiction, the advice given by Supreme Court to the Honorable President is binding on Honorable President. It is true or false? Answer is false. It is not binding. It is just an advice. So advice given is not binding on President. Clear? Court of record. It simply means the decisions which you take are going to set legal precedents and legal references by the other courts. Okay, means other courts, means high courts and other courts are going to refer your judgment, and on this basis they are going to pronounce their judgment. High Court and Supreme Court both are court of records in India. Okay, it has power to punish for contempt of court as well. Power to judicial review. Our Supreme Court can judicially review our legislative action, executive action. They are going to see whether it is in consonance with the provisions of Indian Constitution or not. If not, then this can be declared ultra vires or null and void. Hello and welcome everyone. I hope this message finds you fit and fine. We are in video number 41 in this Laxmikanth series contest, and today we need to talk about parliamentary forums. Generally, students take this topic lightly, saying there are some bol bachans with no real application in Indian polity. But the fact is, UPSC has asked questions in prelims from this area. We just need to give attention to certain nitty-gritties. That's it. Parliamentary forums, why they were created? Purpose was to sensitize our parliamentarians about some crucial issues. so that they can engage better within the parliament, as well as they can work better when they are in their constituencies. First Parliamentary Forum was created in 2005 with the name Parliamentary Forum Water Conservation and Management. This fact also need to be remembered, okay, because sometimes UPSC is asking one or two questions on these facts. There are 8 parliamentary forums listed in front of you on water and conservation, youth, children, population, public health, global warming, climate change, disaster management, arts and craft people, development goal. My advice is, when you are reading this chapter from Laxmikanth, don't just grasp what is written there. Try to link what other schemes which government has made, what other initiatives government is having in these areas, so that you can revise simultaneously. Okay. Objective is first to provide a platform to our members so that they can be sensitized, means they can have meaningful discussion, right, on speedy implementation of the processes which are already being made, so that they can be sensitized. For example, we are talking about Parliamentary Forum on Water Conservation. Everyone knows that water conservation is important for India, but do every parliamentarian is aware about the ground realities which exist in India? No, right? We cannot make policies sitting in AC rooms. We need to have idea what is happening on ground. You may be having nice idea, but when it comes to execution, there may be certain gaps. When you have parliamentary forums and you invite specialists from these areas, you will be able to know what are the gaps, so that you can tweak your discussions in parliament accordingly, and right policies, right laws can be made. For this, data need to be collected. Data is collected from ministries, think tanks, within India, outside India, UN agencies, right? Another thing is, parliamentary forums cannot encroach into the functioning of departmental standing committees. I told you in parliamentary committee chapter importance of departmental committees, right? During the budget making process, these respective departmental committees are important, right? So consider you have a parliamentary forum on a specific topic, a specific issue, and we also have a departmental committee for this. You cannot say that now the work of departmental committee can be done by parliamentary forum. No, right? Composition. One question can be asked from here. That is why I would require your attention here. The Speaker of Lok Sabha is the ex officio president of all forums except is important, except the Parliamentary Forum on Population and Public Health. And who is the president of Parliamentary Forum of Population and Public Health? It is Chairman of Raj Sabha. In this particular forum, Lok Sabha Speaker acts as co-president. Please give attention, I am not saying vice president, I am saying co-president, because vice president is a different position. Deputy Chairman of Raj Sabha, Deputy Speaker of Lok Sabha, the concerned ministers, the Chairman of Departmental Related Standing Committee are ex officio vice presidents in respective forums. Each forum consists of not more than 31 members, but please remember, excluding 3 positions: president, co-president, vice president. The duration is coterminous. Till the point you are a member of the house, you will remain part of this forum until and unless you give resignation to the chairman, or you can say president. If Lok Sabha Speaker is there, then you can give resignation to Lok Sabha Speaker. Now let's talk about functions step by step. First, function of Parliamentary Forum on Water Conservation and Management. Identifying the problem, making suggestion to government and organization. Please remember, we are not just discussing things, we are not just sensitizing parliamentarians. In Parliamentary Forum, we are also making suggestion to government and organizations to organize seminars, workshops, so that people can be sensitized to identify the ways of involving MPs in conservation. For example, you are a member of parliament from an area which is having, shortage or even scarcity of water, and you found that some people have invented, they have made some innovations on ground and they're working fine, but they need government support in this regard. You can bring up this issue in parliamentary forum so that other members of parliament can be sensitized. You may be provided with technical know-how by taking help from respective agencies which Parliamentary Forum is going to arrange, so that your effective when you are working in your state constituency can be enhanced to undertake such other related tasks which may be fit for this particular purpose. Then we have Parliamentary Forum for Youth. Youth represents potential, right? So this Parliamentary Forum is going to connect with youth leaders, invite them in parliamentary forums, understand their issues, keep a check what government is doing and what needs to be done. So this is for youth empowerment, encouraging activities for youth. At this point, you should question yourself. Do you know certain initiatives which our government is running specifically for youth empowerment? Parliamentary Forum on Children. Here you can see Mr. Kailash Satyarthi, Nobel laureate, founder of Bachpan Bachao Andolan. As I told you, experts are also invited. Now, can you just remember what government initiatives are there which are targeted for upliftment of children? Can you name few? As I told you, read this chapter by interlinking with what other initiatives government is having. Can you actually mention certain law with respect to children which was in news recently? There's a bill in Parliament, JJ Act Amendment Bill. So Juvenile Justice Act is in news. So what schemes do you remember? Come on. So since you are actually listening to this video, I will ask you, have a pen and paper and list down the government schemes you know, right? You can pause the video and check from your notes, right? Now, enhance awareness and attention of parliamentarians on critical issues affecting children. You know that children are not voters, and that is why we need specific attention on children. Conducting workshops, seminar, orientation programs. Now, can you tell me the status of NCPCR, National Commission for Protection of Child Rights? Is it a statutory body, executive body, or constitutional body? Come on. Can you tell me what is CWC, Child Welfare Committee? How is it different from JJB, Juvenile Justice Board? What is this concept of foster care which is in discussion in JJ Bill, which is there in JJ Act, but it is not in implementation in India? It's not written here, obviously. So I'm just giving you an opportunity to reflect. Whenever this topic is going to be asked, whether in question or in essay, you should have some ammunition in your mind, right? Interact with UN agencies like UNICEF, what they are doing, how we can be benefited from the initiative. Then undertake any other tasks which they seem important for this particular area. Then population and public health. Who is the president of this particular forum? Come on, in comments. I've just told you in the composition part. Is it speaker or Rajya Sabha chairman? I told you, Rajya Sabha chairman. Strategies to stabilization of population. Now, at this point you should connect. What points do you know when it comes to population stabilization? Do you know certain terms like TFR? What is the total fertility rate in India as of now? Do you know which state is on the higher side, which state is on the lower side? Can you name some government schemes for population stabilization? In UPSC, you should not prepare topics in silos like, oh, I'm reading Parliamentary Forum and I'm done, job done. No. When you have to use these topics, you need to have interlinkage, right? Web-based learning you should have. Better awareness of all sections on this particular topic, population stabilization, sensitize them. Means parliamentarians should know what is happening and what can be done. Other issues concerning public health, they also take help from multilateral agencies like WHO, United Nations Population Fund, academicians and government agencies. Global warming and climate change, similar, identifying the problems, then coordinating with international bodies and spread awareness. 3 points, that's it. Parliamentary Forum on Disaster Management. At this point, can you tell me what is Sendai framework, SENDAI framework? UPSC use these kind of words and in a match the following kind of questions. What is Sendai framework? What are the salient features? Come on. And when you listen to this word, read this word disaster management, can you recall what initiatives, what agencies government have for disaster management? You have a dedicated topic, disaster management, right? What are the various facets of disaster management? Is disaster management only include when disaster is there and now the government responds to that disaster? Should we call that disaster management, or disaster management also include some activities which we do so that we can increase our resilience when such circumstances occur? Connect like this. Identify the problems related to other management and making suggestions, what we have and what need to be done. Interact with specialists in this area, spread awareness. Parliamentary Forum on Artisans and Craftsmen. Now, can you tell me what is TRIFED? TRIFED. How successful is TRIFED? What government schemes you can recall which are for these craftsmen? Can you recall some government schemes? Come on. So what Parliamentary Forum is doing here is spreading awareness, attention of parliamentarians on these critical issues. Provide platform so that exchange of ideas can happen, views, experience, expertise, best practices. Some students take this craftsman part, art part lightly. Oh, these are, we can take up these issues, but these are not that important. But that's a mistake if you're thinking so. Because these issues need to be dealt because, so many people are dependent on it. And many of these craftsmen are actually saving our heritage, certain art forms which are on the verge of extinction. So since you have to become part of bureaucracy, you need to be sensitized on these issues, importance of these issues. If you become district magistrate and you're not sensitized to the importance of supporting these people, then you may be creating loss to our society. That's why UPSC is saying connect with art and culture also. Parliamentary Forum on Millennium Development Goal. Now we have SDG. Purpose is that we should know what are our targets in SDG, what government agencies are doing, what need to be done. If we need to change certain laws, so parliamentarians need to be sensitized. So awareness need to be there, targets need to be enhanced, means targets need to be clear. And if means there should be step by step watch where we are heading. Some of you might be thinking, is it really happening? The goal is this, and some things happen, some may not. But structures are important to actually make things happen, right? Now, attend this question. Come on. Consider the following statement. Parliamentary Forum on Population and Public Health is first parliamentary forum. Statement is true or not? You have to tell correct. Is it correct or not? Come on. It is incorrect. I just told you. The first parliamentary forum was on water conservation, right? I hope you remember in 2005, told you. This is also wrong. I told you 2005. So answer is neither 1 and 2. Water conservation and management 2005, right? Now, Parliamentary Forum will not interfere with the jurisdiction of department related standing committee of the ministry concerned. Second statement is the chairman of department related standing committee are the ex officio vice chairman, vice presidents of the respective forums. Both statements are individually true. Second statement is correct explanation of statement 1. Both statements are individually true, but statement 2 is not the correct explanation of statement 1. Do you think this statement is explanation of this statement? No, right? These are two different statements, right? So answer would be B. Who was the speaker of the Lok Sabha when first parliamentary forum was constituted? Although this question is going to be rarely asked, I mean these kind of questions are not asked, but keeping with the trend, UPSC is asking 1-2 questions which are actually off the beat and factual kind of. So that's why you should know that it was Somnath Chatterjee. Hello and welcome everyone. I hope this message finds you fit and fine. Learning is one thing and consolidation is another, and you need both. Today in our Parliament chapter, we are going to consolidate our learning which we have gathered till now in this heading, multi-functional role of Parliament. So what kind of role Parliament has? All of us know legislative aspect is a prominent one, means to make law. Apart from legislative power, Parliament also has executive power, financial power, constituent power. It means powers related to amendment to Indian Constitution. Then judicial power, electoral power, and other powers. Means we are going to talk about privileges there. Okay. Let's start with the legislative power, law-making power. UPSC will make a statement. Don't look at it. Just listen to my statement and tell me statement is true or false. The statement is Parliament has exclusive power to make law on a matter mentioned in, on a subject mentioned in Union list as well as residuary power. Means statement is using the word exclusive power of Parliament with respect to Union list as well as residuary matters. Tell me the statement is true or false. Come on, in comments. Answer is true. Because residuary power means matter which are not mentioned in Union list, state list, concurrent list. I hope you remember I told you 7th schedule of Indian Constitution divide subjects on which law need to be made into 3 parts: union, state, concurrent. And those things which are not mentioned in any of them, we call them residuary power, residuary subjects. In case of residuary subjects, this power is with center, means union, means Parliament. Clear? Now, with regard to concurrent list, who is going to prevail? Means concurrent is the third list. It means on this Parliament as well as state legislature can make law. But if both are making law, whose law will prevail? Union's law will prevail. Okay? This is the standard, you can say, legislative framework. But I must tell you the update. Supreme Court says, in such a condition when these two laws are in conflict, because these were mentioned in concurrent list, we need not to continue this conflict and we need not to always say that union law is going to prevail. Ultimately, what is the objective? Objective is betterment of the people. So, Supreme Court nowadays is using this doctrine of harmonious construction. Harmonious. What does it mean? Harmony. Right? So, there should be harmony when these two laws are in conflict, means center and state law on matter in concurrent list. Harmony should be there. Now, how can we have harmony? So, Supreme Court construct this harmony. And how Supreme Court can construct this harmony? By actually specifically discussing those provisions in these laws which are in conflict. Then after the discussion, interpreting them in such a way so that this conflict can be resolved. So, this is a harmonious construction. So, Supreme Court is saying we should not align with this idea that always union law should prevail over state law in a matter of concurrent list. But the standard practice is that. Okay, Supreme Court intervention can actually do this harmonious construction. I hope it is clear to you now. Now, apart from this, also remember, this is an important section. Means Parliament can also make law on a matter mentioned in state list. Yes. So it is like Parliament can make law in union list. Parliament can make a law on a matter in concurrent list. Parliament is having exclusive power to make law in residuary list. But state list was remaining. Parliament can make law on a subject matter which is mentioned in state list. So when can Parliament do that? So UPSC is going to give you 3-4 statements and ask you which of the following statements are correct. Okay. Please remember, when Raj Sabha passes a resolution in this regard, this law is of national importance. And that is why Raj Sabha is saying that I am allowing that Parliament should make law. Means now Lok Sabha and Raj Sabha should come together and make a law on a matter mentioned in state list. So this can happen. Second, proclamation of national emergency. National emergency is in place. In this case also happen. More than, means 2 or more states, they come to Parliament. They say, sir, please make law on this matter. Now Parliament is saying this matter is mentioned in state list. Why you are coming to me? Then these states are saying, sir, we think you are more expert in this. So please make law on this matter, though this matter is mentioned in state list. Now Parliament says, okay, check, we are going to make this law. So Parliament can make this law. Okay, but please remember, there's a special case here. The law made in the C condition is going to be applicable just on these states who made this joint request, not all states. Okay, whoever made the request, sir, this matter in state list, please make the law. Then this law is going to be applicable only on these states. Clear? Now, when necessary to give effort to international agreements, for example, in case of Bangladesh, we entered into a national agreement, consider water. It may be a state subject, but for this international agreement, Parliament can make law. I'm using the word can make law when it seems necessary, although political ramifications are also taken into consideration while making such law. But you should know, as per Constitution, this clause D is there. For international agreements, treaties, convention, it can happen, right? So state list is not immune, okay? When president rule is in place, then also parliament can make law on a matter in state list. Clear? So these cases should be, in your mind. There can be a question. Apart from this, we are still discussing legislative powers of parliament. With respect to ordinance, what is ordinance? I told you, Article 1, 2, 3, right? There's a bill, and this Union Council of Ministers, they want this bill to be turned into an act. But as of now, recess is going on. Recess means session is not working, right? So it's like session is not there and you have to turn this bill into a law. So what Union Council of Ministers do? They brought this bill before Honorable President, sir, please declare it as an ordinance and you have to act on the aid and advice of us, Article 74. So now President would say, okay, I'm signing this and now this is an ordinance. You have issued this as an ordinance. Ordinance is like temporary law. But you cannot bypass Parliament because it is legislative power of Parliament. It needs to be approved by Parliament within 6 weeks after its reassembly. Recess was going on, but when Parliament is going to reassemble, then within 6 weeks you have to get this ordinance, this bill passed by Parliament. Ordinance becomes inoperative if it is not approved by Parliament, right? This is another legislative power of Parliament. Now, this word is quite used nowadays, delegated legislation. First, understand what is delegated legislation. In case of delegated legislation, what Parliament do, they make a broad skeleton of law. A skeleton, just consider this. So you have these 8 blocks, 8 clauses. So consider this is a bill, okay? And in this bill, broad sections are mentioned, and within this section, this is not elaborated much, okay? So this bill is floated in Lok Sabha, Raj Sabha and got passed, right? But what Parliament is doing, what Union government is doing in coordination with Parliament, they want the detailed work, means detailed filling within these sections of this law to be done by bureaucrats, by the executives, means by the departments. So actually in this case, what you found, the real work of filling these clauses, filling this law, elaborating this law is delegated to executive branch, bureaucracy. So this is called delegated legislation. Although when this bill is filled by the executive, then this bill needs to be presented before Parliament as well for approval. Okay, but there's a criticism of this particular provision saying nowadays bureaucrats are becoming too much powerful even in lawmaking process. The Parliament makes law in a skeleton form and authorizes the executive, means bureaucrats, to make detailed rules and regulations. Detailed rules filling work would be done by bureaucrats within the framework of parent law. So parent law is broad skeleton within the framework. This is known as delegated legislation or even executive legislation or even subordinate legislation. Okay, subordinate, why subordinate word is used? You got delegated because responsibility was delegated. You got executive legislation because it is being done by executive filling work. Why subordinate? Because real duty of making law is with legislature. So now executive is doing that. That is why subordinate legislation. Such rules and regulations are placed before Parliament for examination as well. Now let's discuss executive power. First of all, you know that when it comes to Indian Parliament, we have an overlap. Means members of Indian Parliament are part of executive branch as well, right? Ministers, Prime Minister, right? So executive is responsible to Parliament for its policies and acts. Means Parliament keep a control over executive. Parliament exercise control over executive, and there are various tools, devices, which we discussed in devices part, 0 hour, question hour, half hour, right? 2.5 hour, motions, resolution. These ministers are collectively responsible to the Parliament and specifically responsible to Lok Sabha because they need to have majority support in Lok Sabha, right? As well as they are individually responsible. I told you about the censure motion which can be leveled against an individual minister, right? So it means you can ask question from a specific minister and minister has to answer you, right? So in this way, legislature is keeping a control over executive policies, what you have done in the 6 months, what you have done for this section, right? Lok Sabha can also express lack of confidence in the government in following ways. Government, executive. Please remember, I'm using the word lack of confidence. I'm not using the word no confidence. Okay. So now, lack of confidence by not passing motion of thanks. I told you, when President comes to the House for speech, there are two occasions. First session every year, first session after new Lok Sabha is convened. Thereafter, this motion of thanks, if it is not passed, then it is a mark that this government is not having majority support in Lok Sabha. Right? It shows lack of confidence. Rejecting money bill. Money bill is actually presented by a minister. Right? It is a public bill. I told you. So now, if minister is presenting a bill and she, they are not actually able to pass this bill from Lok Sabha, what does it mean? It means you are not having majority support in Lok Sabha. Otherwise, you would have passed money bill. So this is also represents lack of confidence. By passing a censure motion, adjournment motion. Censure motion, I told you, against a particular minister, that you're not happy with your conduct, you have to answer this. Breach, there's a breach of privilege. Adjournment motion, when there's a matter of urgent importance, I discussed this when I discussed adjournment prorogue, right? Defeating the government on a vital issue, there's a discussion, after discussion, there's a resolution, and now the government itself, they're not having majority support. Now, so you would be thinking, sir, if a party is having majority in Lok Sabha and they're having government, why would they be defeated? It's like their own people not supporting them. My friends, it happened especially in cases of coalition government. I remember clearly in UPA 2 government, it means when Manmohan Singh was Prime Minister, there was an instance when his government was facing huge criticism and regional parties were actually, snatching away their support. So in these cases, this may happen. Bypassing cut motion. Cut motion, it happens during the budget process. I told you, economy cut, policy cut, token cut. Cut motion is like we are not happy with the amount which you have given for this particular purpose. We are not happy with the policy you have mentioned in the budget. So it means if cut motion is passed, it means your own people are not supporting you. So it shows lack of confidence. Okay. Financial power and functions. So we have discussed legislative power, executive power, now financial power. Now tell me, is it possible for union government to spend in any manner from consolidated government or consolidated fund of India without approval of parliament? Is it possible? Is it possible you go to Modi ji and say, sir, I have this remarkable idea, and if you give me, say, 10,000 crore rupees, only 10,000 crore rupees, but within just 2 days, then I can transform, this particular area in India. Now, can Modi ji actually give you 10,000 rupees? Just sign something and give you 10,000 rupees? No. It's not in the hand of Modi, it's not in the hand of Prime Minister, because when it comes to spending from Consolidated Fund of India, you need approval from Parliament, right? And that approval in the name of budget happens, right? No tax can be levied, collected, no expenditure can be done except by the approval of Parliament, okay? And the budget is placed before the Parliament for its approval. So don't you think it is financial power of Parliament that you need to get it approved? Otherwise, you cannot spend, right? The enactment of the budget by the Parliament legalizes the receipts and expenditure. You have to present that this much we have received, this much we are going to spend, then only it will be legalized. The Parliament also scrutinizes government spending and financial performance. One thing is giving approval. Even if you are given approval and now you are spending, Parliament is going to keep a check. You got approval to spend 10,000 crore rupees in these areas. Now give us the receipt. Give us the proof. Give us the utilization certificate that this much amount is actually spent in this manner. For that, we have our way, CAG, Comptroller and Auditor General of India. So audit is done, then this report is presented to President. President presents this report to Parliament. Within Parliament, this report is presented to PAC, Public Accounts Committee. Now, Public Accounts Committee in Parliament, they keep a check on the government whether you have done the expenditure as per the approval or not. Don't you think it's a good power? It is another matter of debate that whether this power is being used in effective manner or not. Now, they bring out the case of illegal, irregular, unauthorized, improper usage, extravagance. This is done through audit, and this audit report is presented to the Parliament. I told you. The parliamentary control over the executive and financial matter operates in two stages. One is approval and second is post-budgetary control. Budgetary control controls before the appropriation grant. I'm talking about the budget process. And when you have given approval, after that, post-budgetary control means audit, control after appropriation through financial committees, for example, PAC. Okay. Now, budget is presented on the principle of annuality. What does it mean? Budget is being given approval for 1 year. Okay. You're getting permission to spend from consolidated fund for 1 year. And within that also, there will be a rule of lapse. For example, I've given you, say, 1 lakh crore rupees. And from 1 lakh crore rupees, this particular department, say health department, was given, say, 20,000 crore rupees. Now, end of financial year is near. And what we have found that this health department has just spent, say, 15,000 crore rupees. Now, 5,000 crore rupees are remaining and we are in February. So, just one month is remaining. So, rule of lapse says whatever you actually spend till 31st March is going to be considered spent. Extra money, the surplus money will be considered lapse. This money will be coming back to Consolidated Fund of India. And that is why in the March, if any one of you have some parents, siblings, friends working in government department, then they will tell you about March rush. You don't get holidays in March, in general, because there's so much, work there. You have to finalize the, payments. You have to get all the files done, because there'll be lapse. Otherwise, there'll be lapse. There'll be questions also. You were given this much money for the betterment of the public, and you have not spent that money. So, rule of lapse. I hope it is clear to you now. It facilitates effective financial control of the parliament as reserve funds, and parliament can also means government cannot also build a reserve fund on its own. Anything which you are doing with the money, you have to get it approved with the parliament. Okay. I think you must have heard this debate on PM CARES fund, right? Some people were saying, how can PM CARES fund be made as a reserve fund? You can actually read that in the respect of this provision. Some people are saying, how can this happen? So you should know that PM CARES fund is not a government fund. Okay, that is why you cannot say it facilitates effective. You cannot say it's a reserve fund of the government and you need express permission of parliament. It's a separate fund. It is not a reserve fund of government of India. Okay. Heavy rush of expenditure. I told you about March rush. So I think the financial parts are quite clear to you now, right? Clear? Now, constituent power. It means we are talking about amending power of constitution. Who can amend? Parliament. So Parliament can amend using 3 kind of majorities. One is simple majority. Example. Can you just give me example in which kind of amendment simple majority is used? Any one example in comments. Come on. Let's think, recollect. Purpose is not just to make you understand. Purpose is to make you master. And for mastering, you need to reconnect, reflect. Article 3, we talked about amending, right? We talked about changing the name, territories. For that, constitution need to be amended, but this amendment needs just simple majority. Article 3, Article 4, I told you about this in part 1 of Indian Constitution, right? Then special majority. And third case is special majority. Along with this, you need consent of at least half state legislatures. So can you just tell me, although I've explained this to you in amendment chapter, can you just tell me in which case the C kind of majority is used? Come on. Matter, for example, which are related to changing the federal structure. If you're making amendment in constitution in such a way which is going to hamper states as well, state powers as well. In this case, you need ratification from half the states as well. For example, for implementation of GST, I hope you remember 2017, that constitution amendment needed ratification from at least half states, because you were taking away the indirect tax power of states. For example, excise duty, VAT, I hope you remember now, sales tax. Now, the constituent power of the parliament, not unlimited. So parliament is having power to amend constitution, but it is not like it can amend anything anyway, right? You have to adhere to the basic structure doctrine which was given by Supreme Court in case of Nand Bharti case. I hope it is clear to you now. Judicial power. So judicial power, what does it mean? Does it mean that parliament is working as a court? No. And we are talking about matters where parliament is having some judicial function. not necessarily a full-fledged judiciary. For example, in impeachment of president, a removal of vice president. So in these cases, conditions are discussed, why we are removing, then decision is taken. So that is why we are saying judicial function. Okay. Recommend removal of judges, Supreme Court, High Court, punish its members or outsiders for breach of privilege. So there also, it works as a, it is judicial function. Those who are thinking, sir, what is this breach of privilege? We are going to talk about breach of privilege. Just hold on for a bit. Electoral powers. I hope it is clear to you. Judicial in nature, it means removal, right? Or action on in case privilege is violated, contempt of house has happened. Okay. So two words you need to remember, removal or this contempt or breach of privilege. Clear? Now, electoral powers and functions. Yeah, parliamentarians actually take part in various elections as well. For example, president, vice president, Lok Sabha members come together and elect a speaker, right? Deputy speaker. Similarly, Raj Sabha members, they actually elect deputy chairman of Raj Sabha, right? So all of them, they come under electoral powers and functions. Clear? Apart from this, Parliament is also authorized to make law to regulate these elections of president, vice president, Lok Sabha, Raj Sabha, state legislative assembly. And for this, you can consider these as an example. For example, Presidential and Vice Presidential Election Act 1952 means how we are going to have these presidential elections, because in our constitution, how president is going to be elected, what are the qualifications, these things are mentioned, but specifically how procedure is going to be followed. So this is mentioned in this act. Similarly, Representation of People Act 1950, Representation of People Act 1951, right? Other powers and functions. Other powers, for example, Parliament is the highest deliberative body of India, Indian democracy. Important national issues are discussed here, international issues are discussed here. Along with this, there are three types of emergencies which need to be approved by Parliament. For example, emergencies are national, state, financial. We discussed in the emergency chapter as well, right? So apart from this, create or abolish legislative councils. For example, Uttar Pradesh, some states who say that we have large population and we need a second house at state legislature, means we need legislative council. So in this case, on this request of state legislative assembly, Parliament may consider this request and establish legislative council. So this is also power of Parliament to establish second legislative house at the level of state, right? Increase or decrease the area, alter Article 3 बताया था आपको, we discussed this, right? To change the boundary, to carve out another state, for example, Uttarakhand carved out of Uttar Pradesh, right? Using Article 3. It can regulate the organization, jurisdiction of Supreme Court. It can also enhance the jurisdiction of Supreme Court. It can also declare that we are establishing new High Court, establish common High Court also, that this particular High Court is going to be considered as High Court of these two states, right? If new state is being carved out, there will be a new High Court for that. Such law can be made by Parliament. Ineffectiveness of parliamentary control. Now, this is a mains question. There can be a mains question. Discuss the reasons or provisions or practices which reflect that Indian Parliament is having this ineffectiveness or ineffectiveness is hovering over its functions. So this kind of language can be made. So you need to have some points, right, which shows ineffectiveness and what are the reasons. It is said that Parliament is not having time or expertise to actually understand the complexities which we are having in our administration. Our administration has increased in volumes. New challenges are coming up. New sectors are coming up. And our parliamentarians are not equipped enough to understand these sectors. For example, crypto. A lot of hoopla hula is going around crypto. A bill is there in Parliament as of now. Many people are saying no, cryptocurrency and this trading, NFT, all of these things should be allowed. They should need to be regulated. Some people are saying no, these can be threat to our economy. It can provide shock to our economy. They cannot be secure. So, do you think Bitcoin, cryptocurrency is a new concept? No, right? It's an old concept. Why I'm saying old? Because after the subprime crisis in the world, global financial crisis, GFC, which started from US, we saw this emergence of this Bitcoin. So, long time has been passed, but still we are not having a a specific policy with regard to crypto, right? A lot of committees were made. Mr. Shaktikant Das, current RBI governor, I remember when he was Secretary, Department of Economic Affairs, he was also heading one committee who was apprehensive. Then there were some people within the administration who were quite positive. Then there are people still, there are some, you can say, some signals that the government is apprehensive. So it means our parliament, new things are coming up, and parliament need to be ready for that, for these complexities. So there we can see that there's a gap. Parliament's financial control. When it comes to financial control, sometimes it is considered that our parliamentarians are not having specific knowledge of finances. They're like laymen, right? So there are some technicalities within financial administration which our parliamentarians are not equipped to discuss, to understand. So this is another challenge. They're doing crucial job, but they're not well aware of these technicalities. Legislative leadership lies with executive and plays significant role in formulating policies. Legislative leadership means in Lok Sabha, who is actually having majority? Government is having majority. So technically the executive union government is actually having majority say in Lok Sabha, right? So legislative leadership is with executive. Very size of parliament is too large, and that is why unmanageable, ineffective. Majority support is enjoyed by executive, and that is why whatever policies executive want, they actually make it happen. So the difference of opinion is not given that much advantage in our parliament. Financial committees, for example, we have Public Account Committee, examines the public expenditure. But when it is already approved, means I told you the audit is done, then this audit report is presented before the committee. Thus they do not do the post-mortem work. When job is done, now we are seeing audit report where you have done something wrong. So in case of US, their CAG, Comptroller Auditor General, that CAG position is not just involved in audit, they are also involved in appropriation. So one idea is this, although there's a counter opinion that this thing is fine, means post-mortem work by PSA is fine, otherwise it would amount to unnecessary delay in approval of these expenses by Parliament. The growth of delegated legislation has reduced the role of Parliament. Delegated legislation, I told you, executive are having more say in detailing the laws. Lack of strong and steady opposition. From quite some time we are observing this. Opposition is necessary for democracy, but opposition is weak. Apart from this, there are behavior and ethics issues with our parliamentarians. I must tell you, you are living in some of the best time of Indian Parliament, right? You're blessed with that. I've seen that time of Parliament when parliamentarians were actually throwing chairs and mics, papers on each other. Such was the stage of Indian Parliament once. Now, position of Rajya Sabha in respect to Lok Sabha. So we can categorize this into three heads. There can be a pre and mains, both kind of questions from this particular subtopic. There are areas where Rajya Sabha is equal to Lok Sabha. There are areas where Rajya Sabha is unequal to Lok Sabha. It means Lok Sabha is having more power. But there are also some areas where Rajya Sabha is having special powers which are not with Lok Sabha. And you need to know all three cases. Clear? First, equal status. With respect to ordinary bills, Lok Sabha, Rajya Sabha, this introduction and passage of ordinary bill, Lok Sabha and Rajya Sabha have equal say. Means they can be introduced in Lok Sabha as well as Rajya Sabha. Passage need to be approved in the same way, simple majority. Introduction and passage of Finance Bill Class 2. Expenditure of the Consolidate Fund. Why? I hope you remember. I told you Finance Bill Class 1 can be introduced only in Lok Sabha. But in case of Finance Bill Class 2, it can be introduced in Lok Sabha and Rajya Sabha as well. Right? Passage is also same as case of ordinary bill. So in this aspect, the Lok Sabha, Rajya Sabha are equal. Election and impeachment of the president, it can be initiated in the either house. Right? Removal of vice president, same. However, Rajya Sabha alone can initiate the removal of the vice president. So, in case of election, removal of vice president, so Rajya Sabha is not, you can say, below Lok Sabha. But as you know that vice president is ex officio chairman of Rajya Sabha, that is why the proposal can only initiate in Rajya Sabha. Right? I told you, effective majority in Rajya Sabha, then it is passed, then it is presented to Lok Sabha. Right? I hope you remember. And then in Lok Sabha, it need to be passed by simple majority. Right? Making recommendations to the president for removal of the Chief Justice. or Supreme Court judges. In that respect also Lok Sabha, Rajya Sabha are equal. Approval of ordinances. It's not like just get it approved from Lok Sabha and job will be done. No, you need to be approved by Lok Sabha, Rajya Sabha both. Approval proclamation of emergencies. I hope you remember National Emergency chapter. It need to be approved by Parliament within 30 days. I hope you remember within 1 month in case of national emergency. Right? I also told you when Lok Sabha is dissolved and national emergency has already been proclaimed, in that case, get it passed from Rajya Sabha. But when Lok Sabha is reconvened, then you need to pass from Lok Sabha. So it means both houses have say when it comes to approval of national emergency. Right? Selection of ministers, Prime Minister means Prime Minister can be a member of Rajya Sabha as well. For example, Manmohan Singh ji, he was a member of Rajya Sabha. Under the Constitution, the ministers, including Prime Minister, can be a member of any house. But please remember, whether you are a member of Rajya Sabha or Lok Sabha, if you are a minister, you are responsible to Lok Sabha only. When I say only, it means your position is secure till the point you have majority support in Lok Sabha. That is why I am using the word only. Clear? Consideration of the reports of the constitutional bodies like Finance Commission, Union, UPSC, CHE, in that respect, Lok Sabha and Sabha are equal. Prelims kind of question can also be made. This statement can be used. Please remember. Enlargement of jurisdiction of the Supreme Court, UPSC. In this case also, Lok Sabha, Rajya Sabha are equal. Now just attempt this question. I hope it is visible to you comfortably. If not, let me read it out for you. But you have to attempt. And I would highly appreciate when I say comment, you just, whenever you are watching this video, just mention comment. Okay. Now, Rajya Sabha alone can initiate the removal of Vice President by simple majority. Tell me the statement is true or false, because you have to tell correct. This is false. I've just told you. It can initiate in Rajya Sabha, but you need effective majority in Rajya Sabha, right? Resolution for removal of Vice President is to be agreed upon by the Lok Sabha by effective majority. Again, wrong. It need to be approved by Lok Sabha, but by simple majority. Just told you. So, effective majority in Rajya Sabha and simple majority in Lok Sabha. Because Vice President, ex officio chairman of Rajya Sabha. Right? So, there you need effective majority to get him removed or her removed. Rajya Sabha, Lok Sabha has equal power over the election of Vice President. Correct. Vice President is the ex officio chairman of Rajya Sabha. Correct. The electoral college to elect a person to the office of Vice President consists of only or all the elected members of the House of Parliament. Tell me the statement is true or false. Answer is false. Why? Because in case of Vice President election, nominated members can also be included. Right? That is why answer is C. 3 and 4. I hope it is clear to you now. Now, unequal status, let's talk about. Equal status is clear. The cases in which Rajya Sabha, Lok Sabha are equal, unequal status. In case of money bill can only be introduced in Lok Sabha. And also told you the cases. Then in respect of money bill, this Rajya Sabha cannot amend, cannot reject money bill. They can only recommend. And that recommendation is not mandatory in Lok Sabha. They can reject, they can accept. Right? And for the maximum how much time Rajya Sabha can stall a money bill? That is for 14 days. And if nothing has been done by Rajya Sabha for 14 days, it is deemed to have been passed and presented before President. So in this respect, Lok Sabha is considered superior. Right? So finance bill not containing solely matters of Article 110. We are talking about finance bill class 1. I hope you remember. So in this case, it can be introduced only in Lok Sabha. So in this case also, it is unequal in case of in comparison to Rajya Sabha. Now attempt this question. We discussed this in detail, right? When we were discussing bills. Consider the following statement regarding unequal status of Lok Sabha. I think it is visible to you comfortably. Right. The Speaker of Lok Sabha presides over the joint sitting of the both houses. You have to tell correct. Just tell me, this is correct or not? Yes, it is. Told you. Joint sitting presided by Speaker. The Lok Sabha with greater number wins the battle in joint sitting except when combined strength of the ruling party in the both houses is less than the opposite parties. Yes, we compare the Lok Sabha and Rajya Sabha who has numerical strength in comparison to both. So Lok Sabha is more in number, more members in number. So definitely they have advantage. But if ruling party is not having combined strength, if Lok Sabha, Rajya Sabha and opposition members are more, then obviously they cannot have this advantage. Rajya Sabha can only discuss the budget but cannot vote on the demand for grants, which is the exclusive privilege of the Lok Sabha. It is correct. A resolution for the discontinuance of the national emergency can be passed only by the Lok Sabha, not by the Raj Sabha. Yes, it is correct. We discussed this in the emergency chapter. If national emergency is imposed, so if it need to be removed, so a special session in Lok Sabha can be called upon. We discussed it, right? And if it is passed by Lok Sabha, then national emergency is gone. So it means answer is all of the above. D, correct? Special powers of Raj Sabha. Please remember, one is it authorized Parliament to make law on a subject matter on state list. So as per Article 249, this article should be remembered. It keep on, whenever there's an issue on federalism and there are some articles, this article is many times mentioned. So it will be imprinted in your mind on its own when you are going to practice also the questions. It can authorize the Parliament to create All India Service. As you know, there was debate that there should be IJS also, like IAS, IPS. There should be Indian Judicial Service. So how it can happen? Special powers with Raj Sabha. Raj Sabha can authorize the Parliament. Please remember, as per Article 312. Okay, All India Service. Except in financial matters and control over the Council of Ministers, the power and status of Raj Sabha and with respect to Lok Sabha are broadly equal. But when it comes to financial matters, when it comes to control of Council of Ministers, Lok Sabha is superior than Raj Sabha in these aspects for the practical reasons, right? So I hope this is quite clear to you now. Let's talk about parliamentary privileges. What is the meaning of privilege? Privilege means you are given some special, you can say, cover, right? And why special cover, special avenues are provided? So that you can function effectively, right? And same is the logic of parliamentary privileges. So parliamentary privileges are special rights, immunities, exemptions enjoyed by the two houses, their committees and their members. And that is why we divide privileges into two parts, collective privilege and individual privilege. Collective means these privileges, these special immunities are concerned with the house as a whole, and there are individual privileges as well. These are necessary in order to secure the independence and effectiveness in their function. If you're an MP from an area, you need to be provided with certain immunities exemptions so that you can work without fear. Without these privileges, the House can neither maintain authority, dignity, and honor. And that is why for discharging their duties, responsibilities, these parliamentary privileges become important. But you must be thinking, what are these? These are classified into two parts, collective and individual. Collective. For example, there are debates, discussion, reports which are being presented in the House. This is collective responsibility of the House, that House publishes these reports. And House can also obstruct you to publish these reports in public domain. So this is coming from Article 105. What does it mean? It means, consider, you are a reporter and there is a proceeding going on in the House and there was something which was discussed which was unbecoming. And Speaker said, no reporter should publish this report in public domain. Now, tell me, can you do that or not? So, interpretation of Article 105 says you cannot do that since presiding officer said that you cannot publish this outside. So, this was later clarified after 44th Amendment Act. 44th said, if you want to publish truth that actually happened in the Parliament and you have some proof, then you can do that. But you cannot do that if such proceeding was a secret proceeding, secret sitting of the House. You cannot publish report which was in secret sitting of the House. So consider you are a reporter and you met a member of Parliament and you were shaking hand with that member of Parliament and you slipped some microphone or some device in his some say pocket or something, and that member of Parliament was part of secret sitting. And now you took this microphone and you publish this audio or video on your channel for gaining TRP. So you may be getting a letter from Lok Sabha or Raj Sabha. Okay, because this was secret sitting. And you publishing it is against privilege of Parliament. So they will tell you this, you come to our Haveli, okay, and we'll tell you what is going to happen. There can be actions against you. They may be imposed fine, and you may be also suggested that you may be lodged into jail for some time, right? Maybe 3 months or more. It can exclude strangers from its proceedings, hold secret sittings. Okay, you must be knowing that apart from members of Parliament, you as a student can also go to Parliament and actually witness these parliamentary proceedings. Yes, you can go there. How? just go to your local MP or MLA. If you want to go to Parliament, obviously your Lok Sabha MP. If you want to go to Lok Sabha, and you present your application that I'm preparing for UPSC and I want to witness this parliamentary proceeding, please allow me to do so, and you just paste your IDs. Then your Lok Sabha MP is going to write a letter, sign it, and send it to Lok Sabha Secretariat. Then Lok Sabha Secretariat is going to issue a pass to you on a specific day, and you will be invited to be there. Okay, when you are going to enter, you have to give all your keys, mobile, pen, everything outside, and you can actually sit in the visitors lobby. Okay, so interesting, right? You can do that. But if Lok Sabha wants to exclude people from particular sitting, then they can exclude that. No outsider will be allowed in visitors gallery. This can happen. This collective privilege of Parliament. It can make rules to regulate its own procedures. Make rules to regulate means can make own rules, right? For effectively function. It has right to receive immediate information of arrest, detention, conviction. If you're a member of Parliament, okay, and you're arrested, so local police, whoever is arresting you, has to intimate the Lok Sabha Secretariat also. If you're a Raj Sabha member, Raj Sabha Secretariat also, right? It can institute inquiries and attendance of witness and send relevant paper record. If there's some proceedings are going on in the house, they can ask for inquiry and all the papers associated with that. Court are prohibited to actually proceedings of the house, to discuss the proceedings of the house. This proceedings of the house are the immune from the intervention of court. No person, either a member or outsider. Now, this is a catch. Consider you are not an MP, but you were a stranger and sitting in the Lok Sabha by the process I just told you. Now there is a civil case or criminal case against you. Can police actually come into the house and actually grab your collar and arrest you? No. You are in the house. In the house, actually nothing can happen. No arrest, nothing can happen without the permission of presiding officer. So no person, either a member or outsider, can be arrested. No legal process, civil or criminal, can be resolved within the house without the permission of presiding officer. Please remember, I am saying civil or criminal within the house. When you are in the house, when you are outside the house, anything can happen, my friend. Okay. Let's talk about individual privilege. Okay. Some people actually get confused with this provision. So it is your individual privilege that you will not be arrested when session is going on. You will not be arrested 40 days in advance. You will not be arrested 40 days after the session in civil matters, not in criminal matters, right? Or preventive detention cases. So this can be a factual provision-based prelims question. Please remember it. This protection individual privilege is available only in civil case. And those who are thinking, sir, just you told us the protection in civil and criminal. I told you that you will not be arrested, no legal process against you when within the house. Now you are outside the house, right? Clear? And why this 40 days after and during the session? Because it is considered, since you are representative of people and you should be given this time to participate in the house, and before 40 days you need to get ready with the questions or prepare for the house, and after that you need to be among the people and tell them what happened in the house, right? That is why this limit is given. There is freedom of speech in the parliament as per Article 105. So whatever you said in parliament is not going to be questioned in any court. This is your individual privilege. Exempt from jury service. So this is the old practice. Okay, jury service. So what used to happen that there will be judge in a judiciary, and there will be some people, from the society who are considered respectful. They will also listen to the argument within the case. So that was jury service. But now in India, we don't have jury service. So this provision is not applicable. Breach of privilege and contempt of the house. So you got to know the collective privilege and individual privilege. Privileges are fine. But what is going to happen if privileges are breached? When an individual or authority disregard, attack the privileges, the rights, or the immunities, either a member of the individually or collective, then breach of privilege will be considered. And house can initiate action. House can initiate action, right? They will send a letter of the fine or may actually give you some sentence as well. Any act or omission which obstruct the House of Parliament. For example, you are actually stopping a particular officer who is working in Parliament from doing his or her duty. you're obstructing a member of parliament to participate in the housing proceedings. For example, there's a vote going to happen today on an important bill, and you actually kidnapped 2-3 MPs. So it is like you are obstructing. So kidnapping charge would be separate, but breach of privilege will also happen because you're stopping the functioning of the parliament, right? If it is found that you were doing just to actually have some impact on the passage of the bill. So in this case, contempt of the house will happen. This will be considered as contempt of the house since you have obstructed the functioning of the house, and actions can be taken. Sovereignty of Indian Parliament. If I ask you, do you think Indian Parliament is sovereign? First of all, what is the meaning of sovereign? So it means you are supreme, right? So doctrine of sovereignty of Parliament is stated with British Parliament. In Britain, Parliament is supreme. Even Parliament decide what is considered as constitution, what is not considered as constitution, because they are having unwritten constitution. Some legal, documents collectively they are considered as constitution, and then such declaration is done by Parliament of Britain. So supreme power within the state. So supreme power means Great Britain lies, in this case, they have the sovereignty of Parliament. But in India, we don't have sovereignty of Parliament, right? In British case, there are no legal restrictions of the Parliament jurisdiction. But in India, we believe in constitutional supremacy, not supremacy of Parliament. So there are some legal restrictions on our Parliament. What are those legal restrictions? Number one, written nature of our constitution. That is why I said constitution is supreme. Federal system of the government. That is why our parliament cannot function on its own. Parliament cannot make any law which is mentioned in stateless unless the process which I discussed today is followed. Judicial review is also there. You make a law, but there is Supreme Court sitting there. Supreme Court say, okay, we are going to review. If it is against constitution, it will be declared null and void. Fundamental rights. You cannot abridge fundamental rights, right? So it means these are the restrictions over Indian Parliament. So these are some subject matters which are mentioned in your Laxmikanth. Why I mentioned it here? You need not to cram that. Just open your Laxmikanth book and just go through them. That's it. These articles, these subjects, you are going to see in many articles in due course of time. You are going to see in many questions which you are going to practice. So important ones are going to be absorbed in your mind in any case. Now, the question, who said parliamentary system provides a daily as well as periodic assessment of the government? Dr. B.R. Ambedkar. So it's like parliamentary system keeping a check over the government. So sometimes statement kind of questions are also asked. Which one of the following is the largest committee of Indian Parliament? This is a factual question, estimates committee. In the next lecture, we are going to discuss committees also, parliamentary committees. Don't worry. So there's 30 members there, we're going to discuss. Which of the following is not a tool of parliamentary control over public expenditures? Now some questions are going to be understood using logic. That is why I'm using it here. Even if you have not read this, you can answer this. If you understand polity by logic, not just cramming. It is saying which of the following is not a tool of parliamentary control over public expenditure. Parliamentary control. Public Accounts Committee, CAG, Estimates Committee, Committee on Public Undertakings. Now, parliamentary control, direct parliamentary control is done by committees. Okay. Sometimes in questions, options are very close. Some people would think, oh, through CAG, there's a report and this report is taken into consideration by PSC, and that's why we can say that parliamentary control of public expenditure. You are also correct. But my friend, sometimes the options are quite close. In that case, we need to check on the premises of which option is direct and which is indirect. So indirect will be considered, okay, this is wrong. So in this case, these are committees used to keep a check on public expenditure, but this is a separate body. So that is why B is the answer. It is not a tool directly in the hand of parliament. Okay. Hello and welcome everyone. I hope this message finds you fit and fine. Today we need to discuss parliamentary committees. As the name suggests, Parliament Committee. It means members within the Parliament are part of these parliamentary committees. Now, why we need these committees? Consider a situation, a bill is presented before Lok Sabha. Do you think every member in Lok Sabha would be interested enough to understand the technicalities of these bills? Answer would be no. Do you think every member in Lok Sabha, Raj Sabha would be having this intellect to understand the intricacies of these bills? Answer would be no. Along with these bills, there are various other functions within the parliament. To ease this process, we need parliamentary committees. So what 4 conditions are necessary to call a committee a parliamentary committee? These are the 4 conditions. There can be a question from there. UPSC can say ki which of the following statements are, you can say, related to parliamentary committees, right? So first of all, members within parliamentary committee can be elected by the House, or these members can be nominated by the Speaker in case of Lok Sabha and Chairman in case of Raj Sabha. It means members in parliamentary committees can be elected or can be nominated. It depends on the which parliamentary committee we are talking about, right? But if UPSC uses the word parliamentary committee, so election, nomination, both works. Okay. Now works under direction of Speaker in case of Lok Sabha, Chairman in case of Raj Sabha. Presents its report before the House. Before the House means presiding officer, Speaker, Chairman. And provided with secretariat. Secretariat means there will be dedicated staff will be provided by Lok Sabha in case of Lok Sabha specific parliamentary committee, by the Raj Sabha in case of Raj Sabha specific committee. Okay, secretarial staff is necessary for the functioning, right? Staff is needed by these members of the parliament. Now there is another word, consultative committee. So you should know that if these 4 conditions are not met, then you cannot call that committee as parliamentary committee. Okay. This is what is mentioned here. Now we can divide these parliamentary committees into 2 parts, a standing committee, ad hoc committee. A standing committee, it means permanent nature. For example, a committee is constituted. Now members will be part of this standing committee for 1 year. After that, there will be new election. But this committee will exist, right? Because these committees are among the most important category committees. But there are others, ad hoc committee. As the name suggests, temporary in nature. For example, there's a coal scam in India, and we need a specific committee to discuss, or you can say scrutinize, what happened in case of coal ministry and what were the policy failure. So this is an ad hoc committee. Once it presents its report, its job is done, it will be dissolved. Clear? So this is the broad difference between standing and ad hoc committee. When we say standing committee, as I told you, it's permanent in nature. We can divide it into 6 parts. First, finance committees we need to discuss. Let's discuss finance committees. So finance committees, there are 3 finance committees: Public Accounts Committee, Estimate Committee, and this Committee on Undertaking. Public undertakings. Public undertakings means we are talking about PSUs, BHEL, right? GAIL. You must have heard about these government companies, right? Now, as the name suggests, finance. It means these committees are there to keep a check on the finances, you can say, used by the executive, right? So let's have a comparison between these 3 committees, starting from Estimate Committee. What comes into your mind when you use the word estimate? Means estimate has something to do with the amount which is going to be used, right? So it was established in 1950 on the recommendation of Mr. John Mathai, who was then Finance Minister of India. Consists of 30 members, and it actually do the detailed examination of the budget estimates. As I told you, estimate means budget. We are talking about total amount which this government is taking permission from the parliament to spend. So in this case, estimate committee is going to scrutinize it. But there's a intricacy here which you need to understand. Many people get confused between working of estimate committee and role of departmental committees. Second point is departmental standing committee. These are different. When you go to this budget process, you will get to know when this budget is presented. After that, Lok Sabha Speaker would say, okay, now go for adjournment, say 2-3 days, 4 days. Read the draft budget copies presented presented to every member of the House. I'm talking about Lok Sabha. And then this matter is also referred to these departmental committees. Standing departmental committees, there are 24 in number. Department here represents specific ministries. For example, in budget, it says that we need 1,36,000 crore for the health department. Now, departmental committee on health will actually look into this, right? But when this debate happens, after this debate, then there is a voting process, and when vote is done, then estimate committee is also there to keep a check, to advise how you can actually improve. You can say how you can actually increase the efficiency of your spending, right? So report what economy improvements in organization, what you can improve, efficiency, administrative reforms consist with the policy underlying the estimates may be affected. Okay, so this is the role of estimate committee. I'm going to talk about the limitations of estimate committee as well after this. First, let's talk about the broad points which define these committees. Now, Public Accounts Committee, public account, established in 1921 and under the provisions of Government of India Act 1990, means it was started by Britishers. Consists of 15 members from Lok Sabha, 7 members from Raj Sabha, it means 22 members. Here there were 30 members, here there are 22 members. Since 1967, member of opposition is considered as chairman. Now, why this convention was made? You should question this in mind. My friends, the purpose of Public Account Committee is to check whether the government has spent as per the permission this government took from the house. For example, during the budget, government took permission, I'm going to spend this much amount in these heads. Done. But means you have done that expenditure. Now CAG is auditing that, and CAG found, oh, government took permission to spend this in this head, but there's discrepancy there. So now CAG may put this particular matter in his report, and this report is presented to President. President sends this report to House. In House, this report is presented before Public Accounts Committee. CAG is considered as friend, philosopher, guide of Public Account Committee. Means Public Account Committee work in close coordination with CAG. CAG's report is important for Public Account Committee, right? So in this manner, Public Account Committee can actually keep a question in the House from that ministry. What you have done? There are discrepancies in your audit report. So don't you think in this particular context, members of Public Account Committee are questioning the government, right? So if we have some member of opposition party as the chairman, don't you think it will do better job? If chairman is from ruling party, then why this ruling party chairman will actually question its own government? He need to take or she need to take care of his or her political career ahead, right? So that is why this convention was started. And you must be thinking why this was not mentioned in Constitution. My friends, there was a time when every party, means every state, and when it comes to Lok Sabha, means this was, there was complete dominance of Congress, right? So how can you find opposition party at that point of time, right? Quite troublesome job. And that is why it was made. It examines the appropriation of accounts. As I told you, appropriation means permission you took, and the finance accounts along with any other account laid before the Lok Sabha. It is assisted by CAG. I think this point is clear to you, right? Now yes, Committee on Public Undertakings. Undertakings means PSUs we are talking about. Established in 1964, date is not important, but on the recommendation of Krishna Menon Committee. Why it was made in 1964? Just understand the time period. Government was actually spending hugely in public sector undertakings, means government companies were getting established. Huge amount of money from public exchequer was getting pumped in there. So that we can keep a check that amount is spent well, right? Parliament should know that, and that is why this committee was made. So there are 15 plus 7 members, same as Public Accounts Committee, and they keep a check on these spendings or the financial part of PSUs. Okay, what profit you have made, what expenditure you have done. Now, limitations of Public Account Committee. What are the limitations? First of all, it cannot question the policy because expenditure is already done in the debt policy. You are there to post-mortem examination, right? Job is done. Recommendations are advisory in nature. The recommendations they give to the House, they are advisory in nature. Not vested with the power to disallowance of expenditure. Because expenditure is already done. How can you actually disallow government to spend, right? Not an executive body, hence cannot issue an order. Please remember, it cannot issue an order. It can only bring this matter in front of House. It can create this debate there, right? But cannot issue order. The final decision on the findings lies with the Parliament. Then we have limitations of Estimates Committee. So examines the budget estimates only after they have been voted by the Parliament. Please remember, there can be a question from here, right? because when it comes to departmental committees, when they scrutinize budget of respective ministry, they actually talk about this before this voting is done, right? Estimate committee, it takes care of the whole budget, but in practical manner, if you ask me, then the whole budget to be scrutinized in detailed manner by estimate committee in that particular time is not possible. So they also do the selective work. So they cannot question the policy. Recommendations are advisory, examines every year only certain selected ministries and departments, as I told you. Lacks expert assistance by the CAG, like this expert assistance of CAG is available to PAC but not to estimates committee, right? It works is also post-mortem, means it is done, voting is done. Limitation on public undertakings. It cannot examine more than 10 to 12 PSUs. If I ask you how many public sector undertakings, means government companies, central government has, what would be your answer? Rough guess. I hope you have heard about these words: Maharatna companies, Navaratna companies, Mini Ratna companies. Once UPSC asked this question in Prelims as well. What conditions qualify a company, government company, to be regarded as Maharatna company? So I'm asking you, so you can just search about it, but I'm asking you, rough estimate, what do you think? Some of you might be thinking, sir, Navaratna you are saying, it means 9 companies. Maharatna you are saying, so it may be 5-6 companies. And Mini Ratna, mini is like 10 to 20 companies, so it would be around, say, 30-40, right? But there are more than 300 government companies, my friends, more than 300, okay? And to keep a tab on the financial aspects there, from the parliament, we have Committee on Public Undertakings. Nature is post-mortem, does not look into technical matters. Recommendations are advisory. So one thing you got, which is common, is that public account estimate or this Committee on Public Undertakings, they're advisory in nature, right? Now, Departmental Standing Committee. They secure more accountability of the executive. That is the Council of Ministers to the Parliament, particularly financial accountability, because these committees are specific, ministry specific. So they also assist Parliament in debating the budget more effectively, because I told you during the adjustment part, these budget are referred to these respective departmental committees, right? They bring their arguments and so that quality debate can happen on budget. Each standing committee consists of 31 members, 21 from Lok Sabha and 10 from Raj Sabha. That's fact. Now, how many members are there in estimate committee? 30. How many members are there in this PAC? 22 plus 7, right? UPSC has asked question, statement on these member strength as well. Lok Sabha are nominated by the Speaker. In case of Raj Sabha, nominated by Chairman. Ministers are not eligible to be member of departmental committees. Why? Because these departmental committees are made to keep a check on the expenditure part, financial probity part of these ministries. So if minister himself, herself is part of this departmental committee, then why would that person be critical about his own ministry or her own ministry, right? The term of office of each standing committee is 1 year from the date of the constitution, from the date they are made. The functions of each of the standing committee, demand for grants, they question that. Now, departments before they are discussed and voted, as I told you, means after voting, the matter is taken up by estimate committee. Before voting, the matter are taken by respective departmental committees. Not suggesting anything to the nature, cut motion, means they cannot say that please reduce this much amount from this particular budget. Means you have allocated 10,000 crore for this scheme, please reduce this. This is not the job of departmental committee. Please understand this and remember this. This is a, you can say, fact part, but UPSC can play on that. Okay. Examine the bill of respective ministry and you can say also consider the annual report of that particular ministry. Also consider the long-term policy document presented to the House. Okay. So what you got? That these departmental committees are engaged in budget, specific bills, annual report and long-term document, right? Limitations. First of all, should not consider the matters, they are not engaged into day-to-day matter of ministry. So some people say that day-to-day administration of ministry should also be under check by the parliament. So this is not the job which is entitled to the departmental committees as of now. Should not generally consider the matters which are considered other parliamentary committees. So this is a feature. Means if you are a member of a standing committee of the department, say coals, but a particular matter, policy matter, is being discussed by other committee, so you cannot take up that. It should not be not that recommendation of these committees are advisory, other limitation. Now, merits of the standing committee system in the parliament. There can be a means based question also. Okay, provision based. So their proceedings are devoid of any party basis, biases, right? They can be neutral because there's a mixture of different parties within these departmental committees. Yes, mixture of different parties. More flexible, parliamentary control over executive, ensures economy and efficiency in public expenditure via their recommendations, and they actually, when they present their report, it also helps other members to understand these bills in a better manner, understand the functioning of the government in a better manner. So in this context, these departmental committees becomes important. Now we have committee to inquire. As the name suggests, inquire. Inquire means inquiry. Committee on petitions, committee on privileges, and ethics committee. Now committee on petitions. What is the meaning of petition? Petition means some people have certain representation which may include reservation, changes, support, unhappiness, any sort of suggestion. So these petitions are actually taken up by this committee on petitions. Petition on bills on the matter of public importance. Also entertains representations. It may be from all over the India. There may be certain groups, certain members who have certain ideas. They want particular bill to be made. So such kind of petitions can be heard by this committee on petitions. Okay, and for that we have separate committee in Lok Sabha and Rajya Sabha. Okay, in Lok Sabha committee there are 15 members. In Rajya Sabha committee there are 10 members. Then we have committee on privileges. In the previous class I told you about the privilege, collective privilege, individual privilege. I hope you remember, right? So now when these privileges are broken, who is going to take the action? This action is taken by this committee on privilege. So committee are semi-judicial, means because they are going to decide whether their privilege has been broken or not, right? So breach of privilege, they are going to examine, and they are going to actually suggest appropriate action also. In case of Lok Sabha we have 15, in case of Rajya Sabha we have 10 members in this committee. Okay, please remember we have separate committee. So here also 15 member in committee of Lok Sabha, 10 member committee of Rajya Sabha, same here. But when it comes to ethics committee, so this ethics committee was constituted in Rajya Sabha in 1997, in Lok Sabha in 2000. Enforces code of conduct. So purpose, what are the purpose? Purpose is that there should be some ground rules which should be adhered by members of parliament, right? For that this ethics committee is made. It is engaged in maintaining the discipline and decorum in the parliament. It should not be like that people are actually pulling out mic and throwing paper, right? There should be decorum. So for that decorum, we have ethics committee. Now we have committee for to scrutinize and control. Now, scrutinize and control. What does it scrutinize means? It means something has been done within the house. Now there's a committee to keep a check whether this thing is actually true, factually or not. So we have committee on government assurances. It is quite easy. From the name, it is quite clear. I'm going to discuss committee on subordinate legislation, paper laid, welfare, SC/ST, empowerment of women, and office of profit. Let's take one by one. Consider you are a minister and you presented some report, some paper before the floor, before the house, right? So it going to examine the assurances, promises, undertakings given by the minister. So if you have made the promise, so please understand the difference between the two. When it comes to committee on assurance, if you have given some assurance to the house, then this committee is going to keep a check whether the assurance you have given is actually being met or not. Okay, this is assurance. Okay, when I was using the word bill, paper, so that is taken care by other committee, that is committee on paper laid on the table. Okay, so it is quite clear from the name itself. So now in the Lok Sabha, it consists of these 15 members, Rajya Sabha, it consists of 10 members, same. Okay, just remember the name assurance, government assurance. Government has given this assurance and Parliament is going to keep a tab on it. It is quite simple, right? Now, Committee on Subordinate Legislation. What was subordinate legislation I told you in the previous class? It simply means Parliament passed a law, but that law was a broad structure. There were some sections within that particular bill and these were broad, means detail was not there. So detail was later filled by the executive branch. It means department bureaucrats themselves. And these bureaucrats then actually filled that particular bill with the detail. And this is called subordinate legislation or delegated legislation, because this legislation was not totally made by Parliament. This legislation was actually filled in detail by executive. Although that subordinate legislation need to be presented before House again, right? But the major work is done by executive here. So whether this executive is doing its job in a correct manner or not, for that we have Committee on Subordinate Legislation. I guess it is quite clear to you now. In both the houses, the committee consists of 15 members, both the houses. Okay. Now, committee paper laid on the table, paper laid. So, who is presenting paper? Ministers. So, if ministers have actually presented some paper, bill, so now we need to check whether that content of that paper, content of the bill is as per the constitution or an act or the rule of the Parliament. There are three things. Whether those papers, the content is as per the constitution, as per the act, as per the rules of the house. So this is the job of committee on paper laid on the table. Now we have committee for the welfare of SCs and STs. As the name suggests, purpose of this committee is to keep a close coordination with the report which is actually presented by National Commission for SC, National Commission for ST. Also take into consideration whether statutory protections which are given, constitutional protections which are given to this section, whether they are being implemented or not. Along with this, third function is the welfare schemes which are made for this section, are they working or not? So these things are actually done by Committee on Welfare of SCs and STs. New ideas can also be taken up for discussion by this committee. We have Committee on Empowerment of Women, same as Committee for SC and STs is actually taking up and discussing the report for National Commission for SC and ST. Similarly, here we have this committee discussing report from National Commission for Women. Okay, you have this National Commission for SC, National Commission for ST in your constitutional bodies as well. Now we have Joint Committee on Office of Profit. Office of Profit, you know, this can be a basis of disqualification. So what amounts to Office of Profit is going to be decided by this Joint Committee on Office of Profit. The committee examines the composition and character of committees and other bodies appointed by the centre, state, union territory government and recommends whether the person holding these office should be disqualified from being elected as a member of Parliament. The point is whether to know whether this amounts to Office of Profit or not. It consists of 15 members, 10 Lok Sabha and 5 Rajya Sabha. I think it is clear. Now 5 committees related to day-to-day business of the House. Day-to-day business. What are the day-to-day business of the House? To actually present the bill, to get it passed, to finalize the agenda, to prioritize which bill is going to be given the primacy, right? So we have this Business Advisory Committee, Committee on Private Member Bill, Rules Committee, Committee on Absence members. Business Advisory Committee. Business. What is the business of House? As I told you, this legislative work. So regulates the program, the timetable of the House. You know, allocates the time to the members. Lok Sabha committee consists of 15 members, including Speaker as chairman. Please remember, in Lok Sabha Business Advisory Committee, chairman will be Speaker. In Raj Sabha, it has 11 members, including chairman, ex officio chairman, right? So it means Vice President, Chairman of Raj Sabha is going to be the Chairman of Business Advisory Committee. Please remember, Speaker, Chairman, they are the head of these Business Advisory Committee of respective House. This kind of statement can be made. Now, Committee on Private Member Bills and Resolutions. Private Member Bill. It means a bill which is presented by someone who is not a minister, right? So now to classify these bills, to allocate time to these bills by the private members, chairman of this particular committee is Deputy Speaker, right? Raj Sabha does not have any such committee. Please remember, Raj Sabha does not have any such committee as Committee on Private Member Bill and Resolution. Now you must be thinking, so what happens with the private member bills of Raj Sabha? If some private member is introducing bill in Rajya Sabha, who is going to allocate time? So for this case, Business Advisory Committee of Rajya Sabha is going to take care of it. Okay, clear? There can be a question from here. Please remember, exceptions are there. Rules Committee. For any game, you need rules. So if Lok Sabha, Rajya Sabha has to play their game in effective manner, you need rules, and you need to redefine your rules. You need new rules with new challenges as well. So this committee considers the matters of procedure, conduct of the House, recommend necessary amendment to the rules of the House. Lok Sabha committee consists of 15 and Speaker as the ex officio chairman. Speaker ex officio chairman of Rules Committee. Rajya Sabha consists of 16 members and the chairman is ex officio chairman. So by now what you got, when it comes to committees which deal with day-to-day business, these are headed by respective presiding officers. Committee on absence of members. Consider you are a member of parliament and you have not present in the last 60-day proceedings of the House without any intimation to the House. Then my friend, this can be a basis of your disqualification. In Lok Sabha, your matter will be taken up by committee on absence of members. In Rajya Sabha, we don't have any such committee. In Rajya Sabha, if you're absent for 60 days, this amounts to actually be a ground for your disqualification, but this matter will be taken up directly by the House. Okay, this is the difference. Please remember, there can be a question from here. This is a factual part, 15 members in Lok Sabha, and Rajya Sabha you don't have any such committee. Now, housekeeping committees. We have General Purpose Committee, House Committee, Library Committee, Joint Committee on Salaries and Allowances, Basic Work. General Purpose Committee, for any matter which is not taken up by other committees, which we have discussed till now, those matters will be considered as general matter. So these matters will be coming under the jurisdiction of General Purpose Committee. House Committee. Consider you become a member of parliament. You need house, you need perks, you need facilities, food, medical aid, etc. So whether members of parliament are provided these houses and allocation has been done in a better manner. So this is going to be taken up by House Committee. So it's not for us, it's for member of parliament. Now Library Committee, as the name suggests, is going to take care of the library of the parliament, right? Library of the parliament. Now Joint Committee on Salaries and Allowances. So this committee was made after an act of parliament under the Salary, Allowances and Pensions of the Members of Parliament Act 1954. Okay, as the name suggests, is going to take up these cases. It consists of 15 members, 10 from Lok Sabha and 5 from Rajya Sabha. It is one committee. It is not like two houses have two committees. It is one committee. Please remember, these kind of details UPSC is going to play around, but you are not going to mark wrong. Ad hoc committee, temporary committee. We have inquiry and we have this advisory committee, temporary, specific purpose. For example, these are list of some committees which were made in past and which also got dissolved with time as they served their purpose. You need not to cram these committees, obviously. What is the purpose of, so these were inquiry committees. Inquiry made, report done, dissolved. Then we also had advisory committees, time to time. Advisory committees, we have two types, for example, select committee, joint committee. Select committee if advisory committee of a specific house, joint committee if this is a joint committee of Lok Sabha, Rajya Sabha members coming together. It can be on a concerned specific bill or a procedure to be followed on a specific matter. So we have two kind of committees, select and joint. Okay, purpose is just to advise the house, and when advice is done, then you are done. Now just attempt this question. Which of the following committees of Lok Sabha is assisted by CAG? I told you it is Public Accounts Committee. Which one of the following is the correct function of Public Accounts Committee? Come on. It works under President of India, creates account of various ministries. It works under CAG of India, it prepares account. It's a parliamentary committee which gives report to non-plan expenditure of government. It is a parliamentary committee which scrutinizes the report of the CAG. It is correct, right? Which one of the following nominates the chairman of Public Accounts Committee? Who nominates the chairman of the Public Accounts Committee? Now we have Prime Minister, we have President, we have Speaker of Lok Sabha, Chairman. Tell me. So tell me first of all, do you have separate Public Accounts Committee for Lok Sabha, Rajya Sabha? No. You have one Public Accounts Committee, right? 15 plus 7 members told you. But when it comes to Chairman, this is done by Speaker of Lok Sabha. Okay. National Disaster Response Fund is allocated in which fund? I told you about three funds, right? Consolidated Fund of India, Contingency Fund, then public accounts. When it comes to NDRF, it comes under public accounts. Okay? Hello everyone. I hope this message finds you fit and fine. My name is Shashank Tyagi. Welcome to our Laxmikanth series contest. We are continuing our Parliament chapter, and within that today, we need to talk about legislative procedure. It means you have to turn a bill into an act. Now, what is the step-by-step process? This is called legislative procedure. First, you need to introduce that bill, right? Then it needs to be published in Gazette. Gazette is like an official newspaper of government in which government publishes bills, act, notices. Now, here's a question for you. You need to search and tell me in the comment which ministry at the union level is responsible for publishing Gazette and which department within that ministry. UPSC play on these facts, okay? Second, then we go to first reading. So what is first reading? We are going to talk in detail as well. Then comes select committee, means this bill is referred to a committee. Then second reading, then third reading, then bill in the other house. So in the other house as well, we are going to have these three readings, and then president assent, and then it turns into a law. Now, one question must be coming in your mind. Sir, what is this first, second, and third reading? What happens there? And why we are actually reading a bill three times? So let's understand in step-by-step manner. Introduction. So bill is introduced in Parliament. So in which house that bill is going to be introduced? It also depends on the nature of bill. Okay. For that, we need to understand type of bill. One criteria of categorizing is on the basis of who is presenting that bill. Who is presenting or introducing that bill. On this basis, we categorize it into two parts. One is private bill, second is public bill. Public bill means a minister is actually bringing this bill. Then it is a public bill. If any member of parliament other than minister is presenting a bill, then it is a private member bill. Now tell me, is there any exceptional circumstance where a private person, it means any person who is not actually member of a house, can this person actually present a particular bill in house? No. Some people actually misconstrued. Private means I'm not a member of house, I may be considered as private. No. When I use the word private member, it simply means a member of parliament who is not a minister. Okay. So this is on the basis of who actually introduces that bill. Okay. Second criteria is based on the content of the bill. What is there in the bill? Based on the matter. So first is ordinary bill, most common. Now, what is ordinary bill? Any bill which is not financial in nature or which is not talking about amending a constitution, Now that bill is considered as ordinary bill. Okay. Second is money bill. So what constitutes a money bill? It is defined in our constitution, article 110. And who decides whether a bill is a money bill or not? This responsibility is solely in the hand of Lok Sabha Speaker. Please remember, Speaker Lok Sabha, no one else. Raj Sabha Chairman, I'm not saying, okay? Only Lok Sabha Speaker. You know why? Why only Lok Sabha Speaker? Because this bill can only be introduced in Lok Sabha. It is going to be presented in Raj Sabha as well. But introduction, it means for the first time, it is presented only in Lok Sabha. Okay, we are going to discuss this in detail today also, because we are going to talk about categorization of these bills and how it is, what are the conditions associated with money bill. One question is actually asked. This is the important section here. Okay, then finance bills. Now remember, in general connotation, when I say finance, so finance means any matter which is related to taxation, revenue collection, right? So this seems to be finance bill, right? So what is the difference between money bill and finance bill then? My friends, when our constitution makers use this word finance bill, so they used in very technical sense. In general, money bill is also considered as finance bill. But when we divide the bills on the basis of what matter is there, in that sense, finance bill word is used only for those bills which are not money bill. It means there's a bill And within this bill, there are, say, 50 points, 50 clauses. And out of these 50 clauses, you saw that around 10-15 clauses were related to taxation or revenue matters, right? And you were a minister. You presented this bill before Speaker, sir, please declare this as money bill. Because please see, we have financial matters and tax matters in this bill. Now, Speaker might say, there are sections, but the whole bill is not about taxation or revenue. So I'm not declaring this as money bill. And this is complete authority in the hands of Lok Sabha Speaker. So if a Speaker declares that I'm not considering this bill as money bill, then it will be regarded as finance bill. So, which are also concerned with financial matter but are different from money bill. Okay. Now, Constitution Amendment Bill name itself is actually signifying it. A bill which proposes amendment. When I say amendment, what does it mean? It means you want to add something in Constitution, you want to remove something from Constitution, you want to alter language in our Constitution. Then we call it Constitution Amendment Bill. Okay. So these are the 4 broad categories of bill on the basis of matter. And this categorization of bill is on the basis of who is introducing that bill. I hope this is clear. Now, public bill and private bill. Like I told you, the difference is there, right? Now, it is introduced in Parliament by minister, told you. Private bill introduced by a member of Parliament who is not a minister. This is for your quick revision. It reflects policies of the government. Okay, because minister is actually presenting this bill, right? It reflects a stand of opposition. Generally, private member bill are introduced by some member who is not part of ruling party. Okay. It has greater chance to be approved in Parliament. Why greater chance? Because in Lok Sabha, who is having majority? The ruling party, right? So it means ruling party will say, oh, our minister is proposing this bill. Then, okay, we have to give this bill a pass, right? They are going to use the whip. I told you about the whip in the previous session. Whip, a direction by the party through a person who is regarded as whip, that on this bill, these members, the BJP members or Congress members, whoever is the party we are talking about, then they need to get it passed. Then members are going to say, yes, 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 we are passing it. We are supporting it. But when it comes to private member bill, it has lesser chance. Why? Because you need Vishesh Kripa. You need support of that party who is having more than 50% seat in Lok Sabha, right? That is why it is having lesser chance to get passed. Its rejection by the House amounts to expression of wants of parliamentary confidence. Consider, minister actually has introduced a bill, okay, on say Aadhaar, okay. They want to give some new status to Aadhaar, okay. Now it is introduced in Lok Sabha. Now it needs to be passed. But what we found, that it failed to get even simple majority. What does it signify? It signifies this minister and this ruling party is not having majority support in Lok Sabha. How it happened? So it means your confidence will be checked now. It can actually amount to resignation of the whole council of ministers, right? Because if this minister, this government is not able to pass their own bill, it means they are not having majority support. Now, when it comes to private member bill, its reaction by the House has no implication. These are opposition people, right? So, its introduction in the House requires 7 days notice. So, please remember this fact, because nowadays UPSC makes some statements on these basic facts, okay? 7 days notice, and here it requires 1 month notice. You have to give 1 month notice, then only you can introduce this bill. Okay, so which bill you think is having priority? Public bill is having priority in the eyes of House, right? Because only on 7 days notice you can introduce this bill. Now, it is drafted by the concerned department. For example, say Ministry of Home Affairs, they want to bring a certain bill, okay, for strengthening internal security of India. So they have the whole department for them, right? The officers there, legal consultants there, they are going to help this minister to actually draft this bill, okay? But what about private member? So private member is not a minister. He is not having department support. So drafting is the responsibility of the member concerned. You have to draft this bill on your own. Okay. So this is the difference. I hope it is clear. Yes or no? Okay. Now, let's talk about these bills one by one. First, ordinary bill. Every ordinary bill has to pass through the following 5 stages in Parliament. This is first reading. So introduction happened, gazette notification happened. Now first reading is happening. Now what happens in first reading? Just listen to me. If you're a minister, so you will stand up, you will be given time. So you will actually read out the title and the objective with which you think is going to be solved through this particular bill. So it means first reading is brief in nature. Okay, it is brief. There will not be any elaboration there or too much elaboration there. There will not be any debate in first reading. Okay, then this particular matter, this bill is going to be referred to a select committee. Select committee means certain parliamentarians are given responsibility that you are part of this committee. Since this bill is related to your topic, now you need to discuss it on your own. You 6-7 people, you discuss it. It can save time of the house. For example, certain MPs, they are part of, say, a standing committee on coal and energy. Okay, so you got a news that India is having shortage of coal. Okay, and we are purchasing coal from, say, from any other country, and government is making some law with regard to leasing of coal mines in India. Now, in first reading, you need not to debate this bill. Okay, first 5-6 members who are, we think that they are provided with some legal assistant as well, legislative assistant as well. They are going to have this bill. They are going to discuss this bill within this committee. So then it is referred to select committee. Then comes the second reading. Now second reading is, this is the main thing. The main work happens here. Means after select committee has also given their judgment. So this is the concise report which we think these problems are going to solve by this bill. Now exhaustive debate happens in second reading. Debate. Okay, if other members wants to say, no, we want this amendment, we want this to be changed, we are not agreeing with this provision. So everything happened in this second reading. Then comes the third reading. Third reading is the final step. It means now we are going to decide, are we going to amend some provision here or not? Then voting is going to happen here. When voting is done, then after this third reading, the presiding officer of the house, for example, in case of Lok Sabha speaker, now speaker will actually issue a letter along with this document. Consider this is the document. Okay, so this is the bill. Along with this bill, there will be a letter attached by the Lok Sabha speaker, and Lok Sabha speaker is going to send this letter to Raj Sabha in case of this bill being introduced in Lok Sabha. Now in case of Raj Sabha chairman will receive this letter along with this document. Okay, now this bill need to be discussed in Raj Sabha as well. Then Raj Sabha is also going to have this 1, 2, 3 reading. When it is passed, then this bill is presented to Honorable President. When President gives assent, then this bill turns into an act. But what if things don't go the way these are mentioned here? What if Raj Sabha, the second house, it says, I'm not agreeing with this bill? What is going to happen then? Even if Raj Sabha agrees and this bill is sent to President and President is not signing that bill, what options President is having with respect to ordinary bill? So these questions should come in your mind, and let's discuss these questions as well. First reading. Now just read in detail so that you are clear with every point, because UPSC plays in detail, right? Devil is in detail, and we cannot leave any detail. Just read. An ordinary bill can be introduced in either house. Either house. Whether you can introduce in Lok Sabha or Raj Sabha. If it is introduced in Raj Sabha, then Raj Sabha will be considered as first house, first reading, second reading, third reading. Then Raj Sabha chairman will paste a letter, sign and the copy, and send this bill to Lok Sabha. Lok Sabha will be considered as second house. Then first, second, third reading, and then it will be presented to Honorable President, right? The member who wants to introduce the bill, or The bill can be introduced either by minister or any other member. Okay. Why I'm highlighting on these specifics? Because in other cases, in other bills, if we twist these specifics, then UPSC can ask you by twisting these specifics, okay, now tell me the statement is true or false. Because we are talking about ordinary bill, first reading. What if in case of money bill, they make the statement, money bill can be introduced by minister or any other member, means private member. So now you should be clear. First reading of ordinary bill is being discussed, not money bill. Okay? And everything in polity is having a sound logic. Just understand the logic. Just grab the essence of Indian polity and then everything is like cakewalk. Everything is logically connected. It is not like cramming only. Okay, there's a purpose behind it. Why things are planned in this manner. The member who wants to introduce the bill has to ask for the leave of the House. Now, leave is not that I'm going on leave. It is like permission. When the House grants the leave to introduce the bill, the mover of the bill introduced by reading the title and objective. Told you in first reading what you need to do, title and objective. No discussion means what we are reading is already being told to you. Okay, this is just to settle these things in your mind. No discussion on the bill takes place at this stage. Later the bill is published in Gazette of India. If the bill is published in Gazette before its introduction, it can also be a case. Before introduction, this bill was actually introduced in Gazette. Now some of you might think, sir, how this can happen? If it is not introduced, how is it published in Gazette? What happens? Sometimes Lok Sabha Speaker has not given, there are so many bills pending, so not given enough time to actually, slot to introduce that bill. Okay, that bill is ready with the government, so government want to circulate it so that other suggestions can also come. In that case, it can be introduced before introduction of the bill as well. Okay, the bill is published in Gazette of India, so leave of the House to introduce the bill is not necessary. Now, these are the facts on which UPSC can play. Okay, if it is already you can say published in Gazette, then you not permission of House. You don't need permission of House to introduce the bill in that House, whether Lok Sabha or Raj Sabha, because we are talking about either House. The introduction of the bill and its publication in the Gazette constitute the first reading of the House. Means introduction of the bill, its publication in the Gazette. These both are considered under first reading. Okay. Now, second reading. I told you this is the most important one where discussion elaboration happens. Detailed scrutiny assumes its final shape. Okay, detailed scrutiny. Now, with the second reading, we have three stages, three sub-stages. First, a stage of general discussion. Committee stage, because this bill has been referred to a select committee, and then committee is discussing it, then committee is going to present its own views. Now, consideration stage. So, it means general discussion happened, committees went into specifics, then committee gave report, and then consideration stage. Okay, that now this bill is going to be presented before the whole House. Now the third reading. At this stage, the debate is confined to acceptance or rejection. I told you third reading is like voting stage, whether you want to accept it or reject it. Of the whole, no amendments are allowed. No amendments are allowed in this third stage. Why? Because if you want any amendment, then when you are doing detailed scrutiny and then you were talking about final shape in second reading, you should have added it there, right? If the majority of members present in voting accepts, what does it mean? We are talking about ordinary bill, and in case of ordinary bill, you need simple majority to get the bill passed, either from Lok Sabha or Raj Sabha. Okay. Thereafter, the bill is authenticated by the presiding officer. As I told you, the presiding officer is going to paste a letter of the House transmitted to the second House that, this is passed from my House, now onus is on you. Ball is in your court now. A bill is deemed to have been passed by the Parliament only when both the Houses agreed to it, either with or without amendment. I mean, both should actually agree. Then it is going to be passed by both Houses. Bill in the second House. When it goes to second House, As I told you, bill passes through all three stages. Same. Title, objective. Second stage, what was happening in second stage? Tell me. Exhaustive discussion, final shape, scrutiny, right? Three sub-stages, committee, consideration, right? General discussion. I hope it is clear to you. It should be, remembered by you until now. Okay. Now, when three readings have happened, now what are the alternatives with this house? Is it mandatory for this house to accept it? No. It may pass the bill as sent by the first house. The way they have sent the bill, it can pass it. Oh, I am agree. Second choice is they may pass the bill, but with certain amendment that we want these changes. Now, if Lok Sabha is the first house, they have introduced the bill and they have cleared the bill and it is sent to Raj Sabha, and Raj Sabha has said no, we need certain amendment. So now after you have proposed amendment, it is not like you can directly jump onto the stage of president, because you have made certain changes in the house, changes in the bill which are not agreed upon by Lok Sabha, right? So both houses should agree on a particular format of a bill, then only it can be presented to Honorable President. Please remember it. Both houses should agree on a particular format of the bill, means content of the bill, then it is going to be presented before Honorable President. Okay. Now, if you have proposed amendment, it means now you need to send this bill back to the Lok Sabha. Okay. And return it to the first house. If you are not agreeing with, then return it to the first house. Third option is it may reject the bill. It may say, no, I am not passing this bill. So this can also be done by Raj Sabha in case of ordinary bill. It may not take any action, no action. We have not said yes, we have not amended, we have not said even no, we are not doing anything. So here you are having yes, here you are doing some amendment, here you are saying no, and here you are not doing anything. So these are the four options with the second house. Okay, second house means if it is introduced in Lok Sabha and coming to Raj Sabha, then Raj Sabha is second house. If it is introduced in Raj Sabha coming to Lok Sabha, then Lok Sabha is the second house. Lok Sabha can also have these four options. Okay. Now conditions. If the second house passes the bill without any amendment, the first case means yes case. The first house accepts the amendment suggested by the second house. The bill is deemed to have been passed by both the houses. If you accept it the way it is, it means you have passed it and it is sent to President for his assent. If the first house rejects its amendments, consider Raj Sabha made certain amendment, send this back to Lok Sabha first house, but Lok Sabha is saying I am not agreeing with the amendments you have said. I am not agreeing. This is not fine. This is cheating. You should have agreed. So what is going to happen? Now the second house rejects the bill altogether, or second house does not take any action for 6 months. There can be a situation of deadlock. Raj Sabha made certain amendment to a bill which was proposed by Lok Sabha. Lok Sabha saying I am not agreeing with the amendment. So it means both the houses are not in consensus. This can be a situation of deadlock if this pursue for 6 months. For 6 months nothing happened on this bill. In this case, President has one power. President can summon a joint sitting. Means, what happens if there is conflict? If the consensus is not arrived, both parties need to sit together. This is exactly President do. So we call it joint sitting. Joint sitting is presided by the Speaker of Lok Sabha. Now tell me, who has more members in House? Lok Sabha or Raj Sabha? Lok Sabha. Right? And why Raj Sabha chairman was not given this power to preside joint sitting? Because Raj Sabha chairperson is not a member of any house, whether Lok Sabha or Raj Sabha. He is an ex officio position. It's an ex officio position, right? Whoever is vice president is chairman of Raj Sabha. So Speaker of Lok Sabha is going to preside. Now tell me, if Lok Sabha is a number and you have to discuss it and then get this bill passed, now tell me who is going to actually win? Lok Sabha or Raj Sabha, if we talk about numerical strength? Lok Sabha obviously. 543, 250 maximum. There's a huge difference, right? So that is why it is said, that more power is in the hands of Lok Sabha. Because even if joint sitting happens, then Lok Sabha, due to its more numerical strength, they can actually pass this bill. To resolve such deadlock, President summoned the joint sitting. Please remember, joint sitting is summoned by President. The majority of members present in voting joint sitting approves the bill, and the bill is deemed to be passed by both houses. Then it is presented before Honorable President for its assent. Clear? Now comes the time of, say, chance of Honorable President. What President can do? Give assent, agree that okay, I'm agreeing on this bill. Withhold his assent, rejecting it means may return the bill for reconsideration, that I'm attaching some advice. Now just consider my advice. So this can also be done by Honorable President. But you also know that if House passes this bill again, may accept President's recommendation or may not accept President's recommendation. This time, when this bill is again presented before Honorable President, now President is bound to give assent. Okay, I hope you remember I discussed this in President chapter with you in veto, suspensive veto, and it can be applied for one time, right? Means you can send the bill back for reconsideration once. Told you about 42nd Constitutional Amendment Act, 44th Constitutional Amendment Act. Polity should actually come in your mind like this. It is interlinked. Okay? You should not read it in silos. Ki, this was covered there and now we are in different topic. No, you should recall. If the President gives assent to the bill, then bill becomes an act. Job done. Congratulations. Now, if the President withholds his assent, it ends and does not become an act. I also told you the situation when it can happen. In case of private member bill, Council of Ministers can advise to Honorable President, sir, though this bill got passed from Lok Sabha, Raj Sabha, we were supporting this bill earlier as well in Lok Sabha, but now we are suggesting you just withhold this bill. President can reject that bill. In case of government bill, public bill, what can happen? It was passed from Lok Sabha, then Raj Sabha, presented before Honorable President, but now that Lok Sabha got dissolved, new elections happened, fresh elections, and now new government, new parties there, and now new Prime Minister saying, oh, this bill was actually bill belonging to the previous Prime Minister, previous government. Now, Honorable President just reject this bill. So this rejection can happen, withhold can happen. Okay? If President returned the bill for reconsideration, passed by both the houses again with or without amendment, presented to the President for his assent, President must give assent to the bill. I told you all also. President enjoys the power of suspensive veto. It is applied once, means you send this for reconsideration once. Now money bill, Article 110. Now what is money bill? Anything, any bill which is having some provisions of money is money bill. Is it the case? No. We need to be specific. Money bill is mentioned in Article 110. So what the conditions are? Any bill which is talking about imposition, abolition, remission, alteration, regulation of any tax. This is one condition. Means you are adding some tax, you are removing some tax, you are altering some tax, you are regulating some tax. Earlier this tax collection, tax decision power was this body, say GST Council, now you want to transfer this power in the hands of PM or Prime Minister office. So you have to actually consider this bill, present this bill before Speaker to actually declare this bill as money bill, because this particular provision is mentioned in Article 110. Okay. So one is tax. Just remember tax. Okay. Second is credit. It means if a bill is having provisions with respect to government asking permission for taking more credit, loan, the regulation of borrowing of money by the union government. Okay, it means credit. Just remember the keywords. Now third, expenditure. The custody of consulate fund, contingency fund, the payment of monies into or withdrawal of money from any such. Please remember, payment of money into. If you want to make a provision that now we want this additional stream of revenue also getting deposited in consolidated fund of India, so it need to be passed via bill. You need to make an act. If you want to draw some additional money from consolidated fund of India, you need permission of Parliament. It means you need to propose a money bill, right? You need to introduce this bill. Appropriation of money out of constitution. Appropriation means seeking permission of parliament that we have this expenditure. We are giving you the details as well. Allow us to spend this from Consolidated Fund of India. Okay, so what you got now when it comes to Consolidated Fund of India, the biggest fund, largest fund, government is not totally independent. There's a check and balance mechanism. Executive is accountable to legislature. You need to get it passed from legislature. Don't you think it's a good thing? Otherwise, government can actually do anything. At least there's a check there. Declaration of any expenditure charged on Consolidated Fund of India. Now, charged on CFI. What does it mean? When I say charged on Consolidated Fund of India, it simply means consider that you are Attorney General. Say you are, say, CJI, Chief Justice of India. Okay. So your salary is charged on Consolidated Fund of India. Okay. It means that when bill is going to be introduced next time, say annual financial statement, budget. So expenditures which are declared as charged expenditure on CFI, Consolidated Fund of India, you need not to vote on these expenditures again and again. These are safe and secure. These are high priority expenditure. These expenditures need to be done anyhow. Okay. So if you are declaring some expenditure which was actually used to, we used to discuss and debate and then vote. Now you want to elevate its status as charged, then you need to present this as a money bill. Okay. Receipt of money on account of Consolidated Fund of India, public account. I told you in one of my class that when I say government funds, we can categorize into three parts: consolidated fund, contingency fund, public account. Consolidated. What the word consolidate means? Means consolidate, means you are collecting. So the profits of government from various PSUs, right? Tax revenues, all of them come under consolidated fund. Contingency, what this word represents? Means certain emergency. So this is like contingency fund under President of India. On behalf of Honorable President, Finance Secretary manages this fund. It is having 200 crores. Okay, if a certain ministry was given certain budget, but due to some urgency, they need additional budget. So now contingency fund approval can be done. Third is public account. The word itself represents public account. It is your account. It means you invest in small saving schemes. If you're working and every month PF, certain provident fund is being deducted from your salary, where it is going? It is going in public account. EPFO, Employee Provident Fund SC organization is actually managing this fund. So this is public account. So if you want to make some certain changes, how receipts are going to be taken in these funds, then this particular criteria can also be regarded as money bill. Now, the nature of question which is going to be asked. Please remember, my friends, generally people remember 2-3 points with regard to money bill. And they often forget charge, CFI and receipt. Okay, so please remember these keywords, and now you are not going to commit any mistake when it comes to what are the criteria mentioned in Article 110 to actually declare a bill as money bill. Although this authority is with Speaker. A money bill can be questioned whether bill is money bill or not in which court of law? Now attempt this question. In front of President, in Supreme Court, in Lok Sabha itself by presiding officer. It seems like a direct question, okay, but there's a trick here. I told you whether a bill is money bill or not, it is actually declared by Lok Sabha Speaker. I think this is clear to you. Consider a bill is already declared by Speaker as money bill. Now, some people want to question it. How this is a money bill? How this is a money bill? Right? So now where it can be questioned? So law says that it cannot be questioned anywhere. Here the third option is saying in Lok Sabha itself by presiding officer. No. If Lok Sabha Speaker has decided it, it is not like now you are going to put a question and Speaker would say, oh, I might have committed mistake. Let me check again. No, this is not going to happen. And the word presiding officer is there. Presiding officer can be deputy speaker also. So speaker is ill and deputy speaker is in chair, and you are putting this question on deputy speaker dais that, sir, the speakers have declared this as bill as money bill. So you are member of opposition and you are saying, sir, please actually review this and declare this bill as ordinary bill, or say finance bill. No, deputy speaker cannot do, presiding officer cannot do. Once speaker has done it, done, close. So this rule says that. Okay. So if any question arises whether bill or money bill or not, the decision of Speaker of the Lok Sabha is final. Okay. His decision in this regard cannot be questioned in any court of law, in either House of Parliament or even the President. In either House of Parliament, you cannot question in House of Parliament as well. You cannot discuss, debate. So this is privilege. Now, on this point, I want you to read about an interesting debate. When Ms. Sumitra Mahajan was Lok Sabha Speaker and a bill was presented regarding UIDAI, I'm talking about Aadhaar bill. It was, there was controversy around this bill. Opposition members were saying this bill is having certain provisions which are not in nature of money bill, but yet a speaker, due to some political affiliations with BJP, it was declared as money bill. So there was a discussion, debate. So you need to check about what Supreme Court said with regard to Aadhaar bill. What is the update now? Okay, and tell me in comments so that I can also know that you are taking benefit of these classes. Okay. Now, after a money bill is passed by the Lok Sabha, it is transmitted to Raj Sabha for reconsideration. Remember, in case of money bill, it can be introduced only in Lok Sabha, not in Raj Sabha. I'm talking about introduced. Introduced. Okay. Now why? So for why, you should know that actually money bill is talking about tax, credit. So if you just take a look over the nature of provisions in Article 110, they deal with government function. Because government wants more money, they want to change tax. Government want more money because there's urgency. They need to pay for certain development work. They need to pay salaries, and there's some urgency. They want to borrow. So that is why, because government is there, because government is, this particular party is having majority in Lok Sabha, right? So that is why, number one, this bill is actually introduced only in Lok Sabha. Okay. Now it is, after it is passed from Lok Sabha and it is presented to Raj Sabha, so Raj Sabha has restricted powers with regard to money bill. What is restricted power? Raj Sabha can hold this bill for maximum 14 days. 14 days. It cannot reject or amend a money bill. It can only make recommendation. It cannot reject or amend. Please remember, there can be a question from here. And why? You should question why. The reason is, if Raj Sabha is given equal power, like Raj Sabha can stall a bill, like Raj Sabha stalled this ordinary bill for 6 months and then you have to wait for joint sitting. You cannot wait for joint sitting. Money is such an important matter for government. Government work will stop. And that is why Raj Sabha's power is, you can say, quite less in comparison to Lok Sabha when it comes to money bill. Okay. It must return the bill to Lok Sabha within 14 days, whether with or without recommendation. Even if you are given recommendation, then it is up to Lok Sabha whether they want to accept a recommendation or not. The Lok Sabha can either accept or reject all or any of the recommendation of the Raj Sabha. Okay. So I hope you got the status of Raj Sabha with respect to money bill. Now conditions. If Lok Sabha accepts any recommendation in money bill, means Raj Sabha said, although we know that we have less power, but we have some genuine recommendation. You need to improve this money bill. So if Lok Sabha says, oh, yeah, this recommendation sounds good, we are accepting this recommendation, the bill is then deemed to have passed by both houses. If you have accepted the recommendation, then it means it is passed from both houses, then presented before Honorable President. In case you have not accepted a recommendation, still the bill is deemed to have been passed by both houses because ultimate power is in the hands of Lok Sabha. If Raj Sabha does not return the bill to the Lok Sabha within 14 days, then it is deemed to have passed. So whether you say yes, no, or you stall, you only have maximum 14 days to actually stop this bill. Then it is presented before Honorable President. When Honorable President signs this bill, then it turns into an act. On the other hand, both the houses have equal power in case of ordinary bill, but both the houses have unequal power in case of money bill. And I also gave you the reason, means why. I think it is clear now. Finally, when a money bill is presented to the President, he may either give his assent to the bill or withhold his assent to the bill, but cannot return the bill for reconsideration. This is mentioned in Article 110. Means you can say yes, no, but you cannot say suspensive veto you cannot use. Because this money bill was introduced by prior recommendation of Honorable President. Means a concerned minister presented this bill before Speaker, Madam Speaker, or Honorable Sir Speaker, declared this bill as money bill. Sir declared, oh, this bill is money bill. Now you took that bill and went to President. Sir, this is money bill. And Article 110 says, before I introduce this bill in Lok Sabha, I need your recommendation. President says, okay, I paste this letter, I send this, you have recommendation. Now introduce in Lok Sabha. So this is how things work here. Normally the President gives his assent to the money bill as it is introduced in Parliament with his prior permission. I hope now it is clear. It should be ultra clear. Now what we have discussed until now, honorable money bill, so this differentiation is given in this table. At this point of time, just pause this video, open your Laxmikanth, just see this table and just read this table. So this is our discussion is concised here. I hope you have read. Now let's continue. Finance bill. Told you. Bill which are not declared as money bill, then they are categorized as finance bill. In finance bill, we have two types. Class 1, class 2. Let's understand what is the difference in a very simple manner. Finance bills are those bills that deal with fiscal matters. The word fiscal, what does it mean? Fiscal has two meanings, two components. One, what tax you want to impose so that you can earn revenue. And second, expenditure, where, how you have to spend this money. So tax policy, expenditure policy is part of fiscal policy, right? That revenue or expenditure, revenue coming from tax, profits. However, the Constitution uses the term financial bill in a technical manner. Financial bill are of three kinds in general, but technical manner, finance bill class 1, finance bill class 2 are different from money bill. 110 articles talks about money bill. 117 clause 1, 117 clause 3 talk about finance bill, class 1, class 2. So just remember 110 and 117. 117 we have two finance bills. Finance bill class 1, how we can actually, you can say, explain it. Contain not only any all matters mentioned in Article 110. For example, this was a bill and this bill was having 100 clauses. Out of these 100 clauses, around 20 clauses were related to some tax. But now 80 clauses were general in nature. They were making certain new, they were actually helping in making some law, but that was generic in nature. So a financial bill class 1 is a bill that contains not only any or all the matters mentioned in Article 110. I hope now the statement should be clear to you. Not only any or all means you are having only, means out of 100 you are having this 20 provisions related to Article 110. And it may be possible the provisions which we talked about, tax, credit, receipt, right? Charge on consolidate fund. So we can consider that within this 20, you have all the provisions as well. But also other matters of general legislation, these 80 matters, you have other matters also of general legislation. So it means there's a mix here. There is a mix here, right? So in this case, Speaker can say, no, I'm not declaring this bill as money bill. So finance bill class 1 is similar to money bill in what way? Both of them can be introduced only in Lok Sabha and not in Raj Sabha. When we are saying can be introduced only in Lok Sabha, it means it cannot be introduced in Rajya Sabha. It will be present in Rajya Sabha, but not introduced. Both of them can be introduced only on the recommendation of President. So, Lok Sabha introduction, President prior recommendation, these things are same. In all other aspects, this Finance Bill Class 1 actually works as, get passed as ordinary bill. Government by the same legislative process as ordinary bill. Now, I have just discussed till this point, and now I'm asking some questions from you, okay? And you have to answer from your own understanding, even if you have not read it. Now tell me, can, in case of Finance Bill Class 1, joint sitting can be summoned by Honorable President if there is a deadlock condition? Now tell me, the statement is true or false? I'm saying, consider this Finance Bill was introduced in Lok Sabha. It was introduced in Lok Sabha. Then it was presented in Rajya Sabha. It was discussed there. But Rajya Sabha is not agreeing on this bill. And it has been more than 6 months. Now tell me, can President call joint sitting in case of Finance Bill Class 1? Because I told you in case of Money Bill, there is no point of joint sitting because joint sitting happens to resolve the deadlock. But can there be a deadlock in case of Money Bill? No. Because Rajya Sabha can actually stall that bill for maximum 14 days. So why you need joint sitting in case of Money Bill? The status of Rajya Sabha is quite low in case of Money Bill, right? Now tell me, can there be joint sitting here? Yes or no? Answer is yes, because I just told you in all other respects, it acts as an ordinary bill, and in case of ordinary bill, there can be a deadlock, and there can be a deadlock, there can be a joint sitting. Okay, I hope now it is clear to you. Hence, it can either be rejected or amended by the Rajya Sabha, because it is acting as an ordinary bill. But in case of Money Bill, Rajya Sabha cannot reject, Rajya Sabha cannot amend, Rajya Sabha can only recommend. Okay. Now, in case of a disagreement between the two houses, President can summon joint sitting, already told you. Question has been asked by UPSC many times on this statement. When the bill is presented to the President, he can either give his assent to the bill or withhold his assent to the bill or return the bill for reconsideration. This means the third power, suspensive veto, which is not available before to Honorable President in case of Money Bill, is there in case of Finance Bill Class 1, because it is acting like an ordinary bill in all other respects, just in two respects. Introduced in Lok Sabha and presented by prior recommendation of President, it was equal to Money Bill. Right? Now, Finance Bill Class 2. Now, just remember, mix is going on here also. But here, the clauses, means out of 100 when we are talking about 20, these clauses are related to expenditure policy. Expenditure, kharch karna. You are talking this government wants to actually spend some amount in particular category. Contains provisions involving expenditure from the Constituted Fund of India, but does not include any of the matters mentioned in Article 110. Other matters are not there, and they are matters of general, you can say, connotation. It is treated as ordinary bill, and in all respects, it is governed by same legislative procedure which is applicable to any ordinary bill. The only special feature of this bill is that it cannot be passed by either House of Parliament unless President has recommended to that house for consideration of the bill. This detail you need to know. Expenditure, treated as ordinary bill. Finance Bill Class 2 can be introduced in either House of Parliament, and recommendation of the President is not necessary for introduction. Introduction, you need not to have permission. This is the difference between Finance Bill Class 1 and Class 2. It can either be rejected, and yeah, this is another important, either house. In case of Finance Bill Class 1, I told you, it is equal to Money Bill in two respects. Can be introduced in Lok Sabha on prior recommendation of President. But in case of Finance Bill Class 2, it can be introduced in either houses. Either house. Okay, Lok Sabha or Rajya Sabha. In case of disagreement between the two houses over such a bill, President can summon joint sitting. In all other aspects, it is acting like an ordinary bill. When the bill is presented to the President can use all three steps: accept, withhold, reject, or use suspensive veto. I think it is clear to you now. Yes or no? Joint sitting of the two houses. Told you joint sitting. Lok Sabha, Raj Sabha, members are going to sit together. Sitting is going to be presided by Speaker. This particular joint sitting is summoned by Honorable President. President summons joint sitting on the recommendation of Council of Ministers. When bill is rejected by other house, the house have finally disagreed to the amendment. So these are the cases when we can say our deadlock condition is there. Or more than 6 months are passed and the second house has not done anything on that bill. So if you reject, if you amend, which is not, amendments are not agreed by the other house and more than 6 months have passed and you have done nothing. In this case, joint sitting can be called and President summons the joint sitting. Now, it must be noted that joint sitting is applicable in case of honorable and finance bills. Please remember it. Important statement is this, right? In case of money bill, you don't need joint sitting, right? And what was the other type of bill I told you in the start of this lecture? Constitution Amendment Bill. In Constitution Amendment Bill, there is no case of joint sitting. And think of why. Don't just cram it. Ratna nahi hai. Why? My friends, the reason is Lok Sabha and Raj Sabha, if they come into joint sitting, Lok Sabha has more strength. If in case of constitutional amendment, which is a very crucial matter, if joint sitting provisions would have been given by our constitution makers, then it would have given unnecessary, you can say extra power to the ruling government. Because in Lok Sabha they have majority. That's why they are having government. So they could have amended our constitution in a manner they want. Although Supreme Court is there. But this is like giving extra power. We want to balance their power. Constitutional amendment should not be that easy. And that is why equal powers are given in case of constitutional amendment to Lok Sabha and Raj Sabha. Okay? And now, please remember, joint sitting can happen in case of ordinary bill, finance bills. Clear? Okay? Now, in case of money bill, the Lok Sabha has overriding powers. Already told you, constitutional amendment bill must be passed by each house separately. Right? Important, I have already explained this to you. In the reckoning period of 6 months, no account can be taken by any period. Now, when I'm saying joint sitting happens when 6 months have been passed and other house has not done anything. So how these 6 months are calculated? How these days are calculated? Right? So now, any period during which other house to which the bill has been sent is prorogued or adjourned for more than 4 consecutive days. It means when you're counting this six months tenure, so you're counting the working. You're counting the days for which house was functioning. And if it was not functioning, means it was adjourned for more than 4 days or it was recess going on. So recess period and the period when this was adjourned for more than 4 days, this is not counted there. Okay, this is a bit of detail, but no one knows. UPSC can play on this detail as well. Because general notion which comes into mind is, oh, general 6 months, January, February, March, April, May, right? But this is not the case here. If the bill under dispute has already lapsed, now this is a beautiful statement. And it amounts to, to your understanding of the logic. Lapse. Consider the bill was presented from, introduced in Lok Sabha, get passed from Raj Sabha, presented before Honorable President, and it get passed. But there's another case, it was actually passed by Lok Sabha, introduced in Lok Sabha, passed by Lok Sabha, presented to Raj Sabha, and Raj Sabha has not done anything. 6 months have passed. And now President has actually called for joint sitting. And now Lok Sabha got lapsed. Now, what is going to happen with this bill? This bill is going to lapse or not? No, this bill is not going to be lapsed. I told you in the previous lecture, in the cases of lapse, what is going to be the impact on bill if Lok Sabha dissolves. I told you in that particular video that because President has already declared notification of summoning, it means President's security is being provided to the this particular bill. The bill is not going to lapse. When new Lok Sabha is going to be reconstituted after fresh election, now this new Lok Sabha and the Raj Sabha, they are going to have joint sitting. Okay. So already lapsed due to the dissolution of the Lok Sabha, no joint sitting can be summoned. If the bill under dispute has already lapsed, means if it has, the notification has not been released, then it will lapse. But the joint sitting can be held if Lok Sabha is dissolved after the president has notified his intention. If president has notified intention, now bill is secure. If president has not notified its intention, then bill can lapse, because bill has not touched honorable president. I told you this trick in my previous video. After the president notifies his intention to summon joint sitting of the two houses, none of the houses can proceed further with the bill, right? The quorum to constitute the joint sitting is 1/10 of the total numbers. Total number means Lok Sabha plus Raj Sabha. Budget in Parliament. In our constitution, budget word is not mentioned. In its place, under Article 112, annual financial statement word is used. Okay. So what contains in budget? Estimate of revenue and capital receipt, what you are going to receive as revenue and capital receipt. Okay. Ways and means to raise the revenue, how you are going to raise the revenue. Estimates of expenditure, how you are going to spend. Details of the actual receipt and expenditure of the closing financial year. Means in previous year also, in previous budget also, you have predicted this much revenue we are going to have, this much expenditure we are going to do. But in budget, you have to give the details. What are the actual figures? Economic and financial policy of the coming year, the taxation proposals, prospects of revenue, spending program, introduction of the new schemes, project, everything. These points are actually part of annual financial statement, which in general term we call budget. This budget word actually was taken from a word baguette, which is a French word, which is actually was used for a leather bag. Okay, because earlier in many parts of the world, the budget used to be released. The person, or you can say minister concerned, or in some nations, prime minister or president themselves, they used to bring this budget in a leather bag. But you must have seen in our last budget, Ms. Nirmala Sitharaman actually brought this budget in Pothi, that is Indianized version of folder. Now railway budget was separate earlier, but now it is part of union budget. General budget in 1920, recommendation of Ackworth Committee. On the recommendation of Ackworth Committee, it was separated. Bringing you this because this is a fact. The reason or objective of this separation was that railway finance should be flexible. Railway was and is the biggest PSU of Government of India. To facilitate business approach of the railway policy, to secure stability of general revenue, providing assured contribution of railway revenue. But now we have so many forms of transportations, right? We are not just dependent on railways, although railway is the biggest one. To enable railways to keep profits of their own development and paying fixed annual contribution to the general revenue. So this was the purpose of having separate railway budget, but we don't have separate railway budget as of now. Constitutional provisions. President shall, in respect of every financial year, cause to be laid before. Simply saying, actually budget is introduced in Lok Sabha with prior recommendation of Honorable President. Okay, so what happens? For example, budget is proposed on first, means introduced in Lok Sabha on 1st February every year nowadays, right? Earlier it used to be on the last working day of February, but Modi ji changed it to 1st Feb. But the budget making process actually start way back in September, okay? So every department, ministry, they start sending their proposals. This much we have spent, this much we want, to the finance ministry. Within finance ministry, there's a department of economic affairs, okay? So this department is responsible for preparing union budget. So when this Department of Economic Affairs actually consolidate all the data, then they have a meeting in finance ministry under the leadership of finance secretary, which is the topmost bureaucrat in finance ministry. Now they make a blueprint, okay, of the budget. We call it blue sheet. Now finance minister along with finance secretary, they actually take a meeting, take an appointment with PMO, means Prime Minister office. Then they visit PMO, they meet Prime Minister and present this blue sheet. So this is the rough draft of a budget. If you want to add something, remove something, please give a suggestion. When Prime Minister would say, okay, this is fine, this is addition, and then the following suggestions are taken, and then they will come back into the finance ministry and they will have meeting, and within that meeting they're going to finalize, refine this blueprint. And after that there's a team which is actually made. Okay, then these team members are told that you are part of that the team who is going to be responsible for making union budget. Okay, they're given a date as well, that on this date you have to come, and after that they are actually logged into a basement in North Block for more than 10-15 days. Yes, they are locked, but you should not think that it's like a jail. All the facilities, eating and residential and everything is there. Printing, everything, medication, cook, everything is there, because you are part of this team for making union budget. And there's high quality jammers are there, means you cannot actually communicate with your family, you cannot communicate with anyone in the outside world, because if you leak any information what is going to be there in budget, then there will be ramification in that share market. Many people can actually shift their investment, right? So then a copy is released, then these draft copies are released, then this budget is introduced. When this draft copy is released, then finance minister actually takes this draft copy to Honorable President. Sir, this is our draft copy, please give me permission to present this in Lok Sabha. President says, okay, my kripa is with you, I've signed this. Then finance minister take this to cabinet, that this is going to be our government budget, I want support of all my colleagues in cabinet. Then cabinet ministers will say, okay, we are with you. Then they have this photo with cabinet ministers and prime ministers also there. Then finance minister enter into Lok Sabha, and this first reading happens, means title, objective of the bill. So this process is there. Then it is passed from Lok Sabha, then Raj Sabha. No demand for grant shall be made except for recommendation of the president. Because in budget, you are saying from consolidated fund you want this amount. This is part of budget, right? So this is done on the recommendation of president. If even after budget, if you want some additional fund, you need a bill which is actually getting permission from Honorable President. No money bill shall be withdrawn from the Consolidated Fund of India. No money shall be withdrawn except under appropriation made by law. Means you need permission of Lok Sabha. You need to tell in which account where you are going to spend this money. No money bill imposing tax shall be introduced in the parliament except on the recommendation of president, and such a bill shall not be introduced in the Raj Sabha. Money bill is not introduced in Raj Sabha. That is obvious to you now. Now attempt this question. Which one of the following sets of bills is presented to Parliament along with the budget? Along with the budget. Set of bills along with the budget. Direct tax bill, indirect tax bill, contingency bill, appropriation bill, finance bill, appropriation bill, finance bill, contingency bill. There's nothing like contingency bill, my friend, that is contingency fund. Okay. And direct tax bill and indirect tax bill, these are separate thing. If you want to bring certain changes in indirect taxes, then we use it, then we call it indirect tax. Okay. Answer is finance bill, appropriation bill. Which one is not true regarding the bill in Parliament? The legislative process begins with introduction of a bill in either House of Parliament, Lok Sabha or Raj Sabha, exception money bill. Question is asking not true. A bill can be introduced either by minister or private member, told you, public bill, private bill. In case of deadlock between the two houses, Speaker of the Lok Sabha calls the joint session of the Parliament. Don't you think it is a sin to agree on this fact? It is a sin, my friend, because I've already told you that President is the one who is going to call up, summon the joint session. Just remember this as a trick. Session of Parliament is summoned only by Honorable President. Only by Honorable President. Whether it's a normal session or joint session. Joint session, so you have to say not true. So this is not true. This is the answer. A joint session of the two houses presided by the Speaker of the Lok Sabha, you know, this is also correct. So these three statements are correct. This is incorrect. Not true is what you want to say. Hello everyone. I hope this message finds you fit and fine. My name is Shashank Tyagi. Welcome to our Laxmikanth series, Contests, Indian Polity. We are continuing our Parliament chapter. Within that, today we need to discuss devices of parliamentary proceedings. UPSC asks a statement kind of question and match the following kind of questions from this particular section. Parliamentary proceedings, what comes into your mind? Members of the House coming together and actually engaging in legislative business, right? Lawmaking process. But for that, they need certain devices. Devices means processes. okay, to do this function effectively. That is what we need to discuss. First, let's talk about what happens in Parliament, how the usual day in Parliament is slotted. First hour, 11 a.m. to 12 noon, we call it question hour. Question hour. It means members of the Parliament, they ask questions from the ministers to keep the government in check. They represent people, right? From 12 noon to 1 p.m., we call it 0 hour. 0 hour is not mentioned in our constitution, even not mentioned in rules and procedures of Parliament. Okay, so but it represents people. In the 0 hour, you can actually raise matters of public importance. Okay, then 1 p.m. to 2 p.m. you have lunch, go to parliamentary canteen, you have subsidized food waiting for you. Then 2 p.m. to 6 p.m. in case of Lok Sabha, real government business happens. The agenda of the day means which bill need to be discussed. So everything happens, major work happens in this slot. In case of Raj Sabha, this is 2 p.m. to 5 p.m. Okay, so law making process happen in this slot. It is clear to you? Now, question hour. Let's take them one by one. First hour, I told you, members ask questions and ministers usually give answer. So you have three type of questions. Number one, a start question, most important one. Asterisk sign is also used. Okay. In case of start question, the concerned minister has to give an oral answer. Okay, you have to stand up in the house and give oral answer. Okay, and the other person who has asked this question, if you're not satisfied, you can ask counter question, you can ask supplementary question from that particular minister. Okay, one point you need to actually know. Consider you want to ask question from Minister for Defense. It's not like you are going to stand on this day, since question hour is working, I want to ask question from Modi ji. No. You have to send this question in advance, sometimes 1 month, 1.5 months before. And you send this question not directly to that concerned minister. You have to send this question to Lok Sabha Speaker, in case we are talking about Lok Sabha. In case of Raj Sabha, you have to send this question to Raj Sabha Chairman. Then these presiding officers, they are going to send this question to the respective minister. Okay, and now minister is not actually making the answer. Who is making the answer? IAS officers, right? So officers actually make the answer. Actually staff makes the answer on the ground, then officer check, do the dictation work, and then brief the concerned minister. Sir, this question was asked from you in Lok Sabha, and this is the answer we have framed, and we have double checked everything, because if you actually give wrong data, then privilege motion can be actually leveled against that particular minister, right? So this is a very important work. I remember my days in Delhi Legislative, in Delhi Secretariat. So when Delhi Legislative Assembly used to start, session used to start, so we were totally absorbed in this question and answer stuff. Coordinate with department, double check with the data, then frame the answer, then reframe the answer, and then, the secretary, means the topmost officer in the ministry, then our secretary used to, you can say, brief the concerned minister. Now, unstarred question, on the other hand, requires a written answer, and hence supplementary questions cannot follow. Supplementary questions cannot follow. In this case, just give written reply. No need of oral answer. So this is the top category. This is the second category of question. Important questions are categorized as start question. Okay. Now short notice question. If, as I told you, sometimes questions are given 1.5 months back, because you have to check the data from the ground. So if time is given less than 10 days and speaker thinks, oh, you are late, but your question seems important. In this case, it is termed as short notice question. Okay. And it is answered orally. Okay. Now, 0 hour, the next hour we are talking about. So it is informal device available to the members of the parliament to raise matters without any prior notice. Informal device, please remember it. The time gap between the question hour and the agenda means 12 to 1 we are talking about. 1 to 2 you have lunch. It is an Indian innovation and actually field of parliament procedures, and has been in existence since 1962. Please remember, it is an Indian innovation. Okay, and it is an informal device. Now, 0 hour is not defined anywhere, neither in constitution nor in the parliamentary procedures. Okay, so this you need to remember. This can be a direct statement, in your question. Now, let's talk about motions. For example, You have particular opinion on a particular issue that concerned minister has not done enough, or you want a house to realize that this is an important matter. So how you can actually ensure that other members are actually, you can say, agreeing with you, or to check whether other members are disagreeing with you? What's the you can say stand of house on this matter? So we can check this by use of motions. Okay. So no discussion on a matter of general public importance can take place except on a motion made with consent of presiding officer. So what house actually wants, it is decided by how many people are supporting the motion you have raised. Okay, it is like you want to discuss something. Okay, you want to check what majority of members believe in. So you raise this matter to the presiding officer, sir, I want to raise this motion. Then speaker in case of Lok Sabha will say, okay, I'm allowing you to raise this motion. Okay, so you'll raise this motion so that it can be, now this matter can be discussed. Okay, so the House expresses its decisions, opinions on various issues through the adoption or rejection of motion. This is exactly what I have explained to you. I think it is clear now. Please remember, it can be either moved by minister or a private member. Now there are three principal categories of motion. Number one, substantive motion. Substantive motion. I hope it is visible to you. Now substantive word represent that this motion is complete in itself. It is quite extensive motion. Self-contained independent proposal dealing with a very important matter like impeachment of the president, removal of chief election commissioner. So these are important matter. You want to see whether House agrees with you that this is an important matter and we should do something about it. So this is a substantive motion. Second is this substitute motion. What is the meaning of word substitute? Means it is like a replacement, right? So that is exactly the meaning of this motion. It is a motion that is moved in substitution of an original motion. Okay, a particular motion was raised and now substitute motion is raised. So if speaker accepts, yes, I'm allowing the substitute motion, it means now House need to discuss this. Now we can replace the earlier motion. Okay. So alternative to it, if adopted by the House, it supersedes the original motion. Supersedes the original motion, the motion which was initially raised. Now subsidiary. What is the meaning of subsidiary? Subsidiary is like a component of the main thing. Okay, so subsidiary motion is actually component of the main motion. For example, you raised a particular matter and you started discussing it and you want House to adopt it or reject it, whatever is going to happen. Now you find, or someone found, there's another matter which is also connected to this core matter which you have raised. Then that person can say, oh, since House is discussing that, let's discuss this additional matter also. So how this person can actually put his voice. So this person is going to raise this matter before the speaker. Sir, please allow me to put this subsidiary motion. This is subsidiary, a component of the original motion which is in place. So it is a motion that is itself no meaning, cannot state a decision of the House without reference to the original motion. Okay. So proceedings also, it is divided into three subsections. For example, ancillary motion used for regular way of proceeding with the various kind of business. It is regular kind of. A matter of original motion is there and you find that this is a subsidiary. So this can be an ancillary. Superseding motion, it is moved in the course of debate on another issue and seek to supersede that issue. You want to supersede that earlier issue. You think this particular matter is more important. That is why House should discuss this. Amendment to seek, modify or substitute only a part of original motion. Now amendment as a subsidiary motion, it means you want to change some component of the original motion. Please remember, ancillary motion, supplementary motion and this amendment. Ancillary, supplementary and amendment. This ASA is only connected with original motion because all of them are subsidiary motion. They should be actually coming as a component, as an additional part of this original motion. Okay. You have to give reference to this original motion. Okay. Now closure motion. What is the meaning of close? It means you are saying, let's close this issue, what we are discussing. Okay. It is a motion moved by a member to cut short the debate. on a matter before the House, let's cut short the debate. If motion is approved by the House, debate is stopped. If you have raised the motion, sir, we have discussed enough on this issue, so I want to raise closer motion. Then speaker would say, okay, I am accepting the closer motion, let's put this motion to vote. And if majority of members say, yes, I am support of closer motion, it means these people are agreeing, enough is discussed. Enough bol bachan is done. Let's put this matter to the end. Let's put this matter to the vote. So this is closer motion. Okay. Now closer motion have its own types. Simple closure. First, it is one when a member moves that matter having been sufficiently discussed and now put to vote. Please remember, UPSC play on these intricacies. In simple closure, also we are closing. But the difference is, matter has been sufficiently discussed. It is already discussed. And that is why you want to close. Okay, objective is it is sufficiently discussed. Next is closure by compartment. Closure by compartment. In this case, clauses of a bill or lengthy resolutions are grouped into parts before the commencement of the debate. So in this simple closure, matter was sufficiently discussed. But in case of closure by compartment, you are saying before debate starts, let's do one thing. If this particular bill is having, say, 10 major portions, let's divide this bill into 5 portions. Each portion having, say, two major you can say areas. So in this case, now you need not to actually discuss all these 10 provisions in detail. You just need to go to 5 ones, so that you can actually simplify the, you can say, procedure here. You can save the time. So the debate covers the part as a whole and the entire part is put to vote. This is turning it into compartment. But everything is covered. I said 10 points were there, but we categorized them into 5. So everything was covered, but we grouped them. In case of kangaroo closure, what is the meaning? How kangaroo actually walks? You remember, kangaroo jumps. For example, these are the provisions. So kangaroo will jump from 1 to 3, then 3 to 6, 6 to 9, or say 9 to 20. So it means in kangaroo we actually jump on most important provisions. We leave other things which are there. Under this type, only important clauses are taken up for debate and voting, and the intervening clauses are skipped and taken as passed. For that we consider, okay, these are discussed, these are passed. So there are certain clauses which are not even discussed in kangaroo motion. We just jump on important provisions. Okay. Then we have guillotine clause. Guillotine closure. It was in news also because our current government used it during the budget process. Guillotine means no discussion is required. Let's put the matter to the vote without discussion. So guillotine name is taken from a device which was used in England for executing people. Means you put the head of a person on a stone, and then there's a blade which is going to fall down, and the end. So it is one when undiscussed clauses of a bill or resolution are put to vote, also put to vote, undiscussed, with the discussed ones, and want time to, you want to save time, right? So government was criticized on this part. Why you have used guillotine motion in case of guillotine closure motion in case of budget? Budget need to be discussed, it need to be debated. Some other party, some other people may have actually some solid argument which you can include in your budget, right? So guillotine, I hope it is clear to you. Just put the matter to vote. Privilege motion. Remember, privilege motion is raised against a minister. For example, if a minister has broken the privilege of the house, for example, a minister has given distorted facts in the answer, withholding facts, certain facts are not shared before the house, although house asks these facts. So in this case, privilege motion can be raised. What is the meaning of privilege? Privilege motion. It means we want to censor that particular minister. We want to make that minister realize that you have done wrong. Censor that concerned minister. Please remember, privilege motion is not against the whole government. Privilege motion is just against that particular minister. Okay, UPSC will try to make trap by confusing you how privilege motion is against every minister, whole government. No. Okay. Calling attention motion. From name, what do you think it is? Introduced in parliament by a member to call attention of a minister, call attention of a minister on a matter of urgent public importance. to seek an authoritative statement. We want minister to answer. India wants to know. Like the 0R, it is also an Indian innovation in parliamentary procedures. Now, see the difference. And has been in existence in 1954. However, unlike the 0R, it is mentioned in rules of procedure. So what you got? 0R is not mentioned in rules of procedure. 0R is not mentioned in constitution. But calling attention motion is mentioned in rules of procedure of the house. Okay? Not mentioned in constitution. Okay? Rules of procedure, it is within them, it is mentioned. Now, adjournment motion. In the previous class, this adjournment word was used twice. Adjournment and adjournment sign that. That is quite clear to you now, right? Adjournment motion. If there's urgent matter which you need to put before the house and it is very specific, factual, not general, then adjournment motion can be used. Introduced in Parliament, definite matter, urgent public importance, needs support of at least 50 members. Then only this particular motion can be used. It involves element of censure against the government. Okay, in privilege motion, we were raising censure against the minister. Okay, but minister was not losing his seat. Okay, be sure of that. Now, when it comes to adjournment motion, government is not going to fall down, right? But we are censoring government that this is an important matter and you have not done enough. Now, please also remember this adjournment motion is used in case of Lok Sabha, not in case of Rajya Sabha. Why? Because you are censoring the government and government is there because government enjoys majority in Lok Sabha. Discussion on adjournment motion should not last not less than 2 hours and 30 minutes. Means at least, since it's an urgent matter, you should give at least 2 hours 30 minutes for this matter. Now, what are the restrictions with respect to adjournment motion? Means adjournment motion can be raised only in what cases? Should raise a matter which is definite, factual, urgent importance. It should not cover more than one matter. It should be on one matter specifically. Restricted to a specific matter, you cannot have general, debate. Should not frame a general discussion, not raise a question of privilege. Okay? You should not revive discussion which has already been done within that particular session. Should not deal with any matter under adjudication of court. If court is already having this case, then you cannot discuss that matter in the house using adjournment motion. It should not raise any question that is raised on a distinct motion, which has already been raised in distinct motion. Okay? It should be specific, factual, definite, urgent public importance. Now, let's discuss the difference between censure motion and no confidence motion. Censure. What is the meaning of censure? It means you want to pinpoint on a particular minister, you have done this thing wrong and House knows. So it should state the reasons for the adoption in Lok Sabha. Means you want to censor a minister, you should give the reason what wrong that person has done. But in case of no confidence motion, already used in Lok Sabha, you need not to give the reason because purpose is quite clear that this government is not enjoying majority of the Lok Sabha, right? So need not to state the reason. Please remember, a question can be raised, a statement can be made from here in upcoming prelims also. Now, moved against an individual minister, censor or group of minister, but in case of no confidence motion, it is raised against the whole government, means council of minister. Okay, no confidence motion cannot be used against a particular minister or group of minister. It can be actually raised against the council of minister only. Because purpose of no confidence is that we want to state that this government has no right to actually continue because this government is not enjoying majority in the Lok Sabha. It is moved for censoring the council of minister for a specific policies in action because you are giving the reason, right? It is moved to ascertain the confidence of the Lok Sabha, to check whether this government is having majority support in Lok Sabha or not. It is passed in the Lok Sabha, the council of minister need not to resign. After censure motion, need not to resign. But in case of no confidence motion, if it is passed, it means you cannot continue now because you are not having majority, right? And tell me, if no confidence motion is getting passed from Lok Sabha, what does it mean? It means that current government is actually not having majority support. Because this current government was made because more than 50% of the total seats in the Lok Sabha belongs to this particular party. And if no confidence motion is getting passed, it means their own people are not their own people now, right? So this is the, you can say, analysis, or you can say difference between censure and no confidence. Clear? Motion of things. Now our president gets two chances to actually come to the house and give a speech. Those chances are first session every year. When I say every year, every fiscal year. First session after general election. Okay. So there president will come and he will give his speech, or she will give his speech. Now president outlines the policies, programs of the government in the preceding year and ensuing year. What you have done and what is going to be done. Then there is motion of things. Okay, that this thing has been done. Now motion of things, you should not take it lightly. Why? At the end of the discussion, the motion is put to vote. And motion must be passed in the house. And if it is not passed in the house, it means the current government is not having majority. Otherwise, it amounts to defeat of the government. Obviously, this is going to pass in the Lok Sabha, right? Because current government is having majority, that is why they are having government. The inaugural speech of the president is on the occasion available to the members of parliament to raise discussion, debate. So they can raise discussion, debate. Whatever president has said, we do not agree fully. And you would think, oh, these members can actually raise point against the speech which was given by president. Yes. You know why? Because a speech was not given by honorable president on his own. The speech was not actually made by, were not representing the original views of president. Actually, this speech is also decided by Council of Ministers of the time. Okay, and there was one minister, one president, Mr. K.R. Narayan, he raised an objection on this issue. He said, no, I am going to give my own speech. And at that point, the government of the time said, no, sir, you cannot give, because this is the convention. Council of Ministers is going to give you the speech and you have to read that. Okay. So otherwise it will be considered as violation of constitution. And you know what happens when constitution is violated by president? Impeachment happens. Now, point of order. What do you deduce from the word point of order? It means something is not in order and you want to bring back into order. It means if member thinks that house is not working as per the rules and procedure. So now member can raise this point of order. Honorable Speaker, I think house is not running as per the rules and procedures. A member can raise a point order when proceedings of the house do not follow the normal rules of procedures. Okay, should relate to the interpretation and enforcement of the rules of the house. If it is not running as per the rules, then it need to be enforced. It need to be interpreted. Raised by an opposition member in order to bring the government under control. Extraordinary device, it is as it suspend the proceedings before the house. Enough is enough. Whatever you are doing, it is not working as per rule. Let's bring the rule back. No debate is allowed on point of order. Now, half an hour discussion. Now, there are some time slot based discussions. For example, half an hour discussing a matter of sufficient public importance, which has been subjected to a lot of debate and the answer to which needs elucidation on a matter of fact. You need more clarity on that. Now, you would be thinking, sir, if question hour is there, 0 hour is there, why you have this half an hour discussion? My friends, crucial element of democracy is deliberation, discussion. That is why these tools are given in our parliamentary procedures. That if some matter is not discussed in 0 hour, some matter is not raised in question hour, you have these slots in that you can discuss important matters. A speaker can allot 3 days in a week for such discussion. So at least you know in 3 days the slot is available, we can do the discussion. No formal motion, no voting can happen when it comes to half-hour discussion. Short duration discussion, 2-hour discussion. So this is half-hour discussion, this is 2-hour discussion. This is another device. You have another slot available, right? So the time allotted should not exceed 2 hours. Matter of urgent public importance, here also speaker can allot 2 days in a week. So there, you are having 3 days in a week, half-hour discussion, 2 days in a week in 2-hour discussion, or you can say short duration. Easily remember, 2-hour discussion, 2 days in a week. Half-hour discussion, slot is half, so you can give more days, 3 days in a week. There is neither a formal, no, it is same. No formal motion, no voting can happen in this short duration motion. Existence since 1953. Data is not important. Resolution are different from motions in what respect? So till now we were discussing motions. Now there's another word, resolution. Okay. So what is the difference? Major difference. In case of resolution, if a matter is issued and we are saying we want to bring this resolution, it means voting is going to happen. Voting is going to happen. But in case of motions, there are some motions in which voting is not necessary. But in case of resolution, voting is necessary. Why? Because purpose of resolution is to actually have an impact outside or impact inside out of this resolution. Means House has this stand and this stand should have this impact. But this is not a necessary condition in case of motions. All resolutions come in the category of substantive motions. All resolutions come in the category of substantive motion. What was substantive motion? Independent, extensive, complete motion, right? That is to say, every resolution is a particular type of motion. All motions need not necessarily be substantive, right? That is why we discussed subsidiary, substitute. Further, all motions are not necessarily put to vote. I have already told you. The House, whereas all resolutions are required to put to vote. Why? I told you the reason. Because some action need to be taken. Resolutions, a member can move resolution to draw attention of the House or government to a matter of general public importance. Discussion on resolution is strictly relevant and within the scope of resolution. You cannot go beyond that. Member who has moved the resolution or amendment cannot actually withdraw the same except by the leave of the House. If you have started a resolution, now you cannot say, no, I am taking resolution back. No. Matter has been put, means you have raised this matter. Now it is up to House whether they want to give up or not. 3 categories. I hope it is visible to you. Private member resolution, with name you can, I think it is quite clear, means this resolution is raised by private member. It is discussed only on alternate Fridays, that's a fact, and afternoon sittings. The purpose is, or you can say differentiation is, it is raised by private member. Government resolution, it means it is moved by a particular minister. Okay. Statutory resolution, it can be actually raised by both private as well as government, means minister. Moved by either private member or minister, statutory. Now why we call it statutory? What is the meaning of statute? Statute means law. So it is so called because it is a way always tabled in pursuance of a provision of constitution or a law. Means you want clarity of the House, you want to bring this clarity that House is having this stand on this law. House is having this stand on this particular constitutional provision. For that, you bring statutory resolution. Please remember it. Okay, UPSC can play on the application part, like I have explained. Youth Parliament. This is a basic term. Actually, this is a device so that our youth can be, associated with the parliamentary procedure. It means they can know what happens in Parliament. They say that acquaint the younger generation with the practices, imbibe the spirit of discipline and tolerance. Like our parliamentarians have this discipline and tolerance. In quite, we should not comment now. Inculcate in a strength community on the basic values of democracy. Parliamentary Affairs provides necessary training, Ministry of Parliamentary Affairs, so that youth can be encouraged to actually engage with what happens in our democracy. So I hope these devices are clear to you now. Hello everyone. I hope this message finds you fit and fine. My name is Shashank Tyagi. Welcome to Laxmikanth series Indian Polity Contests. We are discussing Parliament, and within that, today we need to talk about leaders in Parliament. Means leader of House in Lok Sabha, leader of House in Raj Sabha. Then we are going to talk about session part as well. Under the rules of Lok Sabha, Prime Minister is the leader of House in case Prime Minister is member of Lok Sabha. For example, Modi ji. So he is member of Parliament, member of Lok Sabha, right, from Varanasi. So that is why he is leader of House in Lok Sabha. But in case of Manmohan Singh ji, so he was member of Raj Sabha, but he was Prime Minister of India, because majority of the members in Lok Sabha supported his name for the Prime Minister position. So in that case, how we are going to decide who is going to be leader of House in Lok Sabha if Prime Minister is not member of Lok Sabha? In that case, Prime Minister can nominate a minister to be leader of House in Lok Sabha. Okay, this is what is mentioned here. Just 2 cases, right? Not a big deal. Clear? So it means leader of House in Lok Sabha position can be held by Prime Minister or Minister. Okay, if Prime Minister is there, then there cannot be any minister who can proclaim himself. Prime Minister cannot nominate anyone else, right? If Prime Minister is already present, already a member of Lok Sabha. Okay, now Leader of House in Rajya Sabha, he is a minister in case Prime Minister is member of Lok Sabha. Or in that case, if for example Manmohan Singh ji, he was member of Rajya Sabha, right? In that case, he is regarded as, you can say, Leader of House in Rajya Sabha. Okay, so you can simply remember this trick. Wherever Prime Minister is having membership, Prime Minister is going to be considered as a leader of that house. And who is going to be leader of other house? Prime Minister is going to decide. Clear? Leader of the opposition. So leader of opposition, the word itself represents opposition. But who is going to have this position? For that, the party should have at least 1/10 seats of the total strength. Okay, in general, you should have 1/10 seat, and you are, you can say, having maximum seat among other parties who are not part of government. Okay, so this position is also considered important for democracy. And you should know that leader of opposition is also given a, you can say, status of cabinet minister. Means leader of opposition is given a dedicated office, staff, you can say bungalow and car, etc. Such is the importance of leader of opposition. His main function is to provide constructive criticism. Therefore, opposition in the Lok Sabha and Rajya Sabha were accorded statutory recognition. Please remember, leader of opposition is not a constitutional position. Okay, it is given a statutory recognition by the parliament itself. Clear? So there can be a scope of question here. Clear? Whip, next character in our story. So whip is a, what do you understand by this word whip? What comes into your mind? I think some of you might be thinking of hunter. Why hunter is used? Hunter is used to, to get those, you can say, herd in the line, right? So that is the purpose of whip. Every political party in the house actually gives status of whip to any one member. So he is responsible to actually ensure discipline among party members. And what kind of discipline we are talking about? First, attendance. You should be present. If you are not present, then you should communicate it, right? Then securing votes. For example, we are presenting a bill and we need necessary votes in the house, then only this proposal is going to float. For that, whip is responsible. Whip is actually communicate to every member of the political party, we are presenting this bill on such date and I want that all of you should actually vote in support. What if they actually reject? No, I'm not going to listen to you. My friends, the decision of whip is actually will of party, and party gave you the ticket, right? Disciplinary action can be leveled against you. And some of you might be thinking, what kind of disciplinary action? What you are going to do? Whip, if you disobey whip, even your membership can be taken away. Means if you read anti-defection law, there's a provision that if party thinks that you are working against the interest of that party, right, then in that case also you can be disqualified. Okay, you should read about the case of Mr. Sharad Yadav and Anwar Ali from JDU party. They were Rajya Sabha members and they were not listening to the party advisors and they were disqualified. So whip need not to be taken lightly. Okay, disciplinary action can be taken. I hope it is clear. Regulates, monitors, clear? And I specifically told you, whip position is not given by speaker or Rajya Sabha chairman. Okay, whip position is given by party itself, right? So that their members can be monitored and regulated. Okay, it is not mentioned in constitution. It is just a convention. Please remember, there can be a scope of question here. I hope you will remember it. That is why I was saying party is actually deciding. Now, sessions of parliament. Session, we are talking about the period within which parliament is going to work, right? Parliament is going to function. So, president from time to time summons each house of parliament. Who summons? Summons means we are calling. that now you, from this date, this time, you have to start working, come to Delhi, right? And President do that on the advice of Council of Ministers. But the maximum gap between two sessions, our Constitution says maximum gap can be 6 months. Our Constitution does not tell about how many sessions you can have per year. Okay, it just tells that should not have gap more than 6 months. It means minimum you should have at least 2 sessions per year, and maximum there's no limit to the maximum. And why there's no limit to the maximum? Because Parliament is there to actually discuss the important matters, to make law. It may be possible that within a year there are 10 times urgency happened. You need new laws. You need 10 sessions. So Parliament should be allowed to have 10 sessions, right? In general, we have 3 sessions: budget session, monsoon session, and winter session. Please remember, these names are not written in our Constitution. It's not like winter is coming and now you should have winter session. No, no such mention is there. Constitution mentions just this. This is Constitution and this is Convention. Please remember the difference. UPSC play on these words. Okay. A session of Parliament is the period spanning between first sitting of the House and the prorogation. Prorogation means ending of the session. Let's understand these words through this schematic. This is the date where session is summoned by President. So President summons. Okay, and whose advice? Council of Ministers advice. Now you can see heartbeat. Tuck, 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 tuck. Finally, session is working. Now, prorogation happens. Prorogation means ending of session. Who is going to do that? Again, President is going to do that. Session ends. Okay. Then there will be gap, say 1 month, 2 months. Then there can be another summon, again by President, and then there can be prorogation. This is how our Parliament work. The period between 2 sessions is called recess. Okay. Now what happens in between? Once session is summoned, now onus is on the presiding officer of respective house. For example, in Lok Sabha, now speaker is there to actually function. Agendas of the day need to be decided and they need to be done. Now within that, is there a possibility to give some off holiday? Yes, there can be. For example, take example of Lok Sabha. Consider after working for 5 days. Now Lok Sabha speaker decided, I want to give 1 day off, right? So 1 day off. So this 1 day off will be called adjournment. Adjournment. Okay, and who does that? Presiding officer of house. In Lok Sabha, speaker. In Rajya Sabha chairman. Okay, so within that, what is happening? President is not having any role. Okay, now when the session is about to end, let session is here. At this point of time, presiding officer also actually declares another thing, that is adjournment sine die. Adjournment sine die, the word is die, right? You can remember, oh, it means now function, now the job of the session is done. Now presiding officer, say speaker in this case, has given this indication to Honorable President, sir, my job is done. Adjournment sine die. Now after few hours or after days, President can declare prorogation. It means now session officially ends. Clear? I think it is clear now. These words should be clear because sometimes UPSC play on these words, right? So during a session, the House meets every day to transact business. The period spanning between prorogation and reassembly of the new session is recess. I think it is clear to you now. Prorogation and reassembly of new session, this period is known as recess. This is the third point. Clear? Adjournment. Adjournment suspends the work for a specified time. For example, here we said 1 day adjournment is happening. Suspending the work. Adjournment sine die means terminating sitting of the Parliament for an indefinite period. I told you in adjournment sine die, speaker is saying, sir, my job is done. That's it. Speaker is not saying, oh, I am going to reconvene the House after 1 day or 2 days. No, that is adjournment. That is why no time limit is mentioned here, because purpose is that job is done. You have to indicate that terminating a sitting of the Parliament. Sitting is done. The power of adjournment as well as adjournment sine die lies with the presiding officer. Presiding officer. Okay, clearly told you. He can also call a sitting of the House before the date or the time which has been adjourned or at any time of the House had been adjourned sine die. For example, you have adjourned the House for 1 day, right? But now Speaker found that there are some emergent circumstances and I have to call House back within 2 hours. Then Speaker can say, I am cancelling the adjournment and you have to come again after 2 hours. Then you being a member of parliament, you cannot say, member of say Lok Sabha, you cannot say, oh sir, how can you change your word? You first promised 1 day off and I have planned my vacation. Then Speaker would say, what vacation you have planned in 1 day? He would say, sir, I'm in Delhi, so I have get together. Then Speaker would say, nation comes first. Within 2 hours, you should come here. If you're not here, session is not going to wait for you. We are going to continue our proceedings, right? So it means a speaker, presiding officer can actually call you back even if they have mentioned this adjournment happened and adjournment sine die happened, okay? But please remember, in case a speaker has declared adjournment sine die, job is done, and prorogation happened, and president was quite fast, president said prorogation. Now speaker cannot call back the session because now you have to summon the session again and power of summoning is with president. Clear? I think it is clear to you now. Now, the difference between adjournment and prorogation, it is cakewalk for you now. It only terminates sitting, adjournment only terminates sitting, right? This is what means speaker can do or Rajya Sabha chairman can do, presiding officer can do. But prorogation, we terminate the session. And who does that? President. It is done by presiding officer, it is done by president. It does not affect. Now this point is new for you in this particular session. It does not affect the bills or any other business. Please remember, prorogation also does not affect the bills or business. Now you would say, sir, what is the difference then? Difference is below. Just read it. But when it comes to notices which are released, for example, pending notice. So other than those introducing bills lapse on prorogation. But in this case, the notices do not, you can say, lapse. For example, let me give you an example. Session starts today, right? And after 2 days, session got adjourned for say 5 hours, right? And on the first day, speaker actually issued one notice to you. And after this adjournment, when you came back, you cannot say, sir, speaker, sir, I'm not going to listen to your notice. Because notice got lapsed after adjournment. Then speaker would say, just read the rule book of Indian Parliament. Then you should be considered yourself worthy of sitting here. Because in adjournment, notices do not lapse, right? Otherwise, it will be a hassle to actually give you notices again and again. There are so many adjournments happen for 1 hour, 2 hour and 5 days or 6 days. But when it comes to prorogation, since session ends, now again there will be a summoning. So in this case, notices lapse. When next session is going to happen, then there will be fresh notices to be released for you. Okay, I think it is clear now. Dissolution. What is dissolution? Dissolution means now it is end. Dissolution. Lok Sabha being a permanent house is not subjected to dissolution. Dissolution means now no one is member of Lok Sabha. We are going to have fresh election in Lok Sabha. Such thing happened in Lok Sabha, but not in Rajya Sabha because Rajya Sabha is a permanent house. Only the Lok Sabha is subject to dissolution. Please remember it. Unlike a prorogation, dissolution ends very life of the existing house. Because now there will be fresh election. After fresh election, there will be new Lok Sabha, new bills, new notices, everything will be new. There are two ways of dissolution. One is normal. For example, 5 years you are having the normal tenure of Lok Sabha. It is done to expiry of tenure. Then it will be dissolved. That is normal. And another is abnormal. Abnormal means in between. Prime Minister can recommend to the Honorable President, sir, I am done with Lok Sabha. I want fresh election. Then President will say, okay, I'm listening to your will, and since you are there for aid and advice of, means Article 74 says that you are there to aid and advise me. I'm going to listen to your advice. I'm dissolving Lok Sabha. There will be fresh elections, like it was done during the Indira Gandhi's time after this national emergency. So there are two ways to dissolution. Now, most important thing for us is what happens after dissolution, right? When the Lok Sabha dissolved, all business, including bill, motion, resolution, notice, petition, and so on, pending before it becomes lapse. Please remember it. This is the impact. This is important. Although there is beautiful question coming from this particular part, and I'm going to simplify this for you. There's a cliche kind of question repeated by UPSC often, that what is going to happen with the bill in case Lok Sabha get dissolved, and if the bill is pending in Raj Sabha, if bill was in Lok Sabha, if bill was in with President. So you need not to cram it. Okay, there's always a simple way to actually master things. Now, to be pursued further must be reintroduced in newly constituted Lok Sabha. Simply saying, if everything is lapsed with Lok Sabha, means these bills and if everything which was pending before Lok Sabha, it means new Lok Sabha. In new Lok Sabha, you need to reintroduce these. However, some pending bills and pending assurances. Now, this is important because this is an exception. Because even if the bill was with Lok Sabha, but bill from Lok Sabha went to this Committee on Government Assurances. So in this case, this bill will be immune from lapsing. Do not lapse. So this is an exception. If bill was not with Lok Sabha, it was with Committee on Government Assurances. So you can easily remember, oh, assurance means now this is giving assurance that it is not going to get lapsed. Okay, you can remember by this trick. Now, position with respect to lapsing of bills. Many students get confused in these cases. Just read them, and then I'm going to simplify them for you. Just read it. I think these are visible over your screen. Some students might be watching through mobile, and those who are not able to read it in a comfortable manner, they can just open their Laxmikanth. The bill pending in the Lok Sabha lapses if Lok Sabha dissolves. Condition is, when Lok Sabha dissolves, what is going to happen? Bill not passed by two houses due to disagreement, and if President has notified the holding of joint sitting before the resolution, bill does not lapse. A bill pending in Raj Sabha but not passed by Lok Sabha does not lapse. A bill passed by both houses pending before President does not lapse. A bill passed by both houses but returned by the President, reconsideration does not lapse. Now, how you are going to cram these? Let's understand in a simple manner. Consider that our President is having a security network. Means, whichever bill touches Honorable President, that bill is going to get security from lapse, even if Lok Sabha get dissolved. You can remember this. Means whichever bill is going to touch Honorable President, is going to be presented before Honorable President, this bill will be secure. And our Lok Sabha, it is having sin, shrap, because it is getting dissolved. So consider a bill starts from Lok Sabha. Okay. Now this bill is in Lok Sabha. This is the first case. And Lok Sabha get dissolved. Now what is going to be the impact on this bill? This bill will lapse. This bill will lapse. I think it is visible to you. This bill will lapse because it was there in Lok Sabha. Now second case. Bill was passed by Lok Sabha, presented before Raj Sabha, and now Lok Sabha lapsed because all the cases are regard to Lok Sabha lapse. So Lok Sabha lapsed. Now what is going to happen with this bill? This bill will also get lapsed. Why? Because it has already touched Lok Sabha and it has not touched the security of President, right? Now consider third case. If bill was presented in Lok Sabha, it went to Raj Sabha, it get passed from Raj Sabha and reaches Honorable President. Now Honorable President, when a bill touches Honorable President, it gets the security. So what is going to happen with this bill if Lok Sabha lapse? This bill will not lapse. Do not lapse. Okay. Let me put NL. Not lapsed. Clear? This case is clear? Now, okay, let me do it like this. Now, fourth, consider a bill is in Raj Sabha Okay, this is Raj Sabha here, right? And this bill is in Raj Sabha. It has not moved anywhere. And Lok Sabha lapses. What is going to happen with this bill? This bill will not lapse because it has not touched Lok Sabha. Lok Sabha is the one who is getting dissolved. Lok Sabha is the one who is having sin, right? Now, fifth, a bill introduced in Raj Sabha, but it, after getting passed from Raj Sabha, it reaches Lok Sabha. Okay? And Lok Sabha gets dissolved. What is going to happen with this bill? This bill is going to lapse. Why? It has touched Lok Sabha, right? Now, another case. Sixth case. Consider a bill was passed. We were talking about Raj Sabha now. Consider this bill was passed by Raj Sabha. It was then presented to Lok Sabha. And then from Lok Sabha, it reached to Honorable President. And then Lok Sabha lapses. What is going to happen? This bill will get secure. It will not lapse. It has reached the President status. Means it has reached till President, right? So it is safe and secure. Now, seventh case. Consider bill was released by Lok Sabha, means presented in Raj Sabha, and then any case possible we can try from this trick. And then it is presented before Lok Sabha. But now there is a struggle there. Means what is happening? There is a deadlock condition. Deadlock means no one is agreeing to the provision which was presented by other. And there has been 6 months. 6 months has been passed. Now, Honorable President has issued a letter. Honorable President has issued a letter, circular. You can remember from circle. So, and this letter says, now you have to have joint sitting. Now, what is going to happen if before joint sitting, this Lok Sabha lapses? In this case, this bill will remain secure. It means it will not lapse. It will not lapse. Because through President, a letter has reached the status. So, President's Ashirwad has reached this bill. Protection has been provided. So, in this case, it will not lapse. Okay? So by this trick, I think now you can actually easily remember all the cases here. A bill passed by both houses pending and sent to the President does not lapse. A bill passed by both houses but returned by the President reconsideration does not lapse. This is another case. Because why it is not going to lapse? Because it has already touched Honorable President. Right? So I have framed this example just to make things simple for you. Okay? I think it is clear. Now, quorum. What is quorum? I told you in the previous lecture also. Quorum is the minimum strength which is required to get House into function. That is quorum. 1/10 members are required. For example, in case of Lok Sabha, you need 55 members minimum. Then only House can function. If there are 54 members, then Speaker would say, go back your home. I'm not going to actually start the session because quorum is not complete. If there is no quorum, then what is going to be done? Adjournment ho jayega, suspension ho jayega. There will be adjournment or suspension. Voting in the House. Majority of cases, simple majority is used. Majority of votes of members present in voting. And specifically there are cases where Constitution mentions a special majority. For example, impeachment, constitutional amendment, right? So these are the two kind of voting methods which are used. Although in one of my previous Laxmikanth series video, I told you the difference between different kind of majorities. Special majority, absolute majority, right? A special majority, we have cases, then effective majority, right? The presiding officer of the House does not vote in first instance. Whoever is presiding, that person needs to be neutral, right? And if there is an equality of vote, then you can vote. This is a rule. Language of Parliament, Hindi and English are languages of Parliament. Although, by getting permission from the presiding officer, any member can actually talk in his/her mother tongue. Now, a question from you. By getting permission from the Honorable President, by presiding officer, consider presiding officer, by getting permission from the presiding officer, a bill can be presented in language other than Hindi and English. It means House can conduct its functioning in other language as well, other than Hindi and English, if permission is given by Honorable Speaker in case of Lok Sabha, Honorable Chairman in case of Raj Sabha. Now you have to tell me answer to this question in comments. Should I repeat? I'm saying officially Hindi and English are languages to conduct the function, proceedings, all the bills, right? I told you presiding officer can permit a member of to address the house in mother tongue. The word is address, means you can speak, right? And the question I framed is that by getting permission from presiding officer, member can present the whole bill in mother tongue and house can conduct its proceedings after permission from presiding officer, proceedings in a language other than Hindi and English. The statement is true or false, that you have to tell me in comment box. Okay. Rights of ministers and attorney general both have one thing common. They can actually participate in proceedings of any house, means Lok Sabha or Raj Sabha. But minister concerned can vote only in the house in which they are member. And attorney general obviously cannot vote, but can be there, can present. Right? If asked to speak on certain matter, then attorney general can speak. So this is what is mentioned here. Now, two reasons. For example, consider you are member of Raj Sabha and you are given the charge of defense ministry by Modi ji. Kripa hai aap par. Now you are member of Raj Sabha, but I am member of Lok Sabha and I am in a position. So I want to ask some question from you. What you have done with the Rafale deal? So you are member of Raj Sabha. So how can I ensure that you actually give your answer to the whole Lok Sabha? So there is a process to that. Process is, yes, you are a minister. You are allowed to present in both houses. So that means you are going to come to Lok Sabha and answer that question before the house. Okay. But that doesn't mean you are going to participate in any voting, right? So that is the purpose. Lame duck session. Consider elections are done and this ongoing Lok Sabha is conducting its last, you can say, session. It's like farewell. So this farewell session is known as lame duck session. Why? Because there may be many members who could not get re-elected to the house and they are called as lame ducks. Now attempt this question. I think it is visible. No. Let me zoom in. I think now it must be visible. Let me read it out for you. If a person is elected to both the House of Parliament, he must intimate within 10 days in which house he desired to serve. First statement, you have to tell which statement is correct. 1, 2, both, neither. Member of Parliament may resign his seat by writing to the chairman of Lok Sabha and Speaker of Raj Sabha. Now tell me which option is correct. Only one, only two, both, neither. Come on. You have 5 seconds to do that. Rapid fire. Answer is 1. Why? Those who are saying, sir, this second statement is correct. So I must say that it is a sin to say that. If someone is thinking that this statement is correct, then this thinking itself is a sinful act. Why? Because chairman of Lok Sabha is speaker in Raj Sabha. What is this? Raj Sabha has chairman and Lok Sabha has speaker. Right? There's a swap happened here. I think it is clear now. Hello everyone. I hope this message finds you fit and fine. My name is Shashank Tyagi. Welcome to this Laxmikanth series. We are continuing our Parliament chapter. Today we need to talk about presiding officers. Preside. It means to bring the house in order, you need someone to be in command. In case of Raj Sabha, that responsibility is with chairman. Whoever is going to be Vice President of India is going to have this position of Raj Sabha chairman. In case of Lok Sabha, this position is held by speaker. So if we categorize separately Lok Sabha and Raj Sabha, in case of Lok Sabha, we have speaker, then deputy speaker, then panel of chairpersons. A speaker and deputy speaker, these are elected from among the members of the Lok Sabha. Okay, but when it comes to panel of chairperson, they are nominated. Nominated by whom? Nominated by a speaker of Lok Sabha. Okay, in case of Raj Sabha, we have chairman, deputy chairman and then panel of vice chairpersons. So again, so you know that when it comes to chairman, this position is held by VP, right? In case of deputy chairman, this position is elected one, okay? Means this person is member of Rajya Sabha, okay? Now when it comes to panel of chairpersons, this position is nominated one. And who is going to nominate? Chairman of Rajya Sabha is going to nominate member of this panel. Now why we are having these panels? As I told you, presiding is an important responsibility. You need someone in command to bring the house in order so that agenda of the house works are finished, right? So consider there's a day where speaker is not there, deputy speaker is not there, then we need someone to preside the house, right? For example, say there are 10 members from Lok Sabha. These are not from outside. These members in these panels are from within the house. Means when we talk about panel of chairperson, they need to be member of Lok Sabha. When I say panel of vice chairperson, they need to be member of Raj Sabha. Okay? So anyone, I'm saying anyone, any one of them can actually preside the proceedings of the house. So that this Lok Sabha should actually continue its work. Okay? Now, let's deal with speaker first. So what is the tenure in election? As I told you, a speaker is someone who is already member of the house. Means this position is elected one. Told you na, elected. Speaker, deputy speaker, elected. Elected by the Lok Sabha from amongst its members, right? A speaker remains in office during the life of the Lok Sabha. For example, in 2019, there were elections in Lok Sabha, right? And in those elections, Mr. Om Birla, so he got elected as Lok Sabha MP from Kota in Rajasthan, Kota parliamentary constituency. Now, from among the members in the Lok Sabha, majority of members are of BJP. So they elected, so there was an election within the Lok Sabha. So they elected Mr. Om Birla as speaker, 17th speaker of Lok Sabha. Okay, that's how he got elected. Now, normal tenure of Lok Sabha is 5 years, right? So till that point, he can be in this position. Is there a possibility that he can be removed also? Yes, he can be removed. There's a process to that. But normally, he can actually continue for 5 years. We are going to understand the process of removal as well. Now, however, he has to vacate his office earlier in any of the 3 cases. Number 1, he ceases to be a member of Lok Sabha. Consider that he went abroad and now he has applied for citizenship of USA. Okay. So if he has got citizenship of USA, now on this basis, his Indian citizenship will be revoked, right? So if someone is not a citizen of India, do you think that person can continue to be a Lok Sabha member? No. So it means he will cease to be a member of Lok Sabha. Now since he ceased to be a member of Lok Sabha, he has to get removed from the position of Lok Sabha speaker also. So in short, you can say, even if he resigns, means he resigns by writing to the deputy speaker, in that case also, this position of Lok Sabha speaker need to be vacated by him, right? Also remember, resignation in written to be given to deputy speaker. UPSC can make a statement that that speaker is going to give resignation, submit resignation to honorable president. But you should get aware, no, it's not president, it is deputy speaker. Okay? If he is removed by resolution passed, now I told you removal process is also there. Now how he can be removed? Resolution passed by majority of all the members. Now please read. This is the statement which is given in Laxmikanth. But I have differences with one word in that statement. I am going to tell you why, but first read that. By a majority of all the members of the Lok Sabha, all the members, majority of all the members, Lok Sabha, such resolution can be moved only after giving 14 days advance notice. So this part is correct, the 14 days advance notice to be given. But if I ask, what kind of majority do you think is needed in Lok Sabha to remove a speaker? Some of you would say, sir, majority of all the members. So if all the members, all the seats are 100, so you would say that, sir, we need 51, means absolute majority, right? But my friends, please take a look what official website, government website says, means Lok Sabha. There's a website speakerloksabha.nic.in, and just read the statement. The speaker can be removed from office only on a resolution of the House passed by a majority of all the then. The word is then members of the House. But in Laxmikanth, the addition I have, and many additions that I have referred, the word is majority of all the members. Then word is missing. Now you would think, sir, what then makes difference? Yes, it makes difference. All the then members means majority of those members who are there, and the vacant seats are not going to be included. For example, there are consider total strength of houses 100. Okay, 100. This says majority of all the members. So majority of all the members would be 51, right? But official website says all the then. For example, 20 seats are vacant as of now. Someone died, someone disqualified, someone resigned, right? Now, as of now, consider we have all the then members, means the present members. We have 80. So now the majority required to remove the Lok Sabha speaker would be 41, not 51. That is why if UPSC asks question, please mark effective majority, because this is the definition of effective majority. Because UPSC is going to follow what official website is saying. And same is the case with Raj Sabha chairperson. There also all the then members is written, right? You can just search rajsabha.nic.in. There also you are going to find the sentence. Okay? So please remember, it is effective majority. Clear? Now, when a resolution for the removal of the speaker is under consideration, so if a speaker is being removed, do you think that person should be given a chance to preside this session? No, right? So he cannot preside at the sitting of the House, though he may be present, because he is member of House, right? So he can be present like a normal member. Okay? However, he can speak and take part in the proceedings of the House at such a time and vote in the first instance. Please remember, when speaker is getting removed, resolution for the removal of speaker is actually in the process, then speaker can actually vote. But vote as a normal member, right? Not as a presiding officer. And why first instance is used? Because you can say there's a process that whoever preside the House, means whoever sitting, and in command, then that person should show neutrality. That is why it is said that you should not vote in first instance. In case there's a matter is in tie, then you can actually vote casting vote, right? To actually remove this tie. Okay? First instance means when first round of counting is done, you can vote there. Though not in the case of equality of votes. And there is equality of vote. Obviously, there's no case of equality of vote when presiding officer, speaker is not presiding officer, acting as a presiding officer in case of removal. He is sitting like a normal person. She's sitting like a normal MP, right? So no, so this particular case is not going to be counted even, right? Now you would ask, sir, who is going to preside? If speaker is sitting among the crowd, then deputy speaker will. And if deputy speaker is ill at that day, then any one member from the panel of chairpersons. That is what I have told you. Now, whenever the Lok Sabha is dissolved, the speaker does not vacate. There can be a statement-wise question on that. Please remember. Because in the start I said, the Lok Sabha speaker will remain till the life of Lok Sabha, right? Tenure of the Lok Sabha. But there's a tradition there. Consider that Lok Sabha is dissolved early. Or consider that there's a fresh election happened, right? But still, there should be continuity in the working of Lok Sabha, because Lok Sabha speaker's job is not just to preside the House. There's a separate Lok Sabha secretariat also. The official work, all the bills which need to be presented, all the questions coming in, the communication with different department, ministries, all being coordinated by Lok Sabha secretariat. And who heads the Lok Sabha secretariat? Lok Sabha speaker. So even if Lok Sabha is dissolved, then she should continue to be in that position and should resign, should actually demit from the office just before the first sitting of the newly elected Lok Sabha. Okay? continue till the newly elected Lok Sabha meets. And the day newly elected Lok Sabha meets, you should actually go your home. Okay, if you are again elected from quota, then you can present in the Lok Sabha as a normal MP. Okay, then it will be decided whether you will be elected as Lok Sabha Speaker or not. Okay, now role, power and functions of Speaker. Head Lok Sabha, as I told you, preside Lok Sabha and actually heads Lok Sabha Secretariat also. Guardian of powers and privileges of Lok Sabha, right? Powers, which powers we are talking about? Lok Sabha Speaker is going to decide which bill need to be presented first, which need to be presented last, how you should actually have agenda. Even the disqualification power means to disqualify an MP in case of anti-defection. This power is with Lok Sabha Speaker, as well as privileges. For example, Lok Sabha's speakers, you can say, has this privilege that whatever he comments in the House cannot be questioned in court of law. He cannot be criticized in the court or within the House, right? Such is the privilege to maintain the decorum of the House. Principal spokesperson of the House, he maintains order and decorum. He adjourns the suspend the House in case quorum is not complete. What is the quorum? Quorum is the minimum number of members which are required, then only proceedings can continue. That is 1/10 of the House. For example, if total strength is say 100, okay, to make it simple for you, then 1/10 is 10. Only when 10 members are present in the Lok Sabha, then only proceedings of the House will continue. Otherwise, Speaker will say, go back to your home. I'm suspending, adjourning the session. There will be no session today. You should show respect and at least quorum need to be maintained. He presides over the joint sitting. In case there's a deadlock between Lok Sabha and Rajya Sabha over a bill and President says you have to sit in a joint sitting. So in that case, who heads the joint sitting? Presides the joint sitting? Speaker. In case Speaker is not there, then Deputy Speaker. Okay. I've marked here that joint sitting is not presided by Rajya Sabha chairperson. So this is the difference between Speaker and Rajya Sabha chairperson. There are statements on comparison also many times asked by UPSC. Decides whether a bill is money bill or not. This power is only with Speaker, not with Rajya Sabha chairperson. He decides the question of disqualification of member. I told you anti-defection law. Same means this power is also with Rajya Sabha chairperson. Okay, for example, Mr. Venkaiah Naidu. So he pronounced this disqualification of Mr. Sharad Yadav and Anwar Ali from JDU party. So they were member of Rajya Sabha from JDU. So they were disqualified by Rajya Sabha chairperson. He acts as the ex-officio chairman of the Indian Parliamentary Group. So there is Indian Parliamentary Group which is given chance to go abroad, learn new practices in different parliaments. So ex officio means who is going to be speaker, he is going to be chairman of Indian Parliamentary Group. He appoints the chairman of all parliamentary committees, means parliamentary committees of the Lok Sabha. Who is going to appoint? The chair appoint. Speaker is going to appoint. Now Lok Sabha Speaker, independence and impartiality. If question is saying which of the following points can be regarded as, you can say, provisions which support impartiality of the office of Speaker, right? There can be a means-based question also. In GS paper 2, sometimes UPSC asks direct provision-based questions also. In 2016, I think around 80% paper was actually on this provision type, okay? And there are other years where, dynamic side was more in GS paper 2. So you should know some keywords, okay? Impartiality. How? In case of tenure, this security of tenure. It means if there is speaker, he should act as neutral, right? So he cannot be removed until and unless process of removal is followed. So there is a process of removal, right? And effective majority, I told you. And it needs support of at least 50 members to even discuss. Okay, so it shows security of tenure to some extent. His salaries and allowances are fixed by Parliament and cannot be changed during his tenure. His work and conduct cannot be discussed and criticized. That's a privilege. His powers are not subject to jurisdiction of any court, although Supreme Court can now actually do this judicial review. For example, on disqualification also. Many times questions are raised before Supreme Court also, so they can check whether facts were correct or there was no malified intention. He cannot vote in the first instance, right? Because he's there presiding, so he has to be neutral. can vote only when there's a equality in votes. He is given high position in order of precedence. Deputy Speaker of Lok Sabha, elected by the Lok Sabha from amongst its members, same, like Speaker is elected, same Deputy Speaker is also elected from amongst the members of Lok Sabha. Also please remember, the word is deputy, okay? So it means primary responsibility to preside is with Speaker. If Speaker is not there, then Deputy Speaker has this responsibility, right? But when Deputy Speaker is acting as presiding officer of Lok Sabha, then he or she enjoys the power of Speaker, okay? If he ceases to be a member of Lok Sabha, then seat need to be vacated, resigns. Now, Deputy Speaker resigns to Speaker, please remember it. In case of, how you can easily remember it, in case of Speaker, he gives written resignation to Deputy Speaker. In case of Deputy Speaker, he gives written resignation to Speaker, okay? If he is removed by a resolution passed by the majority of all the then members of the Lok Sabha, such a resolution need to be presented before, means 14 days notice need to be given. So these conditions are same, you just need to change here. Role, power and functions. First, perform the duties of Speaker when Speaker is not there. Presides over joint sitting if Speaker is absent. He is not subordinate to the Speaker. As I told you, when he is presiding, then he enjoys equal power. And in general also, it is said that you are not subordinate. What is the meaning of not subordinate? If UPSC wants to play with you, then they can also ask an A and R kind of question. Means they will give a statement and a reason also. What is the reason of not subordinate to the Speaker? What is the meaning of this? The meaning is that he is not answerable to Speaker. He or she is answerable only to the House. That is why we are not considering subordinate, right? So in Pushpa movie's dialogue, it would be like, deputy देखकर subordinate समझे क्या? Subordinate नहीं है अपन, equal है, right? So it means this deputy speaker is not responsible to Speaker, okay, answerable to Speaker. He can only exercise a casting vote in case of a tie. It applies with every presiding officer. Whenever he is appointed as a member of parliamentary committee, so he automatically becomes the chairman, such is the stature. When a resolution for the removal of the deputy speaker is under consideration, same, he cannot preside, right? If removal is being done, then he should not preside, but he can sit like a normal member of parliament and he can vote also, same as case of speaker. He is entitled to a regular salary and allowance fixed by parliament, same, right? Up to 10th Lok Sabha, both speaker and deputy speaker were usually from the ruling party. From 11th Lok Sabha, so the convention changed and speaker position was held by a ruling party member and deputy speaker by opposition party member. But if you ask if someone is deputy speaker as of now, no. The position of deputy speaker is vacant as of now. And there were articles as well on this, why there's no deputy speaker. Means the party in power, having majority vote, can actually appoint someone from other party as deputy speaker if they want. They can have election, but such thing has not happened. Now, panel of chairpersons of the Lok Sabha. I've already explained this to you, that rules, now under the rules of Lok Sabha, the speaker nominates. In the starting of the video, I told you, this is nominated position, not elected one. A speaker nominates, okay, among the members of the panel. So whoever is going to be member of panel should be member of Lok Sabha, okay. Any one of them can preside over the house in case speaker and deputy speaker are absent. He has the same power as a speaker when he is acting as a presiding officer. He holds office until a new panel of chairperson is nominated. Please remember, UPSC play in this nominated and elected game. It should be clear in your mind. When a member of panel of the chairperson is also not present, then what is going to happen? And there are two probability, means two kind of questions can be asked, two statements. If speaker is not there, deputy speaker is not there, whole panel is not there, then what? Then house can actually appoint someone for that day to preside the house, okay? Any other person as determined by the house act as a speaker, Okay. Now, let's take another scenario. Consider Speaker resigned and Deputy Speaker died. It means now these both positions are vacant, not absent, vacant. Now tell me, who is going to preside? You would say, sir, panel of chairpersons, anyone from them can preside? No. Reason is that this panel was nominated by Speaker and the Speaker of position is vacant. So the Speaker who nominated these members is not Speaker anymore, right? So in this case, President is going to appoint someone for acting as Speaker at that point of time, okay? So panel of chairperson cannot preside over the House when the office of the Speaker or the Deputy Speaker is vacant, okay? During such time, the Speaker's duties to be performed by such member of the House as President may appoint for the purpose. I think now it's clear to you, okay? Pro tem Speaker. Pro tem. So pro tem is a temporary position. For example, just before the first meeting of newly elected Lok Sabha, I told you that the former Lok Sabha Speaker is going to demit the office, right? Now, for the first meeting, we need someone to preside the House, right? So in that case, President appoints one pro tem Speaker, like a temporary Speaker, okay? And this pro tem Speaker has two duties, only two functions. Number one, oath. Oath to all the new, means those members of parliament who are coming, joining, in this newly elected Lok Sabha. So give oath to them. And second, conduct election of Speaker, actual Speaker, right? So the two functions. And who is generally appointed as pro tem Speaker? Senior most member is generally appointed. Although there's no, you can say, mention in law that only that senior most is going to be appointed, but there's a convention. Constitution, the Speaker of the first Lok Sabha vacates his office immediately before the first meeting, the newly elected Lok Sabha. Therefore, the President appoints a member of the Lok Sabha as pro tem Speaker. I already told you. Usually, the senior most member is selected the President himself administers oath to the pro tem Speaker. So, President administers oath to the pro tem Speaker. The Speaker pro tem has all the powers of the Speaker and presides over the first sitting of the newly elected Lok Sabha. Main duty, two duties, and oath to the new members enables the House to elect a Speaker. Please remember two duties. Now, new Speaker is elected by the House, the office of pro tem Speaker ceased to exist. Means now it is gone, right? It's a temporary office. I think it is clear now, right? So, just remember this. If any question arises whether a bill is money bill, so decision of Speaker is considered final. Okay, I told you also in the functions also, there's a difference that when it comes to deciding a bill as money bill or not, this power is only with Speaker and not Raj Sabha Chairman. Let's start with some questions. Which of the following are not a session in Parliament? So our Constitution does not mention any name, first of all. But in news you must have read budget session, monsoon session, winter session. You must not ever heard of summer session. So summer session is not mentioned, okay? Summer session is not used. Now, insight here is that our Constitution does not mention any of these names also, but these names are used. Our Constitution mentions between two sessions of Parliament, there cannot be gap of more than 6 months. So 12 months in a year, 6 months maximum gap. So it means at least we are going to have 2 sessions per year, at least. In general, we have 3 sessions, budget session, monsoon session, winter session. Although there can be other sessions also, special sessions. If President summons the House, then there can be, you can say, special sessions, okay? So minimum 2 sessions, maximum there is no limit, and these names are not mentioned in our Constitution. I think it is clear. Which of the statement is not correct about Lok Sabha Speaker? Sometimes UPSC is asking some, factual questions also. Indian Polity, 1-2 questions. So please attempt. Meera Kumar and Sumatra Mahajan are the only 2 women Lok Sabha speakers so far. This statement is correct. Tenure of Lok Sabha Speaker is 5 years, correct. In total, 17% have served as Lok Sabha Speaker. If you remember, I told you, Mr. Om Birla is 17th, right? Whenever Lok Sabha dissolves, the speaker resigns from the post. This is incorrect because I told you, even after Lok Sabha dissolves, the speaker is going to continue till the day when the next day is the first session of newly elected Lok Sabha, right? So this D is not correct. Clear? Hello everyone. I hope this message finds you fit and fine. My name is Shashank Tyagi. Welcome to our Laxmikanth series, Contests means we have to master Indian polity. Today we need to talk about Indian Parliament, one section from where you are going to find short questions in your exam. But devil is in detail here, and we have to tame the devil today. Let's start with the basics. Parliament. It is the legislative organ of Indian political system. When I say legislative organ, it means purpose is to make law. So it is based on Westminster model. So Westminster is a place in Britain where British Parliament is situated. Okay. In part 5, we talk about Parliament, means from Article 79 to 122, which are in part 5 of Indian Constitution, we find provisions with respect to Parliament. Now this is the structure of Parliament. It means Lok Sabha, Rajya Sabha and President. Please keep in mind, President is part of Parliament, not member of any house which are considered as part of Parliament. Because when I say Parliament, what comes into your mind? There's a picture, okay, there's a room, big room, members of Parliament are sitting, they're debating, right? That's how your image, you have having image of Parliament, right? But here we are talking about Parliament as a concept, okay? Within this, you have 3 components. And why we have the structure? Purpose is, consider a particular bill is actually proposed in this house. Then it will go to other house for scrutiny, for debate, for addition, subtraction, right? If you want to add something, if you want to subtract something, then you have to give this bill back to the Lok Sabha so that they can also be on consensus. Okay? It means both the houses need to be on consensus on one format of the bill. Then it is presented before Honorable President, and when President signs, then this bill becomes an act. It means President is an essential component of lawmaking process. Clear? Now, as I told you, President is part but not member. Does not sit in the Parliament to attend its meetings. Okay? Now, Rajya Sabha and Lok Sabha. One set of question can be asked on names because UPSC has asked question on such facts as well. Rajya Sabha, the name is Rajya. Rajya means state. So this is also called as Council of States. And why it is called Council of States? Because members in Rajya Sabha are actually elected by the vote of MLAs of states. It means people like you and me, considering you are not a member of Parliament, you are like you're a student and preparing for civil service exam, right? So we do not vote in Rajya Sabha election. Who votes? State Legislative Assembly members, means MLAs. So it means if MLAs are sending representatives, choosing, this person is going to represent interest of our states at the level of Parliament. That is why, because representing the interest of state at the level of Parliament, that is why it is called Rajya Sabha, okay, or Council of States. Sabha means council, state means Rajya, right? Upper house. Why upper house? Basically, this concept is taken from British Parliament, right? They have House of Commons, lower house, and then House of Lords. Purpose of this House of Lords, and similar to the purpose of Rajya Sabha, was that we are going to bring more experienced people as member in these houses, in this house. People who are not going to fight an ordinary election. Means they won't fight election in which people, means voters are going to vote. Means like people like you and me. But they are intellectual. They have concern for, betterment of India. And they they may be having some political clout. So these people can be present in this Rajya Sabha and they can contribute in lawmaking process. And it's also called House of Elderlies. As I told you, more experienced people were actually becoming member in House of Lords in Britain. Do we have some fact which is actually proving this House of Elderlies? Yes. If you want to become member of Rajya Sabha, the minimum age required is 30 years. But if you want to become member of Lok Sabha, minimum age required is 25 years. So, senior members you are going to find in Rajya Sabha. Okay. Now, Lok Sabha. Lok means people. Sabha means a house, means a group. We can say council. But in this case, the word uses house of people. House of people. And why house of people? Because adult citizens of India who are registered in voting list, they actually vote for representative in their respective constituencies. It means the members of Lok Sabha are coming from direct election from the people, right? So it means that is why this is House of People, directly representing the interest of people of their area, from which they fought the election and won this election. House of Representatives and Lower House. This is upper house, this is lower house. House of Representatives, representatives of people. Now, if I ask, I'm making a statement and you have to tell me the statement is true or false immediately in comment box. Rajya Sabha is considered as first house, Lok Sabha is considered as second house. Statement is true or false? Statement is false. Because Lok Sabha is considered as first house and Rajya Sabha is considered as second house. You will say, sir, these are seniors and they are considered as second house. Yes. And what is the reason behind it? Reason is power of Lok Sabha with respect to some bills. Means in law making process, that is the prime objective of parliament. In law making process, there are some bills in which Lok Sabha has more power than Rajya Sabha, and that is why it is considered as first house. Those bills can only be introduced in Lok Sabha. Which are those bills? What is the process? We are going to talk about it. Clear? Now, composition of two houses, Lok Sabha and Rajya Sabha. So we need to understand composition, then election process, duration and term, qualification and disqualification of Lok Sabha and Rajya Sabha. We are going to talk about them together. Okay? Now, composition. 250 is the maximum strength of Rajya Sabha. I am using the word maximum. Okay? But as of now, 229 seats in Rajya Sabha are represented by state. Means state legislative assembly members vote for the members who are going to become member of parliament in Rajya Sabha. Right? So this is for states. 4 seats are representing UTs. Now you will say, sir, all UTs? No. UTs of Delhi, Pondicherry and now Jammu and Kashmir also. Although this composition is mentioned as such as of now, and there was an RTI which was filed recently before Election Commission as well. Ki, sir, as of now you are saying 4 members are going to be represented by UTs, and these UTs which are having MLAs. Means, for example, Delhi and Pondicherry, so these are union territories. And the traditional model of union territories, union is going to have control over this territory. But in case of Delhi and Pondicherry, this is not the complete case. Because people also elect their respective MLAs. They have legislature. So this power is divided, right? So they have some features of state. And that is why they're also given share, opportunity to participate in election of this Rajya Sabha member. They also have representation. So as of now, 233 are elected and 12 are nominated. It means no election is needed. You only need Kripa of Honorable President. And to be precise, not just Kripa of President. President is going to be given a list by Council of Minister headed by Prime Minister. So please appoint these people as Rajya Sabha members. So President will nominate you. Okay. So 12 members nominated, right? I think this is clear. So as of now, the total strength is 245. Maximum is 250, but 5 seats are not being used. Now, representation of state. How representation is ensured? So there are 3, you can say, major questions here. First is voting. Who is going to vote in Rajya Sabha member election? As I told you, MLAs of these states in 2 UTs. Third is also added, Jammu and Kashmir. Seats. So seats are based on population. It means compare the population of Uttar Pradesh with Goa. Do you think Uttar Pradesh and Goa are going to have equal number of seats in Rajya Sabha? True or false? No, there's a difference. And why the difference? Because in Uttar Pradesh there's more population, so it is considered, since they are more populated, they need more representation in Rajya Sabha. Okay, so population is a criteria. Third, process. What is the process of election? Proportional representation and single transferable vote, like we discussed in case of president election and vice president election. I hope you remember. So this is the gist you can remember. Representative states are elected by the elected members of state legislative assemblies. As I told you, seats are allocated to the state basis of population. Okay? If I ask how seat allocation in the upper house of Indian Parliament is different from the upper house of US legislature. Tell me, because in one of my previous video, I told you this. Come on. There's a difference. And difference is every state in USA is allotted 2 seats. There's no criteria of population in US legislature. But we have population as the basis. Okay? So please remember these details, because sometimes UPSC asks question, make the statement comparative in nature. Okay? Elections are held with a system of proportional representation, single transfer vote. I explained you this in president election as well. Now, representation of UTs, Delhi, Pondicherry, Jammu and Kashmir. So voting done by MLAs. But there's an interesting twist here. If UPSC make a statement, as mentioned in Constitution, in election for Rajya Sabha members, Delhi, Pondicherry or Jammu Kashmir name is yet to be added in Indian Constitution with respect to UTs. So consider they are going to use Jammu and Kashmir when it is added, are done by MLAs. My point is, our Constitution has not specifically mentioned this, that in UTs, representation is going to be ensured by MLAs voting. There's a twist here. So what's the reality? Reality is this. Representative of each union territory in the Rajya Sabha are indirectly elected. Indirect election happens. In Rajya Sabha, there's no concept of direct election. Please keep in mind. Right? There's no concept of direct election, because when I say direct election, what does it mean? It means people like you and me are voting in Rajya Sabha. Right? There's concept of indirect election in Rajya Sabha because MLAs vote, not we people directly. Okay? Members of an electoral college specially constituted for the purpose. So this is mentioned, right? And who are the part of special college, constituted for this purpose? MLAs. So practically MLAs are voting, but specifically word MLA was not mentioned. Okay? Elections are held with a system of proportional representation and single transfer vote, and seat allocation is done on population. That is why Delhi is having representation of 3 Rajya Sabha MPs, but when it comes to Pondicherry, it is having only 1. Jammu Kashmir case is yet to be decided. When I am making this video, as there is an update by government, I am going to update this in my Telegram channel. You can reach out by Shashank Tyagi for you. You can just type. And if you have any doubt whatsoever from any section of Indian polity which you find there's tough, or some article in which you are struggling, you can shoot me a message on Telegram also. That is shashank.powerbeing, or you can search Shashank Tyagi for you. I can be reached on Instagram on this as well. Now, nominated members. The president can nominate 12 members and nominated members. Do you remember Sachin Tendulkar, Rajya Sabha MP? Also, Rekha, Bollywood actress, Rajya Sabha MP. How these people become Rajya Sabha MP? They did not fought Rajya Sabha election. They were nominated, right? And what are the bases? There are 4 bases: art, literature, science, and social service. And if a statement is made, Sachin Tendulkar was nominated in Rajya Sabha in the category of sports persons. Contribution is sports. Tell me that statement would be true or false? That would be false, because there is no such category of sports. It is art, literature, science, and social service. He was appointed under category of social service, because when he used to play, then whole nation used to get united. That Sachin, right? So that is why you should remember these details. Now, duration and term of Rajya Sabha. Rajya Sabha is a permanent house. It is a continuing chamber. It means it is not dissolved. When I say dissolved, it means there will be no point where there is no member in Rajya Sabha. You would say, sir, what does it mean? Compare with Lok Sabha, na? In Lok Sabha, when general elections happen, so before that, these people were Lok Sabha member, and it may be possible that Lok Sabha is dissolved and now fresh elections are going to be held. So when Lok Sabha is dissolved, it means it is done. Now there is no person representing a particular constituency in Lok Sabha. Now election need to be there. Although election commission ensures that before completion of tenure, elections are held, right? But the point is, Lok Sabha can be dissolved. Dissolved means no member. But this is not the case of Rajya Sabha. It's a continuing chamber. So how it is ensured? It is ensured by this formula. 1/3 of its members retired every second year. What does it mean? Consider 20 plus 20 plus 20 equal to 60. Okay? So consider, we suppose that 60 is the total strength of Rajya Sabha. Okay? So we are just making this up to simplify things for you. Okay? So this is the total strength. Out of the total strength, 1/3 of its member retired every second year. So now 1/3 member. 1/3 is this. 1/3, right? 20 member. So now these 20 member need to retire every second year. So consider these are retired means in 2022. Okay? 1/3 will retire every second year, means now in the next second year, after 2 years, these are going to retire, and these are going to retire in say 2024, right? Now what about them? 2026, right? Now think of these members. So these came into house in 2022. So 23, 24, 24, 25, 26 means it's been 4 years. 22 to 26, it's been 4 years. Still, they are in Rajya Sabha. Now next election has to happen after 2 years. So now 2 more years are going to be used. So now these people whom we actually discussed as the first, now these people are in position for 6 years. Right or wrong? Yes. So it means there will be no point where all the members of the Rajya Sabha means they are losing their membership at one point. Okay? This will not be a case that their term will complete, together. This difference has been created in completion of their term. Clear? Now why this formula, why this arrangement was made? So that there remains a permanent house. Means there should be no point in the history and the future of Indian political system when there is no house. Means there's no possibility that no house is there. There may be a possibility that we need to discuss some important issues. So there should be one house, right? So Rajya Sabha will be working. Rajya Sabha will be available. Okay? Now, I'm asking one more statement. Constitution specifically mentions Raj Sabha members' tenure to be 6 years. Now tell me the statement is true or false. Statement is false. Because Constitution has not mentioned this 6-year term for Raj Sabha member. Constitution has mentioned this arrangement, and this arrangement itself mean that a person got appointed, this elected in 2022 will remain till 2028, right? So UPSC will play on these words. Please remember. Retiring members are eligible for re-election any number of time, and there is no foundation on age as well. You are 110 years of age and you have ambition to become Raj Sabha member, congratulations. You can become. Okay? Constitution has not fixed the term of Raj Sabha. As I told you, there can be a question. Constitution has not fixed. Is it mentioned somewhere? Yes, it is mentioned in a law made by Parliament, which Parliament made later. I'm talking about RPA, Representation of People Act 1951. This mentions that Raj Sabha members shall be for 6 years. Okay? So mentioned in a law made by Parliament but not in Constitution. Clear? Now qualification for the members. Should be citizen, 30 years of age, any such qualifications which are declared by the Parliament. And where Parliament declares such qualification? Representation of People Act. So he must be registered as an elector of a parliamentary constituency. Means if you want to become a Raj Sabha member, you should actually at least be registered in a voting list in any constituency in India, right? And if you want to fight for a Raj Sabha seat which is in reserved category, say SC and ST, then you must be actually registered as SC and SC in any of the constituency, any of the state. Means he must be a member of scheduled caste, scheduled tribe in any state UT if he wants to contest seat reserved for them. Okay. However, people of SC ST category can also contest from unreserved seat. Okay. For reserved seat, SC ST is going to fight. But if you want to fight, you need to be registered as SC and ST in any of the state or UT. Now, my question to you, and this question I am giving to you. You have to find the answer and let me know in comments. You know that there is difference in the SC list of many states. It means that a person may be registered as SC, may get a certificate that yes, this person belongs to scheduled caste. But if this person goes to another state, it may be possible that other state is not recognizing that person as a scheduled caste. If such differentiation happens, does it have some impact on Raj Sabha election as well? Means if you are getting elected from representing UP from Raj Sabha, UP in Raj Sabha, so is it mandatory that you should have a certificate of that SC category which is recognized as SC category in UP? If you are having a SC category from say some other state, say Andhra Pradesh, but that category is not recognized as SC category in Uttar Pradesh, now tell me, can you still become a Raj Sabha member representing UP? Or you need to fight for Raj Sabha election from Andhra Pradesh? Interesting twist. Search about it and let me know in comments. Purpose of these kind of questions is to open your mind. If you develop this skill set in polity, there can be no question in exam which you cannot mark correctly or answer in a fluent manner at the mains level. Now, oath. Oath is given by President to all Raj Sabha members. Now we need to talk about Lok Sabha. Composition, election process, duration, qualification and disqualification we need to talk together after this. Lok Sabha. Lok Sabha, only elected members are there. There's no nominated member case. Please remember it. Earlier there were 2 seats of Anglo-Indians in Lok Sabha, but now there's no mention of 2 seats because it was removed in 2020. Maximum 552, but as of now 530 are representing states, 13 UTs, it means total 543. Okay, and this Anglo-Indian case is removed. This is composition. Representation of states, directly elected. I told you in case of Lok Sabha, direct election happens. There is no case of indirect elections in case of Lok Sabha. Okay, indirect election happened in Rajya Sabha. And there is no case of direct election in Rajya Sabha. So this is opposite. Easy to remember, right? Elections are based on principle of universal adult franchise. What does it mean? Voting is going to be done by those citizens who are adult and registered as voter in electoral, list of election commission. Representation of union territories chosen by direct election held in union territories. For example, Delhi. Delhi is a union territory. So there are 7 seats. There are 7 constituencies in Delhi, right? So now on these seats, now representation by union territories chosen directly, direct election happens, as Delhi is also divided into Lok Sabha constituencies. People, give vote in Lok Sabha election, and these representatives represent respective constituencies in Lok Sabha. Okay. Nominated members are removed. Okay. Now easy to remember. States direct election in Lok Sabha, UT also direct election in Lok Sabha. States indirect election in Rajya Sabha, UT's indirect election in Rajya Sabha. And who votes? In case of Lok Sabha, universal adult franchise, and you should have registered voter in voting list, and in this case MLAs vote. Clear? Now system of elections in Lok Sabha. As I told you, direct election. But how constituencies are actually made? How division of constituency happens? So please remember, this is the logic. Means number of Lok Sabha MP seats which need to be allocated to a state divided by population. This ratio needs to be same so that there can be uniformity with respect to number of seats allocated to different states in Lok Sabha. There should be no biasness. To remove this biasness, this formula was made. Okay, this was the basis. So allocated a number of seats in the Lok Sabha in such a manner that the ratio, as I told you directly, ratio between the number and its population is same for all states. There can be a statement on this in your exam. The provision does not stand for states having population less than 6 million. If less than 6 million, then this formula need not to be applied. Each state is divided into territorial constituencies. It means area is divided. Okay. In case of Rajya Sabha, there is no such territorial constituency, no territorial representation. There is proportional representation. If you are a Rajya Sabha MP, you are representing the interest of whole state, from where you got elected, from where MLAs of that state voted for you. But in case of Lok Sabha, constituencies are divided territorially, right? For example, wherever you are living in India, you should also know that your area is also representing one territorial constituency, right? Such manner that the ratio between population of each constituency and number of seats allotted same throughout the state. In simple terms, there should be uniformity in representation throughout the constituencies. Okay, area, population. And readjustment after each census. So idea was, since population is a criteria regarding allocation of constituencies, area of constituencies, so population changes. So constituency also changed, but this constituency change did not happen. Means we followed this 1971 census. The reason was, after 1971, government initiated and called upon state that they should actually take steps so that population, growth rate can decrease, right? Population should be managed. Southern states did fairly well in that. States like Kerala, Tamil Nadu, Karnataka, they have done good job when it comes to managing population. But the states like Uttar Pradesh, Bihar, these northern states, so they have progressed in terms of population. Now, if we revisit the census, and if we use say updated census, say 1991 or 2001, so don't you think there will be a huge gap between the population, right? Earlier in 1971, consider the gap was this, but these people managed population, so that is how they increased to this level. But the other states, say northern states, they increased in this level. So there's a huge gap. Don't you think if population is the criteria for allocation of seats, now it will be wrong for the southern states? Because they have less population, they may be allocated less number of seats. Now southern states will say, oh, this is wrong for us. Means we did good. Means it is like we have done our homework and we are punished for that. Our representation in Lok Sabha is reducing, right? So in the backdrop of this logic, 42nd Constitutional Amendment Act 1976 happened. It froze the allocation of seats in the Lok Sabha, froze. 84th Amendment Act 2001 happened, extended this ban on readjustment for another 25 years, that is still 2026. We are living in 2022. 2026, 84th Amendment says they should be frozen. 87th Amendment Act proposed one idea. It said, let's do one thing. Major contention is that southern states are saying and the states are saying we have done well, we managed our population growth rate, and it would be injustice for us. Let's do one thing. We are not going to change the number of seats allocated to states in Lok Sabha. Let's do the internal readjustment. The boundaries of states can be changed, provided for the delimitation of constituencies on the basis of 2001 census without altering the number of seats allotted to each state in Lok Sabha. So this was a middle path. I hope it is clear. Reservation of seats for SC and STs. I'm making a statement, you have to tell me statement is true or false. There's a mandatory reservation for SCs and STs for all states and UTs with regard to representation in Lok Sabha and Rajya Sabha. Now tell me the statement is true or false. Let me reframe this sentence. UPSC can also say there's a mandatory minimum number of seats which need to be reserved in Parliament, if say Lok Sabha, Rajya Sabha, from every state and UT. Now the statement is true or false? You would say, sir, it is true. Right? I think now you're clear with the readjustment after census, right? Please remember the amendments. Now reservation of seats for SCs and STs. What it says, Constitution provides for reservation of seats for SCs and STs in Lok Sabha on the basis of population ratio. Originally this provision was for 10 years, but later it was extended. Under 95th Amendment 2009, the reservation will last until 2020. But 84th Amendment Act 2001 provided for refixing the reserved seats on the basis of population 1991. Then 87th Amendment says 2001. Purpose is that yes, SC/ST reservation is there based on population. Demand is that we need to reassess this on the basis of 2001 census. Proportional representation is not adopted. Why proportional representation is not adopted in the case of Lok Sabha? It is there in Rajya Sabha, not in Lok Sabha. These are the reasons. First of all, we are following territorial representation in Lok Sabha. Means territories are divided, right? So now this is easy. Okay, this is less expensive. Every member of the legislature represents a geographical area. This is the meaning of territorial representation. Okay, that is why we call it constituency. From each constituency, only one member represents. It is not possible that from one constituency, two MPs are saying, I am also MP from this constituency. No, this cannot happen. Because we follow the system of single member constituency. One person is going to win the election. In this system, candidate who secures majority vote is declared elected. Simple majority system of representation does not represent this whole electorate. That is why this system is used. It means, clear as the simple point is that consider that there are 100 members in a constituency. And out of them, only 30 people came out of their home and voted. And there are other members as well. Other members say different parties. So out of this 100, only 30 came. Out of this 30, consider you were fighting the election. You got, say, 9 votes. Okay. Others got, say, 3 votes, 4 votes, 6 votes, etc. till this complete to 30. Now, since you are getting, maximum vote out of these votes, you will be declared as winner. you will be declared as winner. Congratulations. But this is also a basis of criticism, that out of 100 members in constituency, only 9 members supported you. And now you are going to be representative of all 100 members. This simple majority concept, the last point, is not used because simple majority concept says, okay, those who are voting, say 30, at least you should get more than 50% of the people who voted. But no one would actually get more than 50% of the people voted. This will be quite difficult, right? You have to then conduct election again and again. There's a system in Europe. We call it second ballot system. I think it is clear now. Proportional representation of for the general election is not adopted. Why it was not adopted? Difficulty for the voters to understand the system. I hope you remember when I was telling you ballot paper, multiple, you can say, options. I was explaining you this in President chapter, right? So it would be quite difficult. Unsuitable for the parliamentary government due to tendency of the system, because there are different political parties and we need to ensure clear majority, right? And there may be a possibility that there are multiple parties coming together and then forming, you can say, government. So this will become actually quite cumbersome. It is highly expensive. Highly expensive, why? Because in general election you are using this territorial, representation. You have EVMs on different booths, and we know there can be voting. From these booths, these many votes were actually given to this party or this candidate. But in this case, you have to recount. You have to use this ballot, right? So this would be quite tough. It does not give any scope for organizing by-election. By-election possibility is not there. It eliminates intimate contact between voters and representatives. Because if there's territorial representation, you know that I represent this particular territory. You will come to these people. You will ask them their vote. You will interact with them. Otherwise, they are not going to vote you in the next election, because people know exactly who is our representative, point of contact. But in proportional representation, you will be representing the whole state. There are now 100 people representing the whole state. Whose door we should actually knock? Who should be the direct person who is directly responsible? Right? There should be some direct responsibility. Promotes minority thinking, group interest. Minority thinking is not a negative sense. It is in positive sense. That you should think about your constituency, your group. Increases significance of the party and decreases of the voter. If we adopt this. Now, term. So, normal term is 5 years. Okay, it is not a permanent chamber. President can dissolve the Lok Sabha at any time if get recommendation from the Honorable Prime Minister. The term of Lok Sabha can be extended during national emergency, I told you, 1 year at a time till infinity. Means any length of time, because no boundation there. Qualification for member of Lok Sabha, citizen of India, 25 years of age, and this is oath. Must possess qualification prescribed by Parliament, and qualification mentioned in Representation of People Act, right? Registered as an elector in parliamentary constituency, and then SC angle, ST angle is same, like we discussed in Raj Sabha. Oath is given by President. Disqualifications. Office of profit, unsound mind. If person is, has gone mad and court has declared, then it means that person won't be able to continue his duty or her duty. Undischarged insolvent. You have taken so much loan that your known sources of income and your total assets are not going to be pay that loan back. It means you cannot be trusted with public money. Not a citizen of India. Consider you got elected as MP in India, Lok Sabha MP, but you went to US and there you fall in love with a girl, or a girl, if you're a girl, then you with a boy there, and you got married and you actually applied for the citizenship there. So our authorities will be intimated about your, wonders there. Okay, so they will give you blessings in a way, ma'am or sir. Your citizenship is revoked, first of all, and because this is the criteria for a Lok Sabha membership, so you need not to come to Parliament, because now your Lok Sabha membership is taken away. Clear? She is disqualified any law made by Parliament. If Parliament make a law that if this person does this, then this person will be disqualified. So these laws will be applicable on disqualification. Now, with disqualification, you need to remember three broad categories, three categories. One is constitution. If you flout the rule which is mentioned in constitution, like citizen of India. Second is mentioned under RPA, like we are talking about. And third is anti-defection law, 10th schedule. So these are the three broad categories on the basis of which any member of Lok Sabha or Rajya Sabha can be disqualified. Okay, I told you we are talking about Lok Sabha Rajya Sabha disqualification together. He must not have been found guilty in certain election offences. You fraudulently won the election and now it is proved disqualified. If it is found that, consider you were engaged in a murder, means you did a murder. Taking your example, take it lightly. So you are convicted for 5 years and at that point of time you were sitting Lok Sabha MP. So you will be disqualified because 5 years is more than 2 years. Account of elections, you did not give the account of election to Election Commission. This can be a basis of disqualification too. If you are interested in some government contract, it means you took some government contract. That is also wrong. It can be a basis. If there's a company in which more than 25% you can say stake is with government and you are managing director there. So it means you are drawing some profit from there. So this will be counted as office of profit and you can be disqualified. Dismissed from government service, consider you are an IAS officer and you got dismissed from service on corruption charge or disloyalty to the state. And now you thought, okay, I am dismissed. Now I am going to fight election and be part of Lok Sabha or Rajya Sabha. You cannot. Because Representation of People Act says that dismissed from government service on charge of corruption. So is there a way out for you? Is there a scope for your political career? Yes, there can be. If you appeal in Supreme Court and Supreme Court actually changed this, you can say earlier judgment, and it is proved that no, you were not engaged in corruption, then that's a possibility. But if you are dismissed on this basis and this is the paradigm given by court, then you are gone. Your political career is finished. Obviously, I am talking about Lok Sabha, Rajya Sabha. Okay. He must not have been convicted for promoting enmity between different groups. If you are found that you are doing hate speech and due to which there's riot going on and you are convicted for the same, then you are also gone. He must not have been punished for practicing social crimes. Consider that you have taken dowry and your wife has filed a case and it's proved that, yeah, dowry harassment happened. Then my friend, your political career is also finished. Disqualification. Untouchability or sati. Okay, untouchability is also there. Please remember, because UPSC play on these kind of details. Okay, this is also a basis of disqualification from Lok Sabha, Rajya Sabha. Now, disqualification on ground of defection. As I told you, third criteria is anti-defection law. So, if consider you got elected on a party ticket, say Aam Aadmi Party, but you voluntarily give up the membership of the political party on whose ticket you are elected, then you are going to be disqualified. Please remember it. Okay. Now I am making another statement. Let's go into depth. Consider you got elected on Aam Aadmi Party ticket in Lok Sabha, but you did not give up the membership voluntary. Actually, party kicked you out. Now tell me, if party has kicked you out, now tell me, do you think your Lok Sabha membership is going to be, you as a Lok Sabha member is going to be disqualified? Answer is no. You will still be Lok Sabha MP. But if party has kicked you out and you have joined another party, say BJP or Congress, then you will be disqualified. Okay? If he abstains from if party has told you that on this bill you have to vote in favor, but you said no. In Shashank sir's class, I have read Article 19. In Article 19, freedom of speech and expression, I am going to use it. I am going to vote against what my party is saying. So my friends, I am not going to come to save your seat, because you must read this chapter as well. As I am telling you, this will be a basis of your disqualification. Okay? If any independently elected member joins political party, there are some members who get this Lok Sabha seat or Rajya Sabha seat independently. without fighting on a seat ticket of any party. So if they joins any other party now, this will be a ground of disqualification. Now these criteria are for elected members. Now for nominated, consider Sachin Tendulkar. So within 6 months, if you want to join any party, you can join that party. But after 6 months are passed, after expiry of 6 months, if you join now any party, then it will be a ground of disqualification. Now, who is going to disqualify on the basis of anti-defection, on the basis of defection? Defection means you are changing your party. So this decision is taken for Raj Sabha by Raj Sabha chairman and Lok Sabha by Lok Sabha speaker. Please remember it. Now, vacating seats in parliament. So, on what basis a seat can be vacant? Double membership. Consider you are fighting from 2 seats and won from 2 seats. Consider you are fighting Lok Sabha and Raj Sabha and you got elected in both. So, double membership. In case of double membership, 1 seat is going to, you need to actually vacate. Disqualification, resignation, absence, others cases. Let's understand them one by one. Double membership. UPSC can ask question from here. Please remember it. Understand it. A person cannot be a member of both the houses. Okay, you have to be member of one house from 1 seat. You need not to show heroism. You need not to become hero here because provision does not allow you to do so. Representation of People Act provides for the following, that if you are actually elected to both the houses, then you must intimate within 10 days which house, which seat you want to leave. In default, if you have not intimated, in this case, your Raj Sabha seats is going to be vacant. Okay, if you are getting elected to both house, Lok Sabha, Raj Sabha. If a sitting member of one house, you are already a member of one house. Okay, you are fighting just one election for the other house. Also elected to the other house, his seat in the first house becomes vacant. Because now it will be considered that you are not satisfied with your membership one house. That is why you are fighting for the other house, right? If a person is elected to the 2 seats in house, for example, Modi ji fought election from Varanasi as well as Vadodara, right? So he should exercise option for choosing one. Otherwise, both will go. Okay. Disqualification. So first was double membership. In this case, seat can be vacant. Now disqualification. If a member of parliament becomes subject to any disqualification, be it constitution, be it RPA or anti-defection. So these are the 3 criteria. So this can be a ground of vacation. Resignation. You can give resignation to Raj Sabha chairman if you're a Raj Sabha member. You can give resignation to speaker if you're a Lok Sabha member. Absence. If you have not intimated, took permission of Lok Sabha or Raj Sabha and you are absent for more than 60 days, then this can be a basis of declaring that now you are not member of our house. On this absence, on the basis of absence, your seat will be vacant. Now other cases, a member has to vacate his seat in the parliament if election is declared void. It is found that you fought election on fraudulent basis. Expelled from the house, elected to the office of president, vice president, is appointed to the office of governor of a state. Obviously, on these basis, you need to vacate your seat. Now, just attempt this question. Which of the following statement are not correct about the Lok Sabha speaker? Lok Sabha speaker is elected by the Lok Sabha from amongst its members. We need to talk about presiding officers in the next class, but I am bringing this question so that you can read a bit. The date of election of Lok Sabha speaker is fixed by President of India. M.A. Iyengar was the first Lok Sabha speaker. It is true that Lok Sabha speakers now, please remember, Lok Sabha speaker, for example, Mr. Om Birla from Kota. Lok Sabha speaker is always a person who is member of Lok Sabha, right? And there is no nominated member, it means elected, right? And the election date is decided by Honorable President. So Lok Sabha speaker is elected from amongst his members, and the date of election of Lok Sabha speaker is fixed by President of India. Okay? Please remember, in Lok Sabha speaker case, only Lok Sabha members are going to vote. Okay? All Lok Sabha members. The very first Lok Sabha speaker was G.V. Mavalankar. In this question, M.A. Iyengar is given. That is why 1 and 2 is correct. Clear? Hello everyone. I hope this message finds you fit and fine. Welcome to our Laxmikanth series. Today we need to talk about cabinet committees. In previous class, we were talking about Council of Minister. And there I told you that cabinet ministers are the most important ministers, having important portfolios, part of inner circle of Prime Minister. Now these cabinet ministers are arranged, or you can say organized, in different committees so that major decisions can be arrived at after this discussion. Now what are the features of these committees? Number one, these are not mentioned in our constitution. It means these are extra constitutional. Please remember it. UPSC can make a statement, cabinet committees are constitutional bodies. Constitutional bodies are those which are mentioned in constitution, but cabinet committees are not mentioned. Can you say that cabinet committees are unconstitutional? No, unconstitutional means that these bodies are against constitution. These are not against constitution. These are working for upholding the spirit of constitution, right? So not mentioned in constitution. And how they're going to function, there's a separate rules of business which were made by the government, okay? So there are two types of cabinet committees. One, standing committee. Standing means permanent, means on some important issues, for example, political affairs, for example, economic affairs, for example, appointment, cabinet committee appointment. So these are regular business. You need standing committees, permanent cabinet committees for that. Others are ad hoc committees. For example, there are some issues which have just cropped up, right? And you need certain cabinet ministers to sit together and decide what needs to be done. So those are temporary and for special purpose. The membership of these cabinet committees varies from 3 to 8, and usually include cabinet ministers. Now, I'm making a statement, you have to tell me it is true or false. In cabinet committees, only cabinet ministers can be members. Tell me the statement is true or false. Answer is false. Because although we are using the word cabinet committee, and cabinet ministers are the, you can say members, but it doesn't mean that other ministers are debarred from becoming member. A special arrangement can be done. However, the non-cabinet members are not debarred from their membership. Okay, in special case, these non-cabinet members means other members of Council of Ministers. For example, Union Minister of State for Independent Charge, right? They can also be made member of a particular cabinet committee. Okay, so a question can be made on this particular angle. So please remember it. Now, they include ministers in charge of subjects as well as other senior cabinet ministers. Okay. Apart from this, they are mostly headed by Prime Minister. It means all cabinet committees are not headed by Prime Minister. Okay. Other senior cabinet ministers can also head a particular cabinet committee. They are not only there to sort out issues, formulate proposals for cabinet. What does it mean? For example, there are 12 members in a cabinet committee, right? And they are discussing a particular policy issue. And now they have arrived at a conclusion. And they have communicated this to Honorable Prime Minister. So, on this issue, this policy needs to be made. Then who is stopping you? Means certain decisions can be taken by cabinet. But this decision is taken at the stage of just cabinet committee. Now, cabinet committee will communicate this decision to the cabinet. Okay, we have arrived at this discussion. Now, cabinet should agree on this decision which we have arrived at. Okay, in this way, the decisions can be taken in a swift manner. Okay, clear? Now, list of cabinet committee. So, these are the cabinet committees. For example, cabinet committee on political affairs, most important cabinet committee. Cabinet committee on economic affairs, as the name is suggesting. I'm going to talk about functions as well. Cabinet committee on appointment for crucial appointments, secretary level appointments, PSUs, top positions. Cabinet committee on security, parliamentary affairs. For security, you can understand if our Air Force need new aircrafts. So who is going to ensure that yes, this needs to be done? Cabinet committee on security will actually take this decision. Then this will be communicated to the Defence Ministry. Then within Defence Ministry, there is DAC, Defence Acquisition Council. Then they will actually ask that other nations and other bodies who are actually making these aircraft to actually apply for the tenders. So it means crucial, you can say point is this cabinet committee on security. Now this cabinet committee on parliamentary affairs, it is going to take care of the bills which need to be raised in the House. Cabinet Committee on Accommodation, important, you can say Delhi Lutyens area, accommodation need to be provided to the department heads and the other crucial people. Cabinet Committee on Investment and Growth, Cabinet Committee on Employment Skill Development, as name is suggesting itself. Now, functions, political affair. It is known as super cabinet. Why? Because domestic and foreign affairs, crucial decisions are taken by this committee. So name is like, yeah, there are other members in Council of Ministers, there are other members in cabinet, but the real power on domestic and political affairs is with Political Affairs Committee. So it is headed by PM. Okay. Now, Cabinet Committee on Economic Affairs, which is going to take important decisions on economic aspects. For example, recently Cabinet Committee on Economic Affairs was in news for enhancing, means increasing the minimum support price on Rabi crops. So this decision was taken by Cabinet Committee on Economic Affairs. Appointment Committee, as I told you, top positions, PSU, Cabinet Secretariat, means secretary level positions, financial institution, top positions. So these important decisions are taken by Appointment Committee of Cabinet. So is it like that person will be invited to this Appointment Committee on Cabinet and this person will be given appointment letter? No. Many times these positions are actually, the people are appointed by President, but the recommendation is given by Appointment Committee of Cabinet. Similarly, Parliamentary Affairs Committee, as I told you, it is going to prioritize which bill need to be presented in the House. So these are headed by PM, and when it comes to this, it is headed by Home Minister. Okay. Now, Group of Minister, this is another term, Group of Minister. It is a different arrangement from Cabinet. Means certain ministers will be given responsibility that on this issue you need to discuss, arrive at conclusion, and whatever conclusion you are going to arrive at, we are going to think of making policy on that. So some of these group of ministers have been empowered to take decision. So there can be a question by UPSC on this in your prelims. Can group of minister take decision on behalf of cabinet? Yes, it is possible on behalf of the cabinet, whereas the others make recommendation of the cabinet. So it depends on the group of minister you're talking about. Okay, it may be possible that 3 senior cabinet ministers are given this title of group of minister on this issue. So now the decision which they are going to take is going to be considered as a decision for cabinet. Okay. Now, there is a scope of prelims as well, means question on the basis of recommendation which were made by second ARC with regard to functioning of these cabinet committees. So just let's discuss the observations of second ARC. They are saying constitution of a large number of GOMs, cabinet committees, and say GOMs, means from these some ministers are given this title of group of ministers, has resulted into many GOMs not being able to meet regularly. And if they are not being able to meet regularly, don't you think it is going to hamper the functioning? Significant significant matters are stalled due to this. So this is the one point. Second is more selective use of institution of group of minister would perhaps lead to more effective coordination. Means this should be used in selective manner and coordination need to be ensured, because ultimate objective is that decisions need to be taken swiftly. There is need to ensure that existing coordination mechanism of group of minister function effectively and help in early resolution of issues. Because cabinet is bigger, and within this cabinet, we have cabinet committees and group of ministers were made so that decisions can be taken at faster pace. So this needs to be ensured. Now these were the cabinet committees which were in news. Cabinet Committee on Economic Affairs, as I told you, minimum support price has been increased on Rabi crops. And now tell me, when it comes to suggestion with regard to minimum support price, which body is responsible for actually suggesting government? Answer is CACP. UPSC also asked this question in prelims once. Commission for Agriculture Cost and Price. So the decision is not taken by Minister for Agriculture. This decision is taken by this body, Commission for Agriculture Cost and Price. Now, my question to you is, search about SAP. This is a star point from my class. Means this is CACP. But what is SAP? What are state administered price? Also search about what is FRP, fair and remunerative price. UPSC can make a statement. So just search about it. Cabinet Committee on Security was in news because it has given assent for procurement of 56 transport aircraft for Indian Air Force. So I hope you are getting the function. I am giving examples so that function can connect in your mind. Cabinet Committee on Political Affairs, which is the most powerful of all committees, told you super cabinet, was reconstituted. Reconstituted Cabinet Committee Political Affairs comprised Prime Minister and 12 union ministers. Hello everyone. I hope this message finds you fit and fine. Welcome to our Laxmikanth series. In our previous class, we were talking about Prime Minister. Today, we need to talk about Union Council of Minister. Nature of questions from this section are based on provisions which are mentioned in our Constitution. It means, moreover, direct in nature. We are going to understand these provisions in step-by-step manner in this video. And thereafter, I am going to present some MCQs for you to attempt in this class. Now, union. It means we are talking about union government. Council of Minister. Why our constitutional framers use the word Council of Minister, not Group of Minister? One reason is, when you use the word Council, the members here are having responsibility to discuss, deliberate important matters, and the outcome of this discussion is going to have some impact on policies. It is moreover formal in nature. But when we use the word group, it can be used in many senses, maybe informal senses. Okay? So our Constitution uses the word Council of Minister. Okay? Consider, here we have Prime Minister. Prime Minister need ministers for effective functioning of government, right? Prime Minister need various departments to be headed by these ministers so that Prime Minister can ask what you have done. I have given you this responsibility, right? So some people, means some ministers, are considered of inner circle of Prime Minister. Important portfolios, important ministries are given to these people. So these ministers are considered as minister of cabinet rank. Cabinet ministers. Okay. Thereafter, there are other ministers as well. Union Minister of State. And then there is third circle, we call them deputy ministers. Okay. Although, in place of deputy minister, often the word used is Union Minister of State. And senior to this Union Minister of State, then we use the word Union Minister of State independent charge here. So what is this? We are going to understand it. Now, so we adopted this pattern from Britain, and it is headed by Prime Minister. The features of parliamentary system with respect to minister are not that much extensively or detailed manner. They are not mentioned in our Constitution. Specifically, some provisions are mentioned in Article 74 and 75. 74 mentions that there shall be a Council of Minister headed by Prime Minister to aid and advise Honorable President. Right? Now, Article 75, it mentions about appointment, tenure, responsibility, qualification, oath, salary, allowances, etc. So whenever it comes to Council of Minister, you just need to remember two articles, Article 74, Article 75. Why? Because UPSC nowadays in some statements play on these facts, right? It's not like you have to cram every article, right? Specifically means which are in news, right? Now, Article 74, as I told you, there shall be a Council of Minister headed by PM to aid and advise Honorable President, right? There's a debate on what is the meaning of this aid and advice. Is it mandatory or this is just an advice? President has an option whether to choose or reject. So this discussion was taken up at Supreme Court level, and as of now we have seen that even our Parliament has amended in our Constitution, 42nd Constitutional Amendment Act, 44th Constitutional Amendment Act deals with the definition, the meaning of aid and advice. During the Indira Gandhi time, she amended the Constitution and she said that this advice is binding. Later, when Morarji Desai formed the government, so he amended by 44th Constitutional Amendment Act, and he said at least for once, President can actually, send back this advice for reconsideration. But when it is again given to President, now President is bound to accept this advice. So means one chance was given by 44th Constitutional Amendment Act. Clear? The advice tendered by ministers cannot be inquired into any court. Please remember it, right? To give them you can say, an immunity, right? Article 75, what are the other provisions? Now, appointment. So, ministers are appointed by Honorable President on the advice of Prime Minister. And this advice, which is given by Prime Minister to President, is binding. Because Council of Minister is Prime Minister's Council of Minister, right? That is why this much independence need to be given to Prime Minister, right? Now, when it comes to number of ministers, so in our original constitution, there was no limit. And that is why some governments actually made, so many people as ministers. So now you would think, what is the harm? Harm is then all of these people need to be given some, government accommodation, bungalow, car and other facilities. So don't you think it would be, you can say, burden on the government exchequer, taxpayers' money? And apart from this, if there are so many ministers, then there will be a coordination issue, right? So now we have 15% limit. It means 15% of Lok Sabha members. Means total number of seats in Lok Sabha, you can have 15% members as ministers. And when I am saying minister, I am talking about council of minister, all kind of minister, right? So now a member of either house, now we are talking about anti-defection. If a particular minister is disqualified on behalf of anti-defection. Now my question here from you, can you just mention in comment box by which Constitutional Amendment Act anti-defection provisions were added in our constitution? 10th schedule in our constitution talks about anti-defection law. By which amendment this was added? Answer is 52. And thereafter, this 91st Constitutional Amendment Act 2003, this says that if a particular person is actually disqualified as a member of house, whether Lok Sabha, Raj Sabha, then there will be some limitation on this person becoming minister. Otherwise, what would happen? Let me give you one idea. In 1965 to 1971, data says around 4,000 legislators who were elected, whether a state legislature or union legislature, out of them around 50% of these MLAs, MPs, they defected into other party. When I say defected, it means they changed the party. Now some of you would say, sir, what is the harm? There should be freedom, whichever party they want to join. But my friends, if these legislators join different party, then it can create political turmoil. It can actually reduce the majority, turn majority into minority of the union government. So then government will fall. Then we need fresh elections. So don't you think it will harm the continuity in policy making? It will create extra burden on election machinery, right? So that is why, to bring political stability, this 52nd Constitutional Amendment Act 10th schedule anti-defection law was added. But we wanted to actually put a curb on these people getting appointed as ministers. So for a specific period, you cannot be appointed as minister if you are disqualified in anti-defection law. That is what I am saying in 1991st Constitutional Amendment Act. Clear? Minister hold office during the pleasure of president. Who appoints minister? President, right? And who can remove minister? President, right? Council minister shall be collectively responsible to Lok Sabha. Please remember it. In 2014 prelims paper, there was one statement that union minister, council of minister, is responsible to parliament. But it is Lok Sabha. Because union council of minister is there, they are ministers because their party is enjoying majority in Lok Sabha. The point they lose in majority, their government will fall, right? President shall administer oath. So who gives oath to these ministers? President gives oath. Okay. A minister who is not a member of either house, parliament, so that person can become actually minister for 6 months. Consider, you are watching this video and you are above, say, 25 years of age. Although Constitution has not mentioned specifically that in which category the 6 months criteria will work. It simply says that even if you are not a member of Lok Sabha, Raj Sabha, you can be appointed as minister. right? But within 6 months, you have to become member of either house. If you don't become, then your ministership, it will go, right? You have to resign, you will be dismissed. Salaries and allowances of ministers shall be determined by Parliament, please remember, right? It is not like specific amount of salary and allowances of ministers is mentioned in our constitution. No, it is decided by Parliament. Let's talk about 77 article. Conduct of business of the Government of India. All executive action of the Government of India shall be taken in the name of President. We discussed in President chapter also. Orders and instruments are made and executed in his name shall be authenticated in such manner as may be specified by rules. And who is going to make the rules? President is going to make the rules. I discussed in President chapter as well. Further, the validity of an order of instrument which is so authenticated shall not be called into question on the grounds that is not instrument made executed by President. There is an immunity. President shall make the rules for the more convenient transaction of the business of the Government of India and for allocating among ministers of the said business. Now, some of you might be thinking, so this we have read in President chapter as well, why it is mentioned here? Because of this last point. It means portfolio decision is actually taken by Prime Minister, that which minister is going to be given which department, which ministry. But actually officially this allocation is done, allocation of business is done by Honorable President. Okay. Article 78, duties of Prime Minister, we discussed in Prime Minister chapter as well. I told you Prime Minister is like a link or bridge between President and Council of Ministers. I also told you that if President want information with respect to any legislature, any legislation, any bill which was in consideration in Council of Ministers, then Prime Minister is bound to give such information to Honorable President, right? We discussed it. Duties of PM of the President so require submit the consideration of Council of Ministers any matter which has not been considered by the Council. Any matter which was told that it will be considered, but if it is not considered, then Prime Minister is bound to give such information, such report to President. President can ask. Article 88. Right of ministers with respect to houses. Consider, you are a member of Rajya Sabha, okay, and you are appointed as Minister for Home Affairs. Home Ministry is under you. Now tell me, do you think that you will be allowed to take part in the proceedings of Lok Sabha as well? You would say, sir, you just told me that I am member of Rajya Sabha. If I am member of Rajya Sabha and I am given ministerial berth, and I am asking that can you actually present in the proceedings of Lok Sabha? How is it possible? If I am Rajya Sabha member, I will be present in Rajya Sabha. But this is different in case of ministers. In case of minister, it may be possible, since you are having home ministry, some member from Lok Sabha want to ask some question, and that question has been submitted to Lok Sabha Speaker. Sir, I want to ask this question with regard to internal security from Home Minister. Then you will receive a letter from Lok Sabha Secretariat that, sir, you are Minister for Home Affairs and our Lok Sabha member want to ask this question from you because it is connected to your department. You have to come. So you can take part in the proceedings of both houses. Okay. So every minister shall have the right to speak and take part in proceedings of either house. Clear? There can be a statement kind of question from here. Please remember it. Any joint sitting of the House, committee of the Parliament of which they may be named as member. But please remember, purpose of these parliamentary committees is to keep a check on executive, to keep a check on these ministries, right? So that is why even if you are invited there, so you are not going to vote in this committee. If ministers are given power to vote in these committees, then don't you think it will compromise the transparency, right? Transparency to keep a check on these ministries, right? So this is what I have mentioned here. Laxmikanth mentions obviously. Nature of advice of minister. Now, I told you 42 and 44th Amendment Act, they were dealing with the definition of aid and advice. 42nd said advice is binding. 44 said let's give one chance to the Honorable President to give back this advice, right? Now it is quite clear to you. Please remember 42 and 44th are dealing with Council of Minister advice to President. So as of now, for once President can give back, and the second time President has to accept. 1971, Supreme Court held that even after the resolution of Lok Sabha, means even if Lok Sabha dissolves, then it is not like Council of Minister will go home. It will not be like there will be no Council of Minister in India. There will be a caretaker government. And why Supreme Court said this? Supreme Court said, since Article 74 says there shall be a Council of Minister headed by PM to aid and advise President. It means at every point of time, executive actions by President should be based on aid and advice of Council of Minister. Right? Does not cease to hold office. Article 74 is mandatory. Okay? And therefore, the President cannot exercise executive power. Like I explained this to you, without the aid and advice of Council of Minister, any exercise of executive power without aid and advice will be considered as unconstitutional, because as per Article 74. Is it clear to you now? Right? When it comes to aid and advice, please remember 74, 42, 44th Constitutional Amendment Act. Clear? In 1974, now Supreme Court elaborated further. The court held that wherever the Constitution requires satisfaction of the President, so the meaning of word satisfaction of President is not individual satisfaction of the President. It means satisfaction of the Council of Minister. Such is the importance of Council of Minister. Clear? Now, appointment of ministers, I told you, PM gives the advice to the President, then President appoints. Usually the members of Parliament, either Lok Sabha, Raj Sabha, are appointed as ministers. Even if you are not member of Lok Sabha, Raj Sabha, you can be appointed, but you can be there for 6 months. Right? Now, question is, whether nominated members can also be appointed as minister? Nominated member of Raj Sabha. So there is no actually clear-cut, you can say, limitation, or you can say Supreme Court means Constitution has not said this. Nominated members cannot be appointed as minister. So if it is not said it like this, the Constitution is not saying it, it means this can be done. Right? A person who is not a member of either house of Parliament can also be appointed as minister, but within 6 months. 6 months, this I discussed in Prime Minister chapter also, become a member of either house and either elected or nominated. Right? Otherwise, he ceased to be a minister or she ceased to be a minister. Within 6 months, you have to become member of either house, elected or nominated. Clear? Oath is given by President. Now, in 1990, Mr. Devi Lal, so he took oath of Deputy Prime Minister from Honorable President. So some legal luminaries of the time, they said that since our Constitution has not mentioned any post such as Deputy Prime Minister, then this oath-taking ceremony is unconstitutional. So on this point, Supreme Court said, no, there is nothing unconstitutional, because Deputy Prime Minister position is descriptive in nature. It means it is descriptive, whether mentioned in Constitution or not, it is just describing one thing. Although Deputy Prime Minister will be there to actually support Prime Minister, will be part of Council of Minister. So you should consider that Deputy Prime Minister is part of Council of Minister. Salaries and allowances, I told you, they are decided by Parliament. Determined by Parliament. A minister gets salary as payable to a member of Parliament. But since you are a minister, you are also given additional allowances. For example, free accommodation, travelling allowance, medical facilities, etc. Some additional allowances are given. Base salary remains same. Responsibility of minister. So we use two words here, individual responsibility and collective responsibility. When I say collective responsibility, it means these ministers are collectively, jointly responsible to Lok Sabha, because majority factor of Lok Sabha is mandatory. They swim or sink together, right? If no confidence motion get passed in Lok Sabha, it means that now they are not having confidence of the house. Otherwise, how could a no confidence motion get passed? Because you have majority in the house, more than 50% members are yours. So how can more than 50% people say this, that we reject this government? So it clearly means that you don't have majority. So that is why they can sync together. When the Lok Sabha passes no confidence motion against Council of Ministers, all ministers have to resign, including the ministers who are from Raj Sabha. Now there can be a question here. In this case, tell me, do you think, say, if a particular member is member of Raj Sabha and that member is, say, minister, so after this resignation, is it mandatory that that person need to resign from Raj Sabha membership also, or that person will resign only from ministership? What do you think? Answer is only from minister position. Means this person will remain as Raj Sabha member. Okay. Now it is the duty of every minister to stand by cabinet decisions. Cabinet decisions. As I told you, cabinet is the inner circle. So real power lies with them. They take the policy decisions and they are communicated. These decisions are communicated to various members of Council of Ministers, and now these ministers has to agree. If you do not agree, then you have a choice. Choice is resign. For example, Dr. B.R. Ambedkar, C.D. Deshmukh, Arif Muhammad Khan, these ministers actually resigned from the post of minister just because they were not agreeing with the decision of their government. Arif Muhammad Khan is, as of now, Governor of Kerala. Individual responsibility. I told you two responsibilities are there. Individual responsibility because they are working on the pleasure of President. At any point of time, if Prime Minister advises, then President can send a letter, now you are not minister, right? Dismiss. The President removes minister only on the advice of Prime Minister. It's not like any day now President thinks, oh, this particular minister is not working good. Then it's not like President on his own cannot remove. Okay? Because Council of Ministers is of Prime Minister. President can remove a minister even at a time when Council of Ministers enjoys the confidence in the Lok Sabha. Okay? Please remember it. Why? Because here President can remove a minister. We are not saying President can actually remove Council of Ministers. Council of Ministers cannot be removed by Honorable President till the time this Council of Ministers enjoys majority in Lok Sabha, majority support in Lok Sabha. But individual minister can be removed in between because Prime Minister can recommend, right? No legal responsibility is there. It means that there is no provision in the Constitution that the system for legal responsibility of minister. The decisions which are taken, the advice which you are given, now this is actually beyond, you can say it cannot be questioned in the court. Now some of you might be thinking, sir, does it mean no matter how much corruption a minister does, there will be no legal responsibility? No, we are not talking about it. We are talking about the functions which minister has to do in official capacity as mentioned in Constitution. Anything which is of malefied intention, obviously that can be questioned in court. If you have done some corruption, that can be questioned in court, right? It is not required that an order of the President for a public should be countersigned by minister. So our process is not like if President has signed, now it need to be countersigned by minister. It is not like this. Actually, in our departments, in our ministries, when an order is being issued by a minister, so minister will actually have a noting in the file in the name of Honorable President, such decisions are being taken, and then this minister is going to sign it. No need to route every file to the President. Composition of Council of Ministers. As I told you, there are three categories of ministers: Cabinet Ministers, Minister of State, and Deputy Ministers. At the top of all these, Prime Minister is the supreme head, and you know, after that there are Cabinet Ministers. Cabinet Ministers had important ministries, for example, Home, Defence, Finance, External Affairs, etc. It may be possible that Prime Minister decides that now Power Minister is going to be given the status of Cabinet Minister. After some time, Prime Minister can say, now I am not giving Power Minister as status of Cabinet Minister. I want to give this person a status of Union Minister of State, independent charge. So such discretion is with Prime Minister. Okay. So the members who are part of cabinet, so cabinet is the real powerhouse. They are the one who actually take important policy decisions, be it which kind of bill which need to be presented by this government in this Lok Sabha or Raj Sabha, or foreign policy decisions, important issues of which our society is facing, in which government intervention is required. So important decisions are taken by cabinet. Their role is important. Then comes the Minister of State. So here the word state does not need not to be connected with state of Uttar Pradesh provinces. No. Union Minister of State, it means they are below cabinet ministers. The Minister of State can either be given independent charge or just attached to certain cabinet minister to support that particular cabinet minister. What does it mean? If independent charge word is used, Minister of State independent charge, it means that although you are not cabinet minister, but you will have some departments, ministry, for which you will be solely responsible. Considerable amount of power is given. But when we don't use this word I, just Union Minister of State, it means you will be supporting some cabinet minister. You will be working as a union minister. Some duties will be given to you and you have to perform those duties. So in both the cases, work under supervision, guidance, as I told you, in relation with their ministries, department as cabinet ministers. However, they are not members of the cabinet and do not attend the cabinet meetings. Means Minister of State will not attend the cabinet meetings until unless they are specifically invited for particular agenda. Okay. Deputy ministers, sometimes this Minister of State, those who are not given independent charge, they are there just to support some senior ministers. They are also called as deputy ministers, right? Because here we had this division of independent charge and not having independent charge. So they are actually not given independent charge. They are there to support cabinet ministers or for specific departments, right? Then we have this term parliamentary secretaries. So parliamentary secretaries are considered junior most position, although they are not officially called minister because they are not working with specific department. They are just there to support a particular minister in parliament related function. For example, Parliament time to time send letter to various ministries that these questions need to be answered, right? It may be possible that minister is deciding that, oh, I need to present this bill in this session. So in all these works, these parliamentary secretaries can support this minister. They are the members of the last category of Council of Ministers, which is also known as ministry. They have no department under their control, no department, as I told you, attached to the senior minister and assist them in discharging their parliamentary duties, as I told you. Okay. So now what is the difference between cabinet and Council of Ministers? Let's sum up things. When I say Council of Ministers, it is wider body, because within Council of Ministers you have these cabinet minister, Minister of State independent charge, Minister of State, right? Then deputy ministers. So cabinet is a smaller body. When it comes to Council of Ministers, they have three categories, but when it comes to this is just cabinet ministry, but the powerful one. It does not meet as a body to transact some business, right? It means it's not like Council of Ministers is going to meet and then they are going to decide on government policies. No, cabinet do that. So it may be possible that some of you might not be able to read this. So this PDF will be available in this Telegram group Shashank Tyagi for you. So you can just download it and this is available in your Laxmikanth as well. So please open your Laxmikanth meanwhile. Okay. Now, so cabinet actually take the important decisions and cabinet then communicate to the Council of Ministers, these decisions are taken and you have to do that. So it means all powers they have in theory, but they have the real power. Functions are determined by cabinet because cabinet, I told you, they take the decision and they communicate to the Council of Ministers. Implement the decision taken by the cabinet. Now, Council of Ministers is a constitutional body, specifically mentioned in 74 and qualification and this tenure part and salary allowances, this mention that these details are mentioned in Article 75. But when it comes to cabinet word was not used in our original constitution. Okay, if I ask whether the cabinet word is used as of now, yes, it is used as of now. It is used in Article 352, national emergency. Actually, this word was used by 44th Constitutional Amendment Act, because Morarji Desai said in Indira Gandhi's time this national emergency was imposed, and even ministers themselves were not aware that emergency is getting imposed, because this word, this Council of Minister will advise, was taken lightly because it was not clear. So explicitly, Morarji Desai government, they explicitly, made it clear that cabinet will actually, in written form, will communicate to the president that there are circumstances where national emergency need to be imposed, right? So their cabinet word is used. Okay, it enforces the collective responsibility. It is collective responsible to the lower house, means Lok Sabha. So it is collectively responsible, but who enforces it? Cabinet enforces it, because real power to actually drive these Council of Ministers, real power lies with this cabinet through various committees, which we call cabinet committees, which we are going to talk in next video. Now, role of cabinet, highest decision making body hai cabinet, right? Formulation of policies, as I told you, executive authority, chief coordinator, advisory body to the president, chief crisis manager. Whenever there is an issue, then Prime Minister call up this cabinet. Major legislative and financial matters are being dealt by this cabinet. Control over higher appointments, for example, CAG, UPSC chairman. So wherever you see that, president appoint them. So who advises? This cabinet advises. And there's a specific committee, cabinet committee on appointment. We are going to talk about in next class. It deals with all foreign policies and foreign affairs. Now there's another word, kitchen cabinet. So kitchen cabinet is informal term. For example, sometimes Prime Minister actually have a trust of some 3-4 people. So now these 3-4 people actually regularly interact with Prime Minister. So they cook the agenda, they cook the major decisions, and then these decisions are just presented before cabinet that this has been agreed by Prime Minister, and now you have to act on it, you have to agree on it, right? So in kitchen cabinet, some members can be of the cabinet also, some members can be of outside also. For example, in Rajiv Gandhi's time, it is said that some technocrats were actually part of kitchen cabinet. Sometimes Rajiv Gandhi used to give this priority to these technocrats before these cabinet ministers, right? So what is the benefit of it? Benefit is, since kitchen cabinet is small, informal, so decisions can be taken in swift manner, right? Small body, it can easily be called by Honorable Prime Minister, right? So it is composed not only of cabinet minister but outsiders like friends, family members, they can also be part of kitchen cabinet. So this is not official term, okay? Every Prime Minister in India has had inner cabinet or a circle. Indira Gandhiji's inner cabinet, Rajiv Gandhiji's inner cabinet, right? It can meet more often. This is the best part, right? No official intimation is required because you are working as a friend, inner circle, trust circle. By this, PM can maintain secrecy with respect to policies. No need to present officially before whole cabinet or council of minister. It reduces the authority and status of cabinet. This is the negative point, right? If decisions are taken within the kitchen cabinet and then presented before cabinet just to agree, so this is undermining cabinet. It circumvents legal process, allowing outside persons, right? Outside people can actually engage with Prime Minister and know about important decision making, right? So this phenomena of kitchen cabinet where decisions are cooked and placed before cabinet, as I told you, is not unique in India. It also exists in USA as well as Britain. Now let's attempt these questions. Which of the following are not mentioned in Constitution? Council of Minister, collective responsibility, resignation of Minister, office of Deputy Prime Minister. Tell me. Office of Deputy Prime Minister is not there. I just discussed with you the Devi Lal case, right? Have I mentioned resignation of ministers? No. I use these two words, Article 74-75. It means answer is C, because it is saying are not mentioned. So this is not mentioned and this is not mentioned, right? Now, which of the following is our functions of Cabinet Secretariat? Preparation of agenda for the cabinet meetings, secretarial assistance for the cabinet committees, allocation of financial resources to the ministers. No, this allocation is done by Parliament itself, right, through money bill. So it means these are the two, you can say, functions of Cabinet Secretariat. It means 1 and 2 means third. Okay. Which of the following Amendment Act provided Central Council Minister, including Prime Minister, not to exceed 15% of the total? Now attempt, because this we mentioned in the start itself. Answer is 91st Constitutional Amendment Act. B. The President cannot function without Union Council of Ministers. Solicitor General is the highest legal authority of the Union Government. The Union Council of Ministers can function for some time even after death, resignation of the Prime Minister. In the absence of Prime Minister, only the Home Minister can preside over the emergency meetings of the Union Council of Ministers. And this question is asking which of the following is correct. Now, President cannot function without Union Council of Ministers. It is correct. I told you, 1971, what Supreme Court clarified. Solicitor General is highest legal authority. It is wrong, because Attorney General is the highest legal service authority. राइट एक तो होता है गलत, एक सरासर गलत, ये सरासर वाली कैटेगरी हो जाएगी. यूनियन काउंसिल ऑफ मिनिस्टर कैन फंक्शन फॉर सम टाइम इन आफ्टर डेथ और रेजिग्नेशन ऑफ प्राइम मिनिस्टर. नाउ यूनियन काउंसिल ऑफ मिनिस्टर, I mentioned the case if Union Council of Ministers loses majority in Lok Sabha, then they will work as a caretaker government, right? They will remain there. Supreme Court also clarified. But in this case, we are talking about death and resignation of Prime Minister. And this is saying Union Council of Ministers can function for some time. How can Union Council of Ministers function if Prime Minister died or resigned? This is wrong. In the absence of Prime Minister, only Home Minister can prescribe. This is wrong. In the absence of Prime Minister, then senior most minister can actually, function there. Means Prime Minister can give this charge. Means whenever Prime Minister is out of India and there will be, several files, regular files which need to be signed. So at that point of time, a file is moved and Prime Minister gives certain power, signing power to a senior most member. That is the discretion of Prime Minister. So it means only one is correct. Only one is correct. Others are all wrong, right? Because AG is the highest. COM dissolves collective responsibility. In the absence of PM, Deputy Prime Minister or senior most member can actually preside over, as Prime Minister can do so. Hello everyone. I hope this message finds you fit and fine. Welcome to Laxmikanth series Indian Polity Contests. Today we are going to talk about Prime Minister. Let's break this term and focus on word minister. If you remember, in historical background of Indian Constitution chapter, I use this word portfolio. So portfolio system was introduced by Britishers in executive branch. It simply means one person will be responsible for specific departments. And now take a look over minister. If you're a member of parliament, say Lok Sabha, and you have some question with respect to health department, then you can directly ask this question from health minister. Directly means obviously you have to submit that question in the Lok Sabha. But the point is, who is the point of contact. Don't you think it is a feature of responsible government? Now minister concerned has to answer about the activities, failures, achievements of respective departments. Now to guide these ministers, to actually regulate these ministers and departments, to guide them for a particular vision, we made this one position Prime Minister. The word prime was added, right? So this is the list of Prime Ministers. Now, primus inter pares. This word is used most commonly for this position of Prime Minister. But it means first among equals, not chief of the ministers concerned. What is the difference? First among equals means all ministers are equals and Prime Minister is just first among them. Do you think it is true in case of India's political system? In case of India's parliamentary system? No. Because in our system, we use the word Prime Minister, but in our system, Prime Minister is supreme, means above Council of Ministers, right? real power is in the hand of Prime Minister. What kind of real powers we are talking about? I'm going to discuss. Lord Morley agrees on this word. Yes, primus inter pares should be the word. Now, some of you would question, sir, why there is a debate in between this? Whether you adopt first model or second model, what change we are going to have? Yes, there's a change. If I ask, which system do you think is more democratic in nature? When I say democratic, it means members of council of ministers, they will be having fair amount of, you can say, independence to share their views, their visions. What do you think, in which system it will be available more? I think you would agree it is in first system. In case of second system, whatever Prime Minister is thinking, that is going to be the vision that needs to be done. Means level of council of minister is actually less, other ministers is less, right? So that is why some scholars of West says that it is against or not reflecting truly the spirit of democratic system. Because a spirit of democratic system is not just in how elections are being conducted, whether people are given right to vote. No. A spirit of democracy should be reflected at all levels. So that is one idea. I am sharing these views because UPSC is making such statements in prelims as well nowadays, right? Introduction. President is the nominal head. De jure. We use this word de jure. But the real head is Prime Minister, de facto. Real power is in the hand of Prime Minister. So Prime Minister is the head of the government, okay, and President is the head of the state, Indian state. Now let's talk about appointment. So Prime Minister is appointed by President. Please remember, for the post of PM, in India we have no election. There is no election for the post of Prime Minister. Some of you would say, those who have just entered into this domain of polity, sir, we voted for Modi in previous election, we voted for this person. You voted for your local MP, Lok Sabha MP. Okay, you have not voted for directly for the position of Prime Minister. Okay, it was eventual. Okay, that if more than 50% members of Lok Sabha belonging to this particular party, say BJP, and BJP has projected, yes, for us, Prime Minister position is going to be given to Honorable, say, Modi ji, right? So it is eventual, but there is no election. Now some of you would say, sir, it means indirect election must be there. No, I am saying no election. Whether direct or indirect, Prime Minister is appointed. Appointed by whom? President. Now, whether President can appoint anyone as Prime Minister of India? No. There is some guideline for this, because our Constitution says Prime Minister shall be appointed by the President, but does not imply that President is free to appoint anyone as Prime Minister. There is a guideline. What is the guideline? That President has to appoint leader of the majority party in the Lok Sabha as the Prime Minister. Now, does it mean that member should necessarily be the member of Lok Sabha? Means whomsoever is being appointed as Prime Minister by Honorable President should be necessarily member of Lok Sabha. Now tell me, the statement is true or false? So those students who are reading this statements and thinking, sir, it must be true. My answer to you is, the statement is false. Why it is false? I have used the word leader of majority party in Lok Sabha. Nowhere I have mentioned member of Lok Sabha. Right? For example, BJP got more than 50% seats in Lok Sabha. So it means in Lok Sabha, majority party becomes BJP. And now BJP says this Shashank Tyagi working in Delhi and teaching UPSC aspirants, civil service aspirants, Indian Polity, and we want him to be Prime Minister of India. Now tell me, is there any apprehensions in this from the legal standpoint? No apprehensions. Because majority party in Lok Sabha has chosen me as the leader. So now I am going to receive a letter from Rashtrapati Bhavan that you have to come and you have to take oath for this position of Prime Minister. Okay, so I am not a member of even Lok Sabha or Rajya Sabha. But within 6 months, I have to become member of either Lok Sabha or Rajya Sabha. Otherwise, I will be removed from my position constitutionally. Right? So it means majority of the members should choose that person as the leader. Clear? I think this is clear to you now. Now, when no party has clear majority, what is going to happen then? In the Lok Sabha, then President may exercise personal discretion. What does it mean? Consider, no party has got more than 50% seats. And there is no coalition, group of parties who could prove that more than 50% seats are with them. Parties are still in discussion. Now, President may exercise discretion and appoint one person as Prime Minister. And then President is going to give that person a reasonable amount of time. That, okay, within this time, you have to prove majority support in Lok Sabha. Then in Lok Sabha, majority of the members support you as their leader. If you could do that, then you are going to continue for the post of Prime Minister. Otherwise, you will be removed and next person will be given chance. So here, President is acting on his discretion, on his own free will. Clear? Now, situations where President has acted on discretion. For example, when Neelam Sanjeeva Reddy, the then President, appointed Charan Singh, because consensus was not getting built. So Mr. Charan Singh was given opportunity to become Prime Minister, although that his Prime Ministership was short-lived, but this discretion was used. Again, when Indira Gandhi ji was assassinated, after that Gyani Jail Singh, then President of India, gave opportunity to Rajiv Gandhi ji to take oath of Prime Minister and then later prove that yeah, he is having majority support in Lok Sabha. Now, in 1980, Delhi High Court says that, जो मैंने भी आपको explain किया, what I have explained you, that Constitution does not require that a person must prove his majority in Lok Sabha before he is appointed as Prime Minister. That is why in my example, I was first appointed as Prime Minister and later given opportunity to prove majority support. Means second case. In my case, in my example was Lok Sabha's majority members were saying that we want Shashank Tyagi. Right? And second example was that yes, you can be given this position and then given reasonable amount of time ki haan, prove majority. 1997 Supreme Court clearly said that for 6 months this can work, as I told in my example, right? But within 6 months you have to become member of either House of Parliament, means you got the majority. So majority you have to prove in reasonable time, the time which is given to you by Honorable President, and President has discretion in this regard, how much time President is going to give to you, right? So majority is taken, majority is done, but you consider that I am not a member of Lok Sabha or Rajya Sabha. So within 6 months, I have to be member of Lok Sabha or Rajya Sabha. Okay. Now some of you might be questioning, sir, you can become member of Rajya Sabha and still you will be treated as majority leader of Lok Sabha. Yes, majority party's leader I am going to be considered, but I am not going to be member of Lok Sabha. Okay, I am going to be member of Rajya Sabha. Okay. Then some of you might be questioning, sir, then why we are not calling that you are the majority party leader of Rajya Sabha? My friends, because whomsoever is going to form the government at union should be the person or the party getting majority support in Lok Sabha. Because Lok Sabha elections decide who is going to be the who is going to form the government, and that is why majority support of Lok Sabha is used, not Rajya Sabha. So in past we had prime ministers who were part of Rajya Sabha, but they were prime ministers. means representing the majority support of Lok Sabha. For example, Manmohan Singh ji, Indira Gandhi ji also at one point of time. In 1997, Supreme Court held that person who is not member either of House of Parliament can be appointed as Prime Minister for 6 months, within which he should be a member of either house. I have explained to you. 3 Prime Ministers, Indira Gandhi ji, Dev Gowda and Manmohan Singh, they were members of Rajya Sabha. Okay. But now how our parliamentary system, our model with regard to Prime Minister is different from Britain's. In Britain, Prime Minister need to be member of lower house. But in our case, you can become member of lower or upper house, both will work. House of Commons, because there the upper house is House of Lords, right? Now oath. So who gives the oath? Oath is administered by Honorable President, right? Tenure. There's no fixed tenure for the position of Prime Minister. If one statement by UPSC says Prime Minister's office, the position of Prime Minister has tenure of 5 years, that is wrong. Although some of you might say, sir, before this election in 2019, Modi ji was Prime Minister for 5 years. Yes, he was, but tenure nahi tha. There was no fixed tenure. Even before that, if majority members of Lok Sabha, say BJP, they wrote a letter to Honorable President, sir, we don't want Modi ji as Prime Minister and we want to choose Amit Shah as Prime Minister, right? So it means they are shifting the confidence. Right, so this can happen. Prime Minister then need to resign, right? So no fixed tenure is there. Okay. Holds office during the pleasure of President, means President has appointed and President can ask you to dismiss from, resign from office if you are not having, you can say, majority support in Lok Sabha, right? Cannot be dismissed as long as he enjoys majority support in Lok Sabha. Right, till the point you have majority support, you cannot be dismissed. Okay. In my example, as I told you, majority members of Lok Sabha, they have said, no, we want to shift the confidence into another leader. Then President also has some tools in his end. If his dismissal has not been done yet, so he has power to dissolve even Lok Sabha, means he has power to convey advice to Honorable President, sir, please dissolve Lok Sabha. And there can be, a legal debate on this very point. So in this case, President will see, oh, I first received a letter that now you're not enjoying majority support of Lok Sabha. And that is the reason you are recommending me to dissolve the Lok Sabha and have fresh election. Okay. Now I'm going to ask you, since you're advising me, prove your majority. I have received the letter. So it means you have to resign. And when Prime Minister resigns, along with him or her, the whole Council of Ministers also resigns. His new leader is going to become Prime Minister. There is no need of fresh election, because President is not going to accept it, because President has also already received a letter that this person is not having majority support. So your advice is not going to be accepted. So new person is going to be appointed as Prime Minister, and on his advice, new Council of Ministers is also going to take oath. Okay. So if Prime Minister resigns, Prime Minister dies, then whole Council of Ministers is disbanded. Clear? He loses the support in Lok Sabha, he must resign or can be dismissed by Honorable President. That is why we say on the pleasure of President. Now power and functions. Number 1. Prime Minister is the one who recommends to the President that, sir, this is a list, and on the basis of this list, please give letter to these people and invite them for the oath-taking ceremony as ministers. So it means who is going to be minister is actually decided by Honorable Prime Minister. Conveyed to PM decides, conveyed to President, and this President actually appoint them. So appointment is done by President. Clear? Now tell me whether this recommendation that these ministers should be, these persons should be appointed as minister, whether this recommendation is binding on President or not. Answer is, it is binding. It is binding. Such is the importance of Prime Minister, because it is his Council of Ministers, her Council of Ministers, then they are going to decide who is going to be the minister, right? And why this advice was made binding. The reason was that these people are elected by people. These representatives are elected by people. So they have confidence of the people, and that is the call of democracy. And these people are going to be responsible to the parliament. They should be given free will who they want to appoint as minister. Right? Then only you can actually ask them questions, because you have given them freedom. That yeah, you can appoint, you can advise who you want as minister, your minister. Right? Allocates and shuffles portfolio, who is going to be health minister, who is going to finance minister, who is going to defense minister. This is done by the prime minister. Prime minister recommends, and then the letter is issued by honorable president on this advice. Can ask a minister to resign, or if minister is not resigning even after asking by the prime minister, then president is also having power. That PM is going to tell the president that please dismiss this person as minister. What you got? Prime minister does not have power to directly dismiss a minister, because the appointment was done by president. He asked, obviously when prime minister is asking someone to resign, then council of minister member have to resign. These ministers have to resign, because they know otherwise they will receive letter from honorable president. Right? Preside over the council of minister. Preside means to have the meeting, to hold the meeting, the chief person. Guide, direct, control, coordinate the activities of all minister. That is what I have told you in start. If he resigns or dies, what happens? Entire council of minister collapses. Clear? So please remember this in relation to council of minister. So power in relation to council of minister. Now, Lasky, he made a statement on prime minister. He said, is central to the formation, central to the life, central to its death. What Lasky is talking about? He is talking about council of minister. Means prime minister is central to the formation of council of minister, central to the life, central to the death. When prime minister resigns, then council of minister also collapses. He described him as a pivot, jiske around. Pivot means center, and the whole thing actually circulates around this center, around which the entire governmental machinery revolves. The real power center. In relation to the parliament, first, leader of the Lok Sabha, right? Second, parliament has to convene the session. That's how parliament work. But who is going to call this session? President has this power. But president acts on the advice of prime minister, council of minister. So it means advises the president to summon, means to call, to prorogue, means end session of parliament. Okay, so this is his power with respect to parliament. Can recommend dissolution of Lok Sabha, that honorable president, please dissolve the Lok Sabha and we want fresh election, like Indira Gandhi ji did. Just after emergency, she recommended that there was a time was left, but she recommended just we want fresh election. Announces government policies to the House. Now other powers and functions. Prime Minister is chairman to these bodies like Niti Aayog, NDC, National Integration Council, Interstate Council, National Water Resources Council. Please remember these facts, because UPSC use one statement and put that ki haan, Prime Minister is chairman. Or UPSC can also make a statement that in case of National Integration Council, Home Minister is the chairman. Right? You should know that PM is the chairman. Okay, plays a significant role in shaping the foreign policy. You have seen that if you compare with the previous Prime Minister, means Manmohan Singh ji, we have seen that our policy has become more proactive, unambiguous, strong stance. Right? Earlier we saw a sophistication, maneuvering for our interest. Right? So it means political, means when this position changes, it does have impact on the foreign policy as well. Crisis manager hai, leader hai nation ka, leader of the nation, leader of the party, and political head of the services. All the executive, political head, because executive head is president. So now relationship with president. You know that prime minister is along with council of minister for the aid and advice of president. Article 74 says that. 75 we already talked about this, that PM advises that honorable president please appoint these members as ministers. Right? communicate all the decisions, whether what kind of laws you are planning to make, means the legislations, means president can ask prime minister that please tell me on which legislations you're working. Then prime minister has to communicate this. So prime minister is like a bridge between president and council of ministers. So PM has to provide the information which president calls for regarding legislations. If president demand that I remember one of your council of minister, one of the member of your council of minister proposed this kind of legislation. I want update what you have done, what your council has done. Is it considered yet or not considered in your council of minister? PM also advises president about the important appointments like Attorney General of India, CAG. We talked about this when we are talking about executive power of president as well, right? So Munro called prime minister the captain of the ship of the state. You can remember these quotes, or you can say phrases, so that they can readily be used in your mains answer. Ramsay Mui described prime minister the steersman of the steering wheel of the ship of the state. So direction is being decided by prime minister. Now attempt this question. In which of the following circumstances prime minister of India cannot participate in voting? Please remember, it is saying cannot participate in voting. Now, she heads coalition government. She has minority in Rajya Sabha. She is a member of Rajya Sabha. She is forbidden by the Speaker of Lok Sabha. For answering this question, first thing you need to know is voting in no confidence motion against his government. So no confidence motion is actually brought only in Lok Sabha. Only in Lok Sabha. Because it was due to the confidence in the Lok Sabha that this government was formed. So if this motion is going in Lok Sabha, then who can vote? Only members of Lok Sabha can vote, right? So in this statement, if she is a member of Rajya Sabha, now tell me, if PM is member of Rajya Sabha, can this person be allowed to vote in a no confidence motion in Lok Sabha? Answer is no. So that is what this question was asking. In which of the following the Prime Minister of India cannot? So it means answer is C. Clear? This is the explanation. This PDF will be available in Telegram group. Don't worry. Now, according to the Article 74 of the Constitution, which of the following statements relating to the advice tendered to the ministers by the ministers to the President would be correct? It shall not be inquired into any court. What does it mean? It means advice given by minister to the Honorable President cannot be inquired in any court. A statement is true. True is asked. But let's look at other statements. It can be inquired into Supreme Court. It is wrong, because this is a privilege, protection which is given. It can be inquired into all the courts. Can be wrong. It cannot be inquired into High Court. Now, see, sometimes UPSC is going to throw statements like this statement is also correct, that if it is not allowed to inquire into any court, it means in any court, High Court is there. There you have to choose which statement is more correct, means which is explicitly being derived from this article. So that is cannot be inquired into any court. That is why statement 1 is correct. Okay. A bill initiated by which among the following is a government bill? This is a direct question. Minister. A bill initiated by a minister is considered as government bill, right? A bill initiated by any other member other than minister is considered as private member bill. Clear? This is the explanation. Hello everyone. I hope this message finds you fit and fine. Welcome to Laxmikanth series and Twelfth. Today we need to talk about Office of Vice President. But before we jump in, let's start with some questions. First of all, what is position of Vice President? What? Why it was created? The rationale behind. When we are saying Vice President, does it mean that some power of President are shared with Vice President? Is it true or is it false? Some questions should come into your mind like, what is the role of Vice President? How Vice President is elected? How Vice President is removed? And how India's Vice President is different from US Vice President. You know that as of now, US Vice President is a person of origin. Yes, Kamala Harris, right? So we should know the differentiation and the fact there that India's vice president office modeled on US vice president, but still there is differences on these premises, right? And when we are going to go into provisions, I request you reflect, revise how these is removal process, election process role different from president. It would be easier for you to retain if you actually understand polity, having this comparative this is simultaneous. So let's start with the basics. Vice president, second highest, you can say, authority in terms of ranking in president. When I'm saying second highest authority, some people actually relate with the word authority in terms of power. But here I'm just saying that in official variant of precedence, vice president is second position. But if you ask, sir, if we compare the power of president and vice president, can we say that vice president also has considerable amount of power? Although we have talked about the kind of power president has, right? And many times president acts like a ceremonial head. All of you know this by now. There's a word used for vice president, that is his superfluous highness. It means second position is given, but when it comes to the kind of power, responsibilities given by our constitution, they don't match with the second position. Okay, so please remember this word, his superfluous highness. Okay, we are going to mention it later as well. As I told you that this position is modeled on the position of vice president of US, and these provisions are mentioned in article 6073. Let's talk about election. In office of president, election were direct or indirect? You would say, sir, indirect, because people were not participating early. In case of vice president, like you and me, are not voting, right? Considering you are not MP of Lok Sabha or Raj Sabha, right? That means no election direct, means direct in, right? Proportional representation, single transfer vote. Point to remember that the process, the concept is same. Whenever I'm going to put a tick, you can find, okay, is this part is same as we discussed in with respect to the position of president. Okay, proportional representation, single transfer vote, and I explain what the these terms mean by previous video, right? Those who have not watched, you can part and it will take walk for you to understand it. If you have any doubt at any point, then you can just shoot a message on my personal Insta, Shashank.powerbeing, OWE. For any question which you think a bit tricky for you to understand, just shoot me. Now, secret ballot voting. What does it mean? Consider that you are MP of Rajya Sabha and you have voted in this vice president election. And as you came out, media was there, and media asked, sir, you have voted. And you said, I'm not going to say you the I have voted. This secret ballot vote. But I am with this symbol. So you try to play smart. But my friend, your vote will be cancelled. Why? Because you said I am with this symbol. What does it mean? It means you have voted in favor of a candidate who is supported by Congress party. On this ground, the vote can be cancelled. Okay? So it should be seen till results are announced. Indirect election, I told you. And what kind of indirect? Here, the members of parliament, both Lok Sabha and Raj Sabha, they participate in this. In case of president election, I told specific, I stressed on this word, elected members of Lok Sabha and Raj Sabha, elected members of state legislative, elected member. Then we talked about two Delhi and Pune. I gave you example of Jammu and Kashmir as well. Now, what is here? It clearly Sabha, Raj Sabha members. It means all members. There is no differentiation between nominated elected members when it comes to election of vice president. I think it is quite clear now. It should be crystal clear in your mind, right? And that's why I'm saying just differentiate. It will be quite easy for you to remember. States are not included. I just told you. Because we are talking about vice president here. Only parliament members are participating. Clear? And you should ask at this point, why state not included? It was a harm. Why constitution framers did not added state? Because the kind of position which vice president holds not have a kind of power which is going to affect the interest of state. Because moreover, vice president is there ensure political continuity, and second, act as Rajya Sabha chairman. Now, some of you would say, what is this political continuity you are talking about? Consider, president dies, and you know, any bill which you present in Lok Sabha or Rajya Sabha, it needs to be passed by both houses, and then it needs to be presented before honorable president. After he signs, then this bill will convert into an act. I'm saying, and dies. What is going to happen with the law making process? Someone to be in this position, if president is not in position, act. At this point, vice president act as acting president. So that is why I'm saying this is one that is political continuity. Okay, and I'm telling you this because just interlink thing. Okay. Second, I told you that vice president acts as chairman of Rajya Sabha. Duty of chairman. Have you watched any proceeding of Rajya Sabha? Rajya Sabha TV as well. Channel. You will see that vice president is sitting, the whole house members are sitting, and vice president, the office of vice president, right? Okay, which bill is going to be priority? Which person is going to be given chance to participate into this debate? Which questions are going to be taken up? So it means the house are decided by vice president, and when vice president is acting in this manner, so word chairman of Rajya Sabha, and we use the word acts of the chairman. It means whoever is going to become vice president of India, automatically this person is going to be in the position of chairman of Rajya Sabha. Clearly, automatically. Yeah. 20 electors as proposals. Now coming back to the election process. In president election, I told you cannot just stand up one fine day and say, mother, I'm going to fight election of president. No. First thing, you need to know qualifications, and second, you need to support. In case of president, I told you 50 members of electorate propose your name. Proposer. 50 members of electorate. Electorate means members who are going to participate in your election need to second your name, right? Then only your name will be considered, right? In case of vice president, because vice president is second in the precedence, you only need 20 electors as proposers and 20 electors as seconders. And when I'm saying elector, it means members who are going to participate in the voting process. Means I'm talking about Lok Sabha, Rajya Sabha members, whether they are nominated, whether they are elected. It is clear to you now? Now, 15,000 deposit, the same in case of president as well, security deposit, right? And I also told you if 1/6 vote fail to acquire, then what is going to happen? The amount is going to be forfeited. You have wasted the time of this election process, right? You are not the credible candidate. Now, let's compare president election, the vice president. As I told you, all MPs, all elected MPs, all elected MLAs of state legislature, they participate in presidential election. In this case, only MPs, Lok Sabha, Rajya Sabha. No differentiation of nominated, all MPs of Lok Sabha. Can nominated members vote in case of president election? No. Strict no. Right? In case of vice president, yes. As I told you, there's no differentiation. ऐसा कोई भेदभाव नहीं है, right? Now, value of each, just revise, reflect what we discussed there. I told that value of vote of an MLA in a particular state differentiate from the vote value for MLA of different states. For example, in case of president election, consider one member of state legislative assembly elected member is from CUP. So one MLA from UP is voting, another MLA from Mizoram is voting. Vote value depends on population upon number of elected state legislative assemblies multiply by 1 by 1000. Told you that, right? In case of MPs, I told you total vote value of all MLAs, all states divided by total number of seats elected, right? I told you the formula. Now UPSC is not going to ask specifically on formula, but understanding of formula should be there. Their question can, right? I also asked this question from you, that vote value of MP and MLA is going to be different. Vote value of MP of Lok Sabha and MP of Raj Sabha will be, because in case of vote value of MP, I just see one formula, and there I have not given you any differentiation between Lok Sabha and Raj Sabha. I am not differentiating, giving you just one formula and using the word MP, member of parliament. That person can be member of parliament in Raj Sabha or Lok Sabha, right? Quite logical. So we discussed this, right? And this population is taken on 1971, right? But in case of vice president, one vote, one value, right? This kind of SIAPA is not there in case of vice president. Clear? Eligibility should be qualified to become member of Lok Sabha. I told you, member of Lok Sabha, right? So that qualification need not to be specified again and again. In case of vice president, the word is Rajya Sabha, should be qualified to be a member of Rajya Sabha. Nomination paper to be signed by, told you 50 voters as proposers, 50 voters as seconders. In this case, 2020, right? So I think this differentiation is quite clear in your mind. If any question is asked on this basis, you will answer in plain, right? Now, qualification. Just check which qualifications are same as President of Citizen of India, 35 years and above age, should be qualified. This is different. Should be qualified, become member of Rajya Sabha, and this is same. Should not hold any office of profit. I told you office of profit, right? Not be any position in government simultaneously from where the person can drive salary or remuneration. Cannot happen. Oath. In case of president, was given by Jai. Jai is not there, and most judge of Supreme, right? In case of vice president, oath is given by president. And if one statement is made, the UPSC, it says vice president is given oath only by president. Only by president. Vice president can be given oath by president. Now tell me the statement. Some of you would say, quite clear, president. But my friends, second statement as well. President is ill. President is not in India due to any reason. And in this case, president may actually appoint someone for this duty. So that person can actually give oath on the behalf of honorable, right? So whenever UPSC throws an absolute statement for you, your antennas should get open, right? Alert, right? Now conditions of office, this condition is same. What does it mean? You should not be a member of either House of Parliament or state legislature. You cannot be, okay, I am vice president as well as MLA from UP, or I am MP from Lok Sabha or MP from Raj Sabha. No, you are Raj Sabha chairman, but you are not member of Raj Sabha. When I am saying Raj Sabha member, it means I am member of parliament. You will not be on an MP Raj Sabha, whether nominated or elected. This is uniqueness of vice president position. You are chairman, but you are not member. You cannot sit among other members that like speaker in Lok Sabha can actually sit. because Speaker in Lok Sabha is also there to preside the uh, can say proceedings of Lok Sabha. But for example, Mr. Om Birla is Member of Parliament from Kota, right? And Speaker's position, elected position, members of Lok Sabha, they voted and decided, okay, we are going to make Om Birla ji as Speaker, the member of Lok Sabha. But in case of Rajya Sabha, Chairman, ex officio, whoever is going to be the Vice President, going to be the Rajya Sabha Chairman, right? So Rajya Sabha Chairman is not a member of Rajya Sabha, right? Clear? In case someone was member of Rajya Sabha or say member of Lok Sabha, and now that person is fighting for election for Vice President. So in this case, the moment you win, your seat of Lok Sabha or Rajya Sabha MP is going to be cease to exist, will be removed from this position. This is mentioned here. So this particular discussion is same as we discussed in case of President as well, right? Then to not hold any office of profit, I just told you, and same in case of President as well. Now terms of office, 5 years. 5 years a term, same as case of Vice President, President. Now whom Vice President can resign? Can resign in writing to the President. Now my question, whom President gives resign? If President is resigning, this letter need to be addressed to whom? Option, Vice President or CGI or Prime Minister or Chief Election Commissioner. Tell me. And if UPSC would like to confuse, then UPSC say CGI gives Honorable President, comma, and President gives resignation. बात तो ठीक, correct, but that is why? Because President gives resignation to Vice President. And if you ask, sir, what is the logic behind logic is that since Vice President position is there to actually political continuity, right? And Vice President is the one who has to act as acting President, absence of President. Which person need to be informed first? Obviously, Vice President. So President gives resignation to Vice President, right? And Vice President gives, I hope you will remember now, can be removed by an absolute majority of Rajya Sabha. Now, remember, several editions of Laxmikanth are using the word absolute majority of Rajya Sabha. I have written mail to Laxmikanth many years back, I would say I think 5 years back. And my point was that if you look into official website of Rajya Sabha, in case of this removal process of Rajya Sabha chairman, they did not mention absolute majority as a word. You can just Google it, Rajya Sabha's official website. So what they say majority of all the then members of Rajya Sabha. This is the term, phrase. So all the then members means who are members of Rajya Sabha at that point. If certain seats are vacant, death, resignation, disqualification, any case, any of these cases, then vacant seats are not going to, when you have to count the. So what we call this kind of majority, we call it active majority. And in one of the previous videos, I also the difference between majority, absolute, active majority, special majority, right? Remember, here can be removed by active majority. The position of this publisher was that there is no strict, can say, demarcation, this word effective and absolute, any text of government. That is why absolute can also be. This was the reply. But I believe that we need specific, because when we use word absolute majority, case of can say forming government, ensuring absolute majority in Lok Sabha, then the word absolute majority is more than 50% of And there's a difference between total and total strength minus vacant seat, right? When we say total strength, consider total strength was 100, but now vacant seats are 10. Means in these 10 seats, no one is member, and by-elections are yet to happen. In this case, effective strength will be 90, and effective majority will be more than 45, that is 46, right? But in case of absolute majority, total strength is 100, right? So for removing this vice president or say ex officio chairman of Rajya Sabha, I need at least 51 member support. So don't you think there's a difference between 46 and, right? That is why I'm saying specific. Okay, 14 days notice is given, same as case of president. No specific ground of removal is mentioned in our constitution, but in case of president, there's a mention violation of constitution. Although what amounts to violation of constitution is not defined in our constitution, but in case of vice president, ground is even mentioned. Now, vacancy of office. When vice president office can be vacant? Number one, expiry of tenure of 5 years, resignation, removal, death, or there may be a case that election of vice president is declared null and void. Example, you fought for the office of vice president and your actual age was say 33, but you forged some documents, had some documented graduation and affidavit, and now you are saying that my age is 36, and by using documents got appointed as elected as vice president of India. But your contender, opposer, that person filed a petition, court and Supreme Court observed, yes, there are some proofs that you have the document, have wrongfully attained, actually held this position. In this case, now what about the actions which you have taken in these? Consider that you were there in position for 2 months. So the actions will not be invalidated. Okay? Actions will remain, right? Elections declared void. So this is the case, and any election dispute for vice president office is heard in Supreme, and decision of Supreme Court is final, binding. Same as in case of president. In case of other reasons, vacancy, fresh elections need to be held as soon as possible. Newly elected VP serve the full 5-year term. What does it mean? For example, someone was vice president for 2 years and then dies. Fresh elections happened, and now this person is not going to remain for 3 years. Okay, this person will remain in this 5-year term. Okay, I want you to question this. This actually think, and that is how you are going to master Indian politics. Anyone actually question this, that in case of president, in case of vacancy of president, we were saying that elections need to be held within 6 months. Mention that it need to be held in. Why such urgency not given for the vice president election, but such urgency? Answer is simple. Because if vice president is not there, what you stands to? Oh, you're not having Rajya Sabha chairman who is going to preside the Rajya Sabha. In the absence of vice president or Rajya Sabha chairman, deputy chairman is going to preside the Rajya Sabha. And in regular, workings, exclusive powers, as as the person is vice president here, right? Most of the time, the utility of vice president position is Rajya Sabha chairman. But it is clear that it needs to be held as soon as possible. As soon as possible means priority is given. But election priority is not of equal distance as in case of president. Right? Now, election dispute, I told you Supreme Court. Election of a person as vice president cannot be challenged on the ground of electoral college. Same. It is not going to happen that, oh, now 15 or 20 MPs of Rajya Sabha or 15-20 MPs of Lok Sabha, they have resigned. And now they are saying, no, we don't want a vice president election to happen because we are not there. 40 seats are vacant. Electoral college is vacant. That's why you should stall. No. Vice president election is not going to stop for you. Okay. Election of vice president is declared void. The Supreme I told you, acts done during this process by you for 2 months, they will remain valid. Okay? They will not be invalidated. Powers and functions. Ex officio, chairperson of Rajya Sabha, that is the primary job I told you. Power and functions similar to that of speaker in Lok Sabha, I told you, right? Like presiding, ensuring that session moves as per the set agenda, right? Along with if a case of disqualification of a Lok Sabha member is there, case of anti-defection, then the Lok Sabha speaker is there, there has the power. And similarly, in case of anti-defection, if someone changes the position or actually uh, there are allegations that that person is disqualified by anti-defection law, and vice president is going to take example of JDU leader Sharad Yadav and Anwar Ali. The leader Sharad Yadav was disqualified by whom? Rajya Sabha chairman Venkaiah Naidu, vice president, right? Similarly, in case of Lok Sabha speaker, right? America vice president also has similar law. They have two houses, Congress, Senate is upper house. So vice president chairs the Senate, okay, session. Acting president when a sitting president is unable to discharge. I told you, na. One function is this. Another major function, political continuity, that is acting president has to act as president. Office of president vacant due to resignation, removal, death. Otherwise, in this case, someone needs to continue as president. Can act as VP for maximum 6. What does it mean? Within the election commission has to ensure election, right? Fresh election of president need to happen. When acting as president, VP does not discharge duties of chairman of Rajya Sabha. When VP becomes acting president, now that person is acting as why that person is going to Rajya Sabha and perform the duty of Rajya Sabha. Those duties will be taken care of by deputy chairman of Rajya Sabha. Okay, and you should also know it. Point that vice president, Rajya Sabha chairman has a dedicated secretariat also. Secretariat. And who heads this secretariat? Rajya Sabha chairman. But when this person becomes acting president, so in this scenario, that Rajya Sabha chairman's responsibilities are delegated to deputy chairman of Rajya Sabha. Clear? Emoluments. Constitution has not fixed any emolument for the position of vice president. No emolument. Now, is vice president working for free? Obviously not. So this person derives this salary because that person is Rajya Sabha chairman. So no salary in the name of vice president, salary in the name of Rajya Sabha chairman. Okay. When acting as president, gets salary and allowances for the president. In president chapter also, I told you many times in Laxmikanth this line is quite straight, but UPSC can actually play on depth. Two cases are there. Number one, if president dies, resigns, impeached, it means no person is there holding the charge of president. In this case, when acting president acts as president, then salary, allowances, everything is given as given to president. But when president is alive, it is just that president is not fit to perform his duty or her duty. In this case, when vice president is acting as president, acting president, now person is not going to draw the salary of president, because from consolidated fund of India, salary of president is already being 1%. So it is not possible that these two salaries will be given to same position. Okay, I hope you got the logic. If president is kidnapped, president is ill, president is outside India, and in this scenario someone needs to actually do the job of acting president, then vice president can do. Do not expect salary. Can expect the power. Okay, can expect the privileges, but not the salary. Salary in case of death, resignation, impeachment, right? Now, let's compare Indian and American vice president. So, Indian VP office is based on the lines of American VP. I told you, American VP succeeds presidency, succeeds presidency. So, there were certain articles when the Biden got elected as president and Kamala Harris as vice president, many were saying there are high chances that Kamala Harris succeeds, Biden as president. So those articles were on this premises that Biden person possible not be possible to actually complete your term. American president, therefore, 4 years, right? So if anything happens, it is untoward. We should not say this, but if this happens, what is going to happen? What law says, what provision says, we should know. Then American VP succeeds presidency when it falls vacant and remains president for the unexpired term of predecessor. What does it mean? Consider, in 2 years, if US president die, right? So now Kamala Harris will become president of US for 2 years. Okay, but in case of India, there's no. In case of India, vice president can act as acting president, not president. Okay, if someone need to be president, the election need to. Indian VP only become acting president. I told you, the Constitution has not assigned any significant function to the vice president in that capacity, and that is why this word high is superfluous highness is used, right? Is president, board of president, second position, high ranking, but that not that much role is given. This office was created in view of maintaining political continuity. I told you this. Let's attempt this question. The resolution for removing of vice president of India can be moved. Come on, resolution. So that this resolution can start. Sabha, Rajya Sabha, either. Answer is Rajya Sabha. Because vice president is act as chairman of Rajya Sabha, right? So this resolution presented as a first instance in Rajya Sabha, where it needs to be cleared by effective majority, and then it needs brought Sabha, and there it can be passed by simple majority. It's quite simple, right? So this is what is mentioned in explanation. Hello everyone, I hope this message finds you fit and fine. In our previous video, we were discussing President of India in this Laxmikanth series. Today we need to talk about the second part, the important area, powers of Honorable President. Some of you might be thinking, sir, we were thinking that President don't have any power, real power in the hands of Prime Minister. Yeah, real powers are in the hand of Prime Minister, means to run this government, but President do have, some power, and there's diversity there. Executive power, legislative power, judicial power, financial power, diplomatic power, military power, emergency power. There's variety there. So let's understand them one by one. Along with this discussion, we're going to actually read the lines of Laxmikanth as well, okay, to make you understand them better. I'm also going to pinpoint on some trap areas on which UPSC likely to make question. And we are going to practice some MCQs as well. Let's start with a simple power, diplomatic power. Those who aspire to become, say, officer of Indian Foreign Service, so what is the highest position you want to achieve in your diplomatic career? Diplomatic career, I'm saying. So you would say, sir, Foreign Secretary. But before that, you need to become ambassador, right? India's topmost diplomatic official in other nations. So there's a trajectory in this diplomatic career that people who get appointed as India's ambassador to US, there's a high probability that these people, rise to become foreign secretary if they have this, service left. Now, consider that you are becoming ambassador to US. Who is going to give you official letter? Official letter is going to be given by Honorable President, right? Second, if America is sending some diplomatic official as ambassador to India, then this person need to visit to our Honorable President, present this letter. Sir, this letter is from our President. Please accept me as ambassador of US in India. Then that person is accepted, right? So it means one is exchange of top diplomatic officials. Apart from this, all international treaties, agreements are signed in the name of Honorable President. Although these treaties need to be ratified by Parliament as well at the later stage. So you can consider that in international sphere, President represents India as a state. Okay, so these are the points. Clear? I think it is quite clear if you just remember the keywords. International treaty and agreement, sign the name of president, exchange of top diplomatic officials, president represents India in international sphere. Okay. Now, military relations. Just remember 3 points, three key points. President is the supreme commander of our defense forces. Okay, supreme commander, topmost position. All the chiefs, Air Force, Navy, right? So, Army, so they are appointed by Honorable President. War is declared as well as concluded by Honorable President, although it is ratified by Parliament as well at later stage. But please remember, these are the three parts which come under military power of Honorable President. Clear? Executive power. So there's a list here, and here we need to go one by one. Okay, I'm going to simplify each and everything for you, and you need to just grab some keywords so that this knowledge is structured in your mind and readily used in your exam. First point in executive power is all executive decisions of Government of India are taken in the name of President, because Constitution says so, right? Now, if you just check, make rules. Which rules we are talking about? Make rules is specifying the manner. So who is making rules? President of India. So President of India make rules is specifying the manner in which orders and other instruments made and executive in his name be authenticated. This point is related to the first point. You are making orders, executive decisions in the name of President. But the process which is going to be used in this is going to be decided by Honorable President. Although President is not going to decide this rule on his own. Obviously on the aid and advice of Council of Ministers. But rule need to sign by Honorable President. Make rules for more convenient transaction of business. So here business does not mean the real business, means business in the normal sense. Okay, business means the working of the union government or for allocation of said business among the ministers. So it means the duties, responsibilities of the union government and sharing them among ministers. So rules regarding this are made by Honorable President. Okay. So first point is in the name of President. Second is make rules. Okay. Please remember, in your Laxmikanth, this make rules part, this word is going to be used at two places. One in executive power and second in legislative power. Then some of you might be thinking, sir, then make rules will be under executive power. How we are going to remember it? It is quite easy. In these both points, we are talking about making rules with respect to executives. Temporary executive, ministers, government, executive, right? And there we are going to talk about making rules with respect to legislature. Okay, difference is this. We are on the executive side as of now. Okay. Next, appointments. Appointments of Prime Minister, Minister, CEC, UPSC Chairman, CAG. So all these executive positions, the appointment are done by Honorable President. So PM, COM, AG, CAG, CEC, Governor, Chairman, FC, you can remember UPSC, Chairman for National Commission for SC, National Commission for ST. So all these commissions chairman, who appoints them? Honorable President. And it is quite easy to remember because individually when you read these chapters, there you are going to find this detail again and again, and it will be imprinted in your mind. No need to worry. But please remember, appointment to these executive positions come under executive power of Honorable President. Clear? Now, as I explained to you, appointment of CAG, UPSC Chairman, this is written. Now, seeking any information relating to administration of affairs. So, with respect to taking information from Prime Minister regarding Council of Ministers, what particular ministry is doing, or asking Honorable Prime Minister that one minister had proposed some time back this particular proposal, what is the status? Is Council of Ministers has discussed it or not? So it means this information, seeking information from Council of Ministers is also executive power of Honorable President. And Council of Ministers is executive, right? And its link with President will come under executive power. Clear? Just remember this. Can appoint commission to investigate to conditions of SCs and STs. A separate commission can also be made or you can say appointed by Honorable President. Can appoint interstate council to promote center-state and interstate cooperation. We discussed in center-state relations as well, right? Appointed by Honorable President. So this appointment of commission by Honorable President will also come under executive power, because we are talking about executive branch. These commissions are not there to make law, right? These commissions are there to just check whether the laws which were made are being implemented or not, whether we can actually find out solution between the ongoing dispute, right? He administers the union territories through administrators appointed by him. For example, Lakshadweep, Andaman Nicobar. So these UTs are being governed by, say, Lakshadweep. Administrator is there. So administrator is representing whom? Honorable President, working on the pleasure of Honorable President, right? So directions can be given to that administrator. Can declare any area as scheduled area and has powers with respect to scheduled areas and scheduled tribe. If one area is declared as scheduled area, then special protection will be given to that area. Who has this power? President has this power, right? And here he is not making any law, he is just declaring an order. Now coming to the financial power. So I think it is clear. You are going to remember in name of President making rules, these two areas, appointment, seeking information from COM, then appointment of these commissions, interstate council, investigating of SCST, right? And this declaring scheduled area. I hope now it is clear to you, right? Financial power. Any money bill which is presented in Lok Sabha need prior assent, prior recommendation of Honorable President. So money bill is related to money, finances. So this comes under financial power. Budget. Budget is presented in Lok Sabha before prior recommendation of Honorable President. Comes under financial power. Grants. If government needs certain amount from Consolidate Fund of India to be used as a grant, then it need to be this approval of President is mandatory. Prior approval is President is mandatory. It means coming under financial power. Then Consolidate Fund of India. As you know, there are three funds, three prominent funds. One is Consolidated Fund of India. The word is consolidate. It means all the revenues from tax, non-tax receipts, they are coming under this consolidated fund, right? For example, income tax, GST, right? These revenues are coming under Consolidated Fund of India. Okay, from there budget is allocated and then this money is transferred to different departments. Now, second is public account. Public account is, for example, a small savings scheme, PF. From your salary, when you're going to get the job, or those who are doing job, a small amount is deducted from your salary every month. Where does it go? It goes to one organization, EPFO, Employee Provident Fund Organization. So EPFO manages this fund. It means this fund is with government. Now tell me, this fund is of government only, or this fund belongs to you? This fund belongs to you, to public. But this is being managed by government, right, as a saving. So that is why it is called public account. Can government spend money from this fund? Yes, but there are some guidelines, right? So this is public account. Then third is contingency. Contingency is itself, word represents oaths. There's some emergent circumstances. There's shortfall in fund with some ministry and they need immediate fund. So this is consolidated fund. So this fund is with Honorable President, and on the behalf of Honorable President, Finance Secretary, it means topmost official of Finance Ministry, manages this fund. Okay, so this is consolidated fund. So this is special power with Honorable President. So this comes under financial power. So what is the corpus of contingency fund as of now? What amount is managed as contingency fund as of now? Comment in. Just mention in comment box. Answer is 200 crore. Now, Finance Commission. Finance Commission is also appointed by Honorable President. It means it also comes under financial power. Okay. Now, legislative power, another important part. So, I'm going to tell you three words: summon, prorogue, dissolve. Summon means to call the session. Can Parliament work without calling? No. The first step is you need to call the session of parliament, then only people will come, right? So who does the summoning? President does. So it comes under legislative power because it is dealing with legislative branch, right? Like we were earlier discussing matters related to executive branch, and wherever president was involved, what we were calling executive power, right? Here in legislative branch, wherever president is going to be involved, we are going to call it legislative power. Okay, so summon, calling, prorogue, ending the session, right? So this comes under legislative power. There's another word, dissolve. But we do not use the word dissolve with Rajya Sabha. We do use the word dissolve only with Lok Sabha, right? Because Rajya Sabha is a permanent house. There's no point where there's no member in Rajya Sabha. So we are going to discuss why it works like this. What was the idea behind this? We are going to discuss this in Parliament chapter. So Lok Sabha is dissolved, right? So when Lok Sabha is dissolved, so this comes under legislative power of Honorable President. Okay, so three words: summon, prorogue, and dissolve. Now he can address the House on the commencement of first session. When I say first session, there are two meanings. Number one, first session of every year, first session after General Assembly elections. So there president goes there and present his speech. So since at this point president is engaging in legislative branch, that is why it comes under legislative power of Honorable President. Okay. He can send message to the Houses of Parliament whether with respect to a bill pending there or not. Means if there's some bill pending, so he can send message, give me the status, what is happening with them, with those bills, so that they can expedite this process considering the respect to the office of President. Okay. He can appoint member of Lok Sabha as presiding officer. Someone need to preside the house, right? So he can appoint when the office of both speaker and deputy speaker fall vacant. So you know that speaker works as presiding officer of Lok Sabha. In his absence, deputy speaker. If they are not there, then president can appoint. So since engaging in legislative branch, that is why legislative power. Similarly, he can also appoint any member of the Rajya Sabha to preside over its proceedings when the office of both chairman and deputy chairman fall vacant. So in this case also, it is legislative power. He nominates 12 members in Rajya Sabha. So since this power related to legislative branch, nomination of 12 members in Rajya Sabha, it comes under legislative power of Honorable President. He decides on questions to disqualification. In Parliament chapter, we are going to discuss disqualification of members of Parliament. There I am going to tell you the ways a particular member can be disqualified. So if that person is being disqualified on any matter related to say constitutional, the qualifications mentioned in Constitution, now this person is not following that, then that person can be disqualified. Also matters mentioned in Representation of People Act, right? So in these two cases, Election Commission may recommend to the Honorable President, sir, please disqualify this member. So in this case, this power is going to come as regarded as legislative power. For example, if you search on Google, disqualification of 21 AAP MLAs from Delhi. So who actually pronounced this decision that these 21 AAP MLAs stands disqualified on the basis of using office of profit? The decision was taken by Honorable President on the advice of Election Commission. Since this decision is related to legislative branch, it comes under legislative power of Honorable President. Clear? His prior recommendation or permission needed to introduce certain type of bills. Which kind of bills? For example, bill involving expenditure from consolidation fund, I just told you. So this power comes under financial power as well as this legislative power. Okay, a bill for the alteration of boundaries of state. If you remember when I was discussing Article 3, Article 4, we talked about it. Creation of new state. When a bill is sent to the president, what options president has? Consider, I am president. Okay. You never know what happens next, right? Life gives surprises. So now, I am president. I received this bill, right? So bill is always, several laws, certain sections compiled in this manner. Now what choices I have? Either I sign this bill and it becomes an act, right? Or I withhold my assent that, oh, I'm suppressing this bill. Or I don't do anything. It just sit on my table, right? So it means give assent to the bill. Withhold assent to the bill means negation. Return the bill. Return the bill means I'm giving it back to you. That, for example, I received this bill from Lok Sabha. I'm giving it back for reconsideration. I may also give certain advices. Okay, it is up to you whether you accept that or not. Such is the status of Honorable President in this area for reconsideration of the Parliament, right? So here you can see there are three options given. Okay, give assent to the bill, sign the bill, and it becomes an act. Withhold assent to the bill, negation, and reconsideration of the Parliament, sending the bill back for the reconsideration. I also gave you another option, means not doing anything with the bill. Not doing anything with the bill. So that is pocket veto. I'm going to discuss this in detail soon when I'm going to discuss veto. Now, there are cases as well, means UPSC has made statements like with respect to withholding the bill. So withholding the bill as a power of legislative power of Honorable President can be used on which scenarios. Then they give options like private member bill, government bill, even when Council of Ministers is advising Honorable President to give assent. Government bill, where this government bill belongs to the previous government. And polity is quite easy. You just need to understand it with the logic. Just grab the logic and it is sorted. And we are going to understand the logic. If the bill is passed again by the Parliament, consider I send this bill back for reconsideration and you again pass the bill. Now, can I resend this back? No. The President has to give assent to the bill. Now, second time, I have to give assent to the bill. And this applies only when I'm talking about that I'm sending this back for reconsideration. Okay. When a bill passed by state legislature is reserved by the President, you know that a bill is cleared by state legislature, presented to governor, and governor reserve it for the President. Then what President can do? Give assent to the bill. You know, in that cases where governor thinks, oh, this particular bill is in contravention to some central law, that is why I want this bill to be given to Honorable President. Then President can sign the bill, it becomes act. Withhold the assent to the bill, not doing anything, suppressing the bill. Okay. Please remember, some people get confused with the withhold. They think it is negating or it is pocket veto. Actually, there's no term pocket veto mentioned in our constitution. It is actually, you can say, understood when nothing is done to a bill for a longer period of time, then it is considered, oh, it is under pocket veto. There's no explicit announcement by government or explicit announcement by Honorable President that, oh, I'm using pocket veto here. Okay. Direct the governor, return the bill. Right. So third option can also be used. But please remember, this third option, direct the governor, means I'm President and I received this bill as a state legislative bill from governor. So I can send this bill back. But if it is a money bill, then we cannot use it. Means then we cannot return the bill. Direct the governor to return the bill if it is not money bill for reconsideration of the state legislature. Now, some of you might be thinking, sir, why it is written it is not money bill? Simple reason is money bill deals with expenditure which may be more important for the government of the state to be used, right? If they are raising this money bill, it means they are demanding money from consolidate fund of state. So at this point, their time need not to be wasted. That you want to give them the bill back and then this bill will come again. What about the time, right? So that is why either you accept it or reject it. You cannot actually send this bill back for reconsideration. Okay? In money bill, you need to be straight. I'm talking about President's power with respect to bill on state legislature. Bill of state legislature. I hope it is clear to you. It is a good point where UPSC can play. Clear? It should be noted here that it is not obligatory for President to give his assent even if the bill is again passed by state legislature. And this is the difference between this when a bill is given to Honorable President by Union Legislature and bill is given back by state legislature. In case of Union Legislature, I once sent back and then they again passed, I was bound to sign the bill. But in state legislature, this is our state, right? Not equal in terms of, value with the Union Legislature. So in this case, if they are sending this bill back to the President through Governor, sir, we have reconsidered and we don't want to change. So in this case, President is not bound to sign this bill, right? But in case of Union Legislature, if this bill is coming second time, then President is bound. Okay, please remember this. He can promulgate ordinance. Ordinance, you remember? It's like a stopgap solution when both the houses or one house is not in session. And if house is not in session and government wants some law to be passed, how are we going to pass that law? If house is not in session and there's immediate need. So in this case, our constitution gave this tool of ordinance. You can say temporary law. So he can promulgate ordinance when parliament is not in session. But please remember the detail I told you. UPSC play on those details. Parliament is not in session. It means both the houses or one house. Because you cannot make a law by one house, right? At the level of parliament. These ordinances must be approved by parliament within 6 weeks. Please remember. Because it's a stopgap solution. When parliament is going to be reconvened, session is going to be reconvened, within 6 months you have to get this ordinance passed. He can also withdraw an ordinance at any time. Ordinance was passed, a temporary law, and then President himself can declare on the advice of Council Minister, now I am declaring repealed. He lays the report of the CAG, UPSC Finance Commission and others before the Parliament. This line we are going to read in these chapters as well. So you need to remember, this line is related to what? This power means legislative power, because interaction is happening with legislative branch. Clear? He can make regulations for peace, progress, good governance. Where? Andaman Nicobar, Lakshadweep, Daman and Diu, and Pondicherry as well. Okay, it's specifically mentioned. You should remember. Who presides over the joint sitting? This question is from Parliament chapter, but we should actually start grilling around it because we need to discuss Parliament. Right. Just tell me, what is joint sitting? I told you. That's why I asked this. I told you, when a bill is passed by Lok Sabha and stuck in Raj Sabha, ordinary bill, and it's been more than 6 months, and this condition is a deadlock condition, then President can call joint sitting. So here, President is calling joint sitting. It means calling joint sitting is a legislative power of President. Please remember it. Now, who presides over this joint sitting? Means who is going to be in the chair when both the houses are going to sit together and discuss this bill, which is actually creating some deadlock between them. Answer is Speaker of Lok Sabha. Okay. And if Speaker of Lok Sabha is absent, who is going to actually preside over the joint sitting? Then Deputy Speaker of Lok Sabha. And if Deputy Speaker is absent, then Deputy Chairman of Rajya Sabha. Have I mentioned Rajya Sabha Chairman, who is Vice President? No. Please remember these details. And there's a logic behind it. A Speaker of Lok Sabha, if you compare Lok Sabha and Rajya Sabha, who has more strength? Lok Sabha. Right? Then Deputy Speaker is given preference. Then Deputy Chairman. Why not Chairman? Because Deputy Chairman is a member of Rajya Sabha. Whereas Rajya Sabha Chairman position is ex officio position given to Vice President. So Vice President is not an elected or nominated member of Rajya Sabha. And if we are convening joint sitting, only members should be present. Clear? How many members can a president nominate in Lok Sabha? Come on. I also mentioned this in my previous lecture. Answer is none. Why? Earlier 2 positions of Anglo-Indians were there. But in 2020, government removed them. So it means as of now, no. There's no nominated position in Lok Sabha. Now let's talk about judicial power. He appoints Chief Justice. So when I say judicials, immediately your mind works, oh, now sir is going to talk about pardoning power. Respite, reprieve, commute. There's a lot of confusion there. Now sir is going to clear that. I'm going to clear that. But please remember, judicial power is more than that. It means now any engagement of Honorable President in judicial branch will be termed as judicial power of Honorable President. For example, appointment of Chief Justice of India, judges of Supreme Court, High Court, judicial power. Seeking advice from Supreme Court, although that advice is not binding on Honorable President. Okay, he can grant pardon. Now comes this mercy petitions in picture, which you were waiting for. So we are going to discuss about them in detail. In pardoning power, means pardon, reprieve, respite, remission, commutation. Coming to emergency power, I'm going to discuss about them in detail, okay, because there's good scope of questions from here. I'm going to compare with these powers of president with the power of governor as well. Emergency power we discussed in the emergency chapter in detail. National emergency, president rule, and financial emergency. 2 videos are in playlist Laxmikanth series. Check out those who have not. Now comes the veto power. What is the meaning of veto power? Take your example. You along with your friends were making a plan that, we should go Goa this time. Okay. So all is sorted, finances are arranged, everything is set. But one thing you missed. You missed asking your parents' permission. Now you went to your parents, you were sitting on the dinner table and you asked, I have to go to Goa and everything is planned. This person is going, this person is going. And all the ideal kind of friends of yours, you named them. Right? This is what we use, tactics we use. But parents said no. You said, everything is arranged. They said no means no. Now your plan is cancelled. That is veto power of your parents. At any point, if they say no, it means plan is quashed. So president do have some veto power with respect to certain bills. Right? These bills, all bill passed by the parliament need to be present before the president, then only they can become act. Right? This is quite clear. And president can use veto. But before understanding veto, we should know what choices he has or she has. Can give assent. Okay, then it becomes an act. Withhold assent. Now this bill is not going to become act. Return the bill for reconsideration, has to give assent to the bill reconsidered. I have already told you. Send the bill back for reconsideration. Again, it comes back. Sign this bill. I'm talking about bill coming from union legislature to the president. Does the president has the power to withhold the assent to the bill? That is veto power. Veto power. It prevents hasty and ill-conceived legislation. Why this was made? Why president was given this power to withhold or send back for reconsideration? So that if there's some loophole in the bill as well, then this can be highlighted at this stage. Prevents unconstitutional legislation. Okay, although we have additional layer of safety there, but even if president signs the bill, then there is Supreme Court sitting there and they can review and declare this null and void if this is unconstitutional, right? But there's a check here also. There are 4 kinds of vetoes, which president of India has 3 kinds of vetoes. 4th veto is present with president of USA. Absolute veto, suspensive veto, pocket veto. President of USA also has qualified veto. I'm going to discuss about that as well. Now, qualified veto, which can be overridden by higher majority. For example, if you have presented me a bill and you got 52% majority while you actually cleared this bill from legislature. I'm US president now. I sent this bill for reconsideration as a qualified veto. Now, when this bill is received back to me by 60% majority, means 8% more people, more legislative branch members have voted for it. Now I have to clear it. So it means this majority part works there. Okay. But in case of the suspensive veto means sending this bill back for reconsideration. In this case, there is no need to actually clear this bill with more majority this time. You cleared with 51% majority earlier. I received the bill. I received this bill. I send this bill back. You again send this bill back to me with 51% majority. I am bound to sign this bill, right? That is suspensive veto. Absolute veto. So let's understand them one by one. Power to withhold assent to the bill. It's like President is saying, no, I'm not going to sign. But from where our President gets so much, guts to actually say this to Council of Ministers? So there are cases involved. I'm going to talk about. Bill ends and doesn't become an act. Which case? Private member bill. It means if a bill was raised or tabled by someone who is not a minister, then it may be possible that Council of Ministers, which supported this bill to get passed from Lok Sabha and then Raj Sabha, now Council of Ministers advises Honorable President, sir, withhold this bill. Then even though this bill came at the stage of President, it will be withholded. Second case can be, consider that this government actually proposed a bill from Lok Sabha, then it passed from Raj Sabha, presented before Honorable President, but before President could sign this bill, government got dissolved, right? There was fresh election. After fresh election, new government was formed from other party. So President has done nothing with that bill until now. When President was asked, when they got the list, which bills are with Honorable President, so they got to know, oh, this bill is Honorable President. Now the new government will say, for example, Congress government, right? What is harm in thinking? So now they are going to say that President, sir, you have to withhold this bill. Then President is going to withhold that bill, even though that bill was government bill. But that was raised by earlier government, right? Suspensive veto. You can easily remember, the word suspensive comes from the word suspend, and suspend itself is a temporary provision. For example, when you are going to get into service, there may be some time when you are going to get suspended, and there is nothing wrong in getting suspended if you are correct, right? There will be inquiry and then you will be reinstated. So your suspension, this word represents temporary removal, right? So similarly, when a particular bill was received by Honorable President and he sent that bill for reconsideration, so that is temporary rejection. When this bill is going to come back, then President is going to sign this bill. So returns the bill for reconsideration, can again passed, then he has to give his assent. Cannot return money bill for reconsideration. Now, suspensive veto cannot work on money bill. Means, if this bill which I received, which I smartly actually send that back by using suspensive veto, if that bill is money bill, as per Article 110 of Indian Constitution, then I cannot send this bill back for reconsideration. And you are going to ask why? Because money bill is introduced in Lok Sabha by prior recommendation of President, right? If it was introduced by my prior recommendation, why I'm going to waste time in using suspensive veto now, right? Pocket veto. It means taking no action. Bill, no action was taken by President. President neither gives assent nor withhold assent, and this bill is pending indefinitely. In reference to pocket veto, it is said that India's president's pockets are way deeper than US president's pocket. Because in case of US president, there's a limit till what time no action can be actually taken by Honorable President in case of a bill which is pending. But there is no limit which is mentioned by our Constitution with respect to our President. That is why a bill can remain pending for indefinite period. For 24th Constitutional Amendment Act 1971, President has to give assent to Constitutional Amendment Bill. So this was a time of Indira Gandhi ji. She said, in case of Constitutional Amendment Bill, President has to give assent. No choice. In case of USA President, they have to they have to take action within 10 days. Return the bill. Means suspensive qualified can be used, but you cannot do anything for, you can say, more than 10 days. Presidential veto over state legislation. I told you one case, right? Now let's discuss them in detail. A bill passed by state legislature becomes an act after it receives governor's assent. But there are cases where governors reserve the bill for Honorable President. So when it is received, President can give assent, withhold assent, direct the governor to return the bill, but not in case of money bill, told you. Constitution does not prescribe time limit. This is important, in which the President has to take decision. And that is why sometimes this provision is misused. a state's bill may be stalled, right? Ordinance making power of Honorable President, Article 123. And we are going to discuss ordinance making power of Governor in Article 213 later. So, ordinance has same force as an act. I told you it's like a temporary law. Most important, legislative power of President, most important, meant to deal with unforeseen urgent circumstances. UPSC has asked questions in prelims as well as mains on ordinance making power. Let's talk about limitation. President can promulgate ordinance only when, I told you, both houses or either house, means one house is not in session. It means, yeah, genuinely, we cannot make law as of now, right? So in this case, yes, President can actually pass an ordinance on the, means what is going to happen? This Council of Ministers at the level of Union, they are going to present bill directly before President. And they will say, sir, we'll actually go for this Lok Sabha, Rajya Sabha route later. Please sign this bill and declare this as law, as an ordinance. President can make ordinance only when he is satisfied the circumstances exist. Well, taking this house route is not possible. Now, in this Cooper case, please remember, because UPSC asked question, match the following kind of questions on cases as well. Cooper case, Supreme Court said it is not cool. What is not cool? It is not cool to actually President, using this ordinance making power without actually having sound base. It means SEL that President's satisfaction can be questioned on the malefice. You're not having sound base. Why you actually used ordinance? You could have used this route of Lok Sabha, Rajya Sabha. You could have convened the session. You deliberately did not convene the session and use this ordinance route so that you can bypass Lok Sabha, Rajya Sabha. It may be possible that party in power is not having majority in Rajya Sabha. So they thought, oh, even if you get it passed from Lok Sabha, then this bill will stuck in Rajya Sabha. Let's use this ordinance route. So Cooper case, Supreme Court said it's not cool. We can actually check the malefice. That President has deliberately promulgated an ordinance in controversial subject, bypass the authority of Parliament. This is a misuse. Means questions are asked here. Ordinance making power is co-extensive in all regards except duration with the law making power of Parliament. It means it is not ultimate. It is not going to continue. There's a limitation to that. What is the limitation? That when Parliament is going to convene within 6 weeks, you have to get this ordinance passed from there. Otherwise, it will cease to exist. Parliament has even, government has many times played smart in that case also. I'm going to talk about DC Wadhwa case. Now, an ordinance can be issued only on those matters upon which Parliament has power to legislate, not on stateless subject. Now, please remember, this is a trap statement. UPSC may play with you at this point. How? They may say, since this statement is clearly written in Laxmikanth, so those you are going to read this, so this is a snapshot from Laxmikanth itself. But now I'm making a statement, you have to tell me the statement is true or false. UPSC will say, ordinance making power of President in any case cannot extend to state list, comma. This ordinance making power can only be applied on union list. Now tell me the statement is true or false. You will say that it is true, because you are saying that ordinance making power of President does not extend to state list. Yes, and this statement is saying ordinance can be issued only on those matters upon which Parliament can legislate, not on state list subject. It is clearly used. What is trap here? My friends, the statement is wrong. Because this statement is made only with respect to President chapter. But when we discussed, if you remember, emergency provisions, President rule, state emergency. So when there is no state government there and there is no Parliament in session, then in this case, President can actually promulgate an ordinance on a matter in state list as well. So it means there is a possibility there Yes, president can do that in that case. But when this statement was made, like I said, president in any case cannot legislate, cannot actually promulgate ordinance in state list. So cannot in any case. No, there's a case. I just shared with you. Right? So this is how UPSC play. Okay. Ordinance are subject to the same constitutional limitation, means review can happen. Judicial review can happen. Okay. It can be declared null and void. Every ordinance issued by president has to be laid before Parliament House when the Parliament reassembles. If it is approved by Parliament, then it becomes act. If Parliament takes no action, then it ceases to operate after 6 weeks of reassembly. Now, if I ask about the maximum time, maximum life of an ordinance, so this can be 6 months, 6 weeks. Why? Because within 6 weeks, Parliament has to give assent. And if Parliament is going to give assent, means Lok Sabha, Raj Sabha are passing it, then definitely it can convert into an actual act. And why the 6 months? Because maximum time period between 2 sessions of Parliament can be 6 months. Within 6 months, you have to reassemble Parliament. That is the direction of our Constitution, right? So, ceases to operate earlier if both the houses disapprove it. Maximum life, told you. UPSC has asked statement question on this. If an ordinance lapses, then acts done before it lapse remains valid and effective. Please remember it also. Because the actions which were taken by different functionaries exercising power from that ordinance, they will remain valid because this was taken when that particular ordinance was actually working as a law. So that is why they will remain valid. The president can also withdraw an ordinance at any time. Ordinance can be retrospective. Retrospective, it means from backdate. Please remember, retrospective in civil cases, right? Can modify, repeal an act of parliament or another, such is the power of ordinance, right? Now, ordinance making power is not discretionary. It means president has to act on the aid and advice of Council of Ministers. Already told you. Ordinance making power of president is unusual. Means it is not usually found in democratic societies. Why? Because democracy means parliament, people elected by people, representatives elected by people, they should have power with respect to lawmaking process. So it means you are clear with the provisions with respect to ordinance. Now, DC Wadhwa case. Take a look what Supreme Court said. Successive promulgation of an ordinance. What happened? That even if a particular ordinance is not cleared by Parliament, 6 weeks happen, within 6 weeks you need to get it passed. But this particular government is not presenting this particular bill over or ordinance for getting it passed from Lok Sabha or Raj Sabha. What they are doing, they're again actually bringing it before Honorable President. Sir, please promulgate it again. So this would be actually against this. It would be considered unconstitutional. An attempt to get bill passed by Assembly Parliament around violation of the Constitution. Who said this? DC Wadhwa case. Clear? Exceptional power of lawmaking through ordinance cannot be used to substitute the ordinary legislative process. I think it is clear now. Pardoning power. So president can grant pardon. So there's a broad word, mercy, right? Within that we use the word pardon, commutation. So it may be possible that you were pronounced, someone else were pronounced, say. So now we need to talk about pardoning power of president. Consider someone gets life imprisonment from High Court, appeal in Supreme Court, then again life imprisonment. So possibility is given to that person that that person can appeal before Honorable President for mercy. Because there can be an error of judgment, there can be a fault in the judicial process which can be corrected at the law of president. But you should remember that president is independent of judiciary. You should not consider that this is a proper judicial process, that there will be a court of president where that person is going to appeal before Honorable President through an advocate. No. President is going to receive the case file. Okay, so that is why it is an executive power, not the full proof, judicial process. So President is not court of appeal. It is not court of appeal. Okay. Objective of conferring this power to the President, as I told you, keeping the door open for correcting judicial error. It may be possible. Afford relief from a sentence which the President regards unduly harsh. There were cases, for example, if you search about Dhananjay death sentence case. So there was a guard in this West Bengal, specifically in Kolkata, and that person was pronounced this death sentence, in a rape cum murder case. But after this death sentence was given, later some media group found out some proof, and then case was reopened, and it was found that that person did not committed this crime. But death sentence was given. So this scope is there, right? So this scope can be removed. There's a probability that it can be removed by listening to this, or you can say going through this file and case fact before Honorable President. Although President does not act on his own discretion in this case, right? Means Council of Ministers has a role, specifically Home Ministry. Okay. So no right for oral rehearing. I told you, exercise power and advice of Union, right? Council of Ministers, specifically Home Ministry, not bound to give reason for his order, right? Not bound to give an order. Means not, if for example, if President says, oh, I'm pardoning this person, absolving from all the, all the foundations which was put, completely removing life imprisonment, now this person is free. Yes, President can do that. So President is not bound to give reason why President did that. President can afford relief not only from a sentence, but he consider unduly harsh, but from what he considered as a mistake. So in all the cases, he can do that. Supreme Court does not need to lay a specific guideline for the exercise of power of President. Please remember this, because UPSC play on these points. Supreme Court does not need to lay specific guidelines. There's no role of judiciary here. That's why I told you independent of judiciary, right? Here, I told you. This is the meaning of that. Now, if I ask whether this judgment can be considered under judicial review, yes, it is. Judicial review ground when presidential decision is arbitrary. So judicial review applies there as well. Don't think, oh, President is the topmost position, that this decision is going to be on judicial review. No, judicial review hai. In an earlier petition, if an earlier petition is rejected, then the stay cannot be obtained by filing another petition. For example, if this petition was presented before Honorable President, it was not accepted, then you cannot say, I'm filing another petition and meanwhile give me stay. No. This cannot be a basis of taking stay from court just because your petition is with President. Now let's understand these words. What the meaning of word pardon? Complete relief. Complete relief. You are free. It's like Ja Simran Ja, ji le apni zindagi. Okay, the famous dialogue of DDLJ. Now, commutation. There's a trick there. Commutation you can remember with commute. Right? Commute means from one to another. That is what we call commute. So this way you can remember, in commutation, there is actually change in the type of sentence. And sentence's type is changed and it is given at a lighter note. Then remission. Remission you can remember with emission. And all of you know that we need to reduce emission. So in this case, the type of sentence is not changed. It is just reduced. Reducing the period of sentence without changing the character. Clear? Respite. Despite. So this is a trick I have given to you. Despite means, so you can remember, oh, respite means despite a person, a lady is pregnant or a person is disabled, very old, still that person is in jail having this 14 years of sentence. So in this case, on these grounds, a lesser punishment can be given, right? Just to remember. Reprieve. You can remember rep, zip. Zip means stay. Right? So reprieve is like putting a stay. Right? If you were given death sentence, no. Death sentence will not be given as of now. Okay? So I hope now these 5 words and this meaning is clear to you. Now, pardoning power, and let's compare it with governor. President can pardon death sentence. Governor cannot pardon death sentence. President can pardon court-martial. Governor cannot pardon court-martial. President exercises judicial power in the punishment which is given under union law. Governor exercises power under punishment given under state law. Now, I told you judicial review is applicable. Pardoning power of president are wider than governor. As I told you, it is applicable in death sentence as well as in case of court martial, right? If the power is given absolute, so is president's pardoning power is absolute? No, absolute nahi hai. Because it may give right to arbitrariness. Home Ministry can actually send this recommendation, even this person is a hardcore criminal, this person is given death sentence, then Home Ministry can give this recommendation, please pardon that person. Just say that to that person, Ja Simran, Ja Zile apni zindagi. Now the Simran will go into society and create devastations, right? So that is why this is not complete, this is not absolute. So Apuru Sudhakar case, Supreme Court clearly said that we have to check on the pardoning power of the president. What kind of people are completely absolved from any kind of sentence by president? Judiciary can intervene to prevent him from actually doing arbitrary actions. Now, since we are done with the powers, now let's have a summary of president. Nominal executive of our parliamentary system, it is clear. This is the first word which I shared in the video 1. President exercises functions with aid and advice of Council of Ministers. He represents the nation but does not rule the nation. He's a symbol of nation. Executive power of the union vested in president shall be a Council of Ministers to aid and advise. In 42nd Constitutional Amendment Act, Indira Gandhiji's time, president bound by the advice of Council of Ministers. But in 44th Constitutional Amendment, Morarji Desai government came and they made this proposal. They actually made this amendment. It was a proposal earlier. President can request the Council of Ministers to reconsider its advice. But this reconsideration is once the reconsideration advice shall be binding. Means when it's coming back, then it will be binding. President has no constitutional discretion, but situational discretion. Means there are some situations in which president don't need advice of Council of Ministers. For example, if Prime Minister dies and the ruling party is not having any consensus whom they should actually consider as the leader of the house and then declared as Prime Minister by Honorable President. So there is no consensus on the leader. In this case, president can take call on discretion. Okay. Dismissal of the Council of Ministers. If the ruling government, the ruling party, they are not able to prove that they are having confidence in the house, means they are having majority support in Lok Sabha. In this case, dismissal can happen. Dissolution of Lok Sabha in case they loses majority in the Lok Sabha. Right? Now just attempt this question. Council of Ministers in the center shall be collectively responsible to the parliament. Statement is true or false? False, because the word is parliament. Council of Ministers is responsible to Lok Sabha. Right? Till the time they have majority in Lok Sabha, they will remain in as Council of Ministers. Union Minister shall hold the office during the pleasure of President of India. Correct. Prime Minister shall communicate to the President about the proposal for the legislation. Correct. Told you in the executive power, info seeking. Right. So answer is 2 and 3. 2 and 3. Hello everyone. Wish you a very happy Holi. So this video is in continuance with our Laxmikanth series with the name Contasth. So today we need to start Union Executive, which is part 5 of our Constitution, Article 52 to Article 78. When we say Union Executive, there are 5 positions which come under this. UPSC has also asked one question in Prelims on this, and one option was CAG. And the question statement was, identify which of the following is not part of Union Executive. So some students who understand the general meaning of executive is to execute the laws. So that student was confused that CAG is a executive, is a position, right? There to execute laws, and this position is with union government, then by this logic, CAG should be considered as part of Union Executive, right? But my friends, the general meaning of a word may be different from the inferred meaning in a specific part in our Constitution. For example, the meaning of state in general, or you can say the provinces, is different from the meaning of state in Article 12, Article 36, right? So that is why if UPSC was asking this question that what is the meaning of Union Executive, which positions are part of Union Executive as mentioned in part 5, then you should know these are the positions. Okay, President, Vice President, Prime Minister, Council of Minister, then Attorney General. Okay, now let's talk about Honorable President. So here's the list. Now, first thing which should come into your mind is who can be, President of India. What is the qualification? Then what is the election process? Who can vote in this election process? How this election is conducted? What's the process? UPSC has asked question on processes as well. Then impeachment. Appointment is done, election is done, then impeachment. Then finally powers. So powers part we are going to deal in the next video. Today we need to focus on these parts. Okay. So first let's talk about qualification. First qualification is citizen of India. Now, it is not saying that that person should be citizen of India by birth. It is saying citizen of India. But when we read about qualification of US President, that person should be citizen by birth. For example, famous Hollywood actor Arnold Schwarzenegger. So he became governor of California state, but he could not become president. He could not fight the election of president because he was born outside US. He was born in Sicily, near Italian peninsula. So now he should have completed 35 years of age. Minimum age is 35. No maximum age is written. Even if you are 90 years of age and you think you can fight and become US president, Indian president, then you can become Indian president, but you have to go to the process that I'm going to tell you. He should be qualified for election, the member of Lok Sabha. Now many students have this question, sir, Honorable President is not part of Lok Sabha? Correct. It is also said that when a person is president, then that person should not be part of Lok Sabha, Rajya Sabha or any state legislature. Should not be in any office of profit. Means any government office from which he or she can draw some money remuneration. That is correct. Then why the word Lok Sabha is there? The reason is because we are talking about qualification for election. Right? So there are some qualification for election for Lok Sabha members as well. Right? So those qualification for Lok Sabha member are going to be applicable for Honorable President as well. Some changes are there which are specifically mentioned here. For example, for becoming Lok Sabha member, minimum age required is 25 years. Right? But here it is specifically mentioned 35 years. Right? He should not hold any office of profit, as I just told you. Should not be on any other position of government. From there that person can actually draw some money. Right? A sitting president or vice president, the governor of any state and a minister of the union or any state is not deemed to hold any office of profit. What does it mean? It means if you are not in these positions, you are on some other position, then you have to resign from those positions. Right? But if you are on these positions, then you can transition to become the President of India. It will not be considered as office of profit. Right? Qualified as presidential candidate, if you are qualified, then this transition will happen. So please remember, this can be a scope of question. Right? They may say that which of the following is not considered as office of profit when it comes to election of President of India. Not come under. Right? Other statement can be which of the following is considered, can be considered as an office of profit. So you should remember these details: sitting president, vice president, governor, any state or minister of the union or any state. So it is quite easy to remember: president, vice president, governor, minister of union or state. Right? Now, how president is elected? The word is elected means election is going to happen. Means some people are going to vote. Now, is this direct election or indirect election? When I say direct election, it means people of India, means common people, they are going to vote. But in case of president, there is no direct election. Election is indirect. It means our representatives in Lok Sabha, Rajya Sabha, state legislative assemblies, elected representatives, they have this power to participate in the election of president, not the common masses, right? So there was this debate in Constituent Assembly as well, that why not conduct a fresh election, or that election should be like all over the people, all the people, universal electoral franchise should be the basis, and they should participate in election of the president. On this question, Mr. Jawaharlal Nehru stood up in the Constituent Assembly and he replied that in case of India, president position is nominal. Nominal. Real power is with PM. If real power is with PM and this position is nominal, then why you have to conduct such a big exercise that all of the people in India, adult people, they are going to, eligible voters are going to vote? That would be wastage of time. That would be, wastage of public money, right? So that is why it is better to have indirect elections. Because our model is different from the US model. You cannot say in US, in presidential election, every adult voter, they vote. Because real power is president, na. So one logic was this. Second logic which was given by Mr. Jawaharlal Nehru was that if president comes with the direct election, then there may be conflict between president and prime minister. Because president might say that we are living in democracy and people have directly elected me. So I'm not going to listen to your advice every time. I am representing will of the people. Do you think such kind of conflict in these two top positions would be conducive for any country? No. That is why this process needs to be, set in a manner where president knows what his or her responsibilities are, so that this constitution, this machinery actually runs as per Indian Constitution, right? So they are elected by electoral college. When I say electoral college, it means members who are going to participate in election of president. They are called part of electoral college. And who can do that? Elected members of both houses, Lok Sabha, Rajya Sabha. Please remember, I am talking about elected members only, not nominated. Okay. For example, in Rajya Sabha, you have 12 nominated members, so that they cannot participate in election of president. In case of Lok Sabha, earlier we had 2 Anglo-Indian nominated seats, but in 2020, these nominated Anglo-Indian seats were removed. So now in Lok Sabha, we don't have any nominated member, right? So please remember, elected members of both houses plus elected members of state legislative assemblies. Now, please focus. In the statement of the exam, what UPSC can do, they will say LC, Legislative Council. They will say elected members of legislative councils have right to vote in presidential elections. So you will say it is false, it is not correct. Now those who are thinking, why? If at the state level there are 2 houses in legislature, legislative assembly and legislative council, like we have 2 houses at the level of union, Lok Sabha and Rajya Sabha. So if both the elected members of both the houses are allowed to vote, then why not at state level both the houses are being allowed? There's a reason for that. The reason is, not every state is having legislative council, right? And if members of legislative councils are also allowed, then it will create disparity among states. States who are having legislative council, their elected members will be able to vote, and those who are not having legislative council, this will be like decrease in their, you can say, participation in this crucial election, right? I hope now you got the logic. Elected members of the legislative assemblies of UTs of Delhi and Puducherry. Now there's an interesting twist here. J&K. J&K. So J&K is a UT now and a UT with legislative assembly. But we don't have, legislative assembly members as of now there, elected members. So there was one RTI which was filed in Election Commission, and the applicant was asking that whether J&K MLAs who are going to be MLAs in future, because elections are yet to happen, then whether they are going to be allowed to participate in presidential election or not. So on this point, what Election Commission replied, they said, please refer to Article 54. As I told the Union Executive, Articles Part 5 starts from Article 52 to 7 and then end on 78. So Election Commission saying please refer 54. And 54 is talking about this. Elected members of legislative assemblies of the Union Territories of Delhi and Puducherry. It means the name of J&K is yet to be added. Although this bill was floated by our Home Minister himself, but it is yet to be finalized. So some legal luminaries were saying if UTs of Delhi and Puducherry are allowed to participate in this election of president just because they have state legislative assemblies, then by this logic J&K MLAs will also be allowed. Okay. So this is one logic, but I told you what reply of Election Commission was saying. Now let's dwell into the details of this election process. Constitution provides uniformity. Uniformity, as I told you, means parity among states, right? It has been the effort. I told you nominated members cannot vote. Also told you legislative council members cannot vote. Also please remember, what if one or two state legislative assemblies are dissolved when election of president are finalized? So at this moment, can dissolved legislative assembly can be revived and their MLAs will be allowed to vote? No. So it means if some legislative assemblies are dissolved at that point of time, it means there are no MLAs there. Elections are going to happen in that state legislature, but election of president is not going to wait till that point. Okay, that should be clear. If there's any dispute with respect to election of president, means some contender is saying, sir, the other candidate has forged some document. So such disputes are going to be taken up at the level of Supreme Court only. They cannot be taken up at the level of High Court. Please remember these kind of, you can say traps UPSC lay. And the decision of Supreme Court will be final. Okay. Now, if there's incomplete electoral college, incomplete electoral college means, for example, in 3 states, state legislative assemblies are dissolved. So it means some states, 3 states are not having elected MLAs. Now, the election of president is not going to wait for these 3 states. So that is why incomplete electoral college is not ground for challenging the election of president. Okay. I hope these details are clear to you now, right? Now, I use this word uniformity, parity among state. So how election happens? Have you ever voted in your life? So you must have gone to, say, for voting of election of MLA or your Lok Sabha MP. So you have used EVM, electronic voting machine, right? Now tell me, do you think in president election EVM is used? Those who are thinking, yeah sir, EVM is better model, right? That's why everyone is using, every election we are using it. In your state legislative assembly election and Lok Sabha election. And it should be used in president election as well. No, that is not true. Because in case of president election, we have to ensure proportional representation with single transferable vote. 2 words are used. Proportional representation and single transferable vote. And these are quite easy to understand, quite easy. First, let's understand what does this proportional representation means. Our constitution tries to give weightage as per population. It means if you're an MLA from UP, so value of your vote will be decided on the basis of this formula. Quite simple. Just put total population of state here, because we have to bring proportional representation. Total population of state here. Then total number of elected MLA seats, means total number of elected member of state legislative assembly. For example, 404. So you have to put 404 here. If the population is say 11 crore, put it here. Multiply 1 by 1000. So this is how you are going to find vote value of MLA of UP. If you have to find vote value of MLA of say Andhra Pradesh, vote value of Andhra Pradesh, total population of Andhra Pradesh upon total elected MLA seats in state legislative assembly of Andhra Pradesh, and then multiply by 1 by 1000, right? So by this way you will be able to find the vote value of one MLA. Okay, now vote value of an MP. Now total value of votes of all the MLAs. What does it mean? It simply means, for example, we have just found vote value of one MLA of Andhra Pradesh, AP, right? We are going to multiply with the number of MLAs in AP, elected MLAs in Andhra Pradesh Legislative Assembly. So we will be able to get the total vote value of MLAs of AP. Similarly, we are going to identify UP, MP, Punjab, Maharashtra. So by adding all these, we will be able to know what is the total value of votes of all MLAs of all states. Okay. So for some of you, it may be like, sir, it is a bit tricky. It is not tricky. Total population, you need not to count. This is available in census. Just put it here. Total number of seats, those are fixed. Put them here, multiply 1 by 1000. So it is quite clear, right? Adding those, you have to put here, and upon total number of elected MPs, you have to put here. When I say total number of elected MPs, what does it mean? I am using the word parliament, and UPSC once asked question on this formula. UPSC is not going to ask you formula on this formula. It means to understand whether you understand the process or not. The word is parliament. It means Lok Sabha, Raj Sabha both are involved here. So if I ask vote value of a Lok Sabha MP in president election is different from the vote value of Rajya Sabha MP in election of president, tell me that statement would be true or false. That would be false. Why? Because I am using the word parliament, member of parliament. I am using the word value of vote of an MP. I am not distinguished between Lok Sabha and Rajya Sabha. So it means vote value of an Lok Sabha MP who is participating in election of president is same as the vote value of a Rajya Sabha MP. Now I am making another statement. Please answer. Vote value of a MLA of UP is going to be same as the vote value of an MLA of Kerala in presidential election. Tell me the statement is true or false? A statement is false, because here we are categorizing between states. Vote value of an MLA decides on the population of that state. That is why in case of vote value of MLAs, we are going to find difference, because formula says a specific state. But in case of MP, we talk about all the vote value of all the MLAs of all the states, and then divided by total number of elected members in the parliament. Clear? Is it clear? And 1 by 1000 was here, not here. I suppose now it is clear. Now we are going to talk about this word single transferable vote also. Okay? For this, I need to first let you nominate yourself in presidential election. Okay, then I'm going to come to that. Now, who can actually fight presidential election? Is it possible that one fine day you wake up and you say to your father, sir, father, you were thinking I'm going to give UPSC Civil Services exam, but now plan is changed. Father is asking, what's the plan now? I'm going to fight presidential election. So father is saying, have you read the qualification? You are saying, yes, sir. Yes, I have read the qualification. So now, even if you are about 35 years of age, even if you are citizen of India, even if you are not barred on the basis of the mentioned criteria of Lok Sabha MP, now the point is, it's not like you are going to knock the door of Rashtrapati Bhavan or its secretariat that I am going to fight election. There's a criteria there. criteria is you need 50 electors as proposers. Who are 50 electors? Electors means those people who are eligible to actually vote in presidential election. And who is eligible to vote in presidential election? I told you. Elected members of Lok Sabha and Raj Sabha, elected members of State Legislative Assembly, elected member of UTs of Delhi, Pondicherry, Jammu Kashmir can become. So now among these you need to actually befriend 50 people. You need to connect with 50 people and ask them, sir, please support me. I want to get nominated for presidential election at least. So you will get Ashirwad of 50 people. That is the first step. But process is not complete yet. You need 50 seconders also. Another 50 people. Not these. Now you need to reach out to another 50 people. So please second me. Second my proposal that I want to get nominated for the presidential election. So if they think, yeah, you are worthy, then they will say, theek hai. The name was proposed by them and we are seconding this name. So when you are done with this, now you will say, theek hai. Now I can be nominated at least for the presidential race. Okay? But you should actually transfer 50,000 rupees challan into RBI account, right? And if you get less than 1/6 vote, then this 15,000 rupees will be forfeited. Okay? If you get more than 1/6 vote value, in that case your 15,000 rupees will be refunded. So I'm supposing you are not getting elected as president. Okay? If you get elected as president, then 15,000 rupees definitely they will be coming back to you. Okay? And you will be having Rashtrapati Bhavan with you. Now, let's understand what is this STV, single transferable vote. As I told you that EVM is not used in presidential election. What is used? Ballot paper. Ballot paper is used. I think ballot paper is visible in front of you. This is my ballot paper. This is my ballot paper. Okay? And this ballot paper is unique in itself. Why? Because you need not to actually give support to only one person. You can give choices in sequence. For example, you are given a ballot paper and you know 3 candidates are fighting presidential election. Rohit, Prem and Shweta. So consider you gave first preference to Prem, second to Shweta and third to Rohit. Right? There are other MPs and MLAs, elected MPs, MLAs, part of electoral college. They will have their own ballot paper and they will give preference according to them. Right? 1, 2, 3. Some people may give preference to Shweta, first preference to Shweta, second to Prem, third to Rohit. Right? And vice versa. ऐसे चलता रहेगा. Now when all these ballot papers are collected, for example, MPs of Lok Sabha, Raj Sabha, they are going to vote in Parliament House, right, in Parliament, and the MLAs are going to vote in their respective state legislature. Then all the ballot papers will be collected by Election Commission of India. Okay? So now Election Commission of India will start counting. So there will be 3 boxes. You can take this example as boxes. Now if first ballot paper is taken and this ballot paper is saying first preference should be given to Prem. So now this ballot paper will be coming into this box of Prem. So Prem has 1 vote in his favor. Second ballot paper says come in favor of Shweta. So this is coming into Rohit, Shweta. So now only first preference is being counted in first sequence of counting. Only first preference, right? Another ballot paper is giving first preference to say Rohit. So another ballot paper coming into Rohit's basket. Another is saying say Shweta, Shweta's basket. Another saying Shweta, Shweta's basket. Another saying Rohit, another saying Rohit. So it means this counting will go on, right? Now, what need to be checked? The point at which 50% plus 1 vote value, the quota which we say is achieved by anyone, that person will be declared as winner, right? And why I'm saying vote value? Because I told you vote value of MLA is different from vote value of another state MLA, and these vote values are different from vote value of MP, right? This is not like one person, one vote value. There's a difference there. So now, when all these vote values are being calculated and it is found that there's a tie, no person is getting clear majority, what is going to happen now? Now they will look which of these three people who get the third position. So we found that Prem got the third position. So it is time to bid farewell to Prem. Prem, you are out of the game. Now you are not in the race of presidential election. Now what is going to happen with the ballot paper which was given to Prem? So we are going to extract that ballot paper. We extracted that ballot paper. So Prem, you are out of the race. Now what we are going to find? Oh, look, in this ballot paper, what is the second preference? Second preference is Shweta. Now, this ballot paper will transfer into Shweta's basket. So Shweta has one more vote, right? So consider, for example, there is another ballot paper. In that we have checked, oh Shweta, you have another. So it means by this manner, we are going to extract ballot papers from the last person and we are going to divide it as per the second preference. And now we will be able to identify which person is the winner. Now you can congratulate that person as President of India, right? But this person has to take oath. Now, in the start I told you why presidential elections are indirect. I told you because President is the nominal head, real power is with Prime Minister. So it is inconsistent. If this much power is not with President, it is symbolic head. Although you can say in the hierarchy, a president comes before Prime Minister, right? But since not much power and we don't want conflict in the office of President Prime Minister, that is why it was not needed. Direct election costly hai, right? And consume a lot of time. Now the point is oath. Oath of President is the responsibility of CJI or other senior most judge of the Supreme Court, okay? UPSC has asked question on the oath content as well. Okay, so you should know what is the content of oath. Faithfully execute the office, number one. Preserve, protect and defend, PPD. Preserve, protect and defend Constitution and the laws. And the law is mentioned. Devote himself to the service and well-being of the people of India. Okay, so these are the 3 points, the content of oath. Oath is administered by CJI or senior most judge, already told you. Acting President, consider that if President of India actually dies, okay, God forbid, but if dies, what is going to happen? That person is in position, dies. So now Vice President has to act as acting President. But Vice President for that has to take oath. Oath will be same. But Vice President will act as acting President, not full-fledged President. Okay? It means we are going to wait for the fresh election. Okay? Now, conditions of President. Should not be a member of either House of Parliament. As I told you, Lok Sabha, Raj Sabha or any state legislature, you should not be. Office of Profit, you should not be at Office of Profit. Emoluments, allowances, privileges of Office of President are decided by Parliament. Please remember, these are decided by Parliament. Personal immunity, or another point is, if you are appointed as President, elected as President, now your salary, your remunerations, allowances, they cannot be diminished during your tenure. Okay? Personal immunity is provided for all the legal aspect of the office when, for example, you are signing a particular file on the advice of Council of Minister. So you cannot be dragged into court that why you signed that file, right? You are getting immunity for all official acts. So this is official act. What about personal act? So there are two kind of act, official act and personal act. So in personal act, there can be two kind of, you can say, offenses a person can do. For example, civil offenses and criminal offenses. So in case of criminal offenses, you are immune from criminal proceedings, even in respect of personal acts. But I'm immune till what point? Immune only till the point you are President of India. Okay, it is not like you can murder anyone and you can say I'm President of India, nothing can happen to me. The point you are removed from this position, then police will knock your door. Sir, please give us some chance, right? Now, civil proceedings. In case of civil proceedings, means proceedings can actually start against you, but you will be given a 2 months notice, okay, during the term of office in respect of his personal act. But civil proceedings in case of personal act, okay, civil proceedings like there's a case of tax fraud, revenue issue, land issue, family issue. In this case, 2 months notice will be given. Okay, I hope official, personal, 2 cases, I think criminal and civil, these are clear to you, right? Now, term of president office, term is 5 years. Beyond this, until his successor assumes charge, a person will be on this position. Eligible for re-election, because there's no binding thing that there's a limit of 2 times, 3 times. Nothing as such is mentioned in our constitution. You can resign from your position, and this resignation to be given to whom? Vice President. Please remember, oath was given by CJI or senior most judge of Supreme Court, but when it comes to resign was given to Vice President. Can be removed by impeachment. So impeachment is a process which is done in Parliament. So what can be the basis of impeachment? Important topic, because many times question has been asked. So our constitution says violation of constitution is going to be the basis of impeachment. But what is going to be considered as violation of constitution? What is the definition of violation of constitution? It is not defined there. So it is prerogative of Parliament to define what is going to be considered as violation of constitution. Okay. So now let's understand the process of impeachment. Impeachment means we are going to remove honorable president. Now this process can start either in Lok Sabha or Raj Sabha, right? Can start from any house, Lok Sabha or Raj Sabha. And the condition says at least 1/4 members of the house should sign the proposal and give it to the presiding officer of that house. For example, we start this process from Lok Sabha. Okay, so 1/4 member of the Lok Sabha, they're going to make the proposal and they're going to present before the speaker. So now when speaker is going to see the proposal, now speaker is going to give 14 days notice to the honorable president. Okay. After this, Lok Sabha is going to bring resolution in this regard, and this resolution need to be passed by majority of 2/3 of the total strength. Please remember, I'm not talking about present and voting, total strength of the house. You need to get it passed from 2/3 majority, right? And when it is passed from this house, then this proposal will be transferred to other house, say Rajya Sabha. Then Rajya Sabha, after receiving this process, is going to conduct inquiry. Means inquiry is going to be conducted by second house. Please remember, means if this process starts from say Rajya Sabha, then inquiry is going to be conducted in Lok Sabha. If process starts from Lok Sabha, then inquiry is going to be conducted by the second house, that is Rajya Sabha. So when they conduct inquiry and they submit this report before whole house, then they are going to bring this resolution, right, to vote. So they also need 2/3 majority of the total strength of the house. When this is passed from this year, then it is declared that president is impeached. Now president is done, removed from his position. Okay. Now my question is, when 1/4 members of the house presented proposal before speaker that sir, we need to remove honorable president, we have credible proof against honorable president that he has or she has violated constitution. Is it mandatory on the speaker to actually bring this proposal in the house? Or at the speaker stage itself, a speaker can say, okay, you are saying, but I do not agree, and that is why I'm not allowing this impeachment process to start in Lok Sabha. What do you think is truth? Means, is it mandatory or not mandatory? Tell me in comment box. So now, this process is clear to you. Now this is mentioned here in words. 1/4 members of the house frame charges, 14 days notice to be given, passed by 2/3. After that, other house has to investigate the charges. President has the right to appear and represent at such investigation, right? President himself or herself can be present. President can also send someone. Other house has to sustain the charge and pass the impeachment resolution by 2/3. Told you. President stands removed. Impeachment is a quasi-judicial process. Why we call it quasi-judicial? Because House is actually conducting the inquiry, investigation. House is also deciding whether, oh, these charges are proved. This is not going into court, because when you use the word judicial, it means now legal courts are going to work. But in this case, it is not the case, right? Elected members of the state, now who is not going to participate? Obviously, it is quite clear to you. In this whole process of impeachment, have I ever mentioned state legislature? No. So there is no role of state legislature. Elected member of state legislative assembly participated in election of president, but not in removal, right? Now, have I mentioned that only elected members of the parliament, elected members of Lok Sabha are going to participate in this? No, I told you 2/3 of the total strength. And when I am saying 2/3 of total strength, I need maximum strength. Their nominated members are also going to participate in the removal. Okay? So elected members of state UT do not participate in impeachment, although no president has so far been impeached. अभी तक कोई impeach नहीं हुआ. Clear? Nominated members of the either house of parliament can participate in the impeachment. I told you, right? So this is clear to you. Now, vacancy in the office. In what case this position can be vacant? Number one, if 5-year tenure is going to be completed. So although before that, President is this Election Commission of India is bound to conduct election, right? But what if there is resignation? President resigns. President can resign to Vice President. Then position will be vacant. VP will be acting as acting President, but not full-fledged President, right? Means position is vacant. There can be impeachment, like we discussed. There can be death, right? Or there can be disqualification also. For example, in our example, Shweta became President of India. So Prem may file a case in Supreme Court. Sir, Shweta's election should be declared null and void because Shweta in her paper said she is 36 years age, but she is 32 years of age because I got these credible proofs. So on this basis, Shweta's election can be disqualified, right? So on this case, in this case also, this position of president can be vacant. But what is going to happen with the actions which Shweta took in these 2 months when she was President of India? After that, she was disqualified due to forged documents. But whether the actions which were taken by her during these 2 months, whether those will be null and void or not? Answer is no. It means action taken by Shweta by being in the position of president will remain intact. Okay? So, if there is vacancy within 6 months, you have to conduct election. New president remains in office for 5 years. Okay? For example, someone actually was president for 1 year, but after that person resigned. So now the fresh election is going to happen and the next person is going to be in this position for next 5 years. It's not like now this person is going to be for 4 years. No. Until election happens, VP is going to act as acting president. Okay. When a sitting president is unable to discharge his functions due to absence, illness or otherwise, who is going to work? Vice president is going to work as acting president. Okay. So if VP's post is also vacant, then what is going to happen? Then CJI or senior most judges of Supreme Court are going to act as acting president. So it means first president. If president is gone, then vice president. If vice president is gone, then CJI. If CJI also gone, then senior most Supreme Court judge. And we have line of Supreme Court judges. So you need not to worry. There will be someone working as acting president. Okay. Any acting president enjoys all the powers and immunities of the president and is entitled to privileges, emoluments, allowances as determined by parliament. Okay. But there is a trick here, trap here. Although Laxmikanth is quite direct in this regard. Trap is, what if president is ill? And in this case, vice president is working as acting president. So in this case, what do you think? This acting president will get full salary of president? Answer is no. Because already president is alive, president is there, and that person is drawing salary of president. So 2 persons are not going to get salary of president. But in case president die, disqualify, impeached, resign, it means there is no person drawing salary of president. In that case, if anyone acting as vice president, acting as acting president, then in this case that person is going to draw emolument salary of president. Okay, please remember this. Now these are some questions for you for practice. Procedure of impeachment of the President of India is, told you, quasi-judicial process, Electoral College of President of India not consist of whom? Come on. Member of Legislative Council of State. Told you LC is not included. First President of India who got elected anonymously. So this is a factual question. Neelam Sanjeeva Reddy was there. How many times the President of India can be re-elected? Told you there's no limit. Any number of times. I hope this message finds you fit and fine. My name is Shashank Tyagi. Welcome to Contest series of Indian Polity based on Laxmikanth. In our previous class, we were discussing emergency provisions. We started with the base. What is the meaning of word emergency? Why these provisions were added in our constitution? And we discussed in detail Article 352, that is national emergency, first type of emergency. There are three types of emergency. Second, state emergency as mentioned under Article 356, then financial emergency as mentioned under Article 360. So today our focus would be these. But UPSC sometimes asks question giving multiple statement where one statement might be from Article 52 and another from 356. In order to check whether you are clear about the provisions or not. That is why today I am going to start with revision of Article 52, a quick revision. Okay. And I am going to ask questions from you. Rapid fire round. National emergency. It can further be divided into two parts. External emergency, internal emergency. And this division is based on ground. Means basis on which national emergency is imposed. So there are three grounds. War, external aggression, armed rebellion. If above two are the ground for imposition of national emergency, then we call it external emergency. Then we call it external. And if third is the reason, armed rebellion is the reason, means from inside, conditions are such that national emergency need to be imposed, then we call it internal emergency. Quite clear. Then I ask a question from you. Is there a possibility that if none of these three conditions are actually happening, can President still invoke the provisions of Article 52? Can national emergency be imposed in India? Yes or no? Answer is yes. Because immediate danger word is also mentioned in Article 52. It means if there is possibility, high possibility of such circumstances, then also national emergency can be imposed. Now my another question. Is it possible to exempt an area from imposition of national emergency? It means President declare national emergency but give exemption to say Tamil Nadu. That this will not be applicable in Tamil Nadu. Is it possible? Answer is yes. It means it can be applicable in whole of India or part. Why? Security reasons. If there is no security threat persist in Tamil Nadu, it is quite stable, law and order is intact, then there is no need. Okay, so such thing can happen. Now this is Article 52 and we have broken it and understood it. Now when it comes to approval, means you are president and being president you have declared that national emergency is imposed. But it's still this particular national emergency proposal need to be cleared by both houses of parliament within 1 month. Means if you have declared national emergency on 1st Jan, then within January you need to get it passed from both the houses of parliament. Please remember 1 month, because this is a differentiating factor. Only in case of national emergency the word 1 month is used. Okay, but when we talk about state emergency and financial emergency, approval is needed there also, but there we are going to read 2 months. Okay, there should not be any confusion. Now what if Lok Sabha is not there, means Lok Sabha get dissolved, and here we said that it need to be passed by both house, approved by both house. So one house is not there. What is going to happen then? I told you. Then you need to get it passed from Raj Sabha. And when Lok Sabha is reinstated, reconstituted, then within 1 month, within 30 days, specifically 30 days are mentioned, within 30 days you need to get it passed. You need to get it approved, the proposal of this national emergency. Now comes the question, consider it is approved. First step was declaration. Second step was approval from parliament, approval done. Third is, by which majority? Answer is spatial majority. Please remember, Only in case of Article 352, approval need is special majority. Only in case of Article 352, okay? If we compare with other two types, 356 and 360. In 356, in 360, it need only simple majority. Okay, I hope now it will be quite easy for you to remember. Now, consider it is approved. Now, how long this national emergency will continue? Answer is 6 months. Before ending of the 6th month, you have to get it approved from Parliament again. Now, the point is there some limit, or we can actually keep on asking for revival of national emergency and it can continue? Is there some slab? Answer is there's no limit. It means national emergency can continue to infinity because there is no such, you can say, limit mentioned there. Why constitutional framers have not mentioned limit? Because if national emergency is imposed due to some external threat, internal threat, then no one can say when this threat is going to be removed. If the limit would have been imposed, say, 1 year, and threat is continuing for 3 years, then what is going to happen? History teaches us that in many countries were on war for 5 or 6 years. In case of war, more power is needed at the center. So if you put a limit of 1 year, then the purpose of national emergency would have been dissolved, right? I think it is quite clear to you now. Every resolution approving the proclamation to be done by special majority, already told you. Please remember, we are talking about Article 352. Now, revocation of proclamation. 3 cases. 1, जिसने किया वही उसको हटा दे. It means President has declared national emergency. President himself or herself can declare that it is revoked, obviously on the advice of Council of Ministers. Second, power is with Lok Sabha. So one power is with President, another is with Lok Sabha. Lok Sabha can bring resolution, and if it is passed from simple majority that Lok Sabha wants to remove national emergency, it can be removed. Third case was added through 44th Constitutional Amendment Act. It says that if 1/10 member of Lok Sabha, again, the power is in Lok Sabha, but 1/10 member of Lok Sabha can bring a proposal, write a letter, they can sign and give this letter to Speaker. That's Honorable Speaker, just we want a session in the House so that we can bring a proposal for removal of national emergency. If Lok Sabha is not in session, then they can present this letter even to Honorable President. And this provision says within 14 days, session need to be held. And if there it is passed from simple majority that we need to remove national emergency, then it will be removed. So there are 3 cases. I hope now it is clear to you. Now, effect on the life of Lok Sabha and state legislature. Consider that Lok Sabha is having a, say, tenure of 5 years, right? So normally it is tenure of 5 years, but national emergency was imposed in 4.5 years, means 6 months were left. So national emergency is imposed for 6 months, and it can be extended again if condition persists and Parliament approves. So when national emergency is continuing, parallelly, the life of Lok Sabha can also be extended. Extended by how much time? Answer is 1 year. Please remember this. There should be no confusion in this. When it comes to national emergency, it is being extended 6 months at a time. But when it comes to life of Lok Sabha, it is being extended 1 year at a time. And why this difference was made by our constitutional framers? There's a simple logic to that. If you also extend this for 6 months, it would be difficult to actually maintain the need, or you can say maintain this conditionality that within 6 months you have to get it approved. National emergency need to be approved because these are tiring circumstances, and in this government needs a strong Parliament because important discussions will be made there, laws will be made there, the working of Parliament will continue, right? So if Parliament's future itself is under threat that after 6 months it can be dissolved, then how can actually this 6 months extension of national emergency and debate on whether we need to extend it or not can actually happen peacefully, right? That is why security was given to Lok Sabha, then only they can continue with this important decision. Clear? Now, same provision is applicable with respect to state legislature. Means state legislature, because conditions are such that it may be possible that there is no scope of having elections for the state legislature itself, right? So in this case, national emergency is being extended for 6 months at a time. Parallelly, the state legislature tenure can be extended 1 year at a time. And there's no limit mentioned here. I gave you the reason why, right? Now, with respect to its connection with judiciary, you need to remember 3 things. 38th Constitutional Amendment Act, 44th and Mill case. 38th Constitutional Amendment Act was actually, you can say, brought by Indira Gandhi government. What she did? She said this imposition of national emergency is beyond judicial review. Court cannot question, court cannot stall, court cannot revoke. Now, 44th Amendment Act changed this and it brought this national emergency into judicial review. Review means judiciary can check. And minimal case, Supreme Court itself clearly said that this national emergency can be challenged in court. Now, court can check whether malified intentions were there or not, whether adequate proofs were there or not, or it was just for political gain. So it means now judiciary's ambit or judiciary's review is there on national emergency. Clear? Now let's talk about President rule. So now you have actually structured your understanding of national emergency. Now you will be able to compare with 356 and 360 better. We are talking about President rule. Why President rule? President is the executive head of Indian state, right? And some responsibilities are given by Constitution to the center. Responsibilities like this state should run as per the Constitution. This responsibility is mentioned, this duty is mentioned in Article 355. And if duty is under threat, it means some state is not working as per Constitution. Some state government is saying no. Either we are not capable to uphold the Constitution or we don't want to work as per Indian Constitution. Don't you think it can be threat to India? In such circumstances, Article 356 can be used, by which President rule can be imposed. So when I say President rule, it means now state government will not be having power, because this state government was not successful in running the state as per Constitution. So in this case, President is going to rule. And you know, President works on the aid and advice of Council of Ministers. So actually indirectly, central government gets power to rule that state. President's name is there, and governor as the functioner in the state coordinates this functioning. I told you 355 and 356 have relation. 355 talks about the duty on the center, that provisions of Constitution should be, in use in that state. It should be run as per Constitution. 356 says that if there is failure of Constitution machinery, then in this case, you can impose President rule. But how it is going to happen? In this regard, governor of that state can present a report before President. Okay, sir, I am the governor of the state and I have these proofs that this state is not being run as per Constitution. Constitution machinery is a failure. So President will say, okay, we are imposing Article 356. Now CM is not going to have power. His Council of Ministers is not going to have power. We are going to have power. Okay. Now another question is it mandatory for the President to accept the decision, or you can say recommendation of governor that please impose President rule here? No. It is not binding on President to accept such, such recommendation, such report. Now another question comes into mind is whether President has only this dependence on state governor, that only when governor is going to present this report, then only this Article 56 can be used? No. This is just one route, right? If President has adequate proof, evidence, and is satisfied that yes, it needs to be done, then it can be done, obviously on the advice of Council of Ministers. So the popularly known as President rule. Now what are the ground of imposition? So ground of emulation 2, number 1, you know that failure of constitutional machinery. Second is that if a state government fail to actually follow the directions which were given by center. It is clearly mentioned in Article 365 that whenever a state fails to comply with or to give effect to any direction from the center, then also this can be a basis of considering that, yeah, failure of constitutional machinery is there. Okay, there are many disputes on this, that any direction word is mentioned, and in this manner, this is against the concept of federalism. Now, parliamentary approval. In case of national emergency, you know that it need to be approved by both houses within 1 month. In this case, it need to be approved by both houses, but within 2 months. Okay, so President rule must be approved by both the House of Parliament within 2 months. There it was 1 month. There it was special majority. Here it is simple majority from either house. So those who are reading this, have you ever thought why in the first line it is saying President rule must be approved by both the houses of Parliament within 2 months, and here it is saying simple majority in either house? So why both and here either? The reason is that there may be a possibility when Lok Sabha is not in session. So in this case, if Raj Sabha approves it by simple majority, then also it will be considered that it is approved by Parliament as of now. Okay, that is the reason. And the second case is similar. If Lok Sabha is not in session, then you have to get it passed from Raj Sabha. And when Lok Sabha comes again, then you have to get it passed from Lok Sabha within 30 days. Same rule is there. Now the time is extension time. Point is extension time. In case of national emergency, we discussed 6 months extension in one time. Here also, it is 6 months extension in one time. There I told you that there is no limit mentioned, but here there is a limit, that is 3 years. So 6 months at a time, but 3 years is the maximum limit, means for which this President rule can be imposed in one stretch. And this is the scope of actually misusing this. It was saying one stretch, na? For one stretch 3 years, then let them have a government, and then 356 can be misused again. Then again, President rule can be imposed. So such circumstances should not occur. That's why this Bommai case, in this Supreme Court has said that Article 356 should be used in rarest of rare case. Sarkari Commission also said that it should be used in utmost necessary circumstances as a last resort. Now, what is the consequence of President rule? So these are the consequences. First of all, on executive part, President gets the power that President can actually take important decisions with respect to the state government, and on the behalf of President, who is going to act? Governor is going to act. When it comes to legislative aspect, he can declare the power of state legislature are to be exercised by Parliament. Okay, legislative power exercised by Parliament. For example, if there is a matter which is mentioned state list, so now Parliament can make a law on this matter of state list. Then suspension power, what does it mean? That it may be possible certain constitutional provisions related to any body, authority, which they consider need to be suspended for time being, so they can suspend these provisions. Okay. Now, scope of judicial review, it is same. 38th constitutional amendment was saying that it is beyond judicial review. 44th amendment was saying, acha, aisa nahi, this cannot happen. So that is why after 44th amendment, this was deleted, and now it is under judicial review. Okay. Now, what happens when a state governor suspended or dissolved? A state government suspended or dissolved. So now these are the provisions. It is quite easy to understand, but I want you to give attention to the details. The best way to answer any kind of question which UPSC is going to throw, in your paper, is that when you learn by questioning the statement itself. When you learn about a provision, just think, if we change the statement, what meaning it is going to infer, whether this statement will be true then only. So when we have this critical reasoning, then polity becomes a cakewalk. Now, Parliament can delegate the power to make laws for the state to President. Okay, so it means, I told you, with respect to legislative changes, now Parliament can make law with respect to state, right? And here we are saying that consider there's no state government there, right? No state legislature there. So now Parliament can actually delegate this function to President also, or President may specify by him or her. President may specify any other authority which can actually do this function. Okay, so UPSC may actually play here. Okay, so who can make law now for state? Parliament, President, or any other authority which is specified by President. So authority is decided by President. Okay, Parliament, or in case of delegation, the President or any can make laws conferring power or imposing. So simply you can consider that with respect to maintaining the law and order, with respect to achieving the desired outcomes, now duties and responsibilities and powers can also be given to central government officers. That even though you are a central government officer, but now you have to take care of these functions for the state government. So this can also be done. President can authorize, when the Lok Sabha not in session, expenditure. So you can clearly remember, President can authorize expenditure from consolidate fund of state. Okay, can. But when Parliament, when Lok Sabha is not in session. Okay, if Lok Sabha is not in session. Clear? And why we are specifically mentioning Lok Sabha is not in session? Because with respect to expenditure, we talk about money bill, right? And for money bill, Lok Sabha has the power. So it need to be approved by Lok Sabha, right? Fourth is ordinance power. Means if Lok Sabha is not in session and there's a need of law, then in this case, President can actually issue ordinance, which is like temporary law, right? But condition is that either House of Parliament should not be in session. Now, revocation of President rule. It is quite simple. President has imposed, President can remove. In this case, Lok Sabha, Parliament is not involved. So it means proclamation of revocation does not require approval by the Parliament. Okay. This occurs when the leader of political party, means opposition political party or any political parties, they say that we have required majority in the state. Now you don't need to actually have President rule here. We can actually prove the majority and we can have a staple government. So in this case, President can actually declare, okay, we are removing President rule. Now these points are important. Just listen to me one by one. Laws that are made by Parliament or issued by the President, they are going to continue even after President rule is removed. But continue till what time? Till the new state government, new state legislature repeal them. Okay, so they are going to continue. Now, powers of High Court. Will there be any change in power of High Court due to state emergency or President rule? No. No change in power of High Court. Because High Court judiciary is totally different. Here the changes are going to come in legislative and executive power. Right? President rule has no effect on fundamental right. Please remember it. In case of national emergency, we talked about Article 358, Article 359, impact on fundamental rights. But here, no impact. Present rule was the first imposed in Punjab. This is a fact, and sometimes UPSC is asking one statement. They give one statement on fact. Okay. Sarkari Commission gave recommendation on the effective use of Article 56 that it should be used in rarest of rare cases. Right. So I think these points are clear to you. Right. No change on High Court, fundamental rights, no change, no impact. First imposed in Punjab, 1951, and told you that it will continue. It is not like these laws cease to exist the moment President rule is removed. Aisa nahi hai. Please remember it. Now let's talk about financial emergency. The word is financial. It means if finances of India, credit of India, it is under threat. Means financial stability or credit of India or any part of the territory is threatened. In this case, Article 56 might be used by the Honorable President, and then financial emergency is going to be imposed. Now, proclamation must be approved by both the houses of Parliament within 2 months. Please remember, in case of national emergency, it was 1 month. 356, 360, it is 2 months. Okay. If Lok Sabha is not in session, the same case, you have to get it passed from Raj Sabha, and when Lok Sabha come, then you have to get it passed from Lok Sabha within 30 days. Okay. Once approved, I told you, in case of national emergency, approved for 6 months, then it needs to be approved again for infinite, no limit. In case of state emergency, I told you, approved for 6 months. You have to come again for 6 months, but there's a limit, 3 years, right? In case of financial emergency, once approved, it will remain in place. You need not to come again and again for approval. Once approved, both the House of Parliament, financial emergency continues indefinitely till it is revoked. What is the rationale behind it? One logic is that since we are talking about financial emergency, then we need to actually take measures to reduce this financial burden on government. Even if a session is called for 1 day, 2 days for actually continuing getting approval again, it will be huge expenditure on this itself, right? And that is why this was made. Now, effect of financial emergency. So you can remember these keywords. First is extension. It means executive authority of the union over financial matters of the state. Please remember, financial matter we are talking about, right? So it means if state government wants to make a bill to actually bring some new policy, then in this case, president will say, no, you have to give this bill to me. I'm going to review the financial position. Then you can actually pass. So now financial power, this executive power tilted towards center. With respect to reduction, salaries of all government employees can be reduced. Reservation of money bills and other financial bills, as I told you. Then direction can be given to the states by the center that you need to take these austerity measures, means measures to reduce your expenditure. And you should know that in case of financial emergency, even the salaries of judges of Supreme Court and High Court can be reduced. Okay. Now, criticism of emergency provisions. You should remember 3 points. Number 1, that it gives excessive power to center. It turns India's federal model into unitary model. So this is one criticism. Sometimes center abuses these provisions to gain power. Second, fundamental rights. In case of national emergency, I told you Article 58, 59, fundamental rights may be subjugated. Then it is against democracy, because government can actually keep on continuing the tenure of Lok Sabha, and it can continue till infinite time. So some says that it can be a way to have dictatorial tendencies in Indian political system, right? So please remember, register these keywords in your memory when a question is asking about criticism part, okay? Even Dr. B.R. Ambedkar said that he is not denying that these provisions will not be misused or for political gain. So he even agreed. Now let's attempt these questions. Which of the following is not correct regarding financial emergency? Please read the statement and attempt it right now. The declaration of financial emergency requires the approval of both House of Parliament. What do you think? Yes or no? Yes, I've just told you. Approval within 2 months. Resolution approving the declaration of financial emergency should be passed by special majority by either House of Parliament. Are you able to identify some mistake in this statement? Come on, in comments. Special majority. This is a sin if any one of you says this is correct. I told you. The word special majority is used only in case of national emergency. Right? Approval for national emergency, we use special majority. In 356, 360, we use simple majority. And this question was asking not correct. So it means B is the answer, right? Now, attempt this question. Which of the following statement is not true? The fundamental rights of Article 19 are suspended automatically during national emergency declared on the basis of war or external aggression. What do you think? Statement is true or false? Answer is true. I told you, Article 358. In Article 58, I told you, in case of external emergency, means war or external aggression, then in this case, I told you, F6 means 6 fundamental rights mentioned under Article 19, they will be automatically suspended, right? So this statement is correct. Fundamental right of Article 19 cannot be suspended in case of national emergency declared on the basis of armed rebellion. This is also correct because I told you in case of external emergency it is going to be used. But armed rebellion comes under the category of internal emergency. So it is also correct. Article 19 automatically reviews when the national emergency is over. Automatically revives. It is revives. It is correct because I told you in 358 that the time period of the suspension is till this national emergency, external national emergency is in place. When a national emergency is enforced, the fundamental rights of Article 19 are repealed after the President's order. How can this be true? Repealed? Repealed means removed. This is false. And this is what we need to understand. We need to pinpoint. So answer is D. Right? Repealed means removal. Now, next question. Consider the following statement regarding Lok Sabha. Okay. Although we are going to talk about Lok Sabha in Parliament chapter, but since it is connected to national emergency also, one statement that let's attempt. Lok Sabha has a normal term of 5 years. Correct? After which it automatically dissolves. Yes, it is also true. And we have to identify correct. Okay. Once the Lok Sabha is dissolved before the completion of its normal tenure, the dissolution is irrevocable. It means normal tenure is 5 years. But before that, Council of Ministers at the level of Union, if they recommend to the Honorable President, sir, we want to conduct elections now. We know that 6 months are left, but we need to conduct elections now. Please dissolve the Lok Sabha. So on this advice, President can dissolve the Lok Sabha. So it is saying it is irrevocable. So once dissolved, now you cannot say let's actually continue with the same Lok Sabha. So this is true. Right? Revocation of the national emergency is the exclusive power of Lok Sabha. It is saying revocation of national emergency is exclusive power of Lok Sabha. How many ways of revocation of national emergency I have told you? Come on. 3 ways. In 2 ways, there is role of Lok Sabha, but there is 1 way in which Lok Sabha role cannot be considered as exclusive. Means President himself, herself can actually revoke the national emergency. Right? 1, President can revoke. So how can it be exclusive? Second, I told you Lok Sabha passes a resolution by simple majority. Third, I told you after 44th Amendment that 1/10th member of Lok Sabha, if they give this letter to the Speaker or to the President, then within 14 days we need to convene a session of the Lok Sabha so that this matter can be put to debate or this resolution need to be passed. Right? So it means answer is 1 and 2. Means B. B. I hope this message finds you fit and fine. My name is Shashank Tyagi. Welcome to Contest series of Indian Polity based on Laxmikanth. In our previous class, we were discussing emergency provisions. We started with the base. What is the meaning of word emergency? Why these provisions were added in our constitution? And we discussed in detail Article 352, that is national emergency, first type of emergency. There are 3 types of emergency. Second, state emergency as mentioned under Article 356, then financial emergency as mentioned under Article 360. So today our focus would be these. But UPSC sometimes asks question giving multiple statement where one statement might be from Article 52 and another from 356. In order to check whether you are clear about the provisions or not. That is why today I am going to start with revision of Article 52. A quick revision, okay, and I'm going to ask questions from you, rapid fire round. National emergency, it can further be divided into 2 parts, external emergency, internal emergency, and this division is based on ground, means basis on which national emergency is imposed. So there are 3 grounds: war, external aggression, armed rebellion. If above 2 are the ground for imposition of national emergency, then we call it external emergency. Then we call it external. And if third is the reason, armed rebellion is the reason, means from inside conditions are such that national emergency need to be imposed, then we call it internal emergency. Quite clear. Then I ask a question from you. Is there a possibility that if none of these 3 conditions are actually happening, can President still invoke the provisions of Article 52? Can national emergency be imposed in India? Yes or no? Answer is yes. Because imminent danger word is also mentioned in Article 52. It means if there is possibility, high possibility of such circumstances, then also national emergency can be imposed. Now my another question, is it possible to exempt an area from imposition of national emergency? It means President declare national emergency but give exemption to say Tamil Nadu, that this will not be applicable in Tamil Nadu. Is it possible? Answer is yes. It means it can be applicable in whole of India or part. Why? Security reasons. If there is no security threat persist in Tamil Nadu, it is quite stable, law and order is intact, then there is no need. Okay, so such thing can happen. Now this is Article 52 and we have broken it and understood it. Now when it comes to approval, means you are president, and being president you have declared that national emergency is imposed. But it's still, this particular national emergency proposal need to be cleared by both houses of parliament within 1 month. Means if you have declared national emergency on 1st Jan, then within January you need to get it passed from both the houses of parliament. Please remember 1 month, because this is a differentiating factor. Only in case of national emergency the word 1 month is used. Okay, but when we talk about state emergency and financial emergency, approval is needed there also, but there we are going to read 2 months. Okay, there should not be any confusion. Now what if Lok Sabha is not there, means Lok Sabha get dissolved, and here we said that it need to be passed by both house, approved by both house. So one house is not there. What is going to happen then? I told you. Then you need to get it passed from Raj Sabha. And when Lok Sabha is reinstated, reconstituted, then within 1 month, within 30 days, specifically 30 days are mentioned, within 30 days you need to get it passed. You need to get it approved, the proposal of this national emergency. Now comes the question, consider it is approved. First step was declaration. Second step was approval from parliament, approval done. Third is, by which majority? Answer is special majority. Please remember, only in case of Article 352, approval need a special majority. Only in case of Article 352, okay? If we compare with other two types, 356 and 360. In 356, in 360, it need only simple majority. Okay, I hope now it will be quite easy for you to remember. Now, consider it is approved. Now, how long this national emergency will continue? Answer is 6 months. Before ending of the 6th month, you have to get it approved from parliament again. Now the point is there some limit, or we can actually keep on asking for revival of national emergency and it can continue? Is there some slab? Answer is there is no limit. It means national emergency can continue to infinity, because there is no such, you can say, limit mentioned there. Why constitutional framers have not mentioned limit? Because if national emergency is imposed due to some external threat, internal threat, then no one can say when this threat is going to be removed. If the limit would have been imposed, say 1 year, and threat is continuing for 3 years, then what is going to happen? History teaches us that in many countries were on war for 5 or 6 years. In case of war, more power is needed at the center. So if you put a limit of 1 year, then the purpose of national emergency would have been dissolved, right? I think it is quite clear to you now. Every resolution approving the proclamation to be done by special majority, already told you. Please remember, we are talking about Article 352. Now, revocation of proclamation. 3 cases. 1, जिसने किया वही उसको हटा दे. It means President has declared national emergency. President himself or herself can declare that it is revoked, obviously on the advice of Council of Ministers. Second, power is with Lok Sabha. So one power is with President, another is with Lok Sabha. Lok Sabha can bring resolution And if it is passed from simple majority that Lok Sabha wants to remove national emergency, it can be removed. Third case was added through 44th Constitutional Amendment Act. It says that if 1/10 member of Lok Sabha, again, the power is in Lok Sabha, but 1/10 member of Lok Sabha can bring a proposal, write a letter, they can sign and give this letter to Speaker, that's Honorable Speaker, just we want a session in the House so that we can bring a proposal for removal of national emergency. If Lok Sabha is not in session, then they can present this letter even to Honorable President. And this provision says within 14 days, session need to be held. And if there it is passed from simple majority that we need to remove national emergency, then it will be removed. So there are 3 cases. I hope now it is clear to you. Now, effect on the life of Lok Sabha and state legislature. Consider that Lok Sabha is having a tenure of 5 years, right? So normally it is tenure of 5 years, but national emergency was imposed in 4.5 years, means 6 months were left. So national emergency is imposed for 6 months, and it can be extended again if condition persists and Parliament approves. So when national emergency is continuing, parallelly the life of Lok Sabha can also be extended. Extended by how much time? Answer is 1 year. Please remember this. There should be no confusion in this. When it comes to national emergency, it is being extended 6 months at a time. But when it comes to life of Lok Sabha, it is being extended 1 year at a time. And why this difference was made by our constitutional framers? There's a simple logic to that. If you also extend this for 6 months, it would be difficult to actually maintain the need, or you can say maintain this conditionality that within 6 months you have to get it approved. National emergency need to be approved, because these are tiring circumstances, and in this government needs a strong Parliament, because important discussions will be made there, laws will be made there, the working of Parliament will continue, right? So if Parliament's future itself is under threat that after 6 months it can be dissolved, then how can actually this 6 months extension of national emergency and debate on whether we need to extend it or not can actually happen peacefully, right? That is why security was given to Lok Sabha, then only they can continue with this important decision. Clear? Now, same provision is applicable with respect to state legislature. Means state legislature, because conditions are such that it may be possible that there is no scope of having elections for the state legislature itself, right? So in this case, national emergency is being extended for 6 months at a time. Parallelly, the state legislature tenure can be extended 1 year at a time. And there's no limit mentioned here. I gave you the reason why, right? Now, with respect to its connection with judiciary, you need to remember 3 things. 38th Constitutional Amendment Act, 44th and Mill case. 38th Constitutional Amendment Act was actually, you can say, brought by Indira Gandhi government. What she did? She said, this imposition of national emergency is beyond judicial review. Court cannot question, court cannot stall, court cannot revoke. Now, 44th Amendment Act changed this, and it brought this national emergency into judicial review. It means judiciary can check. And in minimal case, Supreme Court itself clearly said that this national emergency can be challenged in court. Now, court can check whether malified intentions were there or not, whether adequate proofs were there or not, or it was just for political gain. So it means now judiciary's ambit or judiciary's review is there on national emergency. Clear? Now let's talk about president rule. So now you have actually structured your understanding on national emergency. Now you will be able to compare with 356 and 360 better. We are talking about president rule. Why president rule? President is the executive head of Indian state, right? And some responsibilities are given by constitution to the center. Responsibilities like this state should run as per the constitution. This responsibility is mentioned, this duty is mentioned in Article 355. And if duty is under threat, it means some state is not working as per constitution. Some state government is saying no. Either we are not capable to uphold the constitution or we don't want to work as per Indian constitution. Don't you think it can be threat to India? In such circumstances, Article 356 can be used, by which president rule can be imposed. So when I say president rule, it means now state government will not be having power, because this state government was not successful in running the state as per constitution. So in this case, president is going to rule. And you know, president works on the aid and advice of Council of Ministers. So actually, indirectly, central government gets power to rule that state. President's name is there, and governor as the functioner in the state coordinates this functioning. I told you 355 and 356 have relation. 355 talks about the duty on the center, that provisions of constitution should be, in use in that state. It should be run as per constitution. 356 says that if there is failure of constitution machinery, then in this case, you can impose president rule. But how it is going to happen? In this regard, governor of that state can present a report before president. Okay, sir, I am the governor of the state and I have these proofs that this state is not being run as per constitution. Constitution machinery is a failure. So president will say, okay, we are imposing Article 356. Now CM is not going to have power. His Council of Ministers is not going to have power. We are going to have power. Okay. Now another question is it mandatory for the president to accept the decision, or you can say recommendation of governor that please impose president rule here? No. It is not binding on president to accept such, such recommendation, such report. Now another question comes into mind is whether president has only, this dependence on state governor, that only when governor is going to present this report, then only this Article 56 can be used? No. This is just one route, right? If president has adequate proof, evidence, and is satisfied that yes, it needs to be done, then it can be done, obviously on the advice of Council of Ministers. So the popularly known as president rule. Now what are the ground of imposition? So ground of imposition 2, number 1, you know that failure of constitutional machinery. Second is that if a state government fail to actually follow the directions which were given by center. It is clearly mentioned in Article 365 that whenever a state fails to comply with or to give effect to any direction from the center, then also this can be a basis of considering that failure of constitutional machinery is there. Okay, there are many disputes on this, that any direction word is mentioned, and in this manner this is against the concept of federalism. Now parliamentary approval. In case of national emergency, you know that it need to be approved by both houses within 1 month. In this case, it need to be approved by both houses, but within 2 months. Okay. So president rule must be approved by both the House of Parliament within 2 months. There it was 1 month. There it was special majority. Here it is simple majority from either house. So those who are reading this, have you ever thought why in the first line it is saying president rule must be approved by both the houses of parliament within 2 months, and here it is saying simple majority in either house? So why both and here either? The reason is that there may be a possibility when Lok Sabha is not in session. So in this case, if Raj Sabha approves it by simple majority, then also it will be considered that it is approved by parliament as of now. Okay, that is the reason. And the second case is similar. If Lok Sabha is not in session, then you have to get it passed from Raj Sabha. And when Lok Sabha comes again, then you have to get it passed from Lok Sabha within 30 days. Same rule is there. Now the time is extension time. Point is extension time. In case of national emergency, we discussed 6 months extension in one time. Here also, it is 6 months extension in one time. There I told you that there is no limit mentioned, but here there is a limit, that is 3 years. So 6 months at a time, but 3 years is the maximum limit, means for which this president rule can be imposed in one stretch. And this is the scope of actually misusing this. It was saying one stretch, for one stretch 3 years, then let them have a government, and then 356 can be misused again, then again president rule can be imposed. So such circumstances should not occur. That's why this Bommai case, in this Supreme Court has said that Article 356 should be used in rarest of rare case. Sarkari Commission also said that it should be used in utmost necessary circumstances as a last resort. Now, what is the consequence of president rule? So these are the consequences. First of all, on executive part, president gets the power that president can actually take important decisions with respect to the state government, and on the behalf of president, who is going to act? Governor is going to act. When it comes to legislative aspect, he can declare the power of state legislature are to be exercised by parliament. Okay, legislative power exercised by parliament. For example, if there's a matter which is mentioned state list, so now parliament can make a law on this matter of state list. Then suspension power, what does it mean? That it may be possible certain constitutional provisions related to any body, authority, which they consider need to be suspended for time being, so they can suspend these provisions. Okay. Now, scope of judicial review, it is same. 38th constitutional amendment was saying that it is beyond judicial review. 44th amendment was saying, acha, aisa nahi, this cannot happen. So that is why after 44th amendment, this was deleted, and now it is under judicial review. Okay. Now, what happens when a state governor suspended or dissolved? A state government suspended or dissolved. So now these are the provisions. It is quite easy to understand, but I want you to give attention to the details. The best way to answer any kind of question which UPSC is going to throw, in your paper, is that when you learn by questioning the statement itself. When you learn about a provision, just think, if we change the statement, what meaning it is going to infer, whether this statement will be true then only. So when we have this critical reasoning, then polity becomes a cakewalk. Now, parliament can delegate the power to make laws for the state to president. Okay, so it means, I told you, with respect to legislative changes, now parliament can make law with respect to state, right? And here we are saying that consider there is no state government there, right? No state legislature there. So now parliament can actually delegate this function to president also, or president may specify by him or her. President may specify any other authority which can actually do this function. Okay, so UPSC may actually play here. Okay, so who can make law now for state? Parliament, president, or any other authority which is specified by president. So authority is decided by president. Okay, parliament, or in case of delegation, the president or any can make laws conferring power or imposing. So simply you can consider that with respect to maintaining the law and order, with respect to achieving the desired outcomes, now duties and responsibilities and powers can also be given to central government officers. That even though you are a central government officer, but now you have to take care of these functions for the state government. So this can also be done. President can authorize, when the Lok Sabha not in session, expenditure. So you can clearly remember, president can authorize expenditure from consulate fund of state. Okay, can. But when parliament, when Lok Sabha is not in session. Okay, if Lok Sabha is not in session. Clear? And why we are specifically mentioning Lok Sabha is not in session? Because with respect to expenditure, we talk about money bill, right? And for money bill, Lok Sabha has the power. So it needs to be approved by Lok Sabha, right? Fourth is ordinance power. Means if Lok Sabha is not in session and there's a need of law, then in this case, president can actually issue ordinance, which is like temporary law, right? But condition is that either house of parliament should not be in session. Now, revocation of president rule. It is quite simple. President has imposed, president can remove. In this case, Lok Sabha, parliament is not involved. So it means proclamation of revocation does not require approval by the parliament. Okay. This occurs when the leader of political party, means opposition political party or any political party, they say that we have required majority in the state. Now you don't need to actually have president rule here. We can actually prove the majority and we can have a staple government. So in this case, president can actually declare, "ठीक है, we are removing president rule." Now these points are important. Just listen to me one by one. Laws that are made by parliament or issued by the president, they are going to continue even after president rule is removed. But continue till what time? Till the new state government, new state legislature repeal them. Okay, so they are going to continue. Now, powers of High Court. Will there be any change in power of High Court due to state emergency or president rule? No. No change in power of High Court. Because High Court judiciary is totally different. Here the changes are going to come in legislative and executive power. Right? President rule has no effect on fundamental right. Please remember it. In case of national emergency, we talked about Article 358, Article 359, impact on fundamental rights. But here, no impact. Present rule was the first imposed in Punjab. This is a fact, and sometimes UPSC is asking one statement. They give one statement on fact. Okay. Sarkari Commission gave recommendation on the effective use of Article 56 that it should be used in rarest of rare cases. Right. So I think these points are clear to you. Right. No change on High Court, fundamental rights, no change, no impact. First imposed in Punjab, 1951, and told you that it will continue. It is not like these laws cease to exist the moment president rule is removed. ऐसा नहीं है. Please remember it. Now let's talk about financial emergency. The word is financial. It means if finances of India, credit of India, it is under threat. Means financial stability or credit of India or any part of the territory is threatened. In this case, Article 56 might be used by the Honorable President, and then financial emergency is going to be imposed. Now, proclamation must be approved by both the houses of parliament within 2 months. Please remember, in case of national emergency, it was 1 month. 356, 360, it is 2 months. Okay. If Lok Sabha is not in session, the same case, you have to get it passed from Raj Sabha, and when Lok Sabha come, then you have to get it passed from Lok Sabha within 30 days. Okay. Once approved, I told you, in case of national emergency, approved for 6 months, then it needs to be approved again for infinite, no limit. In case of state emergency, I told you, approved for 6 months. You have to come again for 6 months, but there's a limit, 3 years. Right? In case of financial emergency, once approved, it will remain in place. You need not to come again and again for approval. Once approved, both the House of Parliament, financial emergency continues indefinitely till it is revoked. What is the rationale behind it? One logic is that since we are talking about financial emergency, then we need to actually take measures to reduce this financial burden on government. Even if a session is called for 1 day, 2 days for actually continuing getting approval again, it will be huge expenditure on this itself, right? And that is why this was made. Now, effect of financial emergency. So you can remember these keywords. First is extension. It means executive authority of the union over financial matters of the state. Please remember, financial matter we are talking about, right? So it means if state government wants to make a bill to actually bring some new policy, then in this case, president will say, no, you have to give this bill to me. I'm going to review the financial position. Then you can actually pass. So now financial power, this executive power tilted towards center. With respect to reduction, salaries of all government employees can be reduced. Reservation of money bills and other financial bills, as I told you. Then direction can be given to the states by the center that you need to take these austerity measures, means measures to reduce your expenditure. And you should know that in case of financial emergency, even the salaries of judges of Supreme Court and High Court can be reduced. Okay. Now, criticism of emergency provisions. You should remember 3 points. Number 1, that it gives excessive power to center. It turns India's federal model into unitary model. So this is one criticism. Sometimes center abuses these provisions to gain power. Second, fundamental rights. In case of national emergency, I told you Article 58, 59, fundamental rights may be subjugated. Then it is against democracy, because government can actually keep on continuing the tenure of Lok Sabha and it can continue till infinite time. So some says that it can be a way to have dictatorial tendencies in Indian political system, right? So please remember, register these keywords in your memory when a question is asking about criticism part, okay? Even Dr. B.R. Ambedkar said that he is not denying that these provisions will not be misused or for political gain. So he even agreed. Now let's attempt these questions. Which of the following is not correct regarding financial emergency? Please read the statement and attempt it right now. The declaration of financial emergency requires the approval of both House of Parliament. What do you think? Yes or no? Yes, I've just told you. Approval within 2 months. Resolution approving the declaration of financial emergency should be passed by special majority by either House of Parliament. Are you able to identify some mistake in this statement? Come on, in comments. Special majority. This is a sin if any one of you says this is correct. I told you. The word special majority is used only in case of national emergency, right? Approval for national emergency, we use special majority. In 356, 360, we use simple majority. And this question was asking not correct. So it means B is the answer, right? Now, attempt this question. Which of the following statement is not true? The fundamental rights of Article 19 are suspended automatically during national emergency declared on the basis of war or external aggression. What do you think? Statement is true or false? Answer is true. I told you. Article 358. In Article 58, I told you, in case of external emergency, means war or external aggression, then in this case, I told you, F6 means 6 fundamental rights mentioned under Article 19, they will be automatically suspended, right? So this statement is correct. Fundamental right of Article 19 cannot be suspended in case of national emergency declared on the basis of armed rebellion. This is also correct, because I told you in case of external emergency it is going to be used. But armed rebellion comes under the category of internal emergency. So it is also correct. Article 19 automatically reviews when the national emergency is over. Automatically revives. It is revives. It is correct, because I told you in 358 that the time period of the suspension is till this national emergency, external national emergency is in place. When a national emergency is enforced, the fundamental rights of Article 19 are repealed after the President's order. How can this be true? Repealed? Repealed means removed. This is false. And this is what we need to understand. We need to pinpoint. So answer is D. Right? Repealed means removal. Now, next question. Consider the following statement regarding Lok Sabha. Okay? Although we are going to talk about Lok Sabha in Parliament chapter, but since it is connected to national emergency also, one statement that let's attempt. Lok Sabha has a normal term of 5 years. Correct? After which it automatically dissolves. Yes, it is also true. And we have to identify correct. Okay? Once the Lok Sabha is dissolved before the completion of its normal tenure, the dissolution is irrevocable. It means normal tenure is 5 years. But before that, Council of Ministers at the level of Union, if they recommend to the Honorable President, sir, we want to conduct elections now. We know that 6 months are left, but we need to conduct elections now. Please dissolve the Lok Sabha. So on this advice, President can dissolve the Lok Sabha. So it is saying it is irrevocable. So once dissolved, now you cannot say let's actually continue with the same Lok Sabha. So this is true. Right? Revocation of the national emergency is the exclusive power of Lok Sabha. It is saying revocation of national emergency is exclusive power of Lok Sabha. How many ways of revocation of national emergency I have told you? Come on. 3 ways. In 2 ways, there is role of Lok Sabha, but there is 1 way in which Lok Sabha role cannot be considered as exclusive. Means President himself, herself can actually revoke the national emergency. right? One, president can revoke. So how can it be exclusive? Second, I told you Lok Sabha passes a resolution by simple majority. Third, I told you after 44th amendment that 1/10th member of Lok Sabha, if they give this letter to the speaker or to the president, then within 14 days we need to convene a session of the Lok Sabha so that this matter can be put to debate, or this resolution need to be passed, right? So it means answer is 1 and 2, means B. Hello everyone. I hope this message finds you fit and fine. My name is Shashank Tyagi. Welcome you all to our contest series on Indian Polity based on Laxmikanth. Today we need to talk about interstate relations. But before we jump into the chapter itself, I want you to relate with this topic. Why we need good relations between different states in India? What India stands to lose if these conflicts persist and there is no effective mechanism to deal with it. Now think and share. Yeah, you should think. Some of you might be thinking, sir, what kind of conflict you're talking about? Is it some armed conflict between states? No, keep arms aside. Now think. Brainstorm. The most popular conflict between these states, you can say, is sharing of water from rivers which they are sharing. And this is not a new dispute, okay? It was prevalent in British time as well, between different provinces. Like there was a Travancore province and Madras presidency, means Madras as a province. Now the point is, if there is water dispute, states are not having consensus on how much water need to be released to other state. Now, what is going to be the impact? Don't you think if there is no mechanism, then one state, for serving its own interest, may overuse the water from this river basin, not allowing enough water to actually go into other state? Don't you think it is going to impact the life of farmers there, impact the growth of industries there who are dependent on water from this river basin? Now, water is one. What else do you can think of? Come on. Can you think of dispute with respect to trade? For example, if Uttar Pradesh government has made a law that any product which is being manufactured from Gujarat, Maharashtra, Madhya Pradesh, and then it is going to be sold in Uttar Pradesh territory, then we are going to impose some 30% additional tax. Don't you think it is going to create problem? What is going to happen with the industries there who are having, you can say, a sense of free trade until now, because we are one nation? But due to this 30% additional tax on specific states, don't you think it would be considered discriminatory in nature? Right? So there may be dispute related to trade, which is going to hamper the livelihood of many people and put a limit on the growth, what we can do, what these states can achieve together. Now, what other dispute you can think of? Come on, think. Laws, public orders, acts. For example, if Uttar Pradesh government has made some law, although that law is going to be applicable within the territory of Uttar Pradesh, but if some citizen from Madhya Pradesh and that citizen for the job purpose is living in this territory, and that law has been, you can say, flouted, and that person came into conflict with that law, and now that person has went back to Madhya Pradesh. So can you say that now that law of Uttar Pradesh is not going to be applicable on that person? No, you can't say that. Otherwise there will be conflict, right? So means there should be acceptance, faith, credit. There should be full faith and credit with respect to laws, public orders and acts of different states, right? Otherwise there will be conflict, right? What else you can think of? Come on, you are free to think around. And conflict is most of the time you can say favorite topic of the people. People are interested in conflict. Now, fourth, can you think of that there may be, you can say, need of consensus or multiple opinions on matters which are with respect to state? For example, there are matters in state subject, okay? And it may be possible that Uttar Pradesh government is having different law and Madhya Pradesh's government is having different law on the same subject which is mentioned state list. But if these two states make different law, different provision, then it is somehow hampering a particular section or particular sector. It may be economic sector, it may be social sector. So if they come in consensus, then I think this will actually create a better, you can say, better positioning, right? So it means dispute with respect to matters in state list. Sometimes these conflicts are also with state as well, but today we need to talk about interstate. That is why we are talking about it, right? Means a law made by a state on a matter which is mentioned state list. But if it is compromising the interest of another state, then there should be some solution in this regard, right? For example, policy with respect to electricity, right? So there should be some coordination there. So I hope now you have some broad, you can say, idea, yeah, these are the kind of popular disputes between state, and there are ramifications if they are not resolved timely. Now the point is, what our constitution says, what is the priority of our constitution? My friends, our constitution has priority that there should be comity, cordial relations between different states. And that is why mechanism for adjudication of interstate disputes are enshrined in Indian Constitution. We are going to talk about them. Article 262. Mutual coordination means there should be coordination through interstate councils. As I told you, policies made by one state hampering another state. So there should be interstate council, right, for better coordination. We are going to talk about it. Article 263. There should be mutual recognition of public acts laws. I gave you the example of Uttar Pradesh government, Madhya Pradesh, right? And there should be freedom of interstate trade, commerce, that is necessary. So it means these four pillars are being addressed by our constitution. Now the question is how? Address to hai, but how? Which bodies are there? Which laws are there? Right? What are the provisions? That we need to understand. So let's first hit the topic of interstate water sharing dispute. Right? So we have Article 262, which says that Parliament is having power to actually provide adjudication of dispute, water dispute between different states. And what kind of water dispute we can talk about? Use, distribution and control of waters, right? Because consider this is Punjab and this is Haryana, and river is coming from, say, flowing from Punjab towards Haryana. Don't connect this with Satluj, okay, Satluj Canal project. Okay, I'm just giving another example. So now, if Punjab stops the river, river flow, control, majority part of that water, then it may actually hamper the prospects of farmers in Haryana, right? So in this case, who is going to come into picture? Parliament is going to come into picture by exercising power given by our constitution in Article 262, right? Now there's an important twist here, and UPSC may ask question from there. Parliament may also provide that neither the Supreme Court or any other court is to exercise jurisdiction with respect to any such dispute or complaint. Now some of you might be surprised. Why is it mentioned like this? Means Parliament can actually sideline Supreme Court or any other court to not execute their jurisdiction into these cases. But these are so important matter, water dispute, and Parliament can sideline them, Supreme Court, High Court, and other courts. Yes, Article 262 says that Parliament may, but my friends, The word is may. Parliament may. Okay, कर सकता है. Right? So, by exercising this power in Article 262, all Parliament constitutes interstate water dispute tribunals. And now these tribunals are responsible for adjudicating, means resolving, pronouncing judgment in these water dispute between different states. But now the reality is that law says that yes, the decisions of this interstate water dispute tribunal are binding. But now Supreme Court in past has gone out of the way and accepted appeal of state against the decision made by interstate water dispute tribunal. Now some legal luminaries asked this question from Supreme Court. Sir, how can you accept such a case if it is clearly mentioned in Interstate Water Dispute Act deriving power from Article 262 that if it is clearly mentioned these reasons are binding, then why you are entertaining the appeal? So Supreme Court says no, our duty is to provide justice and there can be an element of error in any stage, so we can actually accept it. But now some of you might be thinking, okay, Supreme Court gave its interpretation, Supreme Court is free to do that. But why in the first case this is mentioned that Parliament may sideline? Reason is that if these kind of matters are actually raised at any other court, then it will actually take long time. Although these matters are taking long time already, but if appeal or this matter is actually entertained in any court, then it will take longer time, because appeal and appeal and appeal, then review, right? So that is why this provision was added. Now, using power of Article 262, we have two provisions. Number one, River Boards Act 1956, Interstate Water Disputes Act 1956. So first let's talk about River Boards Act. You can see river board word is mentioned. Consider Ganga River, Narmada River, Krishna Godavari. So if Krishna River is passing through multiple states, then what if a board is created by central government and the CMs of these states who are sharing water from Krishna River are made member of it, and the purpose would be for regulation and development of these river basin, right? So it will actually reduce the chances of dispute, right? So provide for establishment of a river board for regulation and development. Please remember it. Now there's a catch here. Central government can establish a river board on the request of states concerned. Okay, the word is central government. It's not Parliament. UPSC actually can make a statement that Parliament can actually establish a river board. So this power is not with Parliament, this power is with central government. Parliament has already done its part when Parliament actually created this River Boards Act. This was created by Parliament. And exercising power which is mentioned in River Boards Act, it says that central government is having power to create a specific river board. So I hope now difference is clear to you. Parliament made the act, exercising power mentioned in Article 262, and this act mentioned that for making a specific river board for a specific river, then central government is having this power. Clear? Now, example, Godavari River Management Board and Krishna River Management Board. Now, second provision is interstate water dispute. Now, empower the central government, again central government, because act has already been made by Parliament, to set up an ad hoc means temporary. For example, there is a Godavari water dispute. So there will be tribunal on this, and the purpose is just resolve this dispute and pronounce your award. Award means decision, and then your job is done. Okay. So it means for adjudicating interstate water dispute. Now decision of this tribunal is final and binding on the parties. So this is mentioned in Interstate Water Dispute Act 1956 that this is final and binding. And that is why I was saying that some legal luminaries were questioning the Supreme Court, why you are accepting appeal when law says this. right? So tribunal will have power of civil court, means they can actually ask for any proof, any evidence, conduct studies, ask any department to actually present before them, right, regarding this particular case. Make schemes for implementation of decisions. How the decision is going to be implemented, the scheme can also be made by this interstate water dispute tribunal. Clear? Now these are some examples of interstate water dispute tribunals. You need not to cram these, okay? Now comes second part, that is interstate councils, mentioned in Article 263. So as I told you, that there may be some matters, some areas where more cooperation, coordination is required, and there comes interstate council in picture. So it specifies the duties that can be assigned with it. Means with it what? Interstate council. So what the purpose is? First point is inquiring and advising on disputes. It means there may be other disputes as well. Na? Water dispute is just one dispute. I told you there can be many disputes. So inquire into those disputes and advise. Second is investigate and discuss subjects on which states and the center and states have common interest. As I told you, that Uttar Pradesh government cannot make a law which can actually adversely impact the interest of Madhya Pradesh government. If such thing happens, then this matter can be raised at the level of interstate council. Okay, so here it is dispute, inquiring and actually advising on dispute. Here we are investigating and discussing subjects. Making recommendations upon any subject, particularly for the better coordination of policy and action, that they can work in coordinated manner. This can be discussed and recommended at the level of interstate council. So basically there are 3 points: dispute, subject and recommendation with regard to better coordination of policy and action with it. Okay, so it is quite easy to remember. Now another important area where UPSC can play. In case of interstate water disputes, I told you that its decisions are final and binding, right? And I also told you Parliament may exclude Supreme Court or any other court for exercising their jurisdiction in this regard. In what regard? Interstate water dispute, right? But in case of interstate council, twist is that their working is complementary in nature with that of Supreme Court. Means on the same matter, Supreme Court can actually act altogether. So council's decisions are actually advisory in nature. Means these people, these member states, interstate council is made on this particular issue. So they are part of that and they are advising, right? When it comes to Supreme Court, its decisions are binding, right? Now Article 263 has been used by President, and we have this example: Central Council on Health, Central Council of Local Government and Urban Development. Purpose was that these are a matter of importance. There can be dispute and this may be important subject. So recommendations are provided. Now establishment of interstate council. So as I told you, President established it. Now just remember what we discussed in center-state relations, 4th video, where I discussed recommendations of important commissions. In Sarkariya Commission, I mentioned that they suggested that there should be a permanent interstate council, permanent. Now, taking into consideration the recommendation, we have some example. For example, Janata Dal government, where VP Singh was Prime Minister, so they actually established an interstate council in 1990. Now, who are part of this interstate council? You should remember this is recommendatory in nature. And who are part? Prime Minister, CM of all states, Chief Minister of all UTs, Administrator of other UTs where Chief Minister is not there. Apart from that, if there is any state where President rule is imposed, now who is actually having the charges regard to administration? Governor. So in that case, Governor should be there. 6 central cabinet ministers. Out of that, 1 should be Home Minister. You can easily remember that if we are talking about dispute, and this dispute is a matter of, say, internal security, so that is why we have Home Minister. And apart from Home Minister, rest can be nominated by President. Okay, President is actually making this interstate council, and President is also nominating the other 5 central ministers. Apart from this, 5 ministers of cabinet or rank a minister of state to be permanent invitees. They're invitees. Now this council to be recommendatory body, I told you, right? And issues relating to up now, there can be a one question relating to interstate, center state and center UT relations. What is going to happen? UPSC will make a statement. Say, interstate, which of the following statement is correct with regard to working of interstate council. So they may say that matters of interstate relations are only taken up. Second, matter of interstate as well as center state can be taken up. Third can say, matter of interstate, center state and center UT relations can be taken up. So answer would be third. Okay, so don't get confused that if it is interstate, the matter can be only interstate. Okay. About the council, the purpose is to coordinate, matters referred to it by chairman. Who is chairman? Prime Minister is chairman. Then all the meetings are done under a camera, in front of camera. All questions to be declared and decided by consensus. I have highlighted this because they may make a statement that there will be majority decision. And if such statement is mentioned, then you should outrightly reject it. The reason is, why in interstate council they are going to have majority, this process of majority decision? Why? This interstate council is recommendatory in nature. What is the use of having actually votes here, right? That's why consensus based. Okay. Council set up by standing committee. So they have a standing committee. The purpose of standing committee is, okay, this has been done, this has been decided. Now standing committee will ensure that whether the decisions which were taken, agreed upon, are actually in action or not. Interstate Council Secretariat was also set up in 1991, headed by Secretary of the Government of India. Now, Public Acts records judicial proceedings. I told you, one kind of dispute related to water, other with regard to subjects. I told you interstate water dispute tribunal, interstate council. Now there may be other dispute, like a law made by Uttar Pradesh government is not getting due respect, full faith in other parts of India, right? So in that case, what is there? Public acts, records and judicial proceedings. Jurisdiction of each state is confined to its own territory, full faith credit clause. Territory is fine, but if any act is done within that territory and that person goes to other territory, yet that act need to be upheld, right? It need to be given full faith. Full faith and credit is to be given throughout the territory. Public acts, records throughout the territory. That is why I mentioned this example. Judicial proceedings of the center and every state. It means full faith and credit, all territory. Next, Parliament. Now, with respect to application of these laws, Parliament may actually make a law talking about the manner it is going to be accepted by other areas, manner in which it can be exercised by others as well. So it means Parliament can make a law, manner and condition in which such acts, records and proceedings are to be proved. Now the third is, final judgments, orders of civil courts in any part of India are capable of execution anywhere within India. For example, if you are having some revenue matter, for example, you have forged some document, and due to this, say Madhya Pradesh government has actually suffered a loss of say 10 crore. Now you have fled to some other territory. Now can you say that, oh, now the civil court of this district in Madhya Pradesh cannot do anything against you? No, you are mistaken, my friend. Because the power of civil court to exercise its judgment is actually anywhere in India. Okay. Now interstate issues with respect to trade. As I told you, trade is also another aspect. We talk about 301 to 307, first 301 and then exceptions. What 301 says? Freedom of trade, commerce, intercourse and guarantees freedom of all except restrictions. Means there should be freedom of trade, commerce, intercourse except some restrictions. Restrictions like 302. What it says? Power of the Parliament to impose restrictions where, with respect to any matter of public interest, for example, there is a shortage of a particular product in India and a particular state is producing it. So considering the future security of that product, Parliament may actually issue guideline that this much production should be done and proved should be submitted first into the buffer stock, right? So means any policy with respect to which is necessary for public interest, on this basis Parliament can actually make a law to impose some restriction on trade, commerce or intercourse, right? Take another example. Last year there was one point where onion prices were actually skyrocketing, right? 130 rupees kg, 150 rupees kg. So now in some areas there was enough, you can say, surplus onion, and there were the other areas where there was deficit in onion. So what government did? First of all, government made a policy on banning, or you can say putting a slab on the export of onion, so that export will be limited and there will be enough supply within the India. So it means trade and commerce may be actually regulated. Then government also made a law that this much amount should be circulated in other areas through government's agency NAFED, right? So it means this can be done for public interest. This is a restriction. You cannot say we should be let free. Public interest matter. Then 303. So 303 broad headline is this: restriction on legislative power of the union and of the states with regard to trade and commerce. And real point is, Parliament and state legislature cannot give preference to one state over another. For example, Uttar Pradesh government cannot say, I'm going to give preference to Uttarakhand, Madhya Pradesh and these areas, and when it comes to say Andhra or say Odisha, if their products enter into Uttar Pradesh territory, we are going to impose 30% tax. No, this cannot be done. Okay. 304. Restriction on trade and commerce and intercourse among states. What it says, a state legislature can impose reasonable restriction in public interest. So this particular provision is similar to what we discussed here in 302. Means power of Parliament to impose a restriction for public interest, and here power of state legislature can impose reasonable restriction in public interest. For this purpose need prior sanction of President. Please remember, if any state legislature is imposing some restriction, then prior permission of President is required, because interstate free trade is a priority mentioned by our Constitution. If one state is making such policy which is against it, then President must review what reasonable restrictions you have given, right? A state legislature cannot give preference to one state over another. Discrimination between states, I told you. A state legislature can impose on goods imported in other states or UTs to any tax in which similar goods are manufactured in that state are subject. Means discriminatory tax cannot be imposed, right? Like I gave you example. Now 305. So this talks about another exception. It means, although we talked about non-discriminatory nature, but if a state wants to have certain monopoly in certain section of say economy, so this can be done. Means existing laws may be there which says that with respect to say uranium, with respect to say aluminium trade, with respect to copper trade, only this PSU of government is going to participate. With respect to power generation, only this PSU can participate. So if such policies are there, then you cannot say, this is against freedom of trade, as I mentioned in 301, no, because this is an exception, So complete partial citizen, means this kind of exception can be actually made. 306 was repealed, and 307 talks about appointment of authority for carrying out the purpose of Article 301 to 304. It means to actually ensure that there is freedom of trade and commerce, and if there are restrictions, they should be as per the exceptions which are mentioned. So there can be a authority. Who is going to create? Parliament is going to create. But till now there is no such authority in India. Please remember it. Now talking about zonal councils, the word is zone and the other word is council. It means we are talking about group of state coming together on a particular dais. So it's a statutory body Why? As per State Reorganization Act 1956. Please remember, UPSC can make a statement, zonal council are constitutional body. So you should remember it's a statutory body. Statutory body, why? Because it was created by an act made by Parliament. Okay, not mentioned in Constitution. So we have 5 zones. Some of you might be thinking, sir, we can see there are 6 zones. 1, 2, 3, 4, 5 and the 6. Then why you are saying that there are 5 zones in the zonal council? There is a reason for that. Because Northeastern Council was created later and there is a separate law for that. And this zonal council has additional responsibilities too. Okay, that is why we count 5 zones here and then separate Northeastern Council. What is the purpose? Consideration while forming means why actually we created Central Zone and Northern Zone. Why have not created this as one zone? The reason is natural divisions of the country, river system means of communication, cultural linguistic affinities, requirement of economic development, security, law and order. So clearly you can remember, first is natural division, river system, culture, economic, security and law and order. So these are the 6 areas, okay, on the basis of which this creation was made. Now who are the members? Please remember, always the chairman would be Home Minister and vice chairman is created from one state of that zone and this is a rotationary position held for 1 year. Okay, 2 other ministers from each states are from this zone are going to be part of zonal council, administrator of that UT which falls into this area, and advisors of zonals means these are advisors means officers to coordinate that whether the decisions which are made are being implemented or not. So now Niti Aayog, Chief Secretary of that state, Defense Commission means Development Commissioner from each state. Now what is the purpose? Purpose to actually spur cooperation and coordination. Some of you might be thinking a lot has been done for ensuring cooperation coordination. Where we are at cooperation coordination, right? Now objective, what is this? Integration of the country. And if after a new state is created, say Uttarakhand created from Uttar Pradesh and now new state is facing some issues, then these can be raised at the level of this particular zonal council. After effect, right? If there is some regionalism, this linguistic, particularistic trend, then these can also be addressed if there is zonal council, which is going to represent that we all are together. Enables the center and state to cooperate with each other. I told you, speedy execution of major development projects, secure a level of political equilibrium between different regions of the country. Political equilibrium, please remember the trend, means the word. Okay, what is the meaning of political equilibrium? That no state should actually make decisions just because of political gain. If you are in zonal council, you are accountable there. So this is the MCQ which you are going to attempt after this class. This PDF is going to be shared in the Telegram group which I am going to show. Now I told you apart from zonal councils 5, we have Northeastern Council created as per Northeastern Council Act 1971. And I told you the additional functions. Number 1, quite easy to remember, to make a unified and coordinated regional plan and to also periodically check what measures have been taken by the governments in this area for maintaining security and law and order problem. Because you know that in Northeast, we have seen the issue of insurgency. That is why this additional layer, additional responsibility has been placed. And you know that law and order issue is also connected with the developmental outcomes. And that is why it has been mentioned. So these are the members of these councils and these are the headquarters. You can just go through them. That's it. Hello everyone. I hope this message finds you fit and fine. My name is Shashank Tyagi. Welcome you all to our contest series on Indian Polity based on Laxmikanth. In our previous 3 videos on this chapter, Center-State Relations, we have covered legislative, executive and financial aspect. Today we need to discuss issues between center and state, commissions which are made in this regard and what were the prominent recommendations. This section is going to give you good fodder point for your prelims as well as mains. So let's talk about trends, means the issues between center state. Were they prominent in 1950s and 60s also? No. Till 1967, the relations were quite smooth. And the reason was Congress party was having hegemony. In center there was Congress, in states there was Congress. And as we saw that many states got non-Congress party leading the government and Congress at the center, then conflicts started emerging. Now you should think, was center-state relations got a downturn, or why we are saying downturn? Because conflicts started emerging. Is it due to some political differences, or this is more than that? Because being a UPSC Civil Service aspirant, you should know that we are more interested in understanding the provision part, what Constitution says, what federalism as a concept says. And on this premise, we are going to decide what claims which are made by states are legitimate and what are just mere for political gains, right? I hope you will agree on this point. Now, what were the tension areas? Number one, governor's appointment. You know that governor is appointed by Honorable President on the advice of Council of Ministers. And this governor works on pleasure of President. It means can be removed, transferred at any point of time without giving any reason. And that is why it is said that this governor works for central government. Allegations are made. So now government's appointment and dismissal and role, it is questioned by state. The state says governor is executive head of the state, but governor works as agent of center. This is against the principle of federalism. Independence of state is being compromised. Second, president being partisan. There are several occasions where governor reserve a bill for the honorable president, and sometimes this bill gets stalled, which actually hampers the legislative power of state. Another issue is central armed police forces. Means states say that many times center enforce, or you can say send forces, central armed police forces, without consultation with state. It actually questions the legitimacy of the role of state. If state government is confident enough to manage the law and order, then central government should not intervene by sending these forces. That is one apprehension. Another is bill. As I told you, state legislature presented a bill to governor. The governor has sent this bill to governor, honorable president. President has a lot of, you can say, powers with respect to passing, giving assent to this bill or stalling this bill. Discrimination in financial allocation. So there are two apprehensions from financial aspect. One is when this division of revenue is done between center and state on the recommendation of Finance Commission, although Finance Commission recommendation is not binding, but it has some value. So state says we get lesser share of revenue and we have more expenses than center. When I say more expenses than center, it should be considered in proportional manner. Means areas in which a state has to spend. I am not talking about the quantum. Sharing of finances. So they question that a state should have more funds from the revenue which are collected by center. The state says we should be given more liberty to make our own policies, because one size fits all won't work for everyone. A policy can work good in, say, Bihar, but that policy won't be, it may be possible that policy won't work that well in Himachal Pradesh. States should be given more funds. They can decide the developmental model they want to adopt. Management of all India services. As you know, IS, IPS, Indian Forest Services, there are 3 all India services. States time and again says that these all India service have patronage towards center, which compromises the, you can say, authority of state government. That is one claim, and in upcoming discussion you will see how many times various you can say commissions which were made by state on center state relations have demanded abolition of all India service. Abolition. Now, use of electronic media for political purpose. It means you must be knowing Doordarshan, All India Radio. So it means these are institutions, prominent channel of communication, although they're not that prominent as of now. But think of the time, we are talking about 60s, 70s. They were the prime, you can say, connection between people and the government or what is happening around the world. So states were saying these channels were actually used by a party in the power in center for their own political purpose, own political gain. That is wrong. Appointment of inquiry commissions against many chief ministers to actually arm twist them. Encroachment on the state list. So you can see these are the prominent, you can say, tension points between center and state. So I asked from you just 5-6 points, and now you have more than that, right? Now, commissions and initiatives which were made. So now, with respect to commissions, we are going to divide them into two parts. Commissions which were made by center, commissions which were made by state. Means state making commission, giving recommendation to center that you should adopt it. Okay? And then we are going to talk about, within the center part, we are going to talk about Sarkariya Commission, Punchi Commission at the last, because they are the most important. We are going to start with ARC, Administrative Reforms Commission, which was headed by Mr. Morarji Desai. So this commission was made to actually look into the issues which were raised by state, whether they are legitimate or illegitimate. If something can be done in this regard, then this commission was given responsibility that you should recommend. So there was a separate study team under MC Setalwat, who was once Attorney General of India. So now what were the recommendations? There were 22 recommendations, and out of them major recommendations are these. Now please connect these recommendations with what we have discussed until now. Okay, first recommendation, establishment of interstate council, non-partisan governor. I told you, number one point was governor issue, and first ARC was recommending non-partisan governor. Governor should not be someone who has political background, which is the culture in present time, right? All politicians are given this responsibility of governor. Delegation of more power to states, more financial resources to state. I think now you are connecting. State demands were being addressed by ARC in these recommendations. Deployment of central forces. They said central forces are being deployed without our consultation. Now they are saying on request of state, right? They should be actually, you can say, deployed. Or if this emergent circumstances, then only this should be deployed by center unilaterally. But whether some action was taken by government on these recommendations, no action by government on this ARC report. Thereafter we saw Raj Mannar Committee. Now this was not a committee which was made by center. This was made by Tamil Nadu government. 3-member committee. So now see the recommendations which were made. Setting of interstate council. You will see similarity. Interstate council was demanded. Here also interstate council was demanded. Permanency of Finance Commission. Then you should question, why permanency? First of all, you are well aware that Finance Commission is a constitutional body, right? Established by Honorable President for a term of 5 years or maybe early. Means there is no fixed tenure of Finance Commission. Okay. Now, Finance Commission is not having some permanent secretariat. It is given a list which we call term of reference, that on these objectives you have to work and give recommendation to the government. Now after these recommendations are given, job is done, and then it can be quashed. Now state said, our future is decided on the basis of recommendation made by Finance Commission with respect to finances, sharing. And if we have certain apprehensions on the formula that Finance Commission has used, where should we go? There is no permanent secretary, a dedicated secretary to Finance Commission. This is a constitutional body, but not permanent body. Make it permanent. So that's why they raise this, so that they can raise their grievances at this stage, right? Disabandonment of Planning Commission. Why? Because Planning Commission was not involving states while deciding 5-year plans. Omission of President rule means they were saying, let's remove this Article 356 usage because it undermines this concept of federalism. Many times, state governments are removed just for political gain by the party in power at center. Residuary powers to state, and now you will see this demand has been consistently raised, residuary powers to state by other commissions as well. Okay, you know the residuary power means subjects which are not mentioned in unions or state list or concurrent list. In these regard, who has the power? Parliament has the power, right? Parliament is supreme in this regard. They said no, state should be made supreme. Abolition of all India service, abolition, removal of all India service. They said we can actually, every state government can work with the provincial civil services. We don't need all India service because all India service people, they're appointed by, on the recommendation of UPSC, cadre handling authority is DOPT. Later it was DOPT, earlier there was service, there was an integrated department for services. So now they said patronage lies with center. It is undermining the authority of state. So abolish it. Okay. So now, was any recommendation of Rajmanar committee accepted? Now see the quantum of change they were asking. Remove president rule, remove all India service, abandon or disabandonment, just remove planning commission. So what central government did? Central government smiled. Okay, let's see. So central government completely ignored the recommendations. Okay. Now second is Anandpur Sahib. This was again a commission which was made by a state, not center, right? Punjab. And it has two objectives. One was political, other was religious, considering the context of Anandpur Sahib. Now, they also asked residuary power should be given to state, as was asked by Rajmanar committee. Equal authority and representation to all state. What does it mean? Take example of US Senate, right? And equate it with Indian Rajya Sabha. India's Rajya Sabha, the number of seats allocated to states are based on population, and that is why seats vary from 1 to 31. Uttar Pradesh is having maximum seats. Why? Because of the population, right? Now, they said we should follow the formula of US. Each state was given 2 seats. That is why 100 membership, 100 members for 50 states. So that was their demand. Then they said this was one of the radical, you can say, recommendation on center-state relation by Anandpur Sahib. They said center's jurisdiction should be limited to only defense, foreign affairs, communication and currency. Every other power should be left to state. So it was like making center weak. And that is why you can easily remember that this recommendation was not accepted. This was like changing the Schedule 7 of Indian Constitution. They were saying change this union list, state list, concurrent list. Then came Bengal, West Bengal memorandum. So this is the third commission which we are discussing from state part, and before that we have discussed ARC, first ARC recommendation on center-state relations. Clear? Now, what they said. Now see the commonality. One common thing is clear, residuary power to state. All three have demanded residuary power to state. They also asked that the word union in our constitution should be replaced with federal, so that states can truly enjoy the independence, the autonomy of the concept of federalism. Presidential rule and financial emergency to be repealed. Means just remove Article 356, just remove financial emergency Article 360. Consent from state for state reorganization means whenever you are going to use Article 3, then consent of state should be mandatory. As of now, it is not mandatory. Although this bill is presented to the state legislature, but their recommendations, their apprehensions are not binding on the center, right, on the parliament. Rajya Sabha should be equal to Lok Sabha. As of now, we know that Lok Sabha has more power in most of the cases. That we are going to discuss in detail when we are going to discuss Parliament chapter. 75% of the revenue to state. Or if you are collecting 100 rupees, then 75 should be distributed in state. Abolition of all India service. They are also asking abolition of all India service. And now you can connect why state governments have so much apprehension for all India service and the level of apprehension they have. That's all India service is going to have inclination towards center. So central government did not accept the demands. So it means whether we talked about Rajmanar, Anandpur Sahib resolution or West Bengal memorandum, Center did not accept it because they were demanding far-reaching changes. They were demanding structural changes in our constitution, right? So now Sarkaria Commission was made under Justice R.S. Sarkaria. And look what he suggested. He said we should not do the structural changes in constitution. What we can do, we can actually change some functional aspect. Operational aspects can be changed. The way we use these laws, this needs to be changed. If governor position is being abused by party in power center, then let's make a rule regarding appointment of governor. If you are seeing that many times state bills are being stalled, then rather than actually taking all the power from the center with respect to this particular process, let's do one thing. Let make government more responsible whenever president stalls a particular bill, right? So it means Sarkaria Commission actually adopted a balanced approach. Let's discuss one by one the recommendations which were made. Interesting one. They said ISC means Interstate Council should be changed into Intergovernmental Council. President rule should be used rarely, means in utmost necessity. All India service to be strengthened. So everyone in these three commissions, three means I'm talking about Anandpur Sahib and Raj Mannar and West Bengal Memorandum. They were saying abolish All India service, but Sarkar said no. All India service should be strengthened, and there should be more All India service. Like IS, IPS, IFS, we need more All India service. Residuary power, they were saying residuary power should be given to state. They said no. Residuary power should be concurrent, means in such matter both can make law, but when it comes to power to tax on something which was not mentioned in all the three lists, it means residuary power with respect to tax, that should be with parliament only. That is what Sarkaria was saying. Reason for withholding. If you withhold a bill of state, then give reason to that state. There was NDC, National Development Council. It should be turned into National Economic and Development Council. The work sphere of this council should be more specific and elaborate. Zonal council should be reactivated so that disputes between states can be resolved at this level. Center should consult states before making law in concurrent list. I hope you're connecting. This was the apprehension that center tried to actually overpower, right? So they are saying if you're making law in this concurrent list, consult states. CM consultation before governor's appointment, because governor has to work in close coordination with CM, so CM's recommendation should be accepted. Sharing corporate tax with states. So in this regard, we already discussed in the previous video, 80th Constitutional Amendment Act was made, so that a scheme of sharing taxes was actually made at par with income tax with respect to corporate tax and custom duties. I discussed this. Council of Ministers having majority. If Council of Ministers is having majority, governor should not disband the government. Okay, because many times governor disband the government and asks for disbanding a government, even if this Council of Ministers is having majority in state legislature. That is wrong. That is a fraud to democracy, right? Because people have elected him. Expect compelling reasons or dismissal of governor. That governor is removed without giving any reason. It should be given some reason. He should or she should be given some reason. Inquiry commission against ministers can be actually made by the demand by parliament. As I told you, there was apprehension that many times CMs and ministers at the state level, inquiry commissions are made by center. So this can be done when parliament made such demand. Surcharge should be in specific case and for short term. And 3-language formula was suggested. You know that in center and state there was apprehension that center is trying to enforce Hindi forcefully, right? And the languages, Hindi was the main reason. So Sarkari Commission recommended 3-language formula. So what does it mean? It simply means that 3 bases should be there whenever language policy is made at the state level. Group identity means the language should be such that people can connect with that language. Second is national unity. National unity is a priority and language is the thread which actually weave people in. Third is administrative efficiency. That should also be the criteria. So please remember, this was the good recommendation which was made by Mr. Raj Sarkaria. So out of these 247 recommendations, 180 recommendations were implemented. including the establishment of interstate council. Don't you think it is a major achievement in the picture of center-state relations in India? Right? That is why I was saying Sarkari Commission is important. Now, after that, Punchi Commission was made, 2007, under Madan Mohan Punchi, former CJI. And now you will see that Punchi Commission discussed some new issues. And whenever a question is being asked on center-state relations, your understanding of Sarkaria and Punchi Commission will give you more than enough points. You will have good amount of points. Now, here they discussed, we need to discuss issue of communal violence. Yeah, means how center and state should coordinate on these issues. Interlinking of rivers. If devolution of powers and autonomy to Panchayati Raj institutions, right? Independent planning and budgeting at district level. Don't you think these are important issues, right? For development at ground and how center and state should actually play their role. Central assistance versus performance of state means assistance is given. States have demanded 75% fund should be given to them. But now Punchi Commission said whether funding should be based on performance. If states have performed well, then they should be given some additional funds so that other states can also get inspired and their administration also work better. Positive discrimination should be also there with respect to some state. It means if some states are lagging behind, say in education, drinking water, basic things, then center should support them more. Tax and VAT regime, although now we have GST, but the kind of VAT system should be adopted so that the trade between different states can be at ease. Integrated domestic market should be established. So it is linked to this. Central law enforcement agencies should actually get into this picture of crime, investigating crime when a particular crime is having ramification on its interstate. Means more than one state are getting impacted due to some case, then central law enforcement agency should have power. So these were the issues, term of references on which it was asked that Punchi Commission, you should look into these issues and recommend us. So now 310 recommendations were given by Punchi Commission. Number one, they said there should be broad agreement between center and state before legislating any matter on this concurrent list. Issues on concurrent list have broad agreement. And I hope now you can see a commonality between what Sarkaria was saying and what Punchi was saying. Sarkaria said, consult center. Center should consult state whenever a law is being made on concurrent list. And Punchi said, this should be done. Restrain parliamentary supremacy in state list. You know that there are cases where center can make law in matter of state list also. So there should be restriction of supremacy, right? It should be done in extremely necessary circumstances. Interstate council to audit concurrent list, whether it was needed to make such law on concurrent list by center only, whether this can be actually delegated to state as well. Interstate council should do the audit. 6 months should be given to the president when a matter, means state bill, is before president, so that a state's necessity to actually turn a bill into act can be taken into consideration. Follow Sarkari recommendation on governor selection. What was the Sarkari recommendation on governor selection? Just tell me. I've just discussed. Come on. I've just told you. Since governor has to work in close coordination with CM, so CM should be consulted while appointing any governor in that state, right? Governor removal should be by impeachment. As of now, you know that governor can get a fax from the president house that now you are not governor, you should pack your things and no reason will be given. No reason is mandatory. So now it should be like impeachment, so that governor's position can get some kind of security and governor can work in an independent manner, not just agent of the center. Governor's discretionary power to be exercised in non-arbitrary manner. As of now, a lot of discretionary power are with governor where no question can be asked. Governor can use this because there is ambiguity on those provisions. Prominent being with respect to when hung assembly is there. You must be knowing about Goa case, right? In 40, I'm talking about the previous elections in Goa, right? When BJP government was formed, when BJP got 13 seats, the seats needed for majority were 21. Congress got 17 seats. So Congress needed only 4 MLAs to prove majority, and this Congress and this BJP needed 8. So, but BJP actually found success. Mridula Sinha was governor at that point of time there, and she was connected to BJP earlier. So some kind of allegations like this are made that governor works in partisan manner and give opportunity to the other party, the party in power in center. Now, decide about the bill in 6 months. Governor should also decide about the bill in 6 months. Constitution to lay down guideline. For example, the hung assembly case, this I told you. When there's hung assembly, it means no party or coalition is getting clear majority. Then who should be given first preference to prove majority? So there's ambiguity there, and that is why governor works in arbitrary manner. Although Punchi Commission said that pre-poll alliance should be given the preference, means alliance of parties which was made before election, right? Governor have the right to sanction prosecution of a state minister. Governor only constitutional role. Governor should not have a role of chancellor and have some statutory position other than this, right? So this was recommendation of Punchi Commission. Apart from this, you know, imposition of president rule is prominent issue between center and state. So they said restrict the use of Article 56. Although we have one important case in which Supreme Court gives the guideline that we should use, means center should use Article 356 sparingly. Can you mention that case in comment? Come on. Case with respect to misuse of Article 356. Come on. Rapid fire round. Name of case is Bommai case. Please remember. Framework to deal localized emergency. For example, if there is some emergency like condition in an area, there should be framework to deal with that condition there only. It is not necessary that you use Article 52, 356 and get more power to center. Right? If an issue can be managed, then it should be managed easily. And Article 263 should be amended, which talks about interstate council. And amended in which manner? Interstate council should be given more power. It should be it should be made more credible. Because if I ask, have you ever heard about some major achievement of interstate council? Then you might look towards your fan or around. Yaad to nahi aa raha hai. Why? Because we have not, discussed. We have not. This particular body has not been in news for some achievement from many years. Zonal councils to meet 2 times at least per year. For example, government has made this empowered committee of finance ministers so that issues with respect to VAT uniformity between state and better trade between state can be ensured. So they have achieved considerable success by this formula. So Punchi Commission said similar kind of empowered group of ministers can be made in other areas as well, right? Although now we have GST. There should be forum of CMs so that they can coordinate on policies in matters like energy, food, etc. If some state has surplus energy, then it should be given on fair terms to the state. If there is some food scarcity and other state is having food surplus, then it should be managed. New All India service should be made. Now see the commonality. Sarkaria Commission was saying All India service should be strengthened and more All India service should be there. Similar kind of recommendation is made by Punchi Commission. They said there should be All India service in case of health, education, engineering, judiciary. Removal of obstacles for well-functioning of Rajya Sabha and equality of representation respect to population size. Means the US model, the Senate model, US Senate model which I discussed. Devolution of power to local bodies. Now go through the term of reference which I said. Means PRI was an objective of term of reference on which Punchi Commission was asked that you should give some recommendation. They said more power should be given to local bodies, right? And when state governments are given responsibility, yes, you should implement the central law. Then if they are implementing the central law, then they should be given more funds. Means cost sharing should be there, right? And when it comes to central government PSUs, harnessing, exploring, extracting some minerals from a particular state, so state is given some royalty. So there are 2 issues in royalty. Number 1, that this royalty is not renewed in a particular interval of time. Same royalty is continuing for so long. Second is the amount of royalty is many times delayed and state government has to manage its finances. So now Punchi Commission said that it should be renewed on timely basis like 3 years. And if there is delay in funds, then interest should be paid by the center to the state, right? When it comes to professional taxes, in previous video when I was talking about financial aspect of center-state relations, I told you that professional tax can be used, by state, but limitation is not more than 2,500 per annum. So Punchi Commission said no ceiling should be there on professional tax. Assessment of all fiscalizations by independent body. If there are some fiscal, with respect to, when I say fiscal, it means I'm talking about two things. Number one, imposing of taxes means revenue collection, and number two, expenditure. And since fiscal policy of center is going to have impact on states as well, that is why there should be an independent body to actually assess these fiscal, fiscal related bills. Mechanism to involve states in finalization of terms of reference Finance Commission. As I told you, that Finance Commission appointed by President on the recommendation of Council Minister, and term of reference means agendas on which Finance Commission is told that you have to work and give recommendation. So there, state participation is missing. So they said state participation should be there so that states can also put forward their points. Fair, recommendation. Now bring down surcharges and cess charges. Permanent Secretariat for Finance Commission. Reason, I told you. So that these states can reach out to Finance Commission. On which basis you are given this recommendation? We have these points and these are valid points. Please consider that. So this should be made, right? Interstate and Commerce Commission should be established under Article 309 as a constitutional body, so that interstate trade and policy can be more, uniform, which is going to benefit all. So I hope now you are clear with the recommendations of Punchi Commission. Center-state relations pay, no matter what question is asked on commissions, it will be far easier for you. It will be cakewalk for you to actually answer it correctly. When questions are asked in mains from center-state relations, just go through this video again, have a pen and paper in front of you or a Laxmikanth, underline things, and it will be easy, cakewalk to understand these. Okay. Apart from this, I've added some MCQs in this PDF. After you go through this video, I'll ask you to go through this PDF. This PDF will be uploaded in this Telegram group, Shashank Tyagi for you. I hope this message finds you fit and fine. My name is Shashank Tyagi and I welcome you all to our contest series of Indian Polity based on Laxmikanth. This is third video on the same chapter, Center-State Relations. In previous videos, we have discussed legislative aspect and executive aspect. Today, we need to focus on financial aspect of center-state relations. I personally feel that many students miss on nuances or miss on reading between the lines on financial provisions. And that is why a good amount of trap statements can be made by UPSC in upcoming prelims. Purpose of this video is to save you from those traps. That is why only thing that is required is your attention to me, not me, to this chapter, okay, to this subsection. So let's start. You know that center-state relations are mentioned in part 11 and part 12, and financial aspect are mentioned in part 12. So in part 11, we have already discussed legislative and executive aspect. Those who have not covered, you can go to the previous video. If you have any doubt from any section, you can shoot me a message on shashank.powerbeam. That is my Insta handle. I'll be more than happy to help you out. Now, financial relations are mentioned from Article 268 to Article 293. Okay. Now, we have to talk about tax, and three terms are going to be used in this video: levy, collection, appropriation. What's the difference between these? Levy means imposition. It means, take example, income tax. We wait for the budget day, and we want to see what kind of changes are made on income tax. Why we wait for union government budget when it comes to income tax slabs? Why not a state government budget? The simple reason is power to impose means power to levy tax on income is with center only, not with state. Okay, so levy means imposition, lagana. Okay, now collection. So second power is collection. It may be possible center has imposed a tax, but collection duty is given to state government. So we need to be, clear about this, that it may be possible that the same authority, it means center, is imposing as well as collecting, or there can be a difference also. We are going to discuss it, but you should be attentive of these words. These are different. Okay. For example, now we have collected this tax. Okay, this collection has happened. Now, the third step, appropriation. Appropriation means decision to actually spend from this collection. To spend. Why you're collecting taxes? Obviously, to spend, right? Now, in certain tax categories, appropriation power is with center. In other tax categories, appropriation power is with state. So we should be having clear idea on which kind of taxes a state government is having appropriation power. Although you need not to cram all the subjects on which taxes are imposed. Okay, that's not going to give you some cost benefit and in the exam. But you should be clear with the provisions, powers, connection, okay, and the issues from means perspective. I'm going to give you an idea of that as well, okay, along with provisions. Now first let's talk about allocation of taxing powers. How taxing power is divided between center and state. You are well aware of union list, schedule 7. Now we discussed union list in legislative aspect as well as executive aspect. But why financial aspect? Because certain subjects mentioned in union list are of the nature where tax can be imposed. Okay, so in those matter, Parliament has exclusive power. I'm using the word exclusive power to impose tax. Okay, when it comes to state, a state has similar exclusive power with respect to subjects mentioned in state list. Okay, so with union list, center has power. With state list, state has power. You can see that when it comes to state list, there are 20 subjects on which tax can be imposed. And here in union list, there are 15 in number. Then you should wonder, oh, state government has more subjects on which tax can be imposed. So states must be richer than center. But it is actually inverse. Why? Because matters like income tax, corporation tax, which give huge chunk of revenue to our government, is actually under the ambit of center. Okay, so it is not about number of areas on which you can impose tax. It is about the crucial areas. How many crucial areas are under your umbrella? Okay, so in this you can clearly remember that Parliament actually collect the huge, you can say, majority of the chunk of tax revenues, and that is why Parliament later share this tax revenue with states as well. We are going to discuss it as well, but I think this difference is clear to you. A number state has more subjects. Now, when it comes to concurrent list, on concurrent list, both can impose tax. Okay, obviously, their tax laws should not be in contravention to each other. So both the Parliament, state legislature can levy on enumerated and concurrent list, which are 3 in numbers. Okay. Now, come to residuary power. It means those subjects which are not mentioned in state list, union list, concurrent list. What about those subjects? For example, a new area of business has come up, which was not there earlier. So that is why this was not expressively mentioned, not clearly mentioned. Now, who is going to have power to impose tax on that? Let me give you one interesting example. So you must have seen taxis roaming around in cities, right? And sometimes you see certain advertisement pasted on the outer layer of these cars, right, on these taxis. Do you know this advertisement on these commercial taxis are also taxed? Yeah. So it means consider that you have a commercial taxi. Okay, you have purchased a car and registered it as a commercial taxi, and now you think that I am the owner of this taxi and I am going to paste an advertisement of, say, your siblings company. Okay, So, and since you are roaming, your driver is roaming around, consider that your driver is roaming around. So, you are thinking no one is going to ask me any tax. But it may be possible that one fine day, the driver's side will be knocked by municipal corporation people that you have to give this much tax to us. Okay? So, it means there can be new areas of taxation, right, which are decided, at that point of time when they are discussed. Oh, this is a new area. Okay, for example, taxes on this digital advertisement. UPSC also asked this question in prelims, Google tax. Okay. So, residuary power of taxation, that is the power to impose tax not enumerated any of the three lists, is vested with Parliament. So, power is with Parliament. If Parliament want to give this power to any other authority, that is Parliament's prerogative. Right? Under this provision, the Parliament has imposed gift tax, wealth tax and expenditure tax. So, I hope allocation of taxes is clear to you. Right? Union, center, state, concurrent, both, and when it comes to residuary, center. Okay? Now, so this I have explained you the difference between levying, collection and appropriation. Okay? For example, income tax. Income tax is levied and collected by the center. Right? Levied by the center, because example is budget, right, our union budget. Collected by center, because we have a income tax department which comes under central government, right. State government don't have any income tax department. They don't have, because they don't have any power to impose tax on your income, personal income, right. Income tax department is only with central government. Okay. Now, proceeds are distributed between center and state. So, whatever is collected, the appropriation, it is distributed between center and state. Okay. Now, restrictions. Restrictions on whom? I am talking about state. My friends, please give due attention here, because this area many students read superficially, right? But sometimes what you read superficially often actually pop up in your question paper, right? Now, there are three provisions which we need to understand from restrictions. Okay. First, taxes on professions, trades, callings, employment. In general, you can understand taxing on professions. So, in some profession, if you are conducting some trade, so one tax is that, oh, I am giving income tax to the government. States will say, you are giving this income tax to center, not to us. And you will say, but I have read in Shashank's polity class that the tax proceeds from income tax is distributed with you as well, distributed with states as well. Now, state will say, yes, they are distributed, but we are not quite happy with that. And that is why we want to impose a tax on your trade. You will say, what kind of tax? And state will say, tax on trade. Those people who are going to engage in this kind of trade, this kind of profession, which we are mentioning in our law, means law made by state legislature, will be taxed. But there is a restriction over it. This is the old provision, and that is why 2,500 per annum. But you should know, yes, this tax can be imposed, but there is a restriction, limit over it, right? And why this limit? Because you should be reasonable enough to impose the quantum, the kind of tax you are taking from people. Otherwise, people will actually start evading taxes, right? Now, second, so this is quite, direct one, but the trick is there in second and third, and it is quite easy to understand. Just read. Consumption and sale of electricity. Take example that there is an authority, at state level, which is actually selling electricity to center. Now, this law is saying, the provision is saying that if any authority working in state is selling some electricity to center, then no tax will be imposed on such transaction. You will say, oh, center is playing smart here. Tax on consumption, sale of electricity allowed, but no tax if consumed, sold to center or railways. Railways also come under center, right? So sold to center, if it is being sold to center, then state government cannot impose any tax on such consumption, such sale. Now, you should not misconstrue it like, oh, center wants to take electricity for free. No, I have not said that this electricity will be given for free to center or any department of center. No, I have just said the transaction is taxed as well. Na? The tax is not going to be imposed. For example, you can, after this class, you can just take electricity bill of your home, and you will see that there is a tax also added on energy consumption or the rate which is actually charged on you. For example, you have consumed say 1000 units and you are charged 6 rupees per unit, okay, 6000 rupees. Apart from this, there's charges like, okay, you have 6 kilowatt connection, then there's a charge say 500 rupees. Now total amount seems to be 6500, but you will see there's additional tax imposed there. Then the tax I'm talking about, that tax cannot be taken from center. Okay, in this transaction, that tax is not going to be used if it is being sold to center. Okay, one thing is clear, sold to center. Now, there's a twist in the third provision. Consider that there's a central government body, for example, NTPC. Okay, so NTPC is a PSU responsible for generating electricity. So PSUs are working in different states, right? Now, if this PSU is selling electricity to some entities, now can this transaction will also be exempted, or state can also impose tax on this transaction? Let's understand this. A state legislature can impose tax in respect of any water or electricity stored, generated, consumed, distributed, or sold by any authority established by parliament. That is why I gave example of NTPC, right? Power Generation Company of Center, right? Unit of center. So now this third provision is saying that if there is any central government body which is engaged in say water, electricity storation, generation, consumption, distribution, then state can impose tax. So here the word is sold by. Earlier it was sold to. No tax can be imposed if center is taking electricity. But if central government body is selling electricity, then state government can impose tax. Now some of you would say, sir, you said restriction on state. Then how this can be considered as a restriction? Restriction hai. Take a look what is written here. Means this can be done, but such bill need to be reserved for the president. Should be reserved for the president's consideration and receives his assent. So it means a state government can impose tax on such entity, that we want to impose tax on NTPC's transaction to different bodies, okay, because we want to use this tax to actually upkeeping or developing the interstate river and river valleys for developing. Because if you are generating say hydropower electricity, so state has responsibility to actually do the upkeeping work, development work around this river valley. So from where you have to do it? From where you can do it? So you can do it from the additional tax which you are collecting from the central government bodies. Okay. So now you can easily remember it. Number first, it was tax on professions, but there is a limit here. That is why we are saying taxation. Second, any electricity which is sold to center is exempted from tax. State will not impose tax. Third is when central body itself is selling, yes, here tax can be imposed. Sold by, tax can be imposed. Okay, but this bill need to be reserved for president, and after president assent, then it can be cleared. Okay, so I hope these three restrictions are clear to you, right? Question can be expected. Now, distribution of tax revenue. So there was 18th Amendment Act 2000 mentioned in your Laxmikanth. Purpose of this amendment was that it enhanced the level of corporation tax and custom duties at par with income tax. So you will see what bought several central taxes at par. What does it mean? What is the meaning of at par with income tax? Let me explain this to you. In earlier slide I told you income tax proceeds are levied, collected by center but distributed between center and state. It is confirmed to you, right? Now, with respect to corporation and custom duties, same is going to be done. That was the mention, you can say that was the provision of this 18th Amendment Act, Constitutional Amendment Act. What does it mean? It means now states are going to get share from corporation and custom duties as well. These are such taxes which are levied and collected by center but distributed with states now after this amendment. I hope it is clear now. Now, moving to the next amendment, the most popular one, 101 amendment. We are talking about GST tax. So GST has simplified the indirect tax structure in India. When I say indirect tax structure, means I'm talking about taxes imposed on goods or services. So it replaced many indirect taxes, tax on final goods. Okay. Now, there may be a question on which of the following ways represent the tax powers or established between center and state. Okay. So you need to understand these areas, means how tax is handled between center and state. You just need to remember it. First case, tax levied by center but collected and appropriated by state. Means center is imposed but given responsibility to state. You collect and you appropriate. You take decision on actually spending it. Stamp duties on bills of exchange, check, promissory note, insurance, transfer of share, excise duties on medicines. So although indirect taxes are being subsumed under GST, you need not to cram the areas on which this scheme of sharing is imposed. Okay? You need to understand the provision. Clear? As I told you, cost benefit, we need to keep in mind the amount of time you spend and the amount of marks you can actually gain in exam. Now, taxes levied and collected by center. So here you have two cases with center. Earlier you were having just one case with center, now two cases, levied and collection by center and assigned to the state. Please remember, I'm focusing on the word assigned. Assigned means now it is given to state. We have imposed, we have collected, now given to state. You actually appropriated. So tax related to interstate trade, commerce, interstate trade. It means tax which is going on if one thing is actually being produced in one state and it is being sold in other state. For example, say one sari being manufactured in city of Surat, Gujarat, and it is being sold in Madhya Pradesh, UP or any area. So this is interstate trade. So any tax which is imposed on interstate trade will be levied and collected by center, but will be assigned to state. And in this case, after the coming of GST, this is shared between these states. Means center will say, no, I am just imposing and collecting. This is going to be divided among you. Okay, this is second formula. Third, taxes levied and collected by the center. Levied and collected by the center. It is same as the second point, but twist is in this distribution thing. It means distributed between center and state. Imposition we are doing, collection we are doing, but this tax is going to be shared between center and state. For example, taxes and duties referred in union list. So the taxes which are imposed and collected by center, because these are exclusive power of parliament, then these are actually shared with state as well. Okay. Now distribution of non-tax revenue. First of all, what is the meaning of this non-tax revenue? Tax you understand, right? Binding, amount which need to be paid by people to the government, right? But what is non-tax? Non-tax is, for example, fees. Means giving tax is your responsibility, that you have to give tax, right? But for example, fine. Now tell me, is it your responsibility to give fine, challan to the government? No, right? So it means fines, profits. Yeah, governments also have profits, right? PSUs through government companies, right? So fines, profits, these are example of non-tax revenues. And state government and central government, they collect a lot of fines and lot, you can say, different revenue streams of profits as well. They have profitable ventures, right? So now in this aspect, they have to deal with their respective list, means the areas in which you can actually impose, you can collect that are yours, right? So a quite independence in this area of non-tax revenue. Now, coming to grants in aid, what is the meaning of grant? And is it different from loan? Yes. When loan is given, it is expected that you are going to pay me back under these conditions, maybe interest. But grants are, I have given you this amount and I don't want this amount to be back. Just take it. So why I am giving you grant? To chill? No, I am giving you this grant so that this can be spent in a specific area. For example, for development purpose. So there are two kinds of grants. One are statutory grants. The word statutory itself represents law, act, right? So Article 275 says that there are certain grants which need to be given by center to the state. It means are given to the states on recommendation of Finance Commission. It means you have to do this. There's no way out, right? But when it comes to discretionary grant, as the word discretion says, Article 282, it says it is discretion of center. If center thinks, yeah, this particular state is having these financial crises, this particular state need to spend more on education, health, or develop, other areas of development. So there, center can actually give it from its, its own side. It is not on the basis of Finance Commission's recommendation, right? So there's a difference between the two. Now there are other grants as well. So one is grant in lieu of export duty. What does it mean? You can take example. For example, a state government wants to increase manufacturing and export in its area. And earlier, this state government used to take some export duty, right? If you're sending these things, then you have to give this particular tax. Now, center might say that, okay, in this area, there's good scope of production. Why don't you give rebate to the people who are investing in your area so that they can easily manufacture? Taking rebate from you, they will be able to sell this product in some other country or some other area on cheaper rate, or you can say on a better rate. If it is being sold on better rate, then there will be high demand, and if there's high demand, then there will be more production in your area, more people will get jobs. Fair deal, right? But it may be possible that state is dicey. State will say, oh, this is going to create revenue losses for me. So in this case, center can come into actually picture and they can compensate. Oh, we are going to give you grant. Okay. Now coming to Finance Commission, Article 280. Finance Commission is a constitutional body. Mentioned in our constitution, it is a quasi-judicial body. Not having full judicial function, but having quasi-judicial power. Although many people question, we have not seen any work of Finance Commission where Finance Commission is acting as a judicial body. Why are you saying it is a quasi-judicial body? My friends, such status was given to it by Constitution, keeping in mind that Finance Commission is going to decide on or give recommendation on division of proceeds, these grants between center and state. So it may require, an area where other states will actually come on Finance Commission and say, these are my grievances, this formula is faulty. So in that context, you have to work as a judicial body also, quasi-judicial body. Okay. Now, it is responsible for giving recommendation on two areas, chiefly, means mainly. Number one, distribution of tax proceeds, total proceeds between center and state, and number two, it also gives recommendation on supplementing the resources of state for Panchayati Raj and local government bodies. Okay, that is also prerogative. Please remember, we are talking about Finance Commission, the central body. Augment the consolidated fund of the state. It can give recommendation to the state how you can augment, improve your financial status, how you can supplement the resources of the panchayats and municipal bodies. Okay, important point. Clear? Now, protection of state's interest. What does it mean? Means if Parliament is not actually having any limitation on its power with respect to changing the tax proceeds or varying or adding any tax, then it may actually negatively impact the interest of state. So we need to have certain protection there. So one is imposing and varying. Imposing means to impose something new. Varying means there's already a tax, but you are varying that, in which states are interested. It may be possible in a particular area, center has already imposed a tax, but center has varied this tax in a manner that industries in this area are going to be negatively impacted, and which is going to impact the other tax proceeds or interest of that state. Don't you think? This is a valid argument that state government will say, although you have varied this tax, but the future of my area, my government, although whole is India, but I am also responsible for development. So my resources are going to be impacted due to your variation, right? So in this case, it is said that prior permission of president is required before actually presenting this bill in parliament, okay? Although it is said that this is not that much security cover, because president has to act on an advice of council minister, and if council minister has decided, because ultimately government is having power to actually vary this tax. So if they have resolved this, then how can actually president stop it? But this is you can say a layer, additional layer, so that if prior recommendation of president is added, it may be possible that president from its own side, since it's a layer, can actually bring some insight on this issue, that there can be possible ramification for this also. Varying the meaning of agriculture income. As you know, agriculture, prerogative of state. So if you vary this, it may hamper the state interest. Impose any surcharge, additional charge on any specific income category or area. So in this case, president's prior recommendation is required. Okay, please remember these three cases. Now, borrowing by the center and state. Now, if I ask you, from where our government, be it center or state, get funds, arrange funds to be spent on these developmental activities and daily activities, salaries and other expenditures? So, you will say, sir, one thing is, when it comes to state government, one source is their revenues, tax revenues. Other may be non-tax revenues. Third may be grants, which they are getting from center. And fourth are borrowings, right? Means taking loan. Now, center and state both can take loan. One thing should be clear. Now, the point is loan from inside and outside. So, answer is that center is allowed to take loan from inside, means our own banks or banks working in our territory or other financial instruments, or from outside as well. And parliament is there to fix a limit on this. But as of now, there is no law made by our parliament to put a limit on the borrowing capacity of a center. So you can read, central government, state government can borrow either within India and outside. Not abroad for state. Here I have mentioned the word D. It means a state government cannot borrow from other areas directly. For example, Uttarakhand government took loan from Asian Development Bank, ADB. So this loan was actually cleared because central government was there clearing this file. Yes, you are allowed to take this loan. So it means state cannot take loan from abroad on their own. Center's role becomes mandatory. Okay, within the limits fixed by parliament, state legislature. When it comes to limit, limit can be fixed by parliament, state legislature. No limit so far, as I told you, no law has been made. A state cannot raise any loan without the consent of the center. And the reason is, it may be possible that a state government has already taken loan from center. And now state government is taking loan from other central government body, say RBI. So central government will say, you have already taken loan. Why you are taking additional loan? Just tell us how you are going to repay, how you are going to maintain your sound financial balance. So that's why this provision has been added. And my friends, this particular issue becomes more important, especially in this pandemic time, because states have said that our primary source was revenues collected from state and different tax proceeds. But due to you can say downturn in our economy, due to these lockdowns, the tax revenues have actually soaked up, right? Second is this grants. But central government has not given grant in this pandemic period due to this financial issue with the center as well. Now, what is the third source? Borrowing. So, states have said that our borrowing limit should be increased. Now, my question to you, what is the borrowing limit of states as of now? Just mention in comments. Do you know a particular law which sets borrowing limit of state? Come on. FRBM Act, Fiscal Responsibility and Budget Management Act, 3.5% of the state's GDP. That's a maximum limit that state can borrow. Although this limit can be changed in special circumstances by Indian Parliament. And that is why this point was raised, that it is valid to raise it now, because these are extraordinary times. We have not expected such downturn. Now, intergovernmental tax immunities. It means immunities where center should not impose tax on state and state should not impose tax on center. Just give this attention here, because this area is also like students actually just turn the pages, but I feel that there can be a question. First, Parliament empowered to remove this ban. It means there's immunity, but Parliament can actually make a law and say, I don't want this immunity in this area. State, you can actually impose tax, but you know that this is not going to happen. Now, property may be used for commercial and sovereign purpose. It means central government department is having some property, in state obviously. So now they may be conducting some commercial activities there. Means central government company has made some shops there, right? Doing some business there. So can state government impose tax on such property since it is being used for commercial purpose? No. For sovereign purpose? No. Right? It means this is a immunity. And it is quite easy to remember for you. Same kind of immunity is available to state government. The state government is also saying, we are having this property, say in Delhi, and we are using it for, say, commercial purpose, say Andhra Bhavan, Gujarat Bhavan, right? And we are having these canteens there. People are flocking for delicacies, but you cannot impose tax on us, right? This is an immunity there, okay? Corporation companies, if central government has some corporation companies, so they're not immune from such taxation. State government can impose tax on them, okay? Now, when it comes to exemption on state, means of state from center, please remember there are 3 points. First, ban can be removed by Parliament themselves. Second is commercial sovereign, कैसा भी use करें, no taxation by state, okay? Corporation companies, tax can be imposed, no immunity. Here, property may be used for commercial sovereign purpose, same. State is also having this immunity. Second, if Parliament provides commercial function, may be taxed. It means if Parliament itself has provided, has supported state government to have this business, sustain this business. So it is like now Parliament will say that it is not your own business. We have also partnered in that. Since we have also partnered in that, we want to actually impose tax. So this can be done. Center tax or income local authorities. So central tax property or income of local authorities. So local authorities can be actually exempted. Means they are having immunity. And immunity from central taxation. Okay. Corporation companies, they are not going to have immunity. Okay. So I hope this is clear. Now, effects of emergency. What is going to happen? Number one, President can actually reduce or cancel the promises which were made by center to the state. We are going to give you this much tax proceed. Now we are not giving. We are going to give you this much grant. Now we are not giving. So it means this can be done in case of national emergency. Second, such modification continues. Now this is an important twist. UPSC will make a statement when national emergency is in place, financial relations between center state are going to be changed, and consider the giving of grants has been shelved now, or sharing of tax proceeds have been shelved. Now they are going to make some words they are going to use like this particular provision will cease to exist after 6 months from the removal of national emergency. Now, since you have read this clause, this particular phrase, that this particular law is going to be applicable only till 6 months from the cancellation or removal of national emergency. So that is why sometimes students actually link this with everything, but that's not true. Okay, in case of financial aspect, this particular provision that like President has cancelled or reduced, this will remain in force till the end of that fiscal year. Such modification continues till the end of that fiscal year, financial year in which the emergency ceases to operate. So consider that emergency ceases to operate in say January 2022. But this fiscal year, financial year is going to continue till 31 March. Right? So now states will not say, oh, now it has been shelved in January, so from February we want the due of our tax proceeds. You cannot say that because it is going to continue till end or cease of this financial year. I hope it is clear. That's why I've put star point here. Financial emergency is imposed. What is going to happen? Then center can say you have to ensure the canons of financial propriety. It means save wherever you can. Second, reduce salaries, allowances of every class of civil servant, means government employees. Along with this, including high court judges, because we are talking about state, right? To reverse all the money bills and the other financial bills for the consideration of president, to reserve. If you want to make some bring some money bill, because we are already in financial emergency, that you have to reserve it. President is going to see whether it is fine to actually continue that or not. Okay? Hello everyone. I hope this message finds you fit and fine. My name is Shashank Tyagi. Welcome you all to our contest series on Indian Polity based on Laxmikanth. In our previous class, we were discussing center-state relations, an important topic. And we know now that we can divide this into three heads, means legislative aspect of center-state relations, then financial, and then executive. We have gone through legislative aspect, and today we need to talk about administrative or executive aspect of center-state relations. Good number of questions can be made in your upcoming prelims, so give due attention. So these relations are mentioned in part 11 and part 12 of Indian Constitution. This is a factual information. Now, Article 256 to Article 263, they deal with administrative relations between center and state. If we talk about the basis of categorization, we can say majorly theme is same as we learn in legislative aspect of center-state relations. What does it mean? It simply means that in case of legislative power, there is Schedule 7, clear division between union, state and concurrent list. So based on these themes, we have delegated or given executive power to center and state, right? So it means theme is same as distribution of legislative aspect. Center has exclusive power on union list. I'm talking about legislative aspect, okay? Because on this basis we have executive. The state has exclusive power on state, and when it comes to cases like making law for implementing any international treaty agreement in that aspect, even if the matter is in state list, center can make this law. We discussed this in previous class, right? With respect to concurrent list, both center and state can make law. Now, please understand, in executive aspect, we are not going to use the word parliament and state legislature like we were using in previous class. Now, we need to use the word central government because our focus is executive. Legislative is there to make law and executive is there to implement law. And there are two kinds of executives, permanent and temporary. So those of you who are preparing for civil service exam, considering all of you are, so you are preparing for permanent executive, and there is temporary executive also, ministers who have to give exam after every 5 years or even before that if their government falls. Now the point is, when we say executive power, whose power we are talking about? We are talking about all executive branches which are there at center as well as state. Now just take an example, say Ayushman Bharat Yojana. a scheme conceptualized by central government. Now tell me, can central government implement this scheme without cooperation from state government? Because when it comes to health department at state level, they come under state government. Because we have central departments as well as state departments. For example, income tax department. So those officers who are working there, they are permanent executive, but they are part of central government. They are there to implement a central law. For example, income tax law, which is applicable all over India. They are there to implement that. For example, health. Health is, say, health department is under state government. So now, why I'm raising this question? I'm raising this question to let you know that in case of executive power, cooperation is necessary. You can say it is mandatory. Without cooperation between executive, whether center and state, with respect to implementation of these policies, no policy will actually see the light for which it is made, right? So it means cooperation is necessary. So when it comes to central government, it has power to execute policies on subjects which are mentioned in union list. And that is why we were saying that yes, there is similarity between distribution in legislative nature and executive nature, right? In case of state government, they have power with respect to state list. It means matters mentioned in state list, if there are some laws, then these laws need to be implemented. These policies need to be implemented by state government. I hope you are getting clearer, right? Executive power does not mean that state government is going to make law on state list, because we are using the word state government. Okay, when we talk about making law, we should use the word state legislature, which we used in previous class. Okay, so there is difference. Now the point is, what about concurrent list? Means state list is clear, union list is clear division of power is there. But in concurrent list, in legislative aspect, we discussed that law can be made by both center and state. What about the executive power? Executive power lies with center or state? What do you think? What's your guess? So some of you might be thinking, sir, in concurrent list we discussed that priority is given to law made by union legislature, means parliament. That is what you discussed. That is what we discussed, right? Can you say this is the same theme when it comes to executive power? No, there's a difference here. Just remember from this particular analogy, in case of union list, power is with central government, executive power, state government. When it comes to concurrent, state and center both have power to execute that law, but priority is of state. Now what does it mean, priority? It simply means that when it comes to concurrent list, the executive power rests with the state until and unless there is a specific mention in that law that okay, the implementation part of this law will be with center. So if there is no mention with the law that who is going to implement this law, then it is going to be responsibility of state executive to execute that law. I hope you are clearer now. So I feel that there can be a question on this. It's a star point. Okay. So there's a difference there. Now, in legislative aspect, we also discuss residuary power. It means law making power on subjects which are not mentioned in any of these three lists. So we discussed that in case of residuary power, power lies with center, right? Means parliament. And I also gave example of USA and Australia, right? Now, in case of USA and Australia, we discussed that residuary power lies with state. But in case of India, residuary power lies with center. We have strong center. Canada has strong center. In case of Canada also, residuary power with respect to law making power, it is with center, right? Now the point is, what about executive? Why we have not mentioned executive power with respect to residuary? My friends, the word residuary is used in law making context only. Okay, that is why in executive we have not used it, because residuary means this subject is not mentioned in any of these lists. So if something is not mentioned, first step is to make law, right? But here we are talking about law making, we are talking about implementation of law. So consider that center has made a law, because center has the this residuary power. Then it's quite obvious that for implementation of that law, there will be mention that which department, which level is going to be responsible for implementing that law. So there is no debate with respect to residuary power here, right? Clearly, if center is going to make, then definitely central government is going to have power. Okay, I hope this is clear. Now, as we start in executive power from Article 256, so first question is, what Article 256 says? क्या कहता है? So there are 2 points which are mentioned in Article 256. First point is that state has to comply with central laws. Means state, while exercising its executive power, cannot contravene central law. So it means opening article of executive aspect of center-state relation gives primacy to center, that state you cannot do this. Okay. And the second clause, I told you there's 2 points here, na? Clause 1, subclause 2. Now, second point says that center can give necessary direction to the state for this purpose. It means a state should uphold the central law. Executive actions of the state cannot contravene central law. So that first subclause says the state has to take care of this. And subclause 2 says if state is not taking care of this, then center has this power, the center can give the necessary direction. Okay. Now, what if a state don't comply? What is going to happen thereafter? So Article 256 do not mention, you can say Article 256 is mute on punishment, or you can say action. We should use the word action. What is going to be the action thereafter? So the Article 256 is mute on that. So why mute? Because Article 356 clearly give action power to the center. What action power we are talking about? Coercive sanction. It means state government can be actually, it can be said that since Article 256 said that you cannot contravene any central law, you have to uphold central law, then if you are doing this, then this can be a ground of imposing president rule, that the state is not working as per constitutional provision. But this power is mentioned in Article 356, constitutional machinery part, and clearly with respect to this direction word is mentioned in Article 356. Now we are using the word coercive sanction. What is coercive? It means that you don't want something, but still that thing is being done with you. That is coercive, right? Now there are 4 cases clearly mentioned where coercive sanction can be used by center, and they clearly tell us the executive relation between center and state. So I feel that there can be a good question from these statements in upcoming prelims. Means a good question can be made. Number 1, the construction and maintenance of means of communication by the state, means such direction can be given, because Article 365 says that direction can be given by the center to the state, and if state does not comply, then this state can be declared that there will be president rule there, right? So 4 kind of directions. First, construction and maintenance of means of communication. Please remember, the word is construction and maintenance. It is not just maintenance. Okay. If UPSC make a statement that as per Article 365, the necessary direction to the state can be given, with respect to means of communication only for maintenance. So no, it's for construction and maintenance, because devil is in the detail. You never know at what deeper level UPSC play with you. Now, for the protection of railways within the state, please remember, it mentions protection of railways, because we have a railways department at center, which is responsible for construction of railway line. Construction of railway line is not done by state. So that is why direction will say, we have built these you can say railways, and now you have to protect, right? So it means construction as a term for this direction is not there. This is just for protection. Clear? Now, third, facilities. And facilities for what? There are 3 points here. Facilities for what? Mother tongue means instruction in mother tongue. Okay. Second, primary stage means instruction in mother tongue, primary stage, and for linguistic minority groups. Okay. So it means if center is giving direction to the state government that you have to provide facilities to give instruction to the children who are studying at primary stage or eligible to study at primary stage in their mother tongue, and specifically talking about linguistic minority, because it is their right to get educated in their mother tongue. So in this case, if a state does not comply, then it will be considered as a base for applicability of Article 365. Okay. So such is the sensitivity or importance of this particular provision. Okay. Now fourth, for execution of specified schemes, please remember the word is execution, not formation. Execution of schemes for welfare of scheduled tribes. So it means if center gives a direction to the state government that we are giving this direction that you have to make this scheme, you have to make a scheme for scheduled tribes welfare, and if state doesn't comply, do you think that can be considered as a base for coercive sanction under Article 365? No. Because state government will say, why you are not making a scheme? You have a dedicated Ministry for Tribal Affairs, you can make the scheme. Why you're not? So here the word is execution. A state has to execute. Okay, although state can also make, but that is state's will. But center can give direction on in the case of execution of that scheme. I hope all these 4 points are clear to you. If a question is asked, it should not be wrong from your point. Now, cooperation between center and state. As I told you, with respect to executive relations, cooperation is necessary, right? So there's Article 261, it says full faith and credit. It means whether there's a law made by center, law made by state, because even if a law is made by center, execution is going to be done in one or other state, then don't you think that executive machinery of state has to respect the implementation of this law which is made by parliament, right? And this can only happen when there is full faith and credit throughout the whole territory of India, right? So this is clearly mentioned in our constitution. So it means public acts, judicial proceedings, center and every state, they should be given they should be received with full faith and credit. Okay. If they are not being, you can say, received in this manner, then it will be considered as an unconstitutional act by that particular department, and actions can be taken against the department, right? Because it is unconstitutional. When I say unconstitutional, it means you are standing opposite to what is mentioned in our constitution. Okay. Article 262, what it says, Parliament can provide for adjudication, means if there's a dispute with respect to distribution and control of waters or any interstate river or river valley. So in this case, Parliament can actually provide for adjudication, means mechanism can be developed by Parliament. Okay. Article 260, please remember Article 262 is talking about dispute related to water, interstate water, river valley. But when we say Article 263, it is having provision with respect to any kind of dispute. What it says, President can establish an interstate council to investigate and discuss subject of common interest between center and state. So it means in interstate council, there can be a possibility that two states are having opposing views on a particular point. Before it becomes a dispute, open dispute, it can be resolved with proper talk and proper, you can say, coordination and arriving at a particular decision and then executing that decision. So you need a dedicated body for that, and that body is interstate council. Okay. So such a council was established in 1990. That's a factual information. Now, public services. As I told you, executive, temporary, permanent, and you have to be part of permanent. So these departments are being run by officers and other staff, right? So where we have three kind of services, which we call public services: state services, central services, all India services. When I say state services, it means people in the service are recruited, trained and deputed by state government only. For example, a particular state government organizes this state PCS exam, Provincial Civil Service Exam. So people, by passing this exam, they also get the position of deputy collector, SDM and DSP, right? But definitely when it comes to promotion and the seniority, they are considered, you can say, at the secondary position in comparison to central service and all India service. Okay, what is common in central service and all India service? The people for them are recruited, trained by center. Okay, I have not used the word deputed or working under, because in state service they have to work under that specific state government, right? But in case of all India service and central service, what is the difference? For example, income tax department. So some of you get elected. So some of you actually, when you were filling your choice in detailed application form, so as per your choice, you got IRS, IT, means Indian Revenue Service, income tax. So you have opted for central service now. Your recruitment is done by UPSC. You are going to be trained by the center, right? And you are going to work in the central department, income tax department, right? But there are other all India service. We have three all India service. Only three all India service are there in India: IAS, IPS, and Indian Forest Service. Please remember, Indian Foreign Service is central service. Okay, Indian Forest Service is all India service. So what is the difference? Difference is, although you will be recruited and trained by the center, because all of the people, they get selected through this UPSC Civil Service exam. For IFOS, you have a separate means and interview. Then these people are trained in Mussoorie, then they go to their respective academies. Now the point is, but in all India service, now they will be allocated cadre, state cadre, right? So although you are recruited and trained by center, but you will be working in a state, and you will be working in close coordination with that state government. You're not part of any central government department. Okay, so this is the difference. Now, there is debate also around this concept of all India service, because some people say that this all India service is against the concept of federalism. So why this debate? They say that federalism as a concept represents division of power, autonomy of state. But what we have seen in past, that since Department of Personnel and Training at central, union level, it is the actual cadre controlling authority of all India service. So it means the patronage of these all India service civil servants lie with center, not with state. And we have seen in past, for example, in case of West Bengal, there was this issue. There was a tussle going on between Mamata Banerjee and union government on the transfer of certain IAS officers. Center was saying, no, we need this IAS officer. And West Bengal government was saying, no, we are not going to allow him to go. We are not going to issue NOC. So this tussle was going on. And at that point of time, the matter was raised, this is against federalism, right? So now this is just basic fact. In 1947, the Indian Civil Service, ICS, was the earlier name, was named IAS. Earlier IP, Indian Police, now named IPS. In 1966, a dedicated service for forest service. Article 312, an important article. By use of this article, Parliament can create a new All India service also. But how it can be actually created by Parliament? We need a resolution passed by Rajya Sabha for that, because we are using the word All India service, and ultimately the people in All India service have to go to state cadre, right? So important service which should be made, there has been a recommendation along this point for quite long, is All India Judicial Service. Means there should be a IJS also to actually you can say fill the vacancies in judicial services in a swift manner. But somehow it could not be materialized as of now. I told you All India service violates the principle of federalism. This is one point. But we should also know what are the positive points. So there are 3 positive points. Number 1, high standard of administration, because all of you, those who are getting actually part of this, getting into the civil service, esteemed civil service, they are going to be trained among the top, you can say, with the top trainers and top services. So high standard can be maintained along all states, right? No matter which state cadre you go, but you will maintain the high standard for which you are trained. Second, uniformity. So one is high standard, second is uniformity. Because if same kind of training, same kind of environment has been created, then definitely you know what is the objective you need to achieve, right? So uniformity. Third is cooperation and coordination, right? Because we need cooperation and coordination in different states in order to achieve our common goals. So if all these people are trained through a common mechanism, then having this coordination, cooperation and joint action would become easier. So please remember these 3 points whenever you have to talk about the positives of this, okay? Now just attempt this question. As when you open this Laxmikanth, you'll find after this public service, you will also find Public Service Commission. Although in your Laxmikanth, there's a dedicated portion there, right? Constitutional bodies, there we are going to discuss this. But since it is mentioned here, you should be aware. Appointment, the chairman and members of the State Public Service Commission is done by. Mentioned in your Laxmikanth. You must have read it. Answer. It is talking about SPSC. So please remember that appointment of chairman and member of SPSC is done by governor. Okay, but they are removed by president. This is the twist, and you should know that. Removed only by president. Okay, statement kind of questions are also asked in this manner. Chairman and member of Joint Public Service Commission are appointed by. So earlier we were talking about SPSC, state PSC, governor appoints, removed by president. In case of JPSC, both the work, appointment and removal, this lies with president only. Appointed by president. I think it is clear now. Now, integrated judicial service. What does it mean? It simply means that no dual system of administration is there. It means whether it is High Court or Supreme Court, they have to uphold the common laws of India, right? Enforces both central laws as well as state laws. Means High Court cannot say, I am High Court of that state, so I have nothing to do with central law. I am going to focus only on state law. No, this cannot happen because we have integrated judicial system. Even if you are a High Court, you have to uphold or enforce central as well as state laws. Okay. Parliament can establish a common High Court for 2 or more than 2 states, right? So it means Parliament has this power. This is right. Parliament can take this decision. What you should remember, that no state government, state legislature has power to establish their own High Court. Okay, this power is only with Parliament. And this is the structure of Indian judiciary. You have Supreme Court, Apex Court, then High Court. In metropolitan areas, you have metropolitan courts, civil and criminal. In districts, you have district session court. Civil means matter which are related to civil, for example, tax matter, land dispute. Criminal matters dealing with Indian Penal Code, which are considered as offence. These are dealt with criminal code. Criminal court are also known as session court, and judges are considered as session judge, and district court as district judge. Okay. Although at the level of district, this hierarchy is headed by one post, that is district judge, DJ. Then we have sub-courts, judicial magistrate court first in class, then principal junior civil judge court, judicial magistrate court second class. Means these judges, judicial officers are appointed through this PCSJ exam, Provincial Civil Service Judicial. Then you have municipal court, means in suburbs, sub areas, there are also, these courts. When we talk about judiciary, we are going to talk about Gram Nyayalayas, Lok Adalat. Everything will be set in your mind, don't worry. Now, attempt this question. The judges of a state high court are appointed by, attempt, come on. President in consultation with Council of Minister and State Governor. Ek to hota galat, ek sarasar. This is sarasar wrong. President in consultation with Chief Justice of India and State Governor. This is correct. Although you should know, the recommendation for name, that who is going to be the judge of a high court, is done by collegium. We are going to discuss collegium when we enter into judiciary chapter. But the word here is appointment, appointed. Appointment is done by President in consultation with Chief Justice of India and State Governor. Okay? I hope it is clear now. Now, how executive relations hamper during emergency. So we have three provisions with respect to emergency. National emergency, Article 352. State emergency or President rule, Article 356. Then financial emergency, Article 360. Right? Now, national emergency. In this case, center can actually direct the state on any matter. The reason is, it may be possible that integrity, unity of India is under threat. So during national emergency, executive power of state can actually be considered that they shift towards center. Direction will be given by center and state has to uphold those directions, right? But you should also know that government is not necessarily suspended when national emergency is in place, okay? They have to adhere to the directions done by, you can say, issued by center. Then we have Article 56, President's sole authority in the state. Now President rule is there, it means now President is actually ruling the state. But President is ruling the state through his representative, her representative, and that is Governor. Okay? Then we have Financial Emergency, Article 60. In this case, center, means here President, can ask a state to reduce salaries and other expenditures since financial emergency is in place. It means austerity measures can be recommended, and at this point, state government has to uphold that. Okay? So it means a state government is not removed here in case of financial emergency. Now some other provisions. For example, Article 355 imposes duties on the center. Two duties. Number one, that you have to protect state from external aggression and internal disturbance. Second, you have to ensure that state is being run through constitution, means provisions of constitution are protected. Now don't you think actually these are the actual grounds, this is the ground on which Article 356 is imposed. Article 356 is used and President rule is imposed that, oh, the state is not being run as per provisions of constitution, right? So now governor of a state is appointed by President. So this is executive power of center, because in this case President is getting a list, and in this list there's one name. Okay, earlier there's a list, and then from this list, Council of Minister headed by Prime Minister selects, okay, this name. For example, Rohit. Mr. Rohit is going to be the governor of Tamil Nadu. Now, President will actually, ask, this is the name, I'm verifying it. Now, this person is going to be appointed as governor. My friends, there's no election for the post of governor in India. Governor of a state works on pleasure of President. It may be possible that you are governor of, say, Uttar Pradesh, and the next day you receive a fax that you have to wrap up your things and move out from Raj Bhavan from actually the next day, because now you're not the governor of UP, and now we have appointed a new governor. So you cannot file a case in Supreme Court or High Court or anywhere that how this can happen to me without reason I'm being fired. Aisa nahi hoga, because you work on the pleasure of President. Okay, and President works on the aid and advice of Council of Minister headed by Prime Minister in this case. Clear about? Now, There's a subtopic within this executive administrative provisions in your Laxmikanth, extra constitutional bodies. So what does it mean? It means this is constitution, and this constitution has certain provisions which talks about center-state relations in executive matter. There can be other ways also, but it is beyond constitution, means it is not mentioned in constitution, it is separate. So this is called extra constitutional. So extra constitutional and unconstitutional are different. Unconstitutional means a particular provision, a particular action is against constitution, but this is not against. It is just that, okay, some themes, some ideas you have done here, but we want some additional means, additional power structure, additional, say, some mechanism. So that is why we are making this. So this is extra, okay, extra constitutional. So who presides over the Chief Minister's Conference? So governor of the state, prime minister, okay. So these, now please remember, it is not like you have to cram every article which is mentioned in this part 11 and part 12. What you need to do? You need to just build your understanding as we have done through this discussion. And when you are going to revise important provisions which are highlighted in your MCQs, will themselves they will settle in your mind. Okay, so you need not to worry, just understand the core, the essence of this. Hello everyone, I hope this message finds you fit and fine. My name is Shashank Tyagi. Welcome you all to our contest series on Indian polity based on Laxmikanth. In our previous video, we were discussing about concept of federalism, how it evolved, and what kind of form of this concept of federalism was adopted for Indian polity. Today's topic, center-state relation, is an extension of previous topic. We need to understand the basis of relation between center and state. In federalism, we use the word division of power. So you can say, today we need to understand this division of power in these three heads. Today we are going to focus on legislative aspect. Okay, but in this topic we need to understand these three heads. First is legislative head, second is financial, and third is executive. In center-state relations, we don't talk about judicial or judiciary as a basis of division. The reason is, in India we adopted integrated model of judiciary. But in case of US, they have division between federal government and state government on the basis of judicial as well. But we don't have that. We have only three areas of division of power. Okay, this division is clearly mentioned in our constitution in part 11 and part 12. And the kind of questions UPSC is going to ask: number one, there can be a statement based on some fact, part, provision. Okay, second statement could be on exceptions within the center-state relations. Okay, and third can be if there is some legal dispute going on, there are some claims made by a state that this law is not the prerogative of center, but this became a news. So one statement can be from that area. Okay, in case of mains, you can have one question where UPSC is going to check your understanding of these provisions. Second question can be dynamic, where you have to infuse your static and dynamic knowledge. Okay, there are good amount of trap questions which can be made from this topic. So if you are cautious while watching this video, I will request that now you should become extra cautious. Have a pen and paper in front of you if you can. If you are traveling, then that is fine, because we are going to have some tricks and tips also here so that these things get concussed in your mind. Okay, now legislative power. So these are mentioned from Article 245 to Article 255. And there are four aspects of division of legislative power. Okay, what are the four aspects? Number one, territorial aspect, means state legislative power is going to have extent to which territory. Center means parliament is going to have influence on which territory. Some of you might be thinking, oh, it's quite obvious. Parliament is going to have the whole of India, and state legislature is going to have specific to that state territory, right? That is what you are thinking. There are three cases in this. Number one, Parliament can have this law-making power to the whole of Indian territory. Second, to a part of Indian territory. Third, beyond Indian territory. Now tell me, which of the three aspects with respect to territorial legislative making power of Parliament are true? Think and just mention in comments. As of now, I have no expectations, because I'm considering that you are just starting off. Okay, at later point, I'm going to have expectations from you. But just answer. Some of you would say, sir, it is quite obvious that Parliament can make law for all of India or part of India. How can Parliament make law for territory which is not part of India? But my friends, answer is all three. So it means you should not take this topic lightly. Okay. Now, subjects, the division of subject between center and state, that we are going to discuss when we are going to discuss Schedule 7. Okay. Today we are going to deal with legislative aspects, all kind of questions, dimensions which can be asked. Now, third aspect is Parliament's power to actually make law on subjects which are considered as state subjects. Fourth aspect is center's power to actually have control on state legislature. What does it mean? It simply means, consider that you are governor of Uttar Pradesh. Okay, no, take yourself as governor of Rajasthan, because in Rajasthan we have a Congress government. So now Congress state legislature, they actually passed a bill, and this bill has been presented to you. You are governor of Rajasthan. Okay. Now, it may be possible that you see, oh, this provision is having some conflict with center, a law made by center. And that is why you reserve this bill for the assent of Honorable President. So when Rajasthan legislature, Rajasthan CM was expecting, oh, now Honorable Governor is going to sign this bill and this will become act. But you took other course. You sent this bill to the Honorable President. And you know that Honorable President has to act on aid and advice of Council of Ministers. And who is the majority party there? Who is the ruling party? BJP, right? So it may be possible they say, oh, no, this is in contravention. So now, don't you think center means here Council of Ministers advising President is having control on legislative power of state legislature? You can say legislative power of state, right? So these are the four aspects in which we have to understand legislative relations. I hope this is clear to you. Just remember these areas. That's it. Okay. Now, territorial extent of center and state legislature. Number first, Parliament can make law for whole of India or any part of India. Okay. Along with this, Parliament has one more power, that is extra territorial power. And this power is only with Parliament, not with state legislature. Please remember that. Okay, there are three cases of territorial law-making power of Parliament. Clear? When it comes to state legislature, it can make law for whole of state as well as for part of state. For example, Madhya Pradesh legislature may make a law which is going to be applied for only 2 districts. If conditions are such, they can apply this law for 2 districts. Okay? Parliament alone has this power, extra, territorial. When I'm using the word territory on which Parliament is having power, what does it mean? It means the definition of territory which we discussed in part 1. It means all states, UTs, as well as all the territories which are acquired, okay, acquired by India. I find a beautiful scope of question here. Just listen to me. What if UPSC make a statement that Parliament's power to make law absolutely extends, Parliament has this absolute power to make law with respect to whole of territory of India, which include all states, all UTs, and other territory which may be acquired by Indian state. Now tell me, the statement would be true or false? And mention in comments. Those who are watching this video, just mention in comments. Should I repeat? I'm saying Parliament has this absolute power to make law with respect to whole territory of India, which include all state, UTs and other territories which may be acquired in future. The statement is true or false? Come on, in comments. Because my purpose is to actually reduce any scope, eliminate any scope of you marking wrong answer in exam. And that is only possible when we actually have maximum accidents within this class through these trap questions. So some of you might be thinking, sir, it is quite clear from the statement, can make law for whole or any part of India. So whole means whole. The statement should be true. And 98% students who have read this chapter for say 1 or 2 times and missed on understanding the detail, the intricacy, will mark wrong. Because answer is not true. Answer is false. Because the word absolute was used in the statement. Absolute power. Absolute power nahi hai. Okay? Because there are exceptions, and within the start of the video I told you that UPSC will play on these exceptions. And we are going to cover this, all of this. Don't worry. But answer is no. And answer is no because absolute power is not there. There are exceptions as well. Okay? What are those exceptions? Let it be a bit of suspicion there. Okay? Not suspicion, suspense. Suspense. Okay? Now, laws of Parliament are also applicable to Indian citizens and their property or any part of the world. That is a part of extraterritorial. There is a famous case in here. Wallace versus Income Tax Commissioner, 1948. Okay? This is related to extraterritorial legislation. So what was happening in this case? There was an England-based company, and this England-based company actually made a partnership with an Indian company. Okay. So now, Income Tax Commissioner sent a letter to this England-based company that you have minted majority of profits from India and you have partnership here. So that is why my assessment says that you have to give this additional amount as income tax, in this case corporation tax. So as a reply, this company said, no, you are using a law which was made by Indian Parliament. This law is not applicable in my territory. Now judgment came, and judgment said, if there is territorial nexus which can be established, it means the claim which Indian state is making in other territory is connected to Indian territory. Then in this case, yes, this England company has to pay this additional tax to India. Because as per Indian law, the tax is right. Okay? But you have to do this test of territorial nexus. I hope that this is clear now. Right? So in this case, what is happening? Extraterritorial legislation is in place. Right? This law is being applied to other territory also. Right? But this power is also not absolute. The test of territorial nexus should be made. Right? Now what are the restrictions? I told you, exceptions are there. Just take a look over these exceptions. President can make regulations for peace, progress and good government of 4 union territories. It means the laws of Parliament not applicable in the following areas. And in which area? These are the area. When I say area, it means peace, progress, good government. In this case, President's regulation will supersede any law which is made by Parliament. And I find beautiful scope of question from there. Now, it is quite easy to remember which UTs we are talking about. It is not applicable to all UTs. Please remember. Only applicable to Lakshadweep, Andaman and Nicobar, and D square. D square means Dadar and Nagar Haveli and Daman and Diu. Okay, Dadar and Daman. Clear? So there are 4 areas which can be considered as exception where President's regulation will supersede a law made by Parliament. Important, I would say. So when UPSC asks this question and you answer it correctly without falling into trap, then you can connect with me at later stage. Yes, sir. That advice actually worked. Now, second case. The governor is empowered. So governor is empowered in what context? In context of scheduled areas. So what can they do? It can direct that an act of parliament does not apply. So even if a parliament has made a law that I am parliament and this law is going to apply in whole area, all the territory of India, then governor for some state may actually present a regulation, and in that regulation governor will say no. Even if this is a parliamentary law, but it is not going to be applicable in the scheduled area. Okay, so it's a limitation on the you can say application of law of parliament, right? Third, in case of governor of Assam can do the same thing for tribal areas. Okay, apply to tribal area, or you can say autonomous district. So why we have this separate point 3 here? The reason is the provision of autonomous districts are there. There may be a case that there are scheduled areas, but in these scheduled areas, we have not given them autonomous power. Okay, so in that case, you have to apply article with this subclause 2. Yeah, point number 2. But it may be possible that due to the demand of these tribals, we have given them autonomous district status. It means when you become a civil servant and you are posted in this area, so you will have a district council. You will be having the core authority, but to support you, there will be a member from this tribal community. Okay, so this is a step towards inclusiveness. Okay, now another is president enjoy the same power with respect to 3 states. Please remember Meghalaya, Tripura and Mizoram. You can remember MeTM. Clear? I hope it is clear. Please remember these exceptions. Nowhere I have mentioned, in this case, I have not mentioned Arunachal Pradesh. I have not mentioned Nagaland. Okay. Although these areas, specific areas, say scheduled area, they can be covered by the governor. But in case of that, the power of governor is there to supersede a law made by parliament. But in this case, in the case of 3 states, president enjoys this power. Okay. Now, distribution of legislative subject. So first was territory, second was subject. So now we are at subject. So there are 3, you can say, list in schedule 7. Union list, concurrent list, state list. Union list, which is the, you can say, the largest list having 100 matters there. Concurrent list means in these areas, state and center, means union and state, both can actually make law, right? And the state list in which a state legislature is going to have power. What kind of questions you can expect? Just go through the subjects on which union has power to make law. But don't think that UPSC wants you to remember all 100, 61 and 52 subjects mentioned here. No, there's no need. If a question is asked on match the following or a statement mentioning that this is a prerogative of union, this is mentioned in union list, then UPSC might ask question only on those subjects which were very much in news. For example, in COVID times, health management was in news, right? So who has the major responsibility to take care of the public health system? Is it center or state? It becomes a topic. Education, citizenship due to CA. So it means UPSC wants to check whether you are aware and whether you are interested, curious enough to connect the current happenings with the, you can say, structure which is mentioned in Indian polity. Okay, this is the approach which they are looking for. as per my analysis in past, around 7-8 years. Now, the power to make laws with respect to residuary subject. Now, what are the residuary subject? It means those subjects which are not mentioned in any of these lists. So, in this case, the power will come to union. Okay. In case of concurrent list, if law is made by both union and state, what is going to happen then? If there's a case of repugnancy, coming new means union and state law coming into conflict, then in this case, law made by union is going to be considered, superior. Okay. But there's a you can say twist here. Some students, when they read Laxmikanth and they see, okay, in case of repugnancy, union law made by parliament will supersede. But on practical grounds, we have so many examples. This led to a conflict which was heard in Supreme Court, and Supreme Court used this doctrine of harmonious construction. Means Supreme Court made an interpretation by which both laws can work. Conflicting provisions were interpreted in such a way so that this conflict can be diffused. So such thing also happened in practical terms. Okay. Now, if we compare Indian, division of legislative subject in central state with, say, USA. So in US Constitution, there is mention of federal subjects. And since just federal subjects are mentioned, what did it signify? The interpretation is that residuary power lies with state. So there, residuary power lies with state. Any matter which is not specifically mentioned, state is going to make law. But any matter which is not mentioned, union is going to make law in context of India. And with Australia as well. In case of Australia also, this residuary power lies with provinces, means states. Okay? So there is a difference. Now, this is fact that union list 100 subjects, state list 61 subject, concurrent list 52 subjects. Okay? Both parliament and state legislature can make law on these subjects. I'm talking about concurrent list, I told you. But in case of conflict between union and state, regarding subject, union law prevail over the state. I've just told you. And I also added one practical example of doctrine of harmonious construction. Now, third aspect is parliamentary legislation on the state field. Okay? What we are doing actually, we are going with the structure. I told you there are 4 aspects. Out of this, we are on third. First, second, now we are on third. Means parliament having say on the legislative power of state legislature. So how can this happen? In this case, Rajya Sabha's role come into being. Because Rajya Sabha represents state interest. It is considered at least. So the constitution empowers the parliament to make law on any matter in state list. Please remember, any matter in state list. But what the condition is? 5 extraordinary circumstances. In 5 extraordinary circumstances, please remember, parliament can make law on any matter in state list. Number 1, when Rajya Sabha passes a resolution in this regard, means there's a matter of national importance and this is in state list, and Rajya Sabha says, I am representing state and parliament, and that is why we are conducting a resolution and we are passing this by special majority. Special majority means 2/3 of present and voting in this case. Okay. So then resolution remains in the force for 1 year. It means any law which is made in this regard, means which is made on matter mentioned in state list, will be in force for at least 1 year. But it can be renewed any number of times. Please remember, any number of times. UPSC play on these things any number of times. Okay, but it should not exceed 1 year at a time. For example, if you have made a law based on matter mentioned in state subject, then it will apply for 1 year. After 1 year, you have to bring this resolution again and then extend it for another 1 year. And you can do this process any number of time. Okay. Now, laws cease to have effect on expiration of 6 months after the resolution has ceased to be in force. Which resolution we are talking about? This resolution. Because consider this resolution was extended to 1 year, and 1 year extension is, say, 1 January 2023, right? On 2023, this 1 year of this resolution will complete. Okay. Now, Parliament has a choice whether to extend this resolution, but they have not extended this resolution. Now, from 1 January 2023 to 6 months, just for 6 months, this particular law will be in place, okay, although it can be repealed before that as well, right? But if it is not repealed, it can actually go on for 6 months, and after that it will be considered expired. Okay, this is the meaning of this particular statement. I hope it is clear now. So this is the first case, first extraordinary circumstance. What is the second? Second is during national emergency. Okay, laws become inoperative on the expiration of 6 months. So it means if national emergency is in place, now legislative power of state comes to the center, because now it is a matter of, sovereignty, integrity of India becomes topmost priority, right? But as emergency is done, after that, till 6 months, this will be in operation, these laws can be in operation, and after that, they will cease to actually, exist, right? So now, are you observing that although power is given to Parliament in extraordinary circumstances to make law on state subject, but our constitutional framers have given some safety wall also, right? So that states' power remain intact, so that concept of federalism can be visible in Indian polity, okay? Because independence of state is being ensured by providing these safety walls. Now, when states make a request, what does it mean? If two or more states request that Honorable Parliament, we want you to make law on this topic, although this is a matter of state subject, but we want you to make law. So in this case, what Parliament is going to say, okay, if you are willing, then we are going to do that. So in this third case also, law enacted and applies only to those states, not to others. Okay, because 2 and 3 states came, right? They may be states which are ruled by the same party which is in power in center, right? So it is not going to be like 3-4 states ruled by the same ruling party in the center. They come and say, sir, make law on state subject as well, and now Parliament is empowered to make law for all the states. No, it is going to be applicable only to those specific states. Any other state may adopt it by passing a resolution to that effect in their legislation. Okay, that is their raza. वो उनकी रजा है. If they want, they can do that. Okay. Fourth, to implement international agreements, for example, Geneva Accord, Vienna Convention, TRIPS, trade-related intellectual property rights. So when we apply these international agreements, sometimes what happens, some aspects are mentioned in state subject, for example, related to trade. So in that scenario, Parliament can say that although matter is in state subject, but to uphold this international agreement, we are making this law, and this will be applicable. So this will be applicable. Okay. Fifth, during President rule, a law made by Parliament continue to operate. I'm talking about Article 356, right? If constitutional machinery is broken, and on this basis, President rule is imposed. So now Parliament will make law in this regard. So although rule is President rule, but Parliament will actually make this law. Okay, but it will be there. And consider that after say 1 year, President rule ceased to exist. So this law, which was made by Parliament for this particular state where President rule was imposed, will continue. And continue till what time? Till it is removed or altered. Such a law can be repealed or altered or reenacted by the state legislature. But after this President rule is removed, now power will come to state legislature. Now this will be choice of state legislature. Okay. So there is no case of this 6 months expiration. Okay. Now just attempt this question. When the legislature of 2 or more states requests the Parliament to enact a law on matters of state list, that law, repealed or amended by state legislature, amended, repealed by Prime Minister, amended, repealed by Parliament, amended or repealed by Governor of that state. This is a good question, because in our discussion, when we are talking about the case of 2 or more states requesting Parliament, so we just discussed that yes, Parliament can make law in this regard, and this law will be applicable to these states. But what about power to amend law, power to repeal law? So if law is made here and it is applicable to these states. Now, power to amend this, change this law, will be with these states or will be with Parliament? Right, this is the question. Although they have requested this, they want this law to be applicable for them. Does it mean that they have also given up the power to amend and repeal that law to be applied on them? Or just mean that they just have asked Parliament to make law and the later function of amendment and repeal they can do? So this is, I find this is a beautiful scope of question. What do you think? Mention in comments. Answer is C. Why it is C? Amend and repealed, power will be with Parliament because Parliament has made the law. When you have requested Parliament to make law in this state subject matter to be applicable to you, at this point of time, you have given up your power with respect to that subject, with respect to that law. Okay? It's not like you cannot make any law on that state subject now. No, you can make other law. But for that law, Parliament is going to have power. Okay? I hope you like the twist. Now, center's control over state legislation. As I told you, certain bills, reservation of certain bills to by the governor for the consideration of Honorable President. Gave you the example of Rajasthan. Certain bills require prior presidential sanction. So in this case also center has control because President is going to act on aid and advice of Council of Ministers. President can direct to reserve money bills and other financial bills during financial emergency. So in this case also President is actually having control on state's legislative power. Right? Hello everyone. I hope this message finds you fit and fine. My name is Shashank Tyagi. Welcome you all to our contest series Indian Polity based on Laxmikanth. Today we need to talk about federal system in India. First, let's talk about this word federal because this comes in news often due to some state-state conflict or state-center conflict. Have you ever taken sight of center that how can state actually demand more funds from center and you associate your political affinity with center? So, if you do that, then this topic is important for you to understand how our political system is arranged. And in lieu of this arrangement, state governments make certain demands on center. And if these demands are specific to Indian context or these demands occur in other areas of the world as well. My friends, these demands are associated with the kind of political system mentioned in Indian Constitution or in their Constitution. Now, the word federal, this comes from the Latin word fidus, and this means treaty, agreement. But treaty agreement between whom? You can take example that consider these are some small areas. These are some small units, areas governed having certain government, but these areas lack some military might, economic proneness. And you know what happens if an area is economically or militarily weak? There may be attack from outside, right? And the people in this area may lose life, property. So now they may take decision to actually get under one unit. They can join together and form one bigger unit. And this bigger unit can be called center. And these small units can have different names. For example, in case of India, we can call them states. In case of Switzerland, they call them cantons. In Russia, they call them republics. Yeah, republics. And in case of Canada, they call them provinces. So it means there can be numerous names, but the context is some small units joining together and this bigger unit is being formed, right? Now, this bigger unit can be formed when these small units come together, as I gave you this example, or there can be another way. For example, there is a bigger area Okay, bigger unit is there. For example, British India. Okay, and British India and their administration organized themselves into certain provinces as well. But at that point of time, when Indian Constitution was being framed, one big unit was sure. Okay, there will be one big unit, that is India, right? Now this big unit is also actually having this in mind, that let's organize our area into some small units. So it means these small units were created later. For example, Gujarat, Maharashtra, Telangana, Andhra, right? So these units were not organized in this manner during British time. They were organized later, right? So it means there can be this model also. Okay? Now, no matter which model we talk about, one thing is clear, that there are small units and there is big unit. Okay? And another thing is clear, that the small units have some list of powers in which they demand some independence. And this big unit also has some list in which this big unit is going to make laws, ensure important decisions are taken timely, right? So now one thing is clear, that this is independent unit in certain areas. And it is due to this relation we call them federal. And whenever center actually subjugate this small unit into these areas which are actually given to them to actually perform, then these states, these constituent units say that, okay, this is not federal. This is against the principle of federalism. This is against the principle of federalism as it was enshrined by our constitutional framers. Okay? So it means now the basic idea of the word federal and this concept federalism is clear to you, right? So among these allegations by different states, for example, Tamil Nadu was raising this point during this 15th Finance Commission, when this commission was about to give this recommendation. So Tamil Nadu government was saying that this recommendation and this formula might be against the interest of Tamil Nadu and certain southern states. So Tamil Nadu and the leader, Mr. M.K. Stalin, he was demanding that, these states should come together and then they should raise this voice in front of center. And there were reports that certain political outfits were also demanding secession from the Indian Union, because 15th Finance Commission could have actually given formula where their interest could have been, you can say, subjugated. Now the point is, many people actually, by reading this news, they plainly say, this is unbecoming. Why states are doing that, right? So you take the side of center, right? Because you consider that taking side of center make you more nationalist, right? But my friend, nationalism is different, right? Because obviously, when it comes to secession idea, definitely you have to be, you have to take stand against it. But when it comes to states coming together against some financial decision, against legal decision made by center, right, and which they think is their prerogative, they should have been taken into, you can say, the loop while making this reason, then in this context, you should think that these are administrative, political decisions, right, and your nationalism will remain intact even if you try to understand the issues raised by states as well, because ultimate objective is welfare of the people, right? And that's why the both models of organizing regional units were made, right? Now, so scholars actually divide this system of governance into two parts. Means government we can divide into two parts. One, you can say federal government, another you can say unitary government. So here unitary, there's federal. So in case of unitary, as the word says, unitary, unit means one unit. So all the power is vested in the national government, okay, and the regional governments if they are there. But please understand, in unitary government, real power lies with national government, and if there are some regional units, then power will be given only by national government. It will be given, okay. It is not that clear division was initially chalked out, okay. But in case of federal government, we have some federal features in Indian Constitution, right? For example, division of power between center and state in Schedule 7 of Indian Constitution, where we have 3 lists, right? Union list, state list, concurrent list, right? So here we see national government and the regional government, they are actually operating in the respective jurisdictions independently, taking their power from these lists, okay. But here they derive the authority from the national government. Real power lies with national government, okay. I've told you about the difference between the models of government. It is not like in case of federal government, the model which we are seeing here is exactly the model which we have in India. We have a hybrid model. Even the word federal is not mentioned in Indian Constitution, okay. And the word we use for Indian model, as K.C. Viray used it, he says quasi-federal, means not fully federal, not fully unitary. We have adopted a middle path here, okay, for considering the challenges in Indian context. So we have some examples in unitary: Britain, France, Japan, China, Italy, Belgium, Norway, Sweden. In case of federal government, we have US, India, Switzerland, Australia, Canada, Russia, Brazil, Argentina, right? So moreover, we are having federal government model, but we are not idealistically, right? And when I say idealistically, for that you need to understand the model which was adopted by world's first established federation, and that was USA, United States of America. Now, just take a look what thing is clear to you. Federation, you are clear with this definition, you are clear with this idea that is not mentioned in our constitution. Indian federal system is based on Canadian model. What does it mean? It means in our case, center is more powerful than state. So this model was adopted by Canada and we have adopted also. Okay, that is why we call it Canadian model. Now this federation can be made by 2 ways. One is integration. For example, after American Revolution, when United States of America was getting formed, it took a long while, right? But initially, 13 states, they came together. Means integration happened. And why? Because they found themselves that we are militarily and economically not viable enough to secure our interest, and that is why it is better that we join together, right? So militarily weak, economically weak, backward, and they join together, that is integration. Then we have disintegration. What does it mean? A big unitary state, for example, India as a state. Now, India as a state has this power using Article 3 that we can actually carve out new states as well, right? We have carved out in this whole journey. So, in this case, the state status to a particular region is also given by the national government, right? So this is disintegration, granting autonomy to the provinces to promote regional interest, and this is the purpose. For example, Uttarakhand was carved out of Uttar Pradesh for what? For spurring economic growth, right? Jharkhand was carved out of Bihar. The reason was growth. Chhattisgarh from Madhya Pradesh, reason was growth, right? So it means here we are observing disintegration. Okay, and disintegration means breaking. Okay, example Canada and India, there we call it disintegration model. Okay, so I think this is clear to you. Now attempt this question, and I find this question as direct, but there is some intricacy involved. Federal form of government power. Just attempt this question. You have 5 seconds to attempt. Power is vested in national government and state government. Power is vested in state government only. Power is vested in national government only. So by simple logic, most of the students, what they are going to do, they are going to remove these options. Yeah, these options are clearly wrong, right? And some students actually are going to mark A as the answer, because the word is power is vested in national and state government. So they will think, okay, yes, power is there. In case of India, power is there with state as well as national government, right? But this option is also wrong. The reason is, question is saying federal form of government power. So they can say federal form of government may be represented by which of the following statement. Sorry. So in this case, what you are going to do, you have to actually understand which definition actually defines this federal concept. So do you think if someone reads this, that person will be able to identify, yes, this is federal form? No. Because I told you na, that in case of unitary government, there may be state, there may be region, and it may be possible that national government will give some power to the state government, right? So in this case, do you think this is directly connecting to the federal form? No. For federal form of government, there should be mention of the word divide, means division of power between center and state. Okay, these details you need to be clear about. So divided between national government and regional government, and both, since they have clear division of power, they can operate in their respective jurisdictions independently. Okay, I hope now you're not going to commit this mistake. Now let's compare federal and unitary features, and this is quite simple to even remember. Okay, UPSC asked one question from here, which of the following features can be represented as federal features, right? So now take a look. Dual government. It means there will be two government. One government at the center, other government at the level of state. Next, you can see written constitution. Now, what federalism has to do with written constitution? There's a reason to that. If constitution is written, then this will have a structure, defined power sharing between center and the constituent units, right? If in case this is not written, the whole power to decide what is going to be considered as constitution is given to parliament at the level of center, don't you think the rights of the constituent units can be subjugated at any point of time, right? So this clarity needs to be in your mind, that written constitution is a feature of federal government, because if these features are clearly written, then there will be a clear clarity in the at state level. Yeah, these are the areas in which we have to work. We are safeguarded by constitution. Okay. Now division of power, that is quite obvious. We were talking about this. National and regional government, they should have clear division of power. Supremacy of the constitution. Constitution should be supreme. It means no other organ of the government can supersede constitution, because it may be possible parliament will try to actually take away the power of state, but this cannot happen in Indian context. Why? Because we have supremacy of constitution, right? There are provisions where actually parliament can actually make law with respect to state list. There are provisions, but this provision cannot be used arbitrarily. There's a logic behind it. If at any point of time parliament try to actually trespass into the prerogatives of state arbitrarily, that is not important for the national integrity, unity. So in this case, what Supreme Court is going to do? Supreme Court will declare such law null and void. So that is why, because Supreme Court is the actually guardian of Indian Constitution, and supremacy of Indian Constitution is a feature. Rigid Constitution. Here rigid Constitution is related to amendability. Means it is difficult to amend Indian Constitution, and especially in federal governments, right? This feature is there, because if amendability is easy, then at any point of time the power dynamics, the area of working between center and state can be changed. So this need not to be changed. That's a promise actually center and state have to uphold between them, right? So that is why rigid word is used. Okay, means amendability is difficult. Then independence of judiciary, because only judiciary can actually ensure supremacy of constitution when center and state are in conflict, right? So basically, independent judiciary is needful for this federal government for two reasons. There are two reasons. Number one, to uphold supremacy of constitution, right? One reason is that, and there's another reason. Second reason is Supreme Court, means in this case judiciary, is going to listen to the conflict between center and state and resolve the conflict between center and state, right? So legal disputes can be taken at the level of judiciary, and a state will go to the judiciary only when there's independence of judiciary, right? So do we have some features of independence of judiciary in Indian context? Yes, we do have. For example, fixed tenure, right? You have, when it comes to their salaries, you have, security that their terms of engagement cannot be changed during their tenure, right? So this represents independence of judiciary. Judiciary has independence with respect to the financial needs they have, right? In Parliament chapter, we are going to discuss this. What is the difference between charged on consolidated fund of India and what factors can be voted? So safety, you can say, independence is given to judiciary. That's a feature of federal government. Bicameral legislature. What does it mean? We have two levels at the level of parliament, two houses, Lok Sabha and Rajya Sabha. And the Rajya Sabha word itself represents Council of State, right? So my friends, you should know this fact that when federalism as a concept was evolving in West, so it emerged from this idea that small units should have some say in legislative body at the center. Small units should have say in legislative body at center, because Lok Sabha actually represents will of people when whole of India is taken into consideration. But when it comes to state specific issues, we need a separate body, separate house, that is Rajya Sabha, right? And in case of India, we have representations given to state in Rajya Sabha based on population, and this representation varies from 1 to 31. Right? And this is difference, because in case of India, how many seats a particular state is going to have in Rajya Sabha depends on the population you have, right? There's no equality in representation with respect to, states. But in case of America, their federal model is such that in US Senate, every state is given 2 seats. No matter how much population you have, no matter what territorial area you have, 2 seats. And that is why the seats are 100. Because 50 states they have, and then independent area Washington DC, right, district. So this is the difference between American and Indian model. But bicameralism is a feature of federal government. Please remember that. Okay. Now, when it comes to unitary government, it is quite easy to remember. Just take a look that we were so actually clear about this. Ki, yeah, these are the features which are needed for federal government, right? In case of unitary, there's a mix. Means maybe written, maybe unwritten, maybe rigid, may not be rigid, maybe supremacy of constitution, may not be supremacy of constitution. Take a look. Unitary government, single government is there, right? Real power lies with center, and center may create regional government. They may give some power to them, but power is coming from the center. Constitution may be written and may be unwritten. For example, France written and Britain unwritten. Both have unitary government. No division of power. Means all power are vested in the national government, but here we have division of power. Constitution may be supreme, may not be supreme. For example, constitution is supreme in Japan, and constitution is not supreme in Britain, because in Britain parliament is supreme. Parliament is deciding which law is going to be considered part of constitution, right? Constitution may be rigid, may be flexible. In case of France, it is rigid. In case of Britain, it is flexible. Judiciary may be independent, may not be independent. Legislature may be bicameral, may not be bicameral. For example, unicameral in China, bicameral in Britain. So it means you should remember the features of federal government. You should be clear about the concept, right? The logic behind them. And here, in case of unitary, you can consider maybe. Okay? So I think it is clear to you now. Now, why India adopted federal system? 2 major reasons. First is our geographical experience. Means our large size, right? In large size, to manage it, there may be some regional aspirations in this area which may be different from this area. So if we divide some power between center and this area. So it would be better for the people of these areas if their regional aspirations can be heard at the level of state as well. If there are some national aspirations that can be heard in Lok Sabha, regional aspirations can be taken into consideration at the level of state as well, right? Social cultural diversity, if social cultural diversity is such, then it means we should actually divide the power into different regional units, right? Now, Article 1, it describes India's state as a union of state. There's no mention of the word federal, and connotation is that meaning is that India is an indestructible union of destructible state. So what does it represent? It means although we are actually having union of state, it means we are talking about a federal model, but the power is tilted towards center. Union of state has been preferred over this. Indian Federation is not the result of agreement. We are not result of agreement, right? Because India as a state was created, and then India as a state was actually making that, yeah, these states will be there. Because American Federation was actually a result of an agreement that some states were coming together. But here, we are not coming together. So there are two models, coming together, holding together. We are not coming together, right? We are holding together, and we were carved out. The states have no right to cede from the federation, right? Federation is union because it is indestructible. Now, features of federalism, those features which we have discussed, I have just given representation here. Now, unitary features means in case of India, we have federal features, we discussed it, right? Now, we also have some unitary features. For example, integrated judiciary, Supreme Court, High Court, and then lower courts. Integrated judiciary is there, right? A strong center is there in India. What does it represent? Unitary features, right? There are areas where center has more power than state, right? States not indestructible, Article 3, states can be divided, and state can be divided and by parliament, and state will not have any, you can say, any power to stop that if we talk about state legislature. Because such bill will be given to state, but their recommendation or their apprehension is not binding on parliament. And this state can be divided by simple majority. I told you in Article 3, Article 4. Single constitution is there. We don't have the system that state can have their own constitution, right? In US case, they have. Single citizenship is there. You need to be citizen of India. You need not to be citizen of other state, right? Flexibility of the constitution, there is amendment procedure, and in case of amendment can be done by simple majority. In some cases, as I gave you we'd had this discussion in amendment to Indian Constitution part, and I gave you example in Article 3, Article 4, right? Apart from this, there are some amendments in which state assent is not needed, right? Emergency provisions are there, Article 352, 356, 360. And when they are used, the power dynamics between center and state, they actually get tilted towards center. So it is a unitary feature. No equality, as I told you. In case of Indian Raj Sabha, we have 1 to 31 seats based on population they have. But in case of US, they have this concept of equality, 2 seats per state, right, in their Senate. So now critical evaluation of the federal system. It means what are experts' opinion on India's federal system? Take a look what K.C. Vere says. He says, India is not completely federal. India has unitary features and these subsidiary federal features rather than a federal state with a subsidiary unitary features. Okay, so it means if we have to decide between federal and unitary features, we have more unitary features and subsidiary federal features. Okay, so you can use this statement in your mains answer. So that's why he used this word, India is a quasi-judicial state, quasi-federal state. You should use the word federal. Quasi-federal means that we are not completely federal. We have adopted a golden mean path. Okay. Now, according to K. Santhanam, India has practically functioned as a unitary state. It means both observations are talking about unitary feature. Though the Indian Union states have tried to function formally, legally as a federation. that we have Rajya Sabha, we have setups in which state upholding the laws made by center, we have this finance commission deciding, giving the formula, recommending the formula of division of financial resources. So it means K. Santhanam is saying, yeah, legally we have functioned as a federalism also, but still we should know that we have unitary features. And why we were having unitary features? Because of the challenges which constitutional framers were observing in India. The challenge of secession, right? Now, Paul Appleby, he says that Indian system is extremely federal. He says that there is division of power. Morris Jones termed as bargaining federalism. Bargaining federalism means now state governments, because they have their political, they can have their political might in center as well. On this basis, they actually bargain with the center. For example, regional parties, when regional parties, they are supporting the coalition at the center, they say we are going to support only when you give 10,000 crore package, a special package to our state. So this kind of bargaining also happens in Indian federalism. Grenville Austin says Indian federalism as a cooperative federalism. It means center and state have a lot of areas where they both cooperate. For example, Niti Aayog, GST Council. It means in GST Council, both center and states are there, right? And they take part into decision whether what should be the GST slab, right? And Niti Aayog, when it comes to big ideas, it is Niti Aayog which actually take into consideration the views of states, check the practicability of those ideas and give recommendation to the center if such policy can be made for that state. So it means Grenville Austin cooperative federalism can be seen here. So in Bombay case, please remember, Bombay case was related to misuse of Article 356 by union, where state governments were toppled for political gain using Article 356. So Bombay case clearly said that no, this misuse of Article 356 should not happen, and just federal system, federalism is the basic structure of Indian Constitution. Okay, so whenever it comes to federalism question, you can quote Bombay case establishing federalism as the basic feature of Indian Constitution. Okay. Now, do we know some trends which actually represent that yes, in Indian political system there is federal spirit? So you can clearly remember them. For example, we have territorial dispute between states. So if territorial disputes are there in between state, it means they recognize themselves as independent political and administrative unit. That is why they are having this conflict, right? We have conflict on water issues, water sharing. We have this emergence of regional parties, and these regional parties actually showing influence in Lok Sabha as well. We have creation of new states, right, on this agenda of development. We have this more financial grant demand by different states. We have this assertion of autonomy of the state, that they want more power, they need certain areas need to be given more, you can say, more authority. So what does it represent? It represents that at the regional level, political and administrative unit has this consideration that there are areas in which they are independent from the national government, and this is called federal spirit. I hope you are clear with the concept now, right? Now attempt this question. Which of the following are recommendations by Sarkaria Commission? You should remember Sarkaria Commission, Punchi Commission on center-state relations. So you should just go through the recommendations made by this Sarkaria Commission, and you can quickly use these points whenever a question is asking you to have arguments on center-state relations. Okay, so if you go through them by recommendation, you will be able to understand the issues as well. Okay, so just take a look. What do you think? A, B, C, D, all four. So answer is all of the above. Okay, so these are the recommendations of Sarkaria Commission.